to
2:30 ಇದ್ರೆ ಮಾತ್ರ so what
Without making us
2:30 ಗೆ ಹಾಕ್ಬೇಕು
ಅಲ್ಲ ನಮ್ಮ ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ
ಅದಕ್ಕೆ 2:30 ಬೇಕಾ ಕೊಡಿ ನಾಳೆಗೆ
2:30.
no adjournment sir.
One matter.
you want to withdraw then be quiet when it reaches you
Matter
tell
at
me
2:30, my lords.
yes
Qualification of members, my lords. Sunday is on election, my lords.
ನಾಳೆ tomorrow ಕೊಡಿ
2:30, my lord. Yesterday I moved attachment order, my lord.
ಕೊಡಿ 2:30
Please.
With your lordship's kind permission, matters pertaining to Bangalore's bench, Councillor
My lord.
Kumar is appearing online.
My lord, this is a KIDB matter, my lord. It was supposed to be listed today, my lord.
not listed
Not listed.
Oh, my lord, it's not,
For
my lord.
tomorrow, my lords.
we'll list it tomorrow is okay tomorrow we'll list it give it
Highly
Wait for
objection,
my-
lords.
2:30, there's a direction to arrest, my lord, by the
Direction to arrest.
executing court.
Ah.
Of course, it was supposed to be CPC, but the classification is because the land acquisition related matter. Therefore, it was supposed to come today, my lord.
ಅಲ್ಲೇ ಬರ್ಲಿ ಮತ್ತೆ CPC ಆದ್ರೆ
Allah, but they've changed it to land acquisition.
Why?
The registry has decided it's land acquisition, so I'm bound by it.
ಬ್ಯಾಂಗ್ಳೂರ್ ಅದ ಇಲ್ಲ ಇಲ್ಲಿದೆ
2:30. 2:30.
serial number 29 permitted to withdraw.
thank you yes
Sir, 174 sir.
you want to withdraw
No sir.
Then
80,000 rupees ಅಷ್ಟೇ ಇದೆ sir arrears.
ಆಯ್ತು ಇರಿ yes wait ನೀವೆಲ್ಲ ಹೋಗ್ಬೇಕು ಇರಿ
My lords, I filed a memo for withdrawal, my lords.
thank you which is that
It's a fresh matter, my lords.
fresh matter memo for
My lords, the child court has already taken the
2:30 ಗೆ ಹಾಕ್ಸಿ ಮೇಡಮ್ withdrawal yes CPC
With my lord's kind permission, may I make a submission, my lord?
in which sir
My
Which
lord,
matter,
serial number 53, my lords.
ah
Could I seek for a short accommodation till tomorrow, my lords?
oh yesterday's matter
Yesterday's matter. Tomorrow I'll come there personally, my lords.
put up ಆಗಿದೆಯಾ
Put up ಆಗಿದೆ, my lords.
Impleading application
Serial
will
number
allow
50.
ಅಲ್ಲ ಅದೇನ್ ಮಾಡ್ತಾರೆ I'll tell you. Your lordship's order is being implemented by the deputy commissioner.
I know sir yesterday ಹೇಳಿದಿರಾ but
When-
impleading application will allow
No, my lords, we have objections to that. Let me make submissions on that, my lords.
I was a party in all the litigation.
I'm just seeking for 1 day's accommodation. I'll come there personally tomorrow with all the documents. I'll try to convince my lords.
Away from Delhi, let the matter be heard, my lord.
who is Gautam is
Yes, yes,
ಇರ
yes.
ಕೇಳಿ ಇಲ್ಲೇ
ಎಲ್ಲ ಬಂದ್ ಪಾಪ ಬೆಳಗ್ಗೆ it has already come now.
ಆಯ್ತು ಸರ್ ಏನ್ ಮಾಡಿ let it be we'll see when it is called
Please.
May I make a submission, my lord?
memo for withdrawal.
ಇದೆಯಾ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ ಸೀರಿಯಲ್ ನಂಬರ್
130.
130 thought
May I make a submission, my lord?
ಏನು
Serial number 65, my lord.
adjournment ಇಲ್ಲ when it is called
My lord, my lord,
I
one
have
submission.
only if you want to
File the
withdraw
My lord, my lord, one submission, my lord. Serial number 65, my lord. Undertake file wakalat, my lord. This one number 2, my lord, sir.
mention when it is called
Please.
yes
Please.
ಆಮೇಲೆ ಅಷ್ಟೇನಾ
My lord, serial number 138, my lord. It's going to withdraw, my lord.
oh thank you 138 in terms of the memo call the case ಲಿಸ್ಟು ಕರಿಬೇಕಾ ಫಸ್ಟ್ ಇಲ್ಲ this list 2 matters which are old 2011 onwards I'll take it at 5 o'clock specifically listed to dispose 5 o'clock will start
First matter.
2011 12 13 ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಇದೆ ಅದಕ್ಕೆ ಸೆಪರೇಟ್ ಲಿಸ್ಟ್ ಮಾಡಿಸಿದ್ದೀನಿ ಸೊ ಪ್ಲೀಸ್ ಕೋಆಪರೇಟ್ ಫಾರ್ ಡಿಸ್ಪೋಸಲ್ ಒಂದು ಅರ್ಧ ಗಂಟೆ ಲೇಟ್ ಆದ್ರೂ ಹೋಗೋದು ಇರಿ ಎಸ್
List 1, serial number 1, Srivatsa Hegde, DS Kamte.
Yes, I represent the petitioner, my lord. My lord, matter related to HESCOM, I was a store manager and an inquiry was held. I was directed to pay rupees 82,000 or so, my lord, and that was being deducted by virtue of the inquiry report dated 15/7/2009. My lord, then this was followed by another notice dated 25/9/2013, 4 years later, saying that the inquiry report is not perfect and that is being withdrawn and additional sum is being sought to be recovered.
Pages.
Kindly see, my lord, page 52.
Which is the impugned order?
C and D.
Now, annexure F is also,
C, D and F.
annexure D, yes, my lord.
Srivats avare, wait.
Yes, my lord.
Yes, tell me, sir.
Lord, in this note, what has happened, Lord? This note, the matter pertains to shortage of materials, Lord.
Shortage of attendance.
Shortage of materials, Lord.
Material, all
So
right.
he's a storekeeper, my Lord.
All right.
Lord, there was a shortage of materials, Lord. Lord, I have Lord, filed detailed objection statement along
So
with the
filed,
documents.
Ah.
Along with the documents to
What
show that, my
documents?
Lord, notices were given, my Lord, continuously, my Lord. No reply was given. Then inquiry was conducted, my Lord. There was an order to, my Lord, recover, my Lord, the
Where is the,
value of the, my
where
Lord,
is the report of the inquiry?
my Lord, in fact, my Lord, your Lordship kindly see, my Lord, annexure E, my Lord. Page 44, my Lord. 15/7/2009.
Page 44.
Page 44.
Typed copy of annexure
Annexure C,
ಇದೆನಾ?
my Lord, typed copy.
Hence no shortage exists. ಏನಿದು?
Order dated, my Lord, 15/7/2009, in exercise the powers conferred, my Lord.
ಸರಿ.
Do hereby pass the following orders, my Lord. The pecuniary loss, my Lord, 82,000, my Lord. That was the, my Lord, value of the, my Lord, shortage of materials, my Lord. Lord, he
To be
accepted
recovered,
it.
1 minute, to be recovered from the salary of the employee. If the delinquent employee returns the above materials declared shortage, the same shall be adjusted against storage's proportionality.
Yes.
2 increments following due is withheld without cumulative effect. Promotion to the next higher cadre shall be withheld for 5 years. The period of absence so and so shall be treated as leave at his credit. Due entry shall be made in the where is the
My Lord, later on, my Lord, what has happened, my Lord, I will just explain, my Lord. After this order, my Lord, Lord, the matter was re-examined by the, my Lord, higher authorities. It was found that, my Lord, with great respect, my Lord, that, my Lord, it was not 82,000, my Lord. The proper, my Lord, consideration of shortage, my Lord, was not considered, my Lord, in this proceedings. So therefore, annexure F, my Lord, detailed notice was issued to show cause, my Lord, why action should not be taken, my Lord, for recovery of, my Lord, the total, my Lord, loss.
15,54,000.
Annexure F, my Lord, your Lordship can decide. 7 days notice, my Lord. So this is, my Lord, the question in this writ petition.
What happened to the inquiry report?
Lord, that is
Determined this 15,54,000.
the inquiry, my Lord, the disciplinary authority.
Which disciplinary authority by himself did this 15,54,000?
Idu,
Was the employee aware of this
Notice,
or
no.
opportunity was given to him in an inquiry or evidence is taken to 15,54,000? How did you increase it without any
notice was given earlier, my Lord.
notice? How did you arrive at this figure?
This, my Lord, annexure
Tomorrow,
F.
if disciplinary authority may arrive at 1 crore, how did you
Yes.
arrive at this figure?
Lord, he was given an opportunity to, my
That's
Lord,
all
reply
right, sir.
this.
How did you arrive at this figure?
Lord,
ESCOM ಅಲ್ಲಿ I'm seeing all arbitrary actions.
Lord,
ಮನ್ಸಿಗೆ
may-
ಬಂದಂಗ್ ಮಾಡ್ತೀರಾ?
Lord, may him, Lord, Lord, page 50, my Lord, the reason is there, my Lord. in
What
the-
reason, sir?
Annexure F, my Lord, actually. My Lord, page 50, my Lord, may I give, read, my Lord, to give notice, my Lord, 7 days, my Lord, notice to reply, my Lord. The detailed reasons are given why, my Lord, we are taking action, my Lord, for recovery of, my Lord, this amount.
How did you determine that? sir?
That is the-
What
that
is
is
the
the-
basis? What is the inquiry officer comes to conclude on a particular premise that the loss is 82,000. All right. He accepts it or not is a different thing. Now, disciplinary authority on his own volition gives a notice determining 15,55,000.
Lord,
Where did he get that?
Lord, determination, my Lord, one
Where
thing.
did he get
Lord,
that?
my Lord, I understand, my Lord. This is the notice, my Lord, this is the
All
notice
right,
itself,
sir.
my Lord.
Notice has to have some basis. Where did he get that?
That is, my Lord, my Lord, my Lord, followed by, my Lord, reasons also, my Lord.
Where, sir?
My Lord, page 50, my Lord, 50, my Lord. ಕ್ರಮ ಸಂಖ್ಯೆ ಕೊರತೆ ಸಾಮಗ್ರಿಗಳ ಮೌಲ್ಯ.
ಅರ್ಲಿಯರ್ ಚಾರ್ಜ್ ಶೀಟ್ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಇದು ಇರ್ಲಿಲ್ವಾ?
ಅದು ಇದಾದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಬರೆದಿದ್ದಾರೆ ಇಲ್ಲಿ ನಾನೇ. ಕ್ರಮ ಸಂಖ್ಯೆ 1
ನಿಮಿಷ ಪ್ಲೀಸ್. ಈಗಿರೋ ನೀವು 15,54,000 ಡಿಟರ್ಮಿನ್ ಮಾಡಿದಿರಲ್ಲ, ದಟ್ ಡಿಟರ್ಮಿನೇಷನ್ ಕೂಡ have been done earlier.
ಮಾಡಿದರೆ
ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ did not consider all this.
ನೋಟಿಸ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಯಾಕೆ ಅದು ಆಕ್ಚುಲಿ ಮೆಲೋಡ್ ದಿಸ್ ಕ್ರಮ ಸಂಖ್ಯೆ 1 ಕೊರತೆ.
ಈಗ is he disagreeing with the findings of the enquiry officer?
This is not the finding, my lord. Actually, this is the reason, my lord, why we are issuing notice to you, my lord.
I'm asking you a simple thing.
Right, please.
This is the order of the disciplinary authority.
Notice section. This is a notice.
Notice of the disciplinary. Did he disagree in this notice to the enquiry officer's report?
Not replied. This is not replied, my lord. Actually, this is a notice.
Sir, did the disciplinary authority disagree with the earlier report of the enquiry officer? No. Without disagreement, how can he issue this notice? Either he should accept the report or close it, or he should disagree with the report and say, give a show cause notice saying why I should not disagree.
ಅದನ್ನೇ ಹೇಳಿದಾರೆ ಅಂತ.
ಎಲ್ಲಿದೆ ಡಿಸಗ್ರಿ ಅಂತ ಎಲ್ಲಿ ತೋರಿಸಿ?
ನಾನು ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ ಜಸ್ಟ್.
ಪೇಜ್ 50 ಗೆ ಬನ್ನಿ ತೋರಿಸಿ.
ಪೇಜ್ 50 ನೋಡಿ. ಜಸ್ಟ್ ಐ ವಿಲ್ ರೀಡ್ ಒನ್ ಸೆಂಟೆನ್ಸ್ ನೋಡಿ ವಿತ್ ಲಾಟ್ಸ್ ಆಫ್ ಪರ್ಮಿಷನ್ ನೋಡಿ.
Yes sir.
ಕ್ರಮ ಸಂಖ್ಯೆ 1 ಕುರಿತು ಸಾಮಗ್ರಿಗಳ ಮೌಲ್ಯ ನೋಡಿ 82,000 ರೆಫರ್ಡ್ ದೇರ್. ವಸೂಲಾತಿ ಮಾಡಲು ಆದೇಶಿಸಿರುವ ಕುರಿತು ಮೇಲಾಧಿಕಾರಿಗಳು ಆಂತರಿಕ ಪರಿಶೋಧನೆಯಿಂದ ಸಾಕಷ್ಟು ಆಕ್ಷೇಪಣೆಗಳು ಬಂದಿರುತ್ತದೆ. ದಿಸ್ ಹಿ ರೆಫರ್ಸ್ ಟು ದಿ ಹಿಮ್ಸೆಲ್ಫ್ ದಿ ಡಿಸಿಪ್ಲಿನರಿ ಅಥಾರಿಟಿ. ದೆನ್ ಮೈ ಲಾರ್ಡ್, ಸದರಿ ವಿಷಯದ ಕುರಿತು ಕೊರತೆ ಸಾಮಗ್ರಿಗಳ ಮೌಲ್ಯ 27 ಲಕ್ಷ ರೂಪಾಯಿ, ಹೆಚ್ಚುವರಿ ಸಾಮಗ್ರಿಗಳ ಮೌಲ್ಯ 15 lakh rupees ಅದು ಡಿಟೆಕ್ಟ್ ಮಾಡಬೇಕಾಗುತ್ತೆ. ಕುರಿತು ಈ ಕಚೇರಿಯಲ್ಲಿ ದಾಖಲೆಗಳನ್ನು ಕೂಲಂಕಷವಾಗಿ ಪರಿಶೀಲಿಸಲಾಗ ಈ ಕೆಳಗಿನ ಅಂಶಗಳು ಗಮನಿಸಲಾಗಿದೆ. He has noticed all these things. Then my lord, the last one sentence I will read, my lord. ಪಂಚನಾಮೆಯಲ್ಲಿ ಕಂಡು ಬಂದ ಕೊರತೆ ಸಾಮಗ್ರಿಗಳು ಮೌಲ್ಯ so and so ಒಂದೇ ಬಗೆಯ ಸಾಮಗ್ರಿಗಳ ಹೊಂದಾಣಿಕೆ ಮಾಡಿ ನಿವ್ವಳ ಕೊರತೆ ಮೊಬಲಗು 10 ಲಕ್ಷ ರೂಪಾಯಿ ಮಾತ್ರ ಉಳಿದಿರುತ್ತದೆ. ವಿವರಗಳನ್ನು ತೋರಿಸುವ ತಖ್ತೆಯನ್ನು ಈ ಪತ್ರಕ್ಕೆ ಲಗತ್ತಿಸಲಾಗಿದೆ. ಡಿಟೇಲ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಸ್ ಗಿವನ್. ಆದ್ರಿಂದ ಕಂಪನಿಗೆ ಆದ ಆರ್ಥಿಕ ನಷ್ಟ 9 ಲಕ್ಷ ರೂಪಾಯಿ 85,000 ರೂಪಾಯಿ so and so ಮಾತ್ರ. ಈಗಾಗಲೇ ವಸೂಲಾತಿ ಮಾಡಲಾಗಿರುವ 82,000 ರೂಪಾಯಿಗಳನ್ನು ಕಳೆದು ನಿಮ್ಮ ವೇತನದಿಂದ ಮರೆತುಕೊಳ್ಬೇಕಾಗಿರುತ್ತದೆ. ಸದರಿ ವಿಷಯದ ಬಗ್ಗೆ ನಿಮ್ಮ ಆಕ್ಷೇಪಣೆಗಳ ಕುರಿತು ಲಿಖಿತ ಉತ್ತರವನ್ನು ಈ ನೋಟಿಸ್ ಮುಟ್ಟಿದ 7 ದಿನಗಳಲ್ಲಿ ಸಲ್ಲಿಸಬೇಕು. ತಪ್ಪಿದಲ್ಲಿ ನಿಮ್ಮ ಆಕ್ಷೇಪಣೆ ಇಲ್ಲವೆಂದು ಮುಂದಿನ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳುತ್ತೇವೆ.
Very good.
The annex F followed by the reasons also with great respect.
Where is he disagreeing with the findings of the enquiry officer? 2005 ಅಲ್ಲಿ ನೀವು ನೋಟಿಸ್ ಕೊಟ್ಟಾಗ, ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಟ್ಟಾಗ, the loss was determined at 2797,850 and excess materials 1554,592 against him. After that, inquiry is conducted. The inquiry officer finds that only 80,000 loss is attributable to him.
The chief is actually, I have given, I have produced the document also, the higher authorities notice that the loss is not 82,000, something more is there actually.
So then he should disagree with the findings of the inquiry officer. Disagreement ಅಲ್ಲಿ ಇವೆಲ್ಲ ರಿಕವರ್ ಮಾಡ್ತೀನಿ ಅಂತ ನೋಟಿಸ್ ಕೊಡಕ್ಕಾಗಲ್ಲ. And what is this penalty that you imposed? ಇರೋಬರೋ penalty ಎಲ್ಲ ಇಂಪೋಸ್ ಮಾಡಿ.
Penalty ಅಲ್ಲ, shortage actually.
Page 46 ಗೆ ಬನ್ನಿ. What is the 2 annual increments ಅದೆಲ್ಲ? How many penalties you impose?
This is not there at present. Annexure is in place of annexure.
ಯಾವ annexure E?
This is annexure F, my lord. This is in place of annexure E. That is 82,000.
What penalty?
ಎಲ್ಲ ಹೋಗೈತಿ, penalty ಏನಿಲ್ಲ.
Sir, page 46 ಏನ್ ಹೇಳಿ? This is why these matters are pending for 12 years. We don't get answers. We'll quash everything and impose exemplary costs for having behaved like this. Their authorities can't think that they are personal fiefdom. They are bound by law. Is this the way to do it?
Annexure F is in place of annexure E.
Where does it say that?
Chief engineer letter R16.
2013 ಇಂದ ಪೆಂಡಿಂಗ್ ಇರೋದು ಇದಕ್ಕೇನೆ. Neither the petitioner will tell nor you will tell. ಈಗ 25/9/2023 you pass an order.
This is order.
That is
notice.
In supersession of the earlier penalty. ಬೇರೆ penalty ಎಲ್ಲ ಹೋಯ್ತಾ? 2 increments ಅದೆಲ್ಲ ಏನಿಲ್ಲ.
Naturally.
ಅದು ಎಲ್ಲಿ?
I understand. Only thing is not the shortage.
ಅಲ್ಲ ಸರ್,
But I
ಶಾರ್ಟೇಜ್ ಅಲ್ಲ.
understand.
ಈ 2 increments, absence ಇದೆಲ್ಲ ಏನಾಯ್ತು?
That will not replace not.
ಆಯ್ತು, ಇದು ರಿಪ್ಲೇಸ್ ಆಗಿದ್ಯಾ? ಇದು ರಿಪ್ಲೇಸ್ ಆಗಿದ್ರೆ ಇದನ್ನ ಡಿಟರ್ಮಿನ್ ಮಾಡಕ್ ಎನ್ಕ್ವೈರಿ ಎಲ್ಲಾಗಿದೆ?
Obviously, therefore,
ಎಲ್ಲ
notice-
ಕೇಸಲ್ಲೂ
I
ಹಿಂಗೆ.
understand, I understand. But obviously, for that reason, notice was given to him, Lord.
ನೋಟಿಸ್ ಈ ರಿಪ್ಲೈ ಮಾಡಲು?
ನೀವು ಮಾಡಿಲ್ಲ. Annexure F ಗೆ reply ಮಾಡಿಲ್ಲ.
ಎಸ್ ಸರ್, ಶ್ರೀವತ್ಸ.
My lord, he has already retired and his pension is also settled.
ಅಯ್ಯೋ ಸರ್, ಪೆನ್ಷನ್ ಇಸ್ ಆಲ್ಸೋ ಸೆಟಲ್ಡ್?
Settled, my lord.
ಅಂದ್ರೆ ಪಿಟಿಷನ್ ಇಸ್ ಇನ್ಫ್ರಕ್ಚಸ್?
That's what the information I could gather, my lord.
ಮತ್ತೆ 15 ನಿಮಿಷ ವೇಸ್ಟ್ ಮಾಡಿದ್ವಲ್ಲ ಇದಕ್ಕೆ. ನೀವ್ರು ಹೇಳ್ಬೇಕು ತಾನೆ ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತ. The learned counsel for the petitioner submits that the petition is rendered infructuous for the reason that the amount is already recovered and petitioner has retired from service and his pension is appropriately settled. In the light of the said submission, the petition is disposed as having become infructuous.
Right.
Bill number 2, Jagdish Patil, Raj, we move on.
Petitioners, regularization, your lords. Earlier, they have been appointed by the society. Subsequently, entire society and the college has been taken over by the government in the year 2010, your lords.
Lordship,
Till today,
management
they are not
also filed
regularized.
one more writ petition.
Sorry?
Management also filed a petition, your lordship. Yesterday it was listed and today is also listed at serial number 196, your lordship.
We'll take them
Same
together.
management, your lordship.
Yes, please.
And what's claim now?
Only for regularization, lords. They have been appointed in the year
Yavaga?
2003, 2004, like that, your lords. That.
How many of you are here?
In my case, around 11 members, your lords. 11
Three petitions,
employees.
your lordship.
In your case ಅಂದ್ರೆ ಇನ್ಯಾವ ಕೇಸ್ ಇದೆ?
ಅಂದ್ರೆ ಮಾತ್ರ ಅವರು ಇದ್ದಾರೆ, ಬೇರೆಯವರು ಇದ್ದಾರೆ.
2, 2.1, 2.2, your lordship.
As what? Where were you appointed?
Your lordship,
In the year 2003, your lords.
Appointed where?
By the society.
Where?
Sorry, your lords. As a FDWA SDC.
ಅಲ್ಲ, ಈಗ 4 respondents ಇದ್ದಾರೆ.
By the respond number 3 and 4. Your lords.
ಅದನ್ನೇ ಕೇಳ್ತಾರೆ.
Sorry, your lords. Respond number 3 and 4.
Yes. As what?
As first petitioner as a SDC, second petitioner as a STC. Petition number 3 as the lecturer in the mechanical department. P4 your lords helper. P5
ಚಾರ್ಟ್ ಹಾಕಿದ್ದೀರಾ?
chart.
Date of entry, date of completion.
ಇಲ್ಲ, sorry your lords.
ನೀವು
That I will do it.
Short dates.
ಕೊಡಿ ಅದು.
Same.
But in 2001, institution is admitted to grant in aid. It started in 1989. Then we got, since the 15 years had not been completed, the institution was still admitted to grant in aid because it was the SC/ST institution. Because as per the government notification, even if there is 1 year, my lord, has passed, my lord, it should be admitted to grant in aid. Now, my lord, subsequently, management is taken over by the government in 2010. My lord, after, my lord, my grievances, my lord, so far as there are, my lord, request me the bottom of the page. My lord, there are 7 subjects which are being taught. The government says we'll take over the management and, my lord, regularize the teachers and other faculties in respect of 4 subjects. For other 3 subjects, my lord, that is our grievance. My lord, the government says we will not, my lord, because that is started in 2003 and 2009.
Everything was by the prior approval of the government?
Yes, the government has passed an order.
Subsequently, your lordship.
My lord, take
3 courses subsequently.
3 courses?
Subsequently.
ಏನು subsequent?
ಆಮೇಲೆ when we have taken over, your lordship, without permission they have.
ಅಪ್ರೂವಲ್ ತಗೊಂಡಿದಾರ ಇಲ್ವಾ?
ಇಲ್ಲ.
ಇಲ್ಲೇ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ ಸಬ್ಜೆಕ್ಟ್.
Please, your lordship, after then subsequently, your lordship, writ petition was filed and they have stated students were there in our college. Then writ petition has allowed and stating that restricting them till the finishing of that academic year, those students who were there, your lordship. Astrometric permission ತಗೊಂಡು they have. That was, please, your lordship.
Earlier writ petition ಹಾಕಿದ್ರಾ?
ಹೌದು.
ಯಾವ್ದದು?
Management has filed.
ಅಲ್ಲ, whoever has filed.
That is the reason, your lordship, it is interlinked, your lordship.
ಆಯ್ತು, 196 ಜೊತೆ ತಗೋಣ. If it reaches, ಇಲ್ಲ ಅಂದ್ರೆ we'll fix a date. ಒಂದು ಚಾರ್ಟ್ ಮಾಡ್ಬಿಡಿ
Yes,
ಯಾವತ್ತು
Your
enter ಆದ್ರೆ ಎಲ್ಲ.
You have filed chronological events, your lordship.
ನೀವು ಮಾಡಿದ್ದೀರಾ?
Earlier, your lordship.
ಆಯ್ತು, let me see.
Please.
Yes, next.
Till number 3. Member Patil.
Lord, my compromise decree was challenged.
Lord, I am for the petitioners in this case, your lordship. I challenge the award passed by the 8th additional district judge and session judge, my lord.
What
That
award?
is the award passed,
Award, date of the
annexure
award.
64, page number 64, your lordship. Relevant page is 65.
60?
5. Relevant page is 65. Annexure M is 64.
Joint memo.
Joint memo is filed by the respond number 1 and the respond number 3, your lordship.
Who's respond number 3?
Respond number 3 is the insurance company, your
Insurance,
lordship.
one yaru?
One is the maternal grandmother of the petition number 1, your lordship. And petition number 2 is the paternal grandmother of the petition number 1, your lordship. And your lordship may kindly see that the respond number 1 was not appointed by any civil court as a minor to act as a minor guardian of petition number 1, your lordship. And the petition number 2 has already filed a petition for compensation on behalf of the minor petition number 1 before the senior civil judge court Hokeri.
That is pending?
Pardon?
That is pending?
That is not pending, your lordship. After the compromise of this petition, that petition was dismissed by filing a memo by the insurance company, your lordship. Your lordship may kindly be see that this petition number 2 is the
Full and final settlement at 12
at
lakhs.
1 lakh rupees, your lordship. It is the collusion of the respond number 1 and
Right,
the
how
respond
much you are entitled to get?
if the deduction of 1/3 is taken into consideration towards the personal expenses of the deceased, then she would be entitled for 24,44,400, your lordship. If it is taken as 50%, then she would be entitled for 18,50,800, your lordship. But it is settled for only for 12 lakhs, that too without any interest. She is entitled for 6% interest from the date of the petition till its realization, your lordship.
Now the minor is entitled on ಹೇಳ್ತಿರೋದಾ?
Please, your lordship. And even the petition number 2 is the genitive mother of the deceased, your lordship. And he was residing with the petition number 2.
Yes, sir. Who are you?
In fact, I am the mother-in-law of the minor guardian. Lord, the case, my lord.
First respondent.
Please. Lord, the case is that, my lord, two grandmother before your lordship, that my lord claiming that the one who was the minor daughter.
What happened to this 12 lakhs?
12 lakh, my lord, it is stayed, my lord.
No, deposit ಮಾಡಿದಾರಾ ಏನು?
It is deposited.
It is not with any one of you.
Please. My lord, sir. Here, my lord, what had happened, my lord? My lord, 2018, my lord, a divorce petition filed by my lords, my father and my mother. The same came to be, my lords, the allowed. Thereafter, my lords, my grandmother, my lords, took me to the, my lords, her place. Thereafter, my lord, 8/3/2019, my father has died. Thereafter, being a guardian mother, my lords, I filed a claim petition. My lords, accordingly, that was allowed.
The claim petition you had filed.
Yes, my lord, that was filed by the grandmother. So the same came to be allowed. My lord, and page 72 for a moment, my lords, I filed an application for.
Why did you get it closed by compromise?
Because, my lords, only, my lords, the granddaughter is entitled, nobody is entitled. That is what 12 lakh is, my lords, compromised. Now the petitioner is nowhere concerned to the present, my lord,
You were not a party there.
No, I have earlier 11 months prior to filing of this petition by the respond number 1, I have filed the petition for claiming the compensation on behalf of the petitioner number 1. I have produced that document at annexure, my lord.
We will determine appropriate compensation and not give it to any one of you. We'll direct the deposit to be made and interest to be utilized towards the interest of the minor. ಇಬ್ಬರಿಗೂ ಬರಲ್ಲ ಅದು.
That can be done, your lordship.
Yes, my lord.
Annexure
That can be allowed. Only that will be done if you are
It is
entitled.
true, my lord. Even your lordship may kindly be see that in view of the judgment of the Honorable Supreme
No
Court is
problem. We will vary the compensation. We will set aside the compromise decree and vary the compensation, but not a pie you will get, both of you.
Your lordship may kindly be see that in view of the
That is the
judgment
only
of the
order
Honorable
passed by the
Supreme
trial
Court,
court, my lord.
this Honorable Court passed a notification on 23/6/2023.
ಏನ್ ನೋಟಿಫಿಕೇಶನ್?
If there are two claim petitions, your lordship, then the second petition which was filed by the legal representative, or it is to be
No
transferred to.
problem. Compromise will be set aside, but not 1 rupee will be paid enhanced compensation to both.
Both may be clubbed and the judgment may be passed. I have no objection, your lordship.
No, I will restore it. I will redo the compensation here itself in accordance with law, and direct deposit to be made by the insurance company. Not, and that interest will be utilized only for the interest of the minor.
Please.
And not to both of you.
One more
Please,
submission, my
I am
lord.
taking care, my lord. She, the daughter,
Whoever is taking
she is
care.
with me only, my lord. And one nimsham, my lord. For a moment, my lord's complaint.
Both of you are fighting for the money that you are getting. You will
No,
not
no,
get.
that is what, my lord. Now, my lord, after death of my father, the petitioner came. My lord, for a moment, complaint one para, my lord. Page 30. Page
Who
30,
is
my
the
lord,
insurance
4 line I am
company you are?
permitted to read.
We have paid the amount, my lord.
12 lakhs you have paid.
Yes. We are under compromise. As per the order, we have paid. That is kept in the name of, I think, minor child.
Minor child, and I am
This
taking.
then
You are the
kept in the
guardian.
FD.
Please, she is with me only, my lord. Now, my lord, this claim was filed by the petitioner claiming that she is the guardian of the said child, my lord. And
Who
my
are you
lord,
claiming to be the guardian? Who are you?
Paternal grandmother, your lord.
ಅದಕ್ಕೆ
She is a
ಅದಕ್ಕೆ
paternal.
First respondent yaru?
She is a maternal grandmother.
mother
Maternal grandmother. She is.
mother.
And my lord, the petition number 2 is also entitled for compensation. your
No,
lordship.
no. Nobody will.
My lord,
be
no,
entitled.
no, my lord, page 30, my lord's complaint.
If you are fighting for that, I will not pass any order on that.
Please, ma'am.
Page 30, my lord, page 30.
Now, what is the compensation one is entitled to in these circumstances in law? 2020 judgment, 2020 accident ಆಗಿರೋದು ಅವತ್ತು.
24,44,400 if.
And what circumstance?
Your lordship may kindly
Break
see
up
that.
ಕೊಡಿ.
If the notional income of 13,250 is considered, because he was a driver as well as he was agriculturist, but if we take the notional income of the deceased, then it will be 13,250. The accident is of the year 2019, your lordship, and 40% of future prospectus is to be considered, and 1/3 is to be deducted towards the personal expenses of the deceased, because he was married, your lordship, as per Sarala Verma. And
ಸರಳ ವರ್ಮ ಪ್ರಣಯಿಸಿ ಅಂತ ಹೇಳಿ. ಸರಳ ವರ್ಮ ಹಳೇದಾಯ್ತು. ಆಮೇಲೆ
please, Amal, that your lordship may kindly be see that if it is taken into consideration, it will come loss of dependency is 23,74,400, your lordship, and conventional heads is 70,000.
See, if someone is entitled to a particular compensation at a higher rate on that day, the compromise is wrong.
My lord, they have come into the compromise with the company.
Whoever it is, one should get adequate compensation. You can't deny that compensation at all.
We have not denied, my
No,
lord.
no. In law, see, you
same, my
ಎಷ್ಟು entitlement ಇರುತ್ತೆ ಅಷ್ಟು ಬರಲೇಬೇಕು.
ಅದ್ರ ಪ್ರಕಾರ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ
12 ಲಕ್ಷ ಎಲ್ಲಿ ಜಾಸ್ತಿ ಬರಲ್ವಾ? ಎಷ್ಟು ಬರುತ್ತೆ? You have entered into a compromise for 12 lakhs. What is the amount of compensation one will get in such circumstances?
Only single dependent, my lord.
Single
Only
dependent,
on behalf of the
50%
minor children, my lord, we filed a claim petition. That is what 12,000 is. And my lord, the
No others
petitioner
are
is nowhere
depending on
concerned
the
with
income of the
the
deceased,
son,
my
my lord. That is the valid compromise, my lord. Now, if your lordship enhance, my lord.
Just and reasonable.
Now, my lord, petitioner is nowhere, his son is adopted a long back, my lord. That is the only complaint. No, petitioner nowhere concerned with the said daughter, my lord. That is what, my
Now,
lord.
12 lakhs is intact.
Please, my lord.
Where is it? Who is receiving the interest?
ಅದು ಇನ್ನೂ ಅಲ್ಲಿ ಹುಡುಗಿ ಹೆಸರು ಮೇಲೆ ಇದೆ, ಅದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ. Now past from 8 years, I am taking care of the child, my lord. School, everything, my lords, I am taking. Just because of the interim order, my lords, I am not able to take care of, my lords.
Your lordship may kindly be see that 12 lakh is, your lordship may kindly be see that if it is reasonable,
We'll
just and
see, we'll
reasonable, if it is in the name of the minor.
Both of you give the breakup.
Please.
Rest the matter on 25th.
Please,
My lord, that amount, my lords.
Interim order may kindly be extended.
Wait, we'll decide on 25th. Yes.
Interim order may kindly be extended.
That amount, my lords.
25 ವರೆಗೆ ಇರಿ sir.
Past from 8 years, my lord, 2014.
In 8 days ಏನಾಗಲ್ಲ. Wait. List on 25th in the fresh matters list. Yes.
Your lordship may kindly be, interim order may kindly be extended.
Interim order ಇದೆಯಾ ಇಲ್ಲಿ?
Yes.
ಏನ್ not to disperse ಅಂತ?
Please, ma'am.
You have taken an interim order since 2021.
Please, my lord. And
It's true, my lord, but it was not
2021 ಇಂದ
reached.
ಎಂಟ್ರಿ ಮಾಡಿ ತಗೊಂಡು ನೀದರ್ ಯಾರ ಇಂಟ್ರೆಸ್ಟ್ಗೂ ಇಲ್ಲ, ಚೈಲ್ಡ್ ಏನ್ ಹೋಗ್ತಾ ಇದೆ ಈಗ?
ಅದು ನಾನು ಒಬ್ನೇ ಕೇರ್ ಮಾಡ್ತಿದ್ದೀನಿ.
What is going to the child now? Out of the 12 lakhs that is entered into a compromise at your instance, interim order is granted here?
My lord, it was not reached in the,
Then
that's
not
why it is
reached.
listed in the fresh matters, your lord.
That I have submitted.
For 4 years, the child has got nothing now.
Please, nothing. my lord.
Please,
This
till
is
2021,
ridiculous.
your lordship,
This can't happen at the instance of you who was never in the picture.
till that, August,
no, no.
1st
List-
August 2021,
List
she was
on,
with
list
the
on
petitioner
Tuesday in
number
fresh
2, your
matters
lord.
list. I am not going to permit this. Yes.
Number 4, KL Patil.
Interim order may kindly be extended till then.
It will be extended only till the next
Please,
date.
please, my lord.
You have no right. Yes.
Lord, yesterday matter, the pension, my lord, has been withheld.
2 penalties imposed both
This,
without inquiry.
Lord may kindly see the, Lord, all the notices were under challenge. Notices of the year 2017. My lord, he retired on 31/5/2021. These pertains to, my lord, without informing the, my lord, the management.
Now pension is not settled.
Pension is not settled.
Why?
There are two aspects, my lord. Even before he could retire, before 3 months, we have forwarded the pension papers, other records. But we have stated that, my lord, since he has taken a benefit of physical disability, the traveling allowance and the relaxation of two components tax, we have requested the government that, my lord, this can be adjusted in discharge.
When did you request?
My lord, this is in 2017.
Where is the communication?
Yes, my lord.
ಈಗ ಏನೇನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮ್ಗೆ ಏನು ಕೊಟ್ಟಿಲ್ವಾ?
ಅಲ್ಲ, ಅವ್ರು ಏನ್ ತಗೊಂಡಿಲ್ಲ.
He is
ನೀವು
not
ಆರ್ಡರ್
ready.
ಮಾಡಿ ಕಳಿಸಿದ್ರು ಕೂಡ ಸಹಿ ಮಾಡಕ್ ಬಂದಿಲ್ಲ ಪೇಪರ್ಗೆ ಅವರು.
He is not ready.
ಫೋಟೋಸ್ಗೆ ಸೈನಿಗೆ ಅಂದ್ರೆ ಅವರು
ಯಾವಾಗ ಕರೆದ್ರಿ?
ಅವಾಗಿಂತ 2017 ನಲ್ಲೇನೆ ಕರೆದಿದ್ದೀವಿ.
ಫಸ್ಟ್ ಕಮ್ಯುನಿಕೇಶನ್ ತೋರಿಸಿ.
Yes. My lord, the first one is on 31/3/2021. He is supposed to retire 31/5/2021.
ರಿಟೈರ್ ಆಗಿದ್ದ.
ರಿಟೈರ್ಮೆಂಟ್ 31/5/2021. ನಾವು ಅವ್ರಿಗೆ ಅವ್ರದ್ದು ಪೇಪರ್ಸ್ ನ ಸೈನ್ ತಗೊಂಡು ಕಳಿಸಿರೋದು 31/3/2021. And the government, for, my lord, making certain, my lord, the objections with regarding the pension papers, that he has not given the passport, my lord, size photos and thumb impress invoices. Yes, it has been written on 3/6/2021. Thereafter, we have, my lord, written letter to him on, my lord, 7/6/2021. He has not signed. He approached this honorable court in 2022.
2020.
And thereafter, you lordships were pleased to direct on 7/6/2023, 7/8/2023, my lord. Even accepting, my lord, these two components, forward all the papers to the, my lord, the
ಅಲ್ಲ, DCRG ಡೈರೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ದು ಎಲ್ಲಿದೆ?
DCRG ಡೈರೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿರೋದು.
ಡೇಟ್ ನಿಮಗೂ ಗೊತ್ತಿಲ್ವಾ?
ಇಲ್ಲ, ಆ ರೀತಿ ಕಮ್ಯುನಿಕೇಶನ್ ಇಲ್ಲ.
ಇದು ಅವ್ರಿಗೂ ಕೊಟ್ಟಿದ್ದೀವಿ, ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಇದಕ್ಕೂ ಕಳಿಸಿದ್ದೀವಿ. 11/3/2021. 11/3/2021. Before the papers were being submitted.
ಯಾರಿಗೆ ಕೊಟ್ರಿ ಇದು? Before papers, why did you communicate this to the government?
While there is, kindly see, before 3 months, my lord, pension paper has to be forwarded. Lord, we have intimated.
Pension paper forward ಮಾಡಿದ್ದು 31/3/2021. ಅದಕ್ಕೆ ಮುಂಚೆ 11/3 ಯಾಕೆ ಕೊಟ್ರಿ?
11/3 is by the management.
Why?
Lord, to intimating the, my lord, the headmaster of the school, who is supposed to, my lord, forward the papers.
Saying what?
Saying that, my lord, from 1992 to 2017, he has taken a benefit of disability, my lord, the professional tax exemption on the basis of physical disability, and he has also, my lord, received traveling allowances for the disabled person.
All right.
So this you can, my lord, we have stated that it can be recovered 1,73,152.
Why it should be recovered?
Because irrespective of 2017, there are a correspondence, we have issued a notice to him.
Why?
Because he has not produced any certificates to that effect to the management, and without informing the management or taking consent to the management, he has submitted the application, he has drawn it. So we have called him an inquiry.
Is he the pay dispersing officer of the institution? Is he the principal?
No, he is not the principal.
What is he?
No, he is a teacher.
All right. Without any intimation, he has.
No, he has, yes, directly has given.
To whom?
The department. And he has replied saying that, I don't know, it should be submitted to the management.
When was it for the first time drawn?
2007, drawn, my lord? 1993.
1993.
Yes.
When did you notice that he has
2017.
directly communicated to the government?
Pardon?
Directly communicate ಮಾಡಿದ್ದಾರೆ ಅಂತ ಯಾವಾಗ ಗೊತ್ತಾಯ್ತು ನಿಮ್ಗೆ?
2017 ಅಲ್ಲಿ.
2017. ಈಗ ಗ್ರಾಂಟ್ಸ್ ಬರುತ್ತಾ ನಿಮ್ಗೆ?
ಗ್ರಾಂಟ್ಸ್ ಬರುತ್ತೆ.
ಆಲ್ ರೈಟ್. 2017 ಅಲ್ಲಿ ಅಂದ್ರೆ 24 ವರ್ಷ ಆದ್ಮೇಲೆ ನಿಮ್ಗೆ ಗೊತ್ತಾಯ್ತು ಇವರು ಡೈರೆಕ್ಟ್ ಆಗಿ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ದಾರೆ, ಅವ್ರಿಗೆ ಬರ್ತಾ ಇದೆ ಸ್ಯಾಲರಿ ಅಂತ.
ಸ್ಯಾಲರಿ ಅಲ್ಲ, ಸ್ಯಾಲರಿ ಕೊಡ್ತಾ ಇದ್ದೇವೆ.
ಅಲೋವೆನ್ಸ್ ಬರ್ತಾ ಇದೆ ಅಂತ ಗೊತ್ತಾಯ್ತು 24 ವರ್ಷ ಆದ್ಮೇಲೆ. ಹೌದಾ ಅಲ್ವಾ?
ಅವರು ರಿಪ್ಲೈ ನಲ್ಲಿ ಇದೆ.
ಅಲ್ಲಿವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
ಅಲ್ಲ, ಅವ್ರ ರಿಪ್ಲೈ ನಲ್ಲಿ ಇದೆ.
ಅವರು ಅಲ್ಲಿವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಸರ್?
ಅಲ್ಲ ಅದು ಗೊತ್ತಾಗಿಲ್ಲ.
ಆಮೇಲೆ
that was not my lord the notice. That is why we have requested, and we have not stated that my lord it should be. We requested it can be
ಏನು
adjusted in, it can be recovered in the DCRG and taken to the government. Not it is that management should get.
How can it be adjusted?
Pardon?
How can it be
no, that is what we have written a letter to them.
After 24 years, how can you do it after 24 years?
May make a submissions, my lord. This is a opinion of the management to the government.
Correct.
That this he has done. We have issued a notice. He has not done. He say these are the explanations which has. 2000 ಅವರೇ ಹೇಳಿದ್ದಾರೆ ಏನಂದ್ರೆ ನಮ್ಗೆ ನಿಮ್ಗೆ ಕೊಡ್ಬೇಕಂತ ಗೊತ್ತಿರ್ಲಿಲ್ಲ, ಗೊತ್ತಿದ್ರೆ ಕೊಡ್ತಿದ್ವಿ, ಗೌರ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಆಮೇಲೆ
ಇದಾದ್ಮೇಲೆ ನಾವು ಲೆಟರ್ ಬರ್ದಿದ್ದೇವೆ ಅವ್ರಿಗೆ. they have to take a decision on the whether this has to be deducted or not. They have to issue a pension.
ಈಗ 4 ವರ್ಷದಿಂದ ಮಾಡಿಲ್ಲ. ಜಾಯಿಂಟ್ ಅಂಡ್ ಸೆವರಲ್ ಕಾಸ್ಟ್ ಲಿಟಿಗೇಷನ್
ನಾವು 3
ಗ್ರಾಂಟ್ ಒಂದು 6 ತಿಂಗಳಿಗೆ ಸ್ಟಾಪ್ ಮಾಡಿ, ಅವಾಗ ಇವ್ರಿಗೆಲ್ಲ ಬುದ್ಧಿ ಬರುತ್ತೆ.
ಅಲ್ಲ 3 ತಿಂಗಳ ಮೊದಲೇ ಕಳಿಸಿದ್ದೇವೆ, ಅವ್ರಿಗೆಲ್ಲ ಪೇಪರ್ಸ್ ಕೊಟ್ಟಿದ್ದೇವೆ. 2017.
How did you even determine that 24 ವರ್ಷ ಆದ್ಮೇಲೆ is directly communicated to the state?
No, after issuing that. No, after issuing a notice to him, and when he has not given any proper explanation, we have
proper explanation. He has communicated to the government. Government has given it. Who are you?
No, Lord, he is my employee.
All right, sir.
He is my employee.
He has communicated to the government. Government has given it.
No,
for 24 years, government gives it and you take it away?
No, that the government would have stated that, my lord, we have already given.
The government had told you, yes, communicated to you that this is given. What do you say? It's a different thing. How can you after 24 years do all this?
No, I understand.
There should not be lawlessness here.
No, I understand. But there is no, my lord, any deliberate, my lord.
On this frivolous ground, he has not got pension for 4 years.
No.
On this frivolous ground of correspondence between you and the state, ಎರಡು ತಗೊಳ್ಳಿ, ಎರಡು ಇಟ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ ಅವರೇನು ಮಾಡಿ.
Playing with a pensioner?
No. Kindly see the order sheets of this honorable court.
No problem.
Kindly see the orders of this honorable court. There is absolutely no
order sheet. You see the order now.
Allah, there is absolutely no, my lord.
Absolutely exemplary costs. A classic case for imposition of exemplary costs.
Lords, may kindly see. We
6 months grant you stop, and those officers you will have to pay cost of litigation from all the pocket of the officers who have not granted pension. I am telling you, teachers' pension jote aata adbidi. If you are playing with any teacher's pension, you are committing a sin. The state will commit a sin. And 4 years in the teacher doesn't have pension, what does he do?
When we have asked him
What
to
when you
get
have
the
correspondences between you will not solve pension ಬರಲ್ಲ ಅವರಿಗೆ ಅದರಲ್ಲಿ.
provisional
ಅಲ್ಲ ಇದು
ತಗೊಂಡು
21 ರಲ್ಲಿ ಸ್ವಾಮಿ. ಅದಾದ್ಮೇಲೆ
21 25 ರಲ್ಲಿ ಇದೀವಿ ಈಗ.
ಅದಕ್ಕೆ 21 ಆದ್ಮೇಲೆ ನಾವು ಎಲ್ಲಾನು ಕಳಿಸಿದೀವಿ ಅವರಿಗೆ. ನೀವು ನಮ್ಮ ಅವರೇ ಅಯ್ಯದಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
First of all, raking up an issue of 24 years was your mistake. You cannot do this. Your ego is hurt because he has communicated to the government. Then what?
Absolutely.
Then what?
Where is the question of? because we have.
You're also on this side seeking
I
pension
know,
many a
I know,
time.
I know.
See,
Most of the time I'll
most
be
of the
there.
time you are there. Management's ego is hurt because he has communicated to the
No,
government.
in this case,
24 years ago.
in this case, my lord, I will make it. In this case, my lord, absolutely that is not, my lord, when your lordship has passed in a first order, my lord, I was the person who was directly called and they have consented. He has, my lord, in 2023, he has not signed a paper.
ಎರಡು component ತೆಗ್ದು
ಇಲ್ಲ ಇಲ್ಲ ಎಲ್ಲ ಸೇರಿಸಿ ಕೊಡಕ್ಕೆ ಹೇಳಿದೀನಿ. ಅವ್ರ ಮುಂದೆನೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದೀನಿ.
Yes.
When your lordship has passed in a first order, I have intimated the management.
Is before this court calling in seeking the following prayer. Heard so and so. Facts in brief, germane, are as follows. The petitioner is appointed as an assistant teacher in Kannada language by the fifth respondent. The fifth respondent is the Hirekerur Taluka Vidyavardhaka Sauharda Sahakari educational institution run by the fifth respondent. The educational institution is the sixth respondent. The petitioner joins the service on 18/7/1987. The petitioner is said to be suffering from disability.
Page 86.
Page
86. Disability notification by the state government.
Certificate
ಇದೆ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ ಅಲ್ಲಿ.
ಎಲ್ಲಿದೆ percentage?
40 less than 40%.
Was said to be suffering from a disability which is to the tune of 40%, as is obtaining in a certificate issued by the state government on 11/3/1998, which only reiterates the earlier disability of the petitioner. The disability leads the petitioner to communicate to the department that he is entitled to certain allowances on the score that he is a disabled employee. The communications were answered by the government and he is granted the benefit of tax deduction being a disabled employee and is also granted traveling allowance. Again, on the score that he is a disabled employee and the disability is at the tune of 40%. The disability of the petitioner is not in dispute by anybody, much less the management or the state government.
My lord, we have stated that he has not submitted any documents to that effect. In his reply itself, it is there.
The management, that is the sixth respondent, appears to have woken up in the year 2017, 24 years after the allowance and tax deduction was permitted by the government itself, answering respective representations by the petitioner. The management then issues a notice in the year 2017 to the petitioner contending that he has directly communicated to the government, which could not have been done, which was 24 years ago, and the amount that he has received as tax benefit or the traveling allowance would be 1,71,000 rupees. This, the management says, could not have been done without their concurrence or the representation routed through the management. The petitioner submits his reply. In the reply, the petitioner accepts the mistake that he has communicated it to the government and pleads ignorance that he always thought that it should be communicated to the government to get the benefit. Anyway, to get the benefit. But the representations, the state does not point a finger at the representation, but grants the benefit. It is the management's ego that appears to have been hurt in the issue. The petitioner then retires on attaining the age of superannuation on 31/5/2021. Prior to the retirement of the date of the retirement of the petitioner, the management has processed the papers and communicated to the state to disburse pension in all, but observing that 1,71,000 was paid to the traveling allowance and tax liability throughout. The state then the correspondences between the state and the respondent and the management galore. In the correspondences, in the teeth of the correspondences, what the casualty is the non-payment of pension to the petitioner. The petitioner, the allegation is that the petitioner has not signed on the papers for the pension on the score that two of the components, i.e. traveling allowance and tax deduction that was taken, could not have been granted. He is asking for full pension. Therefore, he refuses to sign. The refusal leads to filing of the present petition on 25/5/2022. This court has passed a slew of orders way back in the year 2023 itself, directing. One moment.
25.
On 7/8/2023, the following order. On 23/8/2023, the following order. And on 27/9/2023, the following order. And the matter has been pending before this court. On 27/10/2025, the court passes the following order. This ಆಮೇಲೆ ಕಳಿಸಿದ್ದೀರಾ ಈಗ?
ಕಳಿಸಿದೆ.
Subsequently, earlier also we have sent your lordship, ಆಮೇಲೇನು ಕಳಿಸಿದ್ದೀವಿ.
In the teeth of the aforesaid orders, which began in the year 2023, i.e. on 7/8/2023, the fact remains that the petitioner is not paid pension. The non-payment of pension is ostensibly on the score that two of the components are to be deducted. The two of the components are as follows. Two of the components are noted here in above.
And even he is not ready to comply the office objections raised by the accountant.
Why is he adamant? What's his problem? He wants pension or not? He wants pension or not?
ಅಲ್ಲ ತಮ್ಮ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಹೋಗಿ ಮಾಡಿದ್ದೀನಿ.
ಅದಕ್ಕೆ ಮುಂಚೆ ಮಾಡಕ್ಕೆ ಏನಾಗಿತ್ತು ಅಂತ ಕೇಳಿ ಅವ್ರಿಗೆ. Ask him to talk through you. Ask him to talk through you.
5 increment ಹಿಡಿದಿದೆ ಸರ್. 5 increment ಹಿಡಿದಿದೆ. ಮತ್ತೆ ಪೆನ್ಷನ್ ಪೇಪರ್ ಸರಿಯಾಗಿ ಡಿಆರ್ಜಿ ಕೊಡದಲ್ಲ, ಡಿಸಿಆರ್ಜಿ ಕೊಡದಲ್ಲ, ಕಂಡೀಷನ್ ಕೊಡದಲ್ಲ ಅಂತ ಬರೆದ್ರು. ಅದಕ್ಕೆ ಅದು ಹಾಕಿಲ್ಲ.
5 increments were withheld and they were insisting that DCRG and commutation will not be paid. That is why he was.
Where is 5 increments ಎಲ್ಲಿ withhold ಮಾಡಿದ್ದಾರೆ?
Where is the question? It was only regarding that.
Where is?
This is
who has withheld increments?
ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ, ಹಂಗ ಹೇಳಿ ಹೆದರ್ಸ್ಯಾರ ಅಂತ.
ನಾನೇ ಫೋನ್ ಮಾಡಿದ್ದೀನಿ ಅವ್ರಿದ್ರಿಗೆ ಕೇಳಿಲ್ಲ. ಇಲ್ಲ, ಯಾರು ಎದುರಿಸಿಲ್ಲ. ಯಾವುದು ಕಟ್ ಮಾಡಿಲ್ಲ. ಇವ ಎರಡನೇ ಇರೋದು 1,71,000. And he is not even signing the papers.
Pension papers ನಾಗು 17ರಿಂದ 21 ಇನ್ಕ್ರಿಮೆಂಟ್ ಆಡ್ ಮಾಡಿಲ್ಲ.
Increment
ಮಾಡಿಲ್ಲ.
ಎಲ್ಲಿದೆ pension papers?
With my IM lots, which I filed on 9th June 2025.
All right, it will take away the time. I'll pass the order and write this complete manamel. For the aforesaid reasons, the following order. The impugned communications stand quashed.
ಅಲ್ಲ, ಒಂದು ಇನ್ನೊಂದು
notice
annexure L ನಲ್ಲಿ they have withheld payment of 3 months without inquiry. ಅದೊಂದು ಕ್ವಾಶ್ ಆಗಬೇಕು.
ಎಲ್ಲಿದೆ ಅದು?
annexure L page 61. ಅದು
ಕೇಳಿಲ್ವಾ ನೀವು?
ಕೇಳಿವಿ.
ಅದನ್ನೇ ಹೇಳಿದ್ರು. impugned order ತಾನೇ ಅದು?
ಹೌದು.
The impugned orders stand quashed. The petitioner, a pension that is paid to the payable to the petitioner shall be released by the state, shall be processed and be released by the state within outer limit of 8 weeks from the date of receipt of the copy of this order, along with interest at 6% per annum from the date it fell due till the date of payment. The ಮೇಲ್ಗಡೆ writ petition is allowed ಅಂತ ಮಾಡಿ. Writ petition is allowed with costs of rupees 50,000 to be paid to the petitioner by the 6th respondent management. ಆಮೇಲೆ interest to be paid by the 6% interest, ಅದೇ by ಯಾರು ಅಂತಿಲ್ಲ. In the event the amount of pension is not paid by within an outer limit of 8 weeks, the petitioner shall become entitled to interest at 18% per annum, along with costs of rupees 1,000 for every day's delay till the pension reaches the doors of the petitioner. It is open for, ಈಗ ನೀವು ಕೊಡ್ಬೇಕಾಗಿರತ್ತಾನೆ
Pension we are supposed to.
ಕೊಡಿ.
Please, your lordship, will.
ಕಾಸ್ಟ್ ನಿಮಗೆ ಕೊಟ್ಟಿಲ್ಲ, ಅವರು ಕೊಟ್ಟಿಲ್ಲ.
Your papers on correct ಕಳಿಸ್ಬಿಡಿ.
How
Management.
papers, sir?
Pension papers by adding all the increment and other things.
Everything, sir. I have cost everything.
ಅದೊಂದು direction.
ಇನ್ನೇನ್ ಡೈರೆಕ್ಷನ್ ಬೇಕು?
Management to resend the papers.
ನಿಮ್ಗೆ ನಾನು, your lordship has passed an order, I will accept it. When you passed an order on 7/8/2023, I had a video records. He has not even come forward and he has refused to sign, irrespective of your lordship's order.
ಹೌದು, ನಾನೊಂದು ಆರ್ಡರ್ ಮಾಡಿದೆ, ಗೋ ಅಂಡ್ ಸೈನ್ ದಿ ಪೇಪರ್ಸ್ at 3 PM ಅಂತ. ಅದ್ಯಾಕ್ ಮಾಡಿ, ಅದ್ಯಾಕ್ ಅವಾಗ ಯಾಕೆ ಮಾಡಲಿಲ್ಲ?
ಇವ್ರ ಮುಂದೆನೆ ಇವ್ರಿಗೆ ಹೇಳಿ ಹೋಗಪ್ಪ ಅದನ್ನ
ಅವಾಗ ಯಾಕೆ
ಸೇರಿಸ್ಕೊಡು ಅಂತ
ಮಾಡಲಿಲ್ಲ?
ಹೇಳಿ. I had a videograph, if you lordship wants, my lord, I will.
This I have passed 7/8/2023 ಆದ್ಮೇಲೆ I asked on the
ಬಿಟ್ಟು
next
ಕೊಡ್ರಿ ಅಂತ
day,
ಹೇಳಿದಾಗ
go and sign the papers ಅಂತ. Why you did not?
ಅವಾಗ ಹೋಗಿ ಮಾಡಿವಿ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ಸೈ ಮಾಡಿದ್ರು ಸರ್, ಸೈ ಮಾಡಿ ವಿಡಿಯೋನು ಮಾಡ್ಕೊಂಡಲ್ಲ ಅವರು, ನಾನು ಮಾಡಿದ್ದೆ.
ವಿಡಿಯೋ ಮಾಡಿದ್ದೀರಾ?
ಹೌದು ಮಾಡಿದ್ರು, ಅವ್ರು ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಮಾಡಿಸಿದ್ರು ಸರ್.
ಸೈನ್ ಮಾಡಿದ್ದು?
ಸೈ ಮಾಡಿದ್ದೆಲ್ಲ ನಾ ಮಾಡಿದ್ದೆ.
ನಮ್ ಕಡೆನೇ ಇದೆ, ಪೂರ ಪೇಪರ್ಸ್ ಸೈನ್ ಮಾಡಿಲ್ಲ, ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ, ಅದಕ್ಕೆ ಫಾರ್ವರ್ಡ್ ಆಗಿಲ್ಲ.
ಏನ್ ಡೀಟೇಲ್ಸ್
ನಮಗೆ
ಕೊಟ್ಟಿಲ್ಲ?
ಅದರಲ್ಲಿ ಫ್ಯಾಮಿಲಿದು ಫೋಟೋಸ್, ಆಮೇಲೆ ಅವ್ರದ್ದು ತಮ್ಮ ಇಂಪ್ರೆಷನ್ಸ್ ಎಲ್ಲ ಬೇಕು, ಅದಕ್ಕೆ ಅವ್ರು ರಿಟರ್ನ್ ಮಾಡಿದ್ದಾರೆ. ನಾವೆಲ್ಲ ಕಳಿಸಿದ್ದೀವಿ.
I'll undertake, I'll comply everything if that is the
took
case.
it as, my lord, the grudge against the institution. We have not done. He has done it. And irrespective of my telephonic with him,
But
he has refused.
when I passed an order, he should have gone and signed on every paper. Why he did not?
ಸರ್ 14ರಿಂದ
ಇವ್ರ ಮೂರನೇ ಈಗ
ಅದು
ಹೇಳ್ಬಿಡ್ತೀನಿ,
it
ಇವ್ರ ಮೂರನೇ
appears that
ಅಡ್ವೊಕೇಟ್
tussle between the management.
ಆದ್ಮೇಲೆ
I know tussle between management and him. Ask him to go. Yes, go and stand back.
ನಾನೇ ಅವ್ರಿಗೆ ಹೇಳಿದಾದ್ಮೇಲೆ ಸೌರಭ್ ಈಸ್ ದ ಥರ್ಡ್ ಅಡ್ವೊಕೇಟ್. ನಾವು ಇನ್ ಫ್ರಂಟ್ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದೆ. I know because most of them I have appeared, my lord, your lordships know. That is why I said before him I have telephoned to you.
ಅವ್ರು ಹೇಳೋದೇ ಅವು 5 increment add ಮಾಡಲಿಲ್ಲ, DCRG ಕೊಡ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ
ಹಂಗಲ್ಲ. See, when court has passed an order to sign, he has to sign.
I'll have an apology I have filed before the honorable court.
Apology and ಬೇಡ, 50,000 ಕಾಸ್ಟ್ ತೆಗೆದುಬಿಡಿ.
Please.
Interest ಎಲ್ಲ ಇರಲಿ.
Obliged.
But you should not do this. You should not trouble teachers. I don't understand why. I'm seeing this here only.
Yes.
Teachers are not being paid pension. It's shocking. Yes.
Number 5.
Classification. Annexure came and covered by judgment.
Covered? Yen covered?
Page number, Millar's
Covered?
Please, your lordship, earlier he has submitted one judgment, your lordship's judgment, your lordship.
ಏನಿದು?
But
Page number 70 minutes.
70. ಅದು ಗೊತ್ತು. What was this issue?
Pro rata pension, Millar, regarding. He has, Millar, served in the 5th respondent university. The institution.
Oh, Alameen.
Day after, please.
This is Bangalore,
Please.
Alameen, I guess.
Day after,
Alameen institution ಇರ್ಬೇಕು.
4th, Millar,
Yes, Alameen.
please, your lordship. It is my contention that, your lordship,
2020.
earlier he has challenged in the,
2021.
earlier also he has filed a writ petition, your lordship, which is dismissed. And subsequently writ appeal is also filed, your lordship, same is withdrawn by the very same petition.
Where is the earlier petition? Same claim?
Same claim, your lordship.
Which
Same
petition, sir?
Same claim, Millar. So we have hesitated the writ appeal, and in the writ appeal, we filed a memo seeking for Millar's liberty.
Withdraw.
That has been withdrawn, and
Where is it?
page number 100, Millar.
Writ appeal order ಅಲ್ಲಿ?
Page 100, Millar.
Writ appeal 134, your lordship.
Where is the memo? With liberty to pursue such remedies as available in
Please.
law.
Thereafter, Millar.
One minute, sir, 1 minute. Where is the earlier order?
Writ petition order.
Out, sir.
Page number 132, your lordship. Starts from 126.
Writ appeal, Millar. Writ petition. Page 90, Millar. Annexure.
One moment, sir, one moment. Yes, sir.
please, page 90 minutes, annexure N. Wherein Millers, on merit Millers, I have suffered the writ petition. Thereafter Millers, writ petition was challenged. In the writ appeal Millers, after having Millers knowing the judgment of your lordship,
Knowing the
that
reality
is
of
Millers,
dismissal.
no, that is Millers, the benefit of Millers, the judgment. We made a representation without there being Millers representation. I can't. Representation was made as per annexure P Millers, the page 101.
ಆಮೇಲೆ
That representation kept pending Millers.
kept pending.
Yes. Only Millers, my grievance is the after having Millers the resolution, my Millers the joining of respondent number 6 institution has been intimated and their
The
own Millers the
petitioner is before this court seeking the following prayer. The prayer of the petitioner is calling in question a communication dated 20th April 2018, which denies 17 years of his past service. A mandamus is sought by seeking, direction is sought by issuance of a writ in the nature of mandamus, seeking to reckon those services and other consequential benefits. This very petitioner and against the same parties had approached this court in writ petition 46328 of 2018.
19.
In the said writ petition, the prayer reads as follows. Page 82, 83. The coordinate bench of this court on the said prayer passes the following order. Page 93 to 97. The petitioner challenges the said order before the division bench. Before the division bench files a memo on 7th January 2020 seeking to withdraw the petition and pursuing of other remedies available in law. The writ appeal is dismissed by the following order, page 100. After the dismissal of the writ appeal, the present petition is preferred. The writ petition order, in the writ petition that was dismissed by the coordinate bench, the petitioner's prayer is verbatim similar to what is prayed today in the subject petition. The dismissal has become final as the petitioner has withdrawn the writ appeal to pursue other remedies available in law. Availability of other remedy in law would not mean filing a second writ petition on the same prayer, which has already stood decided and the decision having become final. In that light, no indulgence can be shown, notwithstanding any law declared by this court in a contemporaneous case, to entertain the subject petition and grant this relief that he has lost, and the loss having become
thereafter
final.
Millers, thereafter annexure P, their representation, that prayer is also Millers, that prayer, it is not Millers, prayer as that of Millers, the earlier writ petition.
Sir, where there is a right, there is a remedy. You have lost your right.
Regarding that writ petition,
withdraw ಮಾಡಬೇಕಾಗಿತ್ತು?
regarding that writ petition, we are not suppressed Millers,
No,
only for
I'm
the
not
purpose
saying
of
you suppress. Why did you withdraw the writ petition?
only for the
Writ
purpose
appeal.
of jurisdiction Millers, we have withdrawn, and
ಎಲ್ಲಿದೆ ಅದು?
representation was made Millers to that effect, annexure P Millers.
Single judge's order has become final.
Final Millers, but thereafter
ಇಲ್ವೇ ಇಲ್ಲ.
we made a representation Millers, that representation Millers made.
I will not again say he is entitled to pursue remedies. No. Yes,
That
the petition, the petition on the aforesaid score would not become entertainable all over again.
Still Millers, he is working in the respondent number 6
All over
institution.
again, it is open. I would again, I deem it appropriate to reiterate that it is open to the petitioner to pursue his remedies available in law. Yes.
One more Millers observation, may I seek?
Hey.
Now Millers, the petitioner is working still in the respondent number 6.
So
After Millers, the retirement, that benefit is also Millers available.
ಅದು ಬೇರೆ
That cause of action Millers are also.
ಕೊಡೋಂಗಿದ್ರೆ ತಗೊಳ್ಳಿ.
That cause of that observation. Otherwise, my lord, that will be, my lord, the.
No, that will be allowing the petition. No.
No,
No,
after that, my lord,
Sorry,
retirement,
nothing.
after the retirement, my lord,
Then ಆಮೇಲೆ ಬನ್ನಿ ಇನ್ನೊಂದು ಹಾಕಿ. Yes.
that observation, my lord. Otherwise, my lord, he will be.
No, observe. We should never have withdrawn the writ appeal. Yes. Next.
Number 6, Jagdish Patil, MB Kandi.
Lords, in this case, my lords, recently the copy has been served upon me, my lords.
Recently, na?
How?
He is
Mandamus,
appearing,
sir.
Mandamus and the certiorari roads. Let him take it.
Lords.
They have constructed a road in my property. They say
Admitted,
that
na?
they have come, yes, your lords.
Admitted, ah?
Admitted. They say that it was your lords, constructed in the year 2002. I have purchased in the year 2009 and that.
You purchased the property.
Purchased the property.
Subsequent purchase.
Subsequent purchases. In page 40.
Owner ಏನು ಕೇಳಿಲ್ಲ ಬಿಡಿ.
But I am entitled for lots, that's.
My lords, in para 3, they themselves have admitted that there is a cart road.
Who?
The petitioners. Para 3, my lords.
ನಾನು ಒಪ್ಕೊಂಡಿದ್ದೀನಿ, ನಾನೇ ಒಪ್ಕೊಂಡಿದ್ದೀನಿ. I have purchased the property.
ಆಯ್ತು, objection ಹಾಕಿ.
Please, first week ನಲ್ಲಿ.
List on 7th December. ಸಾಕು, 8th
Yes,
ಸಾಕಲ್ಲ?
sir.
8th December, yes. Next.
Number 7, please, Chignarga.
This is covered by the decision.
Covered by?
Please.
What covered?
Grant upon additional increment for having passed the Kannada language examination, lordships. Against which
ಹೌದು, ಒಂದೇ examination ಅಂತ.
writ appeals are pending, your lordships.
ಇದನ್ನೇ ಕೇಳಿದ್ ನಾನು.
ಹೌದು.
Please.
The petitioner is before this court seeking the following prayer. The prior, identical prayers that were sought before this court has been answered by the coordinate bench in terms of its order dated 24th July 2020. The order reads as follows. ಇದು ಹಾಕ್ಬಿಡಿ. ಇಲ್ಲಿಂದ ಹಾಕಿ. Para 14 in the end. The learned HCGP would however contend that writ appeals are pending before the division bench against the said order. If that be so, and there is no stay granted by the division bench to the order, therefore, I deem it appropriate to follow suit SUIT and grant the same benefit to the present petitioner as is granted to those petitioners in the light of the fact that petitioner is similarly situated. Lane operative portion is. Please.
Bill number 8, Hemant Kumar Bhavati, Sadiq Kumar.
Regularization of service, my lordship. It's second time petition before this honorable court, my lordship. They have issued an endorsement, my lordship.
Joined when, sir?
Please.
22/7/97.
22/7/97.
97.
Earlier, did you continue on the strength of any interim order granted?
Please.
Interim order ಕೊಟ್ಟಿದ್ರೆ ಯಾವ್ದಾರು?
ಇಲ್ಲ sir, already
ಇಲ್ಲಲ್ಲ sir.
Continue
Your
with
continuation was on the strength of any interim order.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಏನಿಲ್ಲ, ಕಂಟಿನ್ಯೂ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಇವತ್ತು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಮಾಡ್ತೀವಿ.
Has not completed 10 years, your lordship.
As on 10/4/2006.
Please, your lordship.
Against sanctioned vacant post, huh?
Vacant post, my lordship.
Sanitary inspector.
Please.
The petitioner is before this court seeking the following prayer. Heard so and so. Facts adumbrated are as follows. The petitioner is appointed as a sanitary inspector in the town municipal council Athani pursuant to a resolution of the council owing to a vacancy that existed in the municipality of the post of sanitary inspector. The petitioner works continuously for close to 18 years and then stakes a claim for regularization of his employment in the said municipality on the score that he has completed more than 10 years of service and is entitled to be regularized in the teeth of the judgment of the apex court in the case of Uma Devi. The representation was not considered, therefore the petitioner approaches this court in writ petition 105/276 of 2015. The writ petition comes to be disposed on 8/6/2015 with a direction to the respondent to consider the case of the petitioner in terms of the judgment of the apex court in the case of Umadevi. It is replied by an endorsement on the contending that the petitioner has not completed 10 years of service as on 10/4/2006, and therefore he cannot be considered for regularization of his case cannot be considered for regularization of his services. The petitioner ಏನಿದು has considered ಬೇರೆಯವ್ರದೆಲ್ಲಿದೆ?
ಅದು annexure E2 Lordship, F Lordship.
The learned counsel for the petitioner, Hemant Kumar Havargi, would submit that the petitioner has completed more than 97 and more than 28 years of service as on today. As on the date of the judgment of the apex court in the case of Umadevi, no doubt he had not completed 10 years of service, but it was close to 10 years of service. He would take this court through the documents appended to the petition to demonstrate that in identical cases where, as on the date of the judgment in the case of Umadevi, -10/4/2006, several employees have been regularized. It is only the petitioner who is chosen for a discriminatory treatment is the submission of the learned counsel appearing for the petitioner. The learned HCGP would defend the action of the state in denying the consideration of regularization, again solely on the score that the petitioner had not completed 10 years of service as on 10/4/2006, the date on which the judgment of the apex court in Umadevi was rendered. But the fact that the petitioner was appointed pursuant to a resolution of the municipality owing to a vacancy in the cadre of sanitary inspector is not disputed. However, but would seek dismissal of the petition, contending that the petitioner has no right to claim regularization in the teeth of his appointment and non-completion of 10 years prior to the judgment in the case of Umadevi. I have given my anxious consideration to submissions so and so. The petitioner gets into employment with the town municipal council Athini by way of a resolution. The resolution reads as follows. Annexure A, page 11. The resolution notices that regular recruitment would take a long time and the vacancy available in the case of sanitary inspector was to be filled up and the duties of the sanitary inspector was imperative. In that light, the petitioner gets appointed as a sanitary inspector on temporary basis.
Daily wages.
On daily wages. The petitioner continues in employment for over 17 years and then approaches this court seeking regularization of his services. The coordinate bench disposes the petition by the following order, page 2021. This results in the direction to consider the case of the petitioner results in an endorsement which reads as follows, page 22. The reason rendered is only that the petitioner has not completed 10 years of service as on the date of the judgment of the apex court in the case of Umadevi. The learned counsel for the petitioner has projected instances where several employees are regularized after the judgment in the case of Umadevi, notwithstanding the fact that they had not completed 10 years of service as on 10/4/2006. The said orders of regularization are as follows. Page 24, page 26. If not all, in few of the cases, undoubtedly those employees had not completed 10 years of service as on the date of rendering of the judgment of the apex court in the case of Umadevi, which was on 10/4/2006. The petitioner thus cannot be picked out for a discriminatory treatment if others have been given the benefit of regularization, notwithstanding the aforesaid circumstance. Merely because the petitioner approached this court earlier, he cannot be shown a different treatment, which on the face of it would become arbitrary and violative of Article 14 of the Constitution of India. As to the issue as to whether the petitioner is entitled to regularization or otherwise, The apex court in plethora of judgments in the aftermath of Uma Devi has held as follows. Anandon judgment regularization. So and so. In the light of the law laid down by the apex court, as late as in the case of Dharam Singh versus so and so, the petitioner becomes entitled to consideration of his case for regularization, owing to the aforesaid facts. The petition thus deserves to succeed. Allowed, quashed. The case of the petitioner shall merit consideration for regularization of the services, bearing in mind the observations made in the course of the order, with an outer limit of 12 weeks from the date of receipt of the copy of this order, if not earlier. If on such orders of regularization being passed, the petitioner would be entitled to all consequential benefits except the regular salary of a regular employee. However, the said service rendered after completion of 10 years shall be counted for all other purposes, including terminal benefits.
9, Justice Suresh.
9, my lord, I appear for a petition in this case. This is a case where, my lord, the D group employees, all these petitioners, my lord, they are working in the aided high school. But they are appointed between 1993 to 2000, a regular process of selection. They have been continued work in the institutions, my lord. In the year 2014, my lord, the Annexure A, the government has issued a notification for admitting granted aid for 918, my lord, D group employees working in the aided institutions. So for us, clause 9 of this.
Please, annexure.
This
G,
is
Your
Sunil
Lordship.
Dutt order covered. Nodilva?
Please, Your Lordship.
Page.
But
ಅದು separate
These
IA for disposal
please, Your Lordship, I will.
Not seen?
No, Your Lordship, I will not. I will
List
wait.
the matter on
So far as
26.
this, Your Lordship, Group D is concerned, 2017 ಅಲ್ಲಿ Group D, it is already removed from the resolution notification. Your
order
Lordship.
notice.
No, that is the case where your lordship may kindly see.
26th in the fresh matters list. Next.
Bill number 10, Shri Shanilopan, dear Lord Khan.
My lord, yesterday's matter, my lord. Section 52 of Waqf.
Waqf. Yes, sir.
Lord, Annexure A is a show cause notice issued by the board for the respondents, that is a petitioner, to appear before them and make a say regarding the gazette notification dated 30th January 1974. The claim that is being made by the petitioner is that 1374, that is the Land Reforms Act, by virtue of which they are claiming the tenancy rights.
You prove it, sir, otherwise.
One more submission.
Anything else, sir?
Anything, my submission, my lord.
Yes,
as far as this show cause notice is concerned, it is issued in pursuant to section 52. The parties have to be heard, for which the statutory notice has been given.
To which we have replied, my lord, to the Waqf board.
The contention that has been raised in the other case law that has been referred to, my lord, therein the parties are the tenants. Herein, the very Mutwali is the person who has applied for the grant. That record they have not produced before the court.
Who is Mutwali here?
The very first person who is claiming the property.
Parshurama.
Allah, Parshurama is a subsequent purchaser. Parshuram is not the Mutwali. The first person who has the Mutwali.
When did you purchase?
On 37/2020, my lord.
When did you purchase, sir?
37/2020. It was granted by the land tribunal, my lord. It has attended finality without assailing or setting aside. They have entered the name of Waqf in the record of rights in column number 11, and they are claiming they have issued the show cause notice that it is the Waqf property.
My submission, my lord, till they don't have any title, that the first person who is in favor of whom the grant is being made is being a Mutawalli, he cannot claim.
It was Khidamati, my lord. He was rendering service.
Admittedly, it is a Khidmati service in Am land, my lord. By virtue of which, my lord, the gazette notification is dated 30th January 1974, much earlier to the vesting of the land, my lord. 1374. Section 44, wherein if at all he is claiming as a tenant, he has to be otherwise than the mutawalli of the property. This court, in a similar set of facts, my lord, has held that a mutawalli has no legal right to claim the tenancy rights under the Waqf. That no document have been produced to show that the person who has sold the property, original person in whose favor the property is granted, is not the mutawalli. For the very reason itself, my lord, show cause notice has been issued to bring it to the notice of the concerned parties that
the petitioner is before this court calling in question a notice dated 1/2/2023 by which the petitioner is directed to appear before the Waqf board, before the Waqf board to establish as to why the property should not be treated as a Waqf. Not
contravention of a sale under section 52.
Actually, why is the sale that has happened in contravention of section 52 of the Waqf Act should not be annulled? Heard so and so. Facts in brief germane are as follows. The petitioner is said to be the absolute owner in possession of the property in survey number 8/4 measuring 1 acre 18 guntas situated in so and so. In terms of who comes in, who becomes the owner, in terms of a registered sale deed dated 26/5/2022, executed by one Umesh Gowda, whatever. The petitioner, a little history to the case is that on Yavag Land Tribunal order?
18/5/1981.
The Land Tribunal granted rights to, the Land Tribunal, considering the claim and possession of Khada Saab on the subject property under service inam or khidmati inam, passes an order on in terms of section 19(1) of the Karnataka Land Reforms Act by holding an inquiry with regard to concerning 13 acres and 18 guntas. It is later the father of the vendor of the petitioner gets the rights from the hands of the Land Tribunal for being an occupant of the land on 11/8/1982. It is then the sale has taken place to the hands of the petitioner from the vendor. The Waqf, the first respondent board of the Waqf board issues a notice on dated
1/2/2023.
1/2/2023, invoking seeking to conduct an inquiry under section 52 of the Waqf Act on the score that the petitioner, the sale that has taken place to the vendor and from the vendor to the petitioner being in contravention of the provisions of the Waqf Act. The show cause notice, the notice so issued under section 60 and 60 of the A of the Act is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that they have submitted their reply to the notice and to the notice, and since it was without jurisdiction has approached this court in the subject petition. The learned counsel further submits that overnight the name of Waqf was entered in column number 11 of the record of rights without any rhyme or reason, or the Waqf board having no right or interest in the having no right for such entry. Per contra, the counsel Lord Khan would seek to defend the action, contending that it is only a notice that is given under section 60 and 60A of the Waqf Act, and it is for the petitioner to appear and establish that he is the lawful owner of the property, failing which it becomes a Waqf property. The learned counsel for the petitioner would now seek to join issue, contending that the Waqf board has now issued a notice contending that it is a Waqf property after 43 years of
Gazette notification.
The Gazette notification issued under section 52 of the Act. The learned counsel 52 of the Act, therefore, would submit that the very issuance of show cause notice is without jurisdiction. He would seek to place reliance upon the judgments rendered by the coordinate benches of this court to buttress his submission for quashment of the proceedings. The learned the coordinate bench has, in identical circumstances, held as follows, page 95, 97. The said judgment is again followed by a subsequent order in page 100, 101. The coordinate bench clearly holds on identical set of facts that so long as the order of the land tribunal has remained unchallenged, it would not be open for an inquiry, for the inquiry officer to exercise power under section 54 of the Waqf Act and come to conclude that they were prima facie even Waqf properties. If this were to be permitted, it would amount to nullifying the order of the land tribunal which remained unchallenged. Therefore, the coordinate bench quashes the impugned action therein. In the case at hand as well, the order of the land tribunal has remained unchallenged. Having kept quiet, the Waqf cannot now use section 54 to get over the order of the land tribunal and summon the petitioner to answer as to why the sale that he has the sale pursuant to which he has come into possession should not be annulled. In the light of the issue standing answered by the aforesaid coordinate benches, there is no warrant to pass any other order other than what the coordinate benches have held. For the aforesaid reasons, the following order allowed quashed.
Liberty may kindly be reserved to the respondent.
Yes.
My lord,
Reserved the liberty.
No liberty.
Please.
my lord, serial number 76 also same matter.
70 same urena.
Please, my lord.
Lord Kansar enadano.
76.
Please.
Nivena.
Alla note submission ಮಾಡಿ note submission.
ಅವಾಗ ಕರೆದಾಗ ಹೇಳಿ.
Please.
Please, my lord.
ಅದನ್ನ ನೋಡ್ಕೊಂಡ್ ಬರಕ್ಕಾಗಲ್ವಾ?
They are
ಯಾರು ಅಂತ?
ನಾನು ಇದೀನಿ ಫೈಲ್ಸ್ ನೋಡಿ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀನಿ.
76 ಬಂದಾಗ ಹೇಳಿ.
Please.
Slum 11, Vijayendra Bhimuk now.
Yesterday's
I
matter.
appear for this slum board in this matter, Your Lordship, for R4 and R7.
Without there being any powers under the Karnataka Slum.
Seniority, sir. ಏನಿಲ್ಲ.
Your Lordship, may I make a submission in this matter?
Yes, sir. ನೀವು ಯಾರಿಗೆ?
Your Lordship, I appear for the slum board, Your Lordship.
Where were you yesterday?
Lordship had asked me to get the judgment of the writ appeal, which was confirmed. The order of the Learned
Where were you yesterday, sir?
Your Lordship, Raviraj C. Patil appears in this matter. However, I represent him. There was a death in my family, therefore I could not be present, Your Lordship. But since
All
this
right.
matter was now, the petitioners are relying on the judgment in another case, which is now before the Honorable Apex Court. Now, though the contention of the petitioners in
Take
those
this also
cases
to the Apex Court, sir. Take
No,
this
Lordship.
also to the Apex Court.
The facts
Is there a
in
stay?
that case. No, I'm not
There
on
is
that, Your
a-
Lordship. I am on the point that the admitted fact in this case is that the owners themselves had inducted families on their land. If I may take Your Lordships to page 8 of the petition at paragraph number 3 and 4. The petitioner's case in 101473, which was before the Honorable Division Bench of this Honorable Court and subsequently to the Honorable Apex Court. Their case was that the slum board had inducted families and therefore their land was classified as a slum. But in the
That is not the issue. 1 minute. Whether
Please,
you
Lord.
have power to denotify or withdraw from acquisition. Ashte. That's all
I'll
that
have
is
to-
decided in that. Idya ilva ashte.
that is decided. That is decided, Lordship. I have to concede to that fact that that point has been decided by this
Then if
Honorable
that-
Court
if
and
that
the
goes,
Division Bench.
everything else would go. Whether they have inducted, you have inducted, that is not the issue. The coordinate bench holds that you have no power to withdraw from the notification. Correct?
Please, Your Lordship. That is true.
That is confirmed by the division bench. Correct?
Please, Your Lordship.
The issue is same here.
Please, Your Lordship.
Facts may differ, but the law is the same.
Law is the same, Your Lordship. I have to concede.
The invocation of General Clause Act is what is found fault with.
Please, Your Lordship. In
And
the
the
other
same
case, yes, Your
submission is made by the state, the General Clause Act anta.
Yes, Your Lordship.
Yes.
My only objection may kindly be taken, Your Lordship, that the families were not inducted by us. I'd only pray for that.
Why did you induct
Para number
families?
two, para number 2 of the writ petition may kindly be seen.
Same submission, huh?
They don't read the para number 2. They
Take your
hop
lordship.
To
on
the
to-
writ petition.
Sorry?
Para number 2 of what?
Para 2 of the writ petition.
My lord, sorry for
There was a
interruption.
dispute among the
I take
members
leave
of
of
the
your
family.
Please.
lordship, my lord. I have got-
Yes, sir.
Reaching
Don't-
another.
Don't worry.
There was a dispute in the among the members of the family.
Huh.
Only in the year 2008, pursuant to the order in FDP, my name was entered. By that time, in the year 1976 itself, the said area was declared as a slum, and by virtue of declaration,
The petitioner is before this court seeking the following prayer. Heard so and so. Facts in brief germane are as follows. In terms of a gazette notification dated 10/5/1976, the lands in question were declared to be a slum without issuing an acquisition notification under section 17 of the Act or paying compensation to the petitioner. And the respondents, in order to regulate a makeshift housing or shanties, put up dwellers by virtue of declaration of the land to be a slum under section 3 of the Act. The bit long thereafter, between 16/11/2018 and 22/11/2018, the proceedings of acquisition that had taken place, the declaration of the subject land to be a slum that was on 10/5/1976 comes to be withdrawn or dropped from the said acquisition. The issue is whether the slum board, once having notified the land as notified the land to be declared the land to be a slum as by issuance of a notification under section 7 Madilva section 17 munche
17 ಮಾಡಿದೆ. During the pendency of the writ petition itself, they are in contempt of the order passed by the.
so and so without declaration under section 17 could now drop the denotify the land from acquisition. The issue need not detain this court for long or delve deep into the matter. A coordinate bench in identical circumstances has held as follows, para 2 in the Endorgat. The said order of the division bench, learned single judge is affirmed by the division bench in terms of the order passed on 21st July 2025. The division bench has held as follows.
Para 39.
Issues ಎರಡಿದೆಯಲ್ಲ.
Your Lordship's permission. The only reason for denotification is they did not obtain finance department's approval for.
Come to that. The issues and the answers by the division bench are as follows, para 12 till the end. The learned counsel, Sri Keshav Reddy, representing the state, would now seek to distinguish those orders on a twin score. The reason is that the petitioner himself has inducted people into the area. Therefore, he should not be given the benefit of it to be declared as a slum, which the said submission goes completely contrary to the facts. The slum, it was declared to be a slum way back in the year 1976, and the petitioner is said to have come in possession pursuant to a partition in the family in the year 2009. Therefore, there is no warrant to contend that the petitioner himself in the year 1976 had inducted people into the slum. Therefore, the said submission is contrary to the facts and is turned down. The other submission is that the finance department, the power under the General Clause Act is always available to undo what has been done at the hands of the state. He would invoke section 21 of the General Clause Act. The said submission is already negatived by the learned single judge, in terms of the aforesaid order dated 27 September 2024. And the division bench has affirmed the same. Therefore, the said submission also is unacceptable. Therefore, the twin score that is projected by Sri Keshav Reddy would thus tumble down. The petitioner thus is entitled to, the learned counsel for the petitioner submits that it is denotified only on the score that the finance, there is no approval by the finance department of the state for such acquisition. They said submission, submission need not be considered or gone into in the light of the issue standing completely answered by what the coordinate bench and the division bench have held. The petition thus deserves to succeed. Allowed question.
My request, he is 77 years old. Time limit may be fixed for quantification of the compensation, and
the compensation shall be determined as is ordered by the coordinate benches with an outer limit of 12 weeks from the date of receipt of the copy of the order. Yes.
Along with interest, as
along with all statutory / applicable interest.
Obliged.
Next.
12, Kumar is Badwadgi.
Yadu? 12.
Lordship, could it be taken tomorrow?
26th. Yes. Next.
Meanwhile, statement of objection. They have not.
I have filed your lordship.
26th. Yes.
I
Next.
will file.
Highly obliged.
13, Nagaraj is.
May I request on 4th of December?
Why?
Bank is Lord.
ಅದು ಇಂಟ್ರೆಸ್ಟ್ ಎಲ್ಲ ಏನಾಯ್ತಾರೆ ಅದು?
ಅದು ನಿನ್ನೆ ಇತ್ತು.
ನಿನ್ನೆ ಇತ್ತಾ?
ಹೌದು.
ಅದು ಇನ್ನೊಂದಿನ ಹಾಕೋಣ
Please. 24.
Monday.
Please. I request on 4th December.
Yes, 4th December.
Please. Much obliged.
Film 14, Vijay is. Girish Azar.
Please, ma'am. Yesterday we have filed the application, ma'am.
What application?
For impleading, my lord.
Whom?
Respondent number 1 and 2, who is the adjacent owners of the land, house
Will
property.
issue notice.
Please, ma'am.
Notice on IA. Girish?
Yes.
Notice on IA.
It's a matter where I'm seeking compensation, my lords, on the last date, directed me to file. 4 additional respondents, ma'am.
Notice on IA. ಯಾವ IA? Notice on IA seeking impleadment.
1 of 2025,
1 of 2025.
as well as Marad on the writ petition. I'll send both along with the Marad. I'm sorry, Marad. I'm sorry. In the proposed respondents, Marad, proposed response 3 and 4 are the KNNL, Marad. Chetan Munoli may be directed to take notice.
3 and 4 are?
KNNL.
The learned counsel will allow the impleading application.
In respect of them, but these are the private respondents. The other 2 are.
The private respondents are necessary parties.
Yes.
Mate. For the reasons indicated in the affidavit accompanying the application and being satisfied with the same, the application stands allowed. Insofar as respondents 3 and 4 are concerned, Counsel Chetan Munoli is directed to accept notice for them for the Niravari Nigam Limited. The petitioner to serve a set of papers upon the aforesaid counsel and the emergent notice to the remaining respondents.
They are proposed response 3 and 4. They would be 5 and 6, Marad.
5 and 6.
Yes.
Who are 5 and 6, sir?
KNNL.
Okay, 5 and 6.
Yes. The other 2 would be 3 and 4.
There is a 3 and 4.
Now proposed ranking is different.
3 and 4. Allah will we have implemented them also.
Yes, yes.
Emergent notice to 3 and 4.
Please.
Yes.
Let's. I may permitted to Marad amend the cost title.
Do it, please. Yes. Petitioner is permitted to amend the cost title. Yes. Next.
Any date may I request, Marad?
Barely first week I'll note. Move on.
Please.
Shivraj P. Mutho. Shivatsa is.
Lord, beg to appear for the petitioner, Lord. Lord, the petitioner is chairman of the society. Lord, a disqualification of proceedings was not initiated by the respondent on the ground that the chairman has not failed to conduct annual general body meeting. Lord, annual general body meeting was not annexure B is not the original order. Annexure B. Lord, date of appearance is 9/11 and 15/11 Lord, order of disqualification was passed. Lord, I have filed an appeal.
Come in fresh matters.
There is an interim order, Lord.
That's why. List the matter in preliminary hearing B group.
Please.
On 28th November.
Please.
Yes.
Pray for extension of interim order.
Order subsisting will continue to the next date of hearing. Next.
16, Shan Madhpati.
Lord, challenging the day before yesterday matter, my lord, challenging the compromise decree. My GPA was, my lord, misused and entered into compromise. It's a covered matter, my lord, page 75, my lord.
Yes, Chetnaman.
Please, Lordship, I have produced the judgment of the Honorable Supreme Court, Your Lordship.
Supreme Court ಅಲ್ಲಿ coordinate bench ಅನ್ನು ಹೇಳಿದ್ದಾರೆ.
The same was
That
not.
was reported, my lord.
It and send it back.
Please.
Your Lordship, the alternate remedy is available to them when in case where there's a ground of fraud. In that case, it has to be proved to
Signature
the
ilva nimdu?
signature. He admits that he has signed the
The GPA ಮೇಲೆ my lord,
Only
they
thing
have,
he
my lord,
alleges is that it has been misused.
I was not
Your
informed,
lordship.
there was no such notice, my lord.
What is the date of the compromise?
Well, compromise, my lord, on 26/8/2023, my lord.
23.
Please.
Hmm.
And my lord, the matter was, my lord, GPA is on 19/8/2023.
GPA dated?
19/8/2023.
Compromise on?
26/8/23, my lord.
1 week alli.
1 week only.
Your lordship, moreover, your
I am, my lord,
lordship,
aged
Where
about
is the
7.
GPA?
Lord, it is
Yeah.
at page 47, my
For
lord.
what purpose? Compromise ga?
Only, my lord, to conduct the case, my lord. There was not a single word about compromise. And that was in English, my lord. She was aged about 76 years.
Suit for?
Suit for partition and separate
your lordship.
position. I am the
Her
defendant
right
number
is nowhere
4.
affected, your lordship.
That is
Her
merit,
right
my
is
lord.
nowhere affected.
Why?
She is the defendant. Plaintiffs had filed a suit
Alla,
for partition.
partition suit alli plaintiff defendant alla onde. That distinction is illusory. Elrigu share barutte.
Alla, she has
And then
relinquished
one
her
who
share.
has, my lord, mislead my GPA, he has not, my lord, come, my lord, because he was served.
Anyway, we will follow this, restore the suit.
Please.
The amount that they have received, that should be
Amount ಎಷ್ಟು
30
ಬಂದಿದೆ?
lakh rupees, your lordship. That is
ಬಂದಿದೆ ನಿಮ್ಗೆ?
ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ. I don't know anything
Plaintiffs have
about it.
received under the agreement, your lordship.
Who has
Under-
received?
Plaintiffs, your lordship, who are respondents number 1 and 2.
ಅವರು ಸರ್ವ್ ಆಗಿದೆಯಾ ಅಲ್ಲಿ?
ಆಗಿದೆ.
Partition ಆಗಿಲ್ಲ, ಅವ್ರಿಗೆ share ಕೊಟ್ಟಿಲ್ಲ, your lordship. The only thing that is given to them is the right of passage, your lordship.
No. Ill respondents are served and represented.
Please,
Served and
all are served.
unrepresented.
The petitioner is before this court seeking the following prayer. The petitioner is not a party to the, a suit is instituted in OS 291 of 2022 seeking partition and separate possession. It transpires that the petitioner executes a general power of attorney to conduct the case before the concerned court on 19/8/2022. 1 week thereafter, the matter ends up in a compromise. The learned counsel for the petitioner now submits that the general power of attorney did not indicate the entering into a compromise and taking away the rights of the petitioner. It was only to conduct the case. And 1 week within the execution of the GPA, the matter is compromised and the proceeds are now distributed to all. The learned counsel submits that the issue in the list stands answered by the judgment rendered by the coordinate bench in 103-766 of 2018, wherein the coordinate bench is held as follows. The coordinate bench directs by issuance of guidelines as to how a compromise should be recorded before the Lok Adalat. The directions so issued would cover the issue that is projected in the case at hand as well. In the light of the issue standing answered and the contention of the petitioner that the GPA was never intended to be used to enter into a compromise, the petition, I deem it appropriate to allow the petition recall the order which closes the suit on the said compromise petition and restore the partition suit on the file of the concerned court. Liberty ಇಲ್ಲಿ end page 89 lane order ಇದೆ ಅದಕ್ಕೆ. Yes, ordered accordingly. ಅದು GPA ಇದೆ.
GPA, but there, your lordship, her right was adversely affected. But in this case,
that is, we'll see. Yes.
Please, my lord.
your lordship, that return of amount, your lordship, which they have received.
The proceeds of compromise by all the parties shall be deposited before the concerned court.
Please, much.
Same shall be released. Released.
Subject to outcomes is next.
Your lordship, that is nowhere subject matter of the suit, your lordship.
ಯಾವುದು?
Because ಅದು ಅವ್ರ right of passage ಕೊಟ್ಟಿದ್ದಕ್ಕೆ we had paid them 30 lakh rupees. That was the only compromise. That was the.
Which respondent are you?
Please, your lordship.
Which defendant are you there?
Your lordship, I am defendant number.
Lord, that also
1 to 3,
I had objected
1 to
because
3.
The learned counsel Chetna Viraj submits that the defendants had agreed to a compromise and had paid 30 lakh rupees only for the right of passage, and therefore that should be returned back to those defendants. It is open to the petitioner to file is open to the respondents to file an application before the concerned court seeking release of the said amount once it is deposited. It is the concerned court shall answer the said application in accordance with law.
But my lord, in respect of that amount is concerned, my consent is, my lord, recorded in the compromise petition.
But you have not paid it.
That, my lord, sir, may
Release ಮಾಡಿದ್ದೀನಿ.
He has not paid it.
In accordance with law. Yes, next.
Please.
17, HM Dharwad.
Matter pertaining to my lord selection of Anganwadi worker.
Number 18.
17. Selection of Anganwadi worker. Well, initially, my lord, the petitioner appointed as a the Anganwadi helper in the year 2009. Thereafter, in the year 2012, the respondent issued notification regarding Anganwadi worker. Accordingly, selected in the year 2013 as Anganwadi worker at Nidsoshi village. That is challenged by the non-selected candidate before this honorable court as per Annexure E. This honorable court set aside my appointment order, and the direct the respondents. Para 10 of the order, page 39. The direct the respondents to accommodate the petitioner to the any vacant post in that surrounding in that taluk.
ಏನ್ ಮಾಡಿದ್ರ ಆಮೇಲೆ?
That is a place before the annexure of the committee. The respondents also participated in the committee. The committee passed a resolution. Appoint the petitioner as the Anganwadi worker at the Mankalkeri village. Pass a resolution, page para 42. Thereafter, she was the joint duty at Mankalkeri village as per Annexure H.
Joint duty also.
Please, orally direct the petitioner to join duty at Mankalkeri village. Orally. Thereafter, she request give the appointment order. That thereafter the payment also not paid for a period of 4 months. Then approach this honorable court as per Annexure N. This honorable court direct the respondent to consider that representation in accordance with law. Thereafter issued endorsement as per Annexure R.
What is that?
Stating that he produced the residential certificate of Mankalkeri village.
You are not a resident of that.
Not a resident, as per direction of this honorable court, the KDT committee the pass a resolution. Appoint the petitioner as a Anganwadi worker, the accommodate at Mankalkeri village.
Again back.
Allah, Ali work ಮಾಡ್ತಾ ಇಲ್ಲ, ಲಾಕ್ ಮಾಡ್ಕೊಂಡು ಅಡ್ಡಾಡ್ತಾ ಇದ್ದಾರೆ.
ನಿಮ್ಮನ್ನ ಲಾಕ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಅಂಗನವಾಡಿ ವರ್ಕ್ ಕೆಲಸ ಇದು. ಅಂಗನವಾಡಿ ಕೇಂದ್ರನ. That's why filed writ petition before this honorable court. This one granted an interim order. Permit.
ಇವಾಗ ಬಿಡ್ತೀರಾ ಕೆಲಸ ಮಾಡಕ್ಕೆ?
Your Lordship, as per the order of this honorable court, Your Lordship, in WP number 79897, Your Lordship, another candidate has been selected and she has been working in the place of the petitioner, Your Lordship. Earlier.
Then why did you give it there?
Your Lordship, because even as per the guidelines of Your Lordship, she must be a resident of that.
Did that person come by direct recruitment, is it?
Your Lordship.
How did the other person who is working there come there by direct recruitment?
Because now we are seeking.
Appoint your ಜಾಗದಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿರೋರು ಹೆಂಗ್ ಅಪಾಯಿಂಟ್ ಆದ್ರು?
Because of the writ petition, Your Lordship, which is pending, and she, as per the order of this honorable court, she has been given, Your Lordship. And in Mankalkeri village, Your Lordship, where now she is working, she has been stated, Your Lordship, but she is not given an appointment, Your Lordship. We are asking her for residential proof also, Your Lordship, but she is not resident of that place, Your Lordship. Then issuance of appointment does not arise, Your Lordship. As per the guidelines of the guidelines,
this court directed her to be accommodated elsewhere.
in accordance with law, Your Lordship.
Law generate ಮಾಡ್ತೀರಾ litigation.
Page 39. Para 10.
It is open for the respondent to accommodate third respondent in any other vacant Anganwadi
ಅಲ್ಲಿ
center.
accordance with law ಅಂತ ಹೇಳಿಲ್ಲ ಅಲ್ಲಿ.
Please.
11 ವರ್ಷ ಕೆಲಸ ಮಾಡಿರ್ಲಿಲ್ವಾ? ಯಾವ ಸ್ಟ್ರೆಂತ್ ಮೇಲೆ ಮಾಡಿದ್ದು?
Petition was filed in the 2013, Your Lordship.
11 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ಮೇಲೆ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ something should be ಈಗ ಅಲ್ಲಿ ಯಾರು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
ಮಣಕಲ್ ಕೆರೆ.
ಅಲ್ಲಿ ಖಾಲಿ ಇದೆ ಇವಾಗ ನಾವು ಕೆಲಸ
ಈಗಲೂ
ಮಾಡಿ
ಖಾಲಿ ಇದೆಯಾ?
ಖಾಲಿ ಇದೆ, ಲಾಕ್ ಮಾಡ್ಕೊಂಡು ಇಟ್ಟಿದ್ದಾರೆ ಅಂಗನವಾಡಿ.
As she is
ಈಗ
not
ಯಾವಾಗ
resident,
ಕೊಡ್ತೀರಾ?
resident of a village,
It's all
she
right.
must,
ಈಗ ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
as per
Order
the
ಮಾಡ್ತೀರಾ?
guidelines, your lordship.
No, as per guidelines. The petitioner is before this court seeking the following prayer. The
As they
petitioner,
have filed a contempt also before this honorable
ಅದನ್ನ
division bench, your
precipitate
lordship.
ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. The petitioner was appointed pursuant to a appointed as an Anganwadi worker pursuant to a notification issued on 6/9/2012. The appointment of the petitioner comes to be challenged by another candidate, a non-selected candidate, in writ petition 79897 of 2013, which comes to be disposed on 16th February 2024 by the coordinate bench by the following order. Page 37, 39. While disposing the matter, the coordinate bench observes that the petitioner had worked for 11 long years and directed the state to observe that it was open for the state to accommodate the third respondent in any other vacant Anganwadi center in the area where third respondent resides. Yaar third respondent?
That is regular.
That the petitioner reported to the Anganwadi center to work as an Anganwadi worker at another, what's that name?
Manankal Kere.
Manankal Kere. Long thereafter, it transpires that the state directed the petitioner to produce a residence certificate of being a resident at Manankal Kere, failing which the appointment of the petitioner would not be approved. The petitioner admittedly cannot produce a certificate of residence certificate of Manankal Kere, as she is not a resident of that area. It is only owing to the direction of this court for having worked for 11 years, the owing to direction of this court, which recognized the service of the petitioner for having worked over 11 years and left it open to the respondents to accommodate her in any nearby Anganwadi center. Having accommodated, it was now not open to the state to contend that it shall be only after production of residence certificate. The order which observed that it was open for the state is not challenged by the state before the division bench. In that light, the petition deserves to succeed with a direction. Deserves to succeed, so and so quashed. The mandamus is issued to permit the petitioner for discharging her duties as Anganwadi worker at Manankal Kere Center so and so by issuing appropriate appointment orders till the next direct recruitment would take place.
My objections.
What objection?
As your lordship, as per the guidelines, your lordship.
The learned HCGP would put up vehement opposition for any order to be passed, as the direction now issued would run counter to law. The guidelines are clear that the appointment shall be only from that Anganwadi center, resident of that Anganwadi center and not in elsewhere. The submission of the learned HCGP, though, would merit acceptance in the first blush. The situation in the case at hand is peculiar. Therefore, as a one-off solution to the one-off problem that has emerged, the petition deserves to succeed. With the following order.
Your lordship, contempt has been filed, your lordship.
The learned counsel for the petitioner undertakes to withdraw the contempt. Undertaking is placed on record. The order shall be complied with in the next 4 weeks from the date of receipt of the copy of the order.
8 weeks, your lordship.
8 weeks.
Please.
Jagdish Patil, Uchar Gundappa.
Here on behalf of.
Appear petitioner for respondent 20 minutes.
This respond number 20.
Am I audible, my lord?
Credible.
Audible.
Audible.
Am I audible? Am I audible, my lord?
You're credibly audible, sir.
Lordships had heard it briefly. In fact, avattu ಮೂರು ಜನ VCಯಲ್ಲಿ we were talking and it became so then your lordship said that
It became talk of the town.
ಅದಕ್ಕೆ so we were here.
ಸರಿ. ನೋಡಿ ನಾನು ಹೇಳಿದ್ದೊಂದು 5 ನಿಮಿಷ ಆದ್ಮೇಲೆ ರೀಚ್ ಆಗುತ್ತಲ್ಲಿ. ಹೇಳಿ.
Two things which two aspects we have challenged. That is one with regard to the seniority, where my lord, the person who has completed the degree, person is
ABT ಇದು?
no
No, KHB matter.
KHB matter.
Karnataka Housing Board.
DPC.
And the earlier, my lord, I have challenged one writ.
KHB ಗೊತ್ತಪ್ಪ.
Days matter.
ABT ನ ಅಂತ ಕೇಳಿದ್ದು.
ಇದಲ್ಲ.
ABT ಅಂತ ಗೊತ್ತಿಲ್ವಾ?
ಇದಲ್ಲ.
Appointment by transfer.
ಇಲ್ಲ. There are two aspects. One, whether promotional avenues can be given to the diploma.
Diploma holders can be posted as executive engineers.
Executive engineers.
Or they should stop at assistant executive engineer.
Assistant executive. Whether that promotional avenues can be, that is one aspect, that is one prayer. The first prayer is, now the person who has joined as a diploma, as the junior engineer, they are then promoted to assistant engineer. And the degree holders come directly as the assistant engineer. Then from the assistant engineer, they go to assistant executive. Lordships, I don't have to really have to, your lordships are thinking this, so I don't have to really labor much on that. So my lord, now what has happened is, the person completes the degree in 2020. But she is placed above the degree holders. So my lord, it should be from the date of completion.
Just one moment.
Yes.
This is executive engineer.
Yes.
All right. Feeder cadre is from
Assistant executive.
assistant executive engineer. Only degree holders are entitled.
To executive. She has, so my lord, with regard
No,
to,
my lord, there are two.
yes,
In terms of the C&R, only degree holders are entitled. All right. Now, these assistant executive engineers who have come up to the level of AEE on the strength of a diploma that they are holding, complete their degree while they are working as assistant executive engineers. Now they become eligible by completion of degree during their tenure as AEE, which is the feeder cadre. Now they are also entitled for promotion to EE.
No, that is not the issue. One
Lord,
point.
so what I am submitting is, so one aspect of the matter is that Vasant Kumari, my lord, our challenge to that seniority is that she was a diploma holder, she has completed, that she is eligible to be promoted as an executive engineer, that we have no quarrel. And
Seniority is what?
seniority is, my lord, the degree holders have to be placed above her, she has to be placed at the bottom. That is one. Second, now what happens is, earlier cadre and recruitment rules in 2005, my lord, there was no promotional avenues for the diploma holders for execute to the post of.
Now, what is the present C&R, sir?
The present cadre and recruitment rule says, my lord, where they have given promotional avenue for the diploma holders, where about 4 posts have been reserved for diploma holders and 12 have been reserved for the degree holders.
Page 32, my lords.
So annexure A is the first recruitment.
Petition.
Petition.
Yes. Annexure.
Annexure A is the 2005 cadre and recruitment rules. Annexure A, if your lordships would to turn to page 14.
Executive engineer, 75% by degree, 25% by promotion with diploma.
Yes.
ಇದೆಯಲ್ಲ?
ಅಲ್ಲ ಅದೇ ಈ 21 ಅಲ್ಲಿ ಮೊದಲು ಇರ್ಲಿಲ್ಲ. So if my lord, on the last occasion, what your lordships, my lord, relying on Trilokinath, my lord, what your lordships.
Yes, sir.
So my lord, so your lordships are saying it's a policy decision. So my lord, but now, my lord, in Trilokinath itself, this similar issue was there, And they said that educational qualification can be a criteria and there is no.
You can definitely do it, not a problem. Now, the present 20, when are you all promoted?
Well, we are now eligible for promotion.
Eligible for promotion. They are also eligible for promotion.
Yes, now as I said, my lord, our prayer are twofold. One, my lord, is that the person who has completed the degree during the tenure, they should not be placed above us. That is one prayer. That they have to be placed below us. That's one.
Yes,
prayer.
one moment.
Yes.
This comes into effect on what date?
Lord, this is
C&R.
Annexure
1620, Annexure B, my lord.
1/6/2022.
Annexure B, page
ನೀವು
28.
AWA ಆಗಿದ್ದು ಯಾವಾಗ ಎಲ್ಲರೂ?
172021.
The petitioners, Lord, appointed in the year 2010. Lord, they are promoted.
ನೀವು
AWE, Lord.
Vasant Kumari, my lord,
ನೀವು
appointed.
ಹೆಸರು ಹೇಳಿದ್ರೆ ಯಾರು ಗೊತ್ತು?
Respondent
First
20.
tell me.
20, my lord.
May I submit?
20.
Sir, ನೀವು ಒಂದು ನಿಮಿಷ.
May I submit
ಏನು
the
ಕೇಳಿಸೋದೇ ಇಲ್ಲ,
correct
wait.
facts,
Yes,
Vasant
Vijay Kumar.
Kumari, my lord, sir.
2000 petitioners appoint ಆಗಿದ್ದು ಯಾವಾಗ?
2010.
10.
As what?
As assistant engineer.
Assistant engineer.
When were you promoted as AWE?
172021, my lord.
1/7/2021.
Please.
When were you promoted as AWE?
Lord, I was,
17.
I am representing respondent number 21. Lord.
Whoever, sir. Facts ಹೇಳಿ.
17, my lord. 17.
ನೀವು 17 ಏನಾ?
Please.
I am appointed in the year 89. 2003, I am promoted as assistant engineer. And 2007,
AWE ಯಾವಾಗಾದ್ರಿ?
25/7/2007.
25/7/2007.
2007. Prior to their appointment to the post of assistant engineer.
2007. Then you were only diploma.
Yes, Lord.
All right.
Yes, Lord.
When now you have a degree.
No, my lord. I'm still in diploma, my lord. There is a provision made for promotion to the post of executive engineer under the diploma.
Diploma ಇದೆಯಲ್ಲ 25%.
Under that provision, my lord, I'm being placed as under rule 32, my lord. The interim order granted by this honorable court, my lord, is coming in the way of considering my for regular court.
R20, we are saying that R20 who has completed the degree. R20 could not be placed.
They are not encroaching upon your 75%. They are getting promotion on their 25%. 1 minute. ನಾನು ಕೇಳ್ಬಿಡ್ತೀನಿ, ತಪ್ಪಿದ್ರೆ ನೀವು ಹೇಳಿ. They are 25%, they are getting promotion. Now, when both of you are getting promotion under 75%, 25%, how the seniority had to be worked out is in the feeder cadre. In the feeder cadre, they are 2007, you are 2010. They were AWEs before even you were born in the cadre in 2010. As simple as that, they will have the seniority will be worked out only according to the date of entry into service as AWE. Why? Because it's a separate channel for promotion. They are not encroaching upon unless quota rota is applied here. It is not the issue.
My lord, now they have come into our thing because they become eligible now. Now, my lord, the question is R20 now is eligible to become an executive engineer from AWE to EE. So, but we are also AWE. Now we are also eligible for executive engineer. So there are like 75 and 25. So 12 position. She comes in that 12.
That is why I said as simple as which is the feeder cadre? AWE.
But the qualification or the judgment say.
Which judgment? There is an avenue for promotion even for diploma holders, sir.
When my lord they complete, if a diploma holder, my lord,
not necessary to complete at all.
Our foral. If they go into that other 4, then it's a different matter.
There is no compartmentalization here. You go into the common stream.
They have to either, my lord, they have to either go into this or into that. No, they cannot claim under.
This to that andre yavado.
ಈಗ 4 posts which are reserved. My lord, that is also in challenge before your lordships, my lord.
What is challenge? ಅವ್ರಿಗೆ revenue ಕೊಟ್ಟರದೇ ತಪ್ಪು ಅಂತನಾ?
Diploma holders ge executive engineer kodbadu anta. That's why I'm saying, Lord,
that is
also
recruitment. This notification is challenged.
Yes, notification, yes.
My lord, without arranging
my lord, the entire notification is challenged, which may not be correct. Our prayer is restricted only to that rule, where they have now been given in 20. So your lordships, my lord, on the last occasion, your lordship said that it's a policy decision and the courts cannot.
When did I say?
No, on the last occasion. Trilokinath ತಾವು ಪಾಲಿಸಿ ಡಿಸಿಷನ್ ಎಜುಕೇಶನಲ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಅಂತ
ನಾನು ಹೇಳಿದ್ದೀನಿ.
ಇಲ್ಲಾರೆ ನಾನು BCA ಹಂಗಾರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಕೇಳಿಸ್ಕೊಂಡಿರ್ಲಿಕ್ಕೆ.
ಅಲ್ಲ, have I passed any?
ಇಲ್ಲ, your lordships are not passed anything. Your lordships are only hearing briefly that day. Your lordships only briefly heard that matter.
I had heard this matter.
Briefly, last week.
Last week.
I have, ಯಾವಾಗ ಇದು 21 to 2025. Therefore, till resolution of the dispute, the Departmental commotion shall be.
So, my
I
lord,
deferred it.
our challenge.
Jyoti Mulimani madam has
So, my lord, our challenge.
17.
permitted.
17. Our challenge to this particular rule where now promotional avenues have been opened up for Kumar on few grounds. One.
ಯಾಕೆ ಸರ್ ನೀವೇ ಇರ್ಬೇಕು ಅಂತಿದ್ಯಲ್ಲ? ನೀವೇ ಇರ್ಬೇಕು, ಡಿಗ್ರಿ ಹೋಲ್ಡರ್ಸ್ ಮಾತ್ರ ಇರ್ಬೇಕು ಅಂತ.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ everywhere, even in the mother department, PWD, also the executive engineer has not been subject to correction if what they have to point out. If there also, my lord, this position is not reserved for diploma holders. And my lord, even in Trilokinath, which they rely on for saying about the policy decision, there they say on the basis of educational qualification, it can be done so. And my lord, in all other things, my lord, we have all the things ready with us, where to show in all other departments, executive engineer post, my lord.
So that I am aware. I was, because this comes about after I came here. I didn't know about this. Because I was always of the opinion, why should executive engineer be given only to degree holders? Why diploma holders are treated otherwise?
No, my lord.
Now state has woken up and done this.
No, my lord. What happens is this. In fact, the urban development, the principal secretary also, my lord, writes a letter to the commissioner saying that it may not be proper to reserve this post. That has not been considered. My lord, and then this cadre and recruitment rules, my lord, now when they change it, my lord, there has to be some basis. My lord, and what they say, my lord, in fact, even the latest judgment of where Justice Chandrachud also, my lord, where he also, my lord, records that on the basis of qualification, in fact, Trilokinath.
You can, sir, on the basis of qualification, you can definitely create cadre within cadre, not a problem at all. We are not on that. Now the C&R permit 75, nimage 25.
So, what happens is this. Earlier, when, my lord, the diploma holders went to the court, that time, my lord, the court said, yes, there can be a thing and there is no violation to Article 14 and...
no problem.
Yes, ma'am. So, my lord, what I'm trying to say is, if the cadre and recruitment rule bars them, that's also a policy decision, cannot be challenged. If
way, sir, if it grants them, policy decision.
If they give them, also it's a policy.
Straight away covered by P.U. Joshi.
Yes.
Very ಏನು ಇಲ್ಲ ಅಲ್ಲಿ. Straight away covered.
I have that.
Pushparani, my lord.
2005 6 SEC 236 completely covers the issue.
No, my lord, because even as
court will not sit and assess why this cadre is included, why this is excluded, unless it is arbitrary.
Yes.
Or takes away the right of person. What right of yours is taken?
2023, 15, my lord, again 3 judges bench, my lord, again relying on Trilokinath. My lord, there they say that this classification can be, my lord, what I am submitting before your lordships is this. Now, earlier cadre and recruitment rules, my lord, did not permit the diploma holders to be posted to executive engineers. My lord, there have been a lot of people who have been promoted who have completed the degree. It is not as though...
2003 6 SEC.
Kindly take the list of citations submitted to by advocate on record.
You
I have produced it.
Bhagwat sir ಯಾರಿಗೆ?
R20, my lord.
Oh, respondent.
Mr. Kulkarni.
Kulkarni. Who is Kulkarni?
Yes.
Kulkarni has placed the citations, my lord.
Educated on record.
Arvind Kulkarni.
Please, me.
2003 to 632.
Yes, please.
Para 10 ನಲ್ಲಿ ನಾವು ಏನು ಮಾಡೋಂಗೇ ಇಲ್ಲ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. Court cannot sit and tinker with anything.
Unless arbitrary, my lord, that is where, my lord, if your lordship sees that in Trilokinath, my lord, it is...
I think P.U. Joshi is subsequently reiterated in...
Yes, no, that is in 2025. In 2023 also, my lord, they have said that. I can read out, I'll produce all those things. Lord, what I'm submitting is this. In Trilokinath, my lord, when the diploma holders challenge, saying that we have the experience...
Trilokinath 1974, sir.
Adna 2023 al follow madidare.
Parvalla.
That they have followed because there also Chandrachud was there, 23 also Chandrachud, the father and son. So there also...
So don't tell me son followed the father.
Generally he distinguished and he dissented from his father in one, but here, my lord, he is followed, so in our favor to that extent. So, my lord, now, in 2023 also they say that there can be a discrimination on the basis of educational qualification. Now, my lord,
ಏನ್ ತೊಂದ್ರೆ ಆಗಿದೆ ನಿಮ್ಗೆ? 25% ಅವರು ಬರ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ ಹಾಗಲ್ಲ, ಅದನ್ನ ಎಲ್ಲೂ
ಅವ್ರು ನೀವು ಹುಟ್ಟಕ್ ಮುಂಚೆ ಹುಟ್ಟಿದ್ದಾರೆ ಏಡಬಲಿಯಾಗಿ.
ಅಲ್ಲ ಹಾಗಲ್ಲ, ಅದನ್ನ
Exactly.
without
You come in by direct recruitment in the year 2010. Correct? You take birth in the cadre in the year 2010. Even before you were born in the cadre, these people are AEE in 2007.
Maybe so.
Maybe so alla. Only because it is so.
No, I'm saying maybe so only because that cannot be. Then, my lord, the rules. My lord, may I just also point out, my lord, that there are a few things, my lord, I may probably need a little time to produce all that.
Wait, no time, sir. Ishtalla admele mugispidi.
Allala. Just
whatever your preparation is.
My lord, your lordship may kindly turn to 74.
Section 74. What 74?
74 of the Karnataka Housing Board Act.
ಇಲ್ಲ ಇಲ್ಲ. ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಕಾಪಿ? ವಿಜಯ್ ಕುಮಾರ್, ಹೌಸಿಂಗ್ ಬೋರ್ಡ್ ಆಕ್ಟ್ ಇದೆಯಾ?
Madam.
ಅದಿಲ್ಲಿರಲ್ಲ.
Yes. So here, power to make rules. They have the 74. Now your lordship may kindly turn to 75. Rules and notification to be laid before the state legislature. Every rule made under this act and every notification issued under section 8 shall be laid as soon as maybe after it's made or issued before each house of the state legislature while it is in session for a total period of 30 days. And so now here they'll have to tell whether this was placed before the state, the amendment, the cadre and recruitment rules.
This could have been done even without amendment to the rules, only by a government order.
No, my lord, but what they have done now, this has not even been placed. My lord, this one, my lord, what I'm submitting is this, my lord, we produce all these.
Now, sir,
I will
one minute.
produce even also.
Facts ಆಯ್ತು. Now marshal your grounds.
Now on the, my lord, ultimately this is only on the law now, my lord, because facts are not disputed at all. So it is only on the law. My lord, now where the people challenged in Trilokinath, where they said that diploma holders should be given promotion to the executive engineer, and where, my lord, the writ was dismissed, writ appeal was allowed, the Supreme Court said no, that distinction can be made and there is no violation to Article 14. That, sir, my lord, even in 2023.
Services, I tell you, must be dynamic like the Constitution. It can't be stagnant. 1974 it was correct, andre today you can't say that.
No, my lord, now one more aspect of the matter, my lord. There are certain, my lord, it is, my lord, why in none of the states or none of the departments in the state, my lord, give promotion, my lord, even the mother department PWD or other departments, my lord, I will produce those things, my lord, where the rules are there, where promotional avenues are not been given. Lord, there must be some reason as to why. Lord, diploma,
so water resources
is, lord,
housing board.
Please,
that's a separate board. Why are you bothered about mother department? Don't go to other department at all.
Engineer to idu agatalla, executive engineer where it is on similar lines.
Housing board is a statutory board, sir. Yes. It has its own power.
No,
to make rules.
It has, my lord. So as per that rules, they should have placed it before the legislature. They have to tell whether they have placed and got the approval.
That we will ask. Don't Who appears to the board?
Myself, my lord.
Yes, sir.
2 and 3.
Yes, Bhagwat, sir. We'll allow the petition and set aside all the.
Whether they have got.
We'll set aside the rules.
Kindly see the prayer, my lord, in the writ petition. I don't think, my lord, look at the prayer made by them. Entire rule, they say, not only executive engineer.
The senior council is restricting it to only 25%.
Now you may not have objection.
Lord, according to me, my lord,
we'll allow the petition.
Lord, as far I am concerned, I am degree holder. I am a degree holder.
But
I am a degree holder.
Why made him party then?
My lord, if I'm not mistaken, my lord, he must be representing R20.
R20.
Yes. Seniority. Nam mele hakidare.
Degree holder.
Degree.
Our promotion is under challenge.
Degree.
Our promotion is under challenge before the principal bench, where I have filed a petition. My lord, respondent number 20, my lord, acquires a PE degree while she was working in service as assistant engineer. After completion of the graduation, my lord, without qualifying service, my lord, straight away.
The ABT.
Yes, that is ABT.
That is ABT.
Yes.
You are ABT born, sir.
No, my lord, I'm not
Eh?
ABT born. I'm not ABT born.
ಆಯ್ತು ಅಲ್ಲ
But I
ಆನ್ಸರ್
was
ಮಾಡ್ಕೊಳ್ಳಿ ತೊಂದ್ರೆ ಇಲ್ಲ.
My lord, I was appointed as a, my lord, I was appointed as junior engineer in the year 2000. Promoted as assistant engineer in the year 2005 with diploma qualification. As assistant executive engineer, I was promoted to the post of. Yes, sir.
My lord, I'll require some
But
time.
I have.
Because
But I have
ಅಲ್ಲಲ್ಲ ಇಲ್ಲ ಇದಕ್ಕೆ ಯಾಕಂದ್ರೆ
ಏನ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Yes,
ಹೌದು.
my lord.
Subject to the result ಮಾಡ್ಬೇಡ.
ಅಲ್ಲಲ್ಲ
Yes, my lord.
We'll make the promotions, seniority, everything subject to the result of the petition.
We were ready to argue on last occasion. Today also, my lord, I'm before your lordship.
I am
my lord,
ready to hear, sir.
Only for this reason, my lord, because
What reason?
no, I want to place all the other judgments, my lord, where
Please, sir.
with regard to seniority also.
Please give, sir.
But I have one more submission. But they have accepted my seniority. They are not questioned in 2022. I have produced that seniority list
Somebody
also.
else is questioned, bidi.
No, nobody has questioned, my lord. Nobody has questioned.
This is on the chat.
Kindly take, my lord, annexure, my lord, or reply
ಅಷ್ಟೇ
filed by the.
ಏನಿಲ್ಲ. There is nothing mind boggling here. ಕೊಡಿ.
Your lordships are making it too simple, my lord.
It is too simple only, ಏನಿಲ್ವೇ ಇಲ್ಲ.
ಅಲ್ಲಲ್ಲ, your lordship then.
Page 74 of the reply filed by the my lord, housing board. Seniority it is produced by the housing board. 2022 respondent petitioners have accepted my seniority. They have not questioned it.
Yes, ಆಯ್ತಾ? Judgments ಹೇಳಿ, paragraphs.
Yes. Now, Lord, 1974 Trilokinath's judgment.
ಅದೇ ಇಲ್ಲ ಇದರಲ್ಲಿ.
Para 34.
ಎಲ್ಲಿದೆ? Trilokinath Kosha.
I think the other side has also produced.
Para 30,
also relying.
You are relying on that.
I have extracted in my statement of objections.
ಆಯ್ತು ಹೇಳಿ, you rely on
32
ನಿಮ್
and
ಜಡ್ಮೆಂಟ್ಸ್
34.
ಇದು ಪಾಟೀಲ್ ಸರ್ ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್ ಹಾಕ್ಬೇಕು, ಇದ್ರಲ್ಲಿ ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಂತ ಹಾಕ್ಬಿಟ್ಟು ಕೊಟ್ಟು ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ಕೊಡಿ.
But respondent 20 has submitted the
ನೀವು ಕ್ಯಾಂಟೀನ್ ಇದ್ದೀರಾ? ಒಂದು ಕಪ್ ಕಾಫಿ ಕುಡ್ಬಿಟ್ಟು ಬನ್ನಿ ಕ್ಯಾಂಟೀನ್ ಅಲ್ಲಿ. ಎಸ್,
ಕ್ಯಾಂಟೀನ್ ದೂರ ಆಗುತ್ತೆ.
ಓ, ಅಲ್ಲಿಗೆ ಸಪ್ಲೈ ಮಾಡ್ಬೇಕಂದ್ರೆ ಸರಿ ಬಿಡಿ. ಎಸ್ ಸರ್.
Para 34.
Of what, sir?
Of Trilokinath, 1974 one is.
ಆಯ್ತು, ಅದ್ರ ತ್ರಿಲೋಕಿನಾಥ್ ಇಲ್ಲ ಅದರಲ್ಲಿ.
ಇದೆ.
ಎಲ್ಲಿದೆ? ನಿಮ್ ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ಕಾಣಲಿಲ್ಲ.
65. Page 65.
ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ಕಾಣಲಿಲ್ಲ, ಇದೆಯಾ?
This is the only reason I said para 50 and the other para.
ಆಯ್ತು, ಅಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್
Para 65 ಇದೆ.
Para 34, my lord, if your lordship so to see. On the facts of the case, classification on the basis of educational qualification.
No qualm about it, sir. I don't dispute that at all.
So, my lord, my submission to your lordship says, if 2005 cadre and recruitment rules were challenged by the diploma holder saying that there is no promotional avenues for us for becoming executive.
That is dismissed.
It was not, but that will get dismissed on the ground. It's a policy decision. Now, when they give it and it is challenged, it will again be dismissed on the ground that it's a policy decision.
That's what I'm going to do.
No, why I'm saying that is, it's for this reason. Now, if they change, my lord, if they're able to show as to why, how they have done it, and my lord, this on educational qualification, my lord, they have said unless it is shown as arbitrary, then it cannot be done, my lord. Now, on this, when it was very clearly mentioned here, and even as far in 2023 also, I'll show that judgment, my lord, that is 2022.
15 SSC 334.
This is 2022 15 SSC 452. Yes, 450. Which are lordship's memories with. No, we can't keep up with your lordship's memory.
Expedite.
ಈಗಿನ ಒಂದು 5 ನಿಮಿಷದಲ್ಲಿ ಮರ್ತು ಹೋಗ್ಬಿಡ್ತದೆ. ಈಗಾಗಲೇ ತ್ರಿಲೋಕಿನಾಥ್ ಮರ್ತ್ಬಿಟ್ಟೆ ನನಗೆ. ಎಸ್ ಜೋಸ್
if you are relying on that,
Yes.
ಅದರಲ್ಲಿ discussion is there from para 13 to 20.
Yes. Para 33 also, my lord, is there. Then
30,
9.
32 and 34.
It's all those, there are, my lord, 25 in that F, then 28, 4, 28, 5, 28, 6, 39 and 43 also. So where they say that it can be done.
So, see, creating a difference in the cadre on the basis of educational qualification is not found fault with. That doesn't mean it ties the hands of the state to bring in those persons who are diploma holders to a particular cadre. Why should they be ostracized, saying that not an avenue for promotion, executive engineer, agle bardu ante?
The question
Also,
would
there is a
remain
distinction,
where,
Lord.
no, the question
Yeah.
would remain.
Not only the
Question would remain. The question would remain as to if they have to do that, if they have to change it from a particular rules, where those rules in other departments are not there or in their own department, there has to be some reasoning or as to why and how they are doing it. And then with regard to 75, the rules of KHB where they're supposed to place, that we don't know whether they have actually placed it. Yes. So,
We'll ask them. ಅಷ್ಟೇನಾ?
ಅಲ್ಲ ಅದ್ ಹೇಳ್ತೀನಿ ಅವರು ಒಂದಷ್ಟು ಹೇಳ್ಬಿಡಿ ಆಮೇಲೆ ನಮ್ ರಿಜಾಯಿಂಡರ್ ಒಂದ್ ಸ್ವಲ್ಪ ಚಾನ್ಸ್ ಕೊಡಿ.
ರಿಜಾಯಿಂಡರ್ ಅಷ್ಟೊತ್ತಿಗೆ ಜಡ್ಮೆಂಟ್ಸ್ ನೋಡ್ಕೊಂಡ್ಬಿಡಿ.
ಅಷ್ಟಲ್ಲಿ
not only the distinction, Lord, with regard to qualification, there is, Lord, if my lords could see page 32, there is, Lord, provision made, Lord, for promotion from the cadre of assistant executive engineer diploma. Lord, they will have to, Lord, complete 5 years of experience and 3 years of
that is the extra 2 years that they have to put in for those
Still also
25%.
Not only, Lord, we are not at all.
I will set aside that and make 3 years now. Ibruguna. Illi, if you see page 32,
Yes.
degree holders must have put in service of not less than 3 years as AEE.
Yes.
Diploma holders 5 years.
Yes.
Arbitrary. I'll say that also should be 3 years now.
From 2007 to 2022, my lords, I have not been promoted. I'm still
No,
working
I have seen AEEs stagnating for 25 years and retiring as AEEs. It's high time that they gave opportunity, and I'm happy that they have given this opportunity.
To our detriment, some lodges are to take you.
No, see, it's not correct. Executive engineers, degree holders coming. Yeah, our experience.
Our degree ಮಾಡ್ಕೊಂಡವ್ರಿಗೆ ಸಿಗ್ತಾ ಇದೆ ಅಲ್ಲ ಡಿಪ್ಲೊಮಾ. They can complete their degree. What stops them from completing?
Diploma ಕೊಟ್ರೆ ಏನ್ ತಪ್ಪು?
Diploma is after, my lord.
You tell me.
It has been held that it is like a.
You tell me the qualification. Because of the diploma qualification, they cannot hold at all the post of executive engineer. Yaki.
There is also.
Merely because Supreme Court says that the difference should be maintained. No. Why do you say diploma holders are not eligible, entitled to be, or
the scope of work?
They are short qualified to hold executive engineer's post?
Now, a person, my lord, obviously, a person who does diploma after 10th or, my lord, which is like 3 years after 10th, and person who does engineering, obviously, my lord, there is a difference in the qualification. So, my lord, at the executive engineer level, where certain decision, my lord, that also will have to be looked into as to whether they are actually qualified.
But they are not encroaching upon your territory. 25% ಅವರು separate ಮಾಡಿದೆ.
ಅಲ್ಲ, in a way that they are not encroaching is true. But then even though 4 posts, because that we will be deprived of. And it is.
ಎಷ್ಟು vacancy ಇದೆ?
4. Executive engineer post, 16 posts are there, my lord.
Out of 16, 12 are for
12 for the
4 are for
and 4 for the diploma.
Our 4 ಅವ್ರಿಗೆ ಸಿಗುತ್ತೆ. ನಿಮ್ಮ 12 ನಿಮಗೆ ಸಿಗುತ್ತೆ. Seniority ಯಾರಿಗೆ ಸಿಗುತ್ತೆ is the problem.
ಅಲ್ಲ, ಅದೊಂದು, that is one prayer also.
ಯಾವುದು prayer?
ಅಲ್ಲ, ಒಂದು that R20, she has to be placed below us, and that's also, my lord, we have the judgments, my lord, which say that if they are there, they'll have to be placed at the bottom.
Why?
In service, those who are completed.
ಏನ್ degree?
ಹೌದು, ಈಗ ಏನಾಗುತ್ತೆ, then she is going to R20 will come in this 12, not in the other 4.
As on the date of consideration, or when the candidate comes to the zone of consideration, is she qualified or not?
She's qualified. She's entitled to. Only there, with regard to R20,
having the qualification.
ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ.
Yes.
How she has come into zone of consideration?
Yes.
Subject to
Yes.
that.
Yes. Subject.
No, no, he has challenged her coming into zone of consideration.
Promotion is on the
One more writ petition before the
At
principal
20.
bench.
No, my lord, they have not questioned it. They have not questioned it.
ಏನ್ notice
Kindly see the
ಆಗಿಲ್ವಾ
prayer.
ಅದ್ರದ್ದು?
ಅಲ್ಲಿ stay ಇದೆ, ಅಲ್ಲಿ entry ಮಾಡ್ಬೇಕು.
Seniority list, my lord, seniority list is concerned, they have accepted it. Kindly take note, annexure, my lord, kindly take the seniority list of.
ಆಯ್ತು, ನಿಮ್ ಜಡ್ಮೆಂಟ್ಸ್ ಕೊಡಿ.
Pass over.
I have
Page,
extracted only the judgments, my lord, in my
One-
chamber of and I'll furnish the judgments.
176,
Anything else, sir?
76, 176.
Look, your lordships are not deciding on R20.
R20 I am not deciding. R20 I think writ petition number ಹೇಳಿದಿರಾ ವಿಜಯ್ ಕುಮಾರ್?
Yes, my lords.
Writ
17915
petition
of
number
23.
R20 ಯಾವ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು?
My lord, that was the challenge. The learned friend have produced the writ petition copy along with the memo.
R20 will be considered against 12, Gurudas Kannur sir. R20 will be considered against the 12 vacancies subject to the result of the petition.
Yes.
So, my lord, here we have challenged the
Yes,
final
my lord.
seniority list.
The very
11th of
seniority
all your
list itself
lordships,
is
my lord,
subject
that
to result of that
Lord,
writ
because what happened was on the last occasion.
ಅವ್ರೇನೋ ಹೇಳ್ತಾರೆ, ತಲೆ ಕೆಡ್ಸ್ಕೊಬೇಡಿ. ಸೀನಿಯರ್ ಲಿಸ್ಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರ ನನಗೂ
My lord.
ಗೊತ್ತು. ಅವ್ರು ಆಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಅದಲ್ಲ. He is saying you have
My
accepted the
seniority list is
seniority list.
accepted. Yes, my lord, kindly take note, page 75 of the reply filed by the housing board. They have accepted, they have not questioned it. Page 75.
ನಿಮ್ ಪ್ರೇಯರ್ ಏನು ಸರ್?
Nam
Prayer is-
your lordships will get it at
Prayer ಇಲ್ಲ, seniority list better ಇಲ್ಲ.
Nam writ ಅಲ್ಲಿ page 11th ತಾವು ನೋಡಿ.
ಇಲ್ಲ, prayer ಅಲ್ಲಿ.
Annexure G ಏನು ಸರ್?
Annexure G,
Yes.
page 54. my lords.
ಸೀನಿಯರಿಟಿ ಲಿಸ್ಟಾ?
Seniority list.
Seniority.
Annexure G.
So,
Final,
ಅಲ್ಲಿ-
ಭಾಗವತ್ ಸರ್.
Provisional seniority list, provisional
ಅಲ್ಲ,
seniority list.
provisional when we had filed the writ, after
It
we
has
filed
been
the
ಮಾಡಿದ್ದೀರಲ್ವಾ?
final senior, we amended, final seniority list has been challenged. That's what we told on the last occasion. So that's also in challenge before your lordships. my
ಅದು
lord.
ಅವ್ರಿಗೆ ಹೇಳಿಲ್ವಾ ನೀವು?
No,
ಭಾಗವತ್
it
ಸರ್
is there, my
ಹೇಳಿಲ್ವಾ?
lord.
ಇಲ್ಲ
But
ಹೇಳಿದ್ವಿ,
question-
last time ಹೇಳಿದ್ವಿ.
ಹೇಳಿದ್ದಾರೆ, my point is, my lord, they have accepted my seniority list dated 1/6/22. Page 76 of the reply filed by the housing board.
Sir, you fight it out in a writ petition filed by Vijay Kumar.
No, I am not saying that, my lord. Question before your lordship is whether seniority.
See, R20 will come within the zone of consideration of these 12 vacancies subject to the result of that petition.
Yes,
That
my
is
lord.
produced along with the memo, my
Yes.
lord.
ಇವ್ರೇನು ಚಾಲೆಂಜ್ ಮಾಡಿದಾರಲ್ಲ, she comes in by acquires degree during her service as AEE.
That your
ಅಲ್ಲ,
lordships will have to make it clear.
AE. One minute.
No, my lord.
I'll make it clear. AE, she acquires qualification of degree, jumps as AEE within 1 year, even before
Yes.
the completion of qualifying service,
Yes.
that he has challenged.
That
That
is
is
the-
appointment by transfer.
Yes.
It's all right. That is a
No,
separate
my
issue.
lord, by promotion, not transfer. By promotion. She has not been transferred. She has been promoted along with.
ಅದನ್ನ ಅಲ್ಲಿ ಆನ್ಸರ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
Yes, my lord.
Yes.
My lord, I will answer it. I will answer it. My
ಆ
lord, may this-
ಪೆಟಿಷನ್ ಆನ್ಸರ್ ಮಾಡಿ.
I-
So in so far as the others are concerned, we will see what order is to be passed. ಅಷ್ಟೇ. Anything else, sir?
My lord, these judgments and
ಕೊಡಿ
this.
ಸರ್. ಕೊಡಿ, ಪ್ಯಾರಾಗ್ರಾಫ್ ಹಾಕಿ.
ಅಲ್ಲ, there are some.
ಪ್ಯಾರಾಗ್ರಾಫ್ ಹಾಕೊಡಿ.
I'm relying on the two judgments, P. Joshi and Pushparani, my lord, which I have already
placed,
extracted.
already placed.
ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದೆ ಪಿ ಯು ಜೋಶಿ ಪುಷ್ಪರಾಣಿ.
And the writ petition copy is also produced along with the memo, my lord. Some learned friend have filed before this honorable court, my lord. But the writ
There
petition.
has to be something, my lord, with regard to the scope of work. My lord, and learned friend is not yet answered.
ಸರ್, ಇಬ್ರು AEE, ಇಬ್ರು EE. ಸ್ಕೋಪ್ ಆಫ್ ವರ್ಕ್ ಡಿಪ್ಲೊಮಾ ಅವ್ರಿಗೆ ಬೇರೆ, ಡಿಗ್ರಿಗೆ ಬೇರೆ ಇಲ್ಲ ಇಲ್ಲಿ. AEE ಅಷ್ಟೇ. ಇಟ್ಸ್ ಅ ಕೇಡರ್.
My lord, but they have to still answer with regard to 75. Your lordship said you.
Yes, ಅದೇನ್
75 my lords already taken, but I will place the
Lord, that will have to be then given
papers,
to
my
us,
lords.
Lord. We need to
Taken,
see
taken.
that. Lord, because then, my lord, if it is not.
If that is not done, it will work as a government order. Yes.
So, yeah,
Entry
it
ಮಾಡಬೇಕು
does
sir.
not matter whether it is there or not. Yes.
ಯೂಸ್ ಗುಂಡಪ್ಪ ಎಲ್ಲಿದು?
I will place it, my lords.
So because he said that I don't know, I'll
No,
seek
no, my
instructions
lords.
is what. Lord, now he says that it is there. So in fact, morning itself I asked with regard to 75. So he said he will probably seek instructions. They are not aware. My lord, at least that they should make it clear to us, my lord. And then
We'll see.
Please.
ಅಲ್ಲ ಇಲ್ಲರೆ ಅದರ ಮೇಲೆ ಮತ್ತೀಗ if the rule itself is clear, my lord, because your lordship said KHB has its own rules. So in one breath, my lord, they will say that ours is different set. So even in PWD, other places it's not there, ours we can
That
do.
can-
According to their own
Sir,
rules, my lord, 75 if there is
That can
violation.
be done post facto, not.
Well, Annexure B, my lord, it's very specific.
So
It says, my
after
lord,
now, after the judgment, my
referring
lord,
to
then they'll have to
section
do it, my lord,
74.
then.
We'll
Taken,
see.
taken.
I'll
my lord.
answer that also.
My lord, section 74 is more considered, my lord, as per Annexure B, my lord, which is impugned in the present petition. That is the rules, my lord. My lord, now therefore, in exercise of the powers conferred by section 74, read with section 10A. of
They
the
rely on
Karnataka Housing
74.
Code.
So 75, what has happened there on 62? Now, learned trend is right. So under 74, they are saying that it is done under 74. So 74 they have followed. Then what about 75 then?
We'll see. We'll answer.
Please. We'll just give those
What do you
thing
put?
and those
Judgments.
judgments on both the.
Heard reserved, yes.
And my lord, your lordship said that because though we have challenged it here, my lord, because then it should not be that the final seniority list goes unchallenged and then she becomes entitled for promotion in this in the.
You're against R20 only, huh?
R20 is one day. With that first prayer is with
But
regard to R20, the final
R20
seniority
is
list.
concerned, my lord, R20
So that,
is
my lord,
concerned.
then that aspect, my lord, because then there is, in Bangalore petition, I'm not aware if he has challenged the final seniority
No, my
list.
lord, he has not questioned it.
That is
1
produced
plus
by-
20, only promotion is questioned, not the seniority list.
So then the final seniority list, my lord, then they should not. So, my lord, I don't know. I'm also little
Duty-
thing about
Duty
whether
Ramaswamy
your
case-
lordships will have to decide or that court will with regard to R20, my lord, because the final seniority and provisional are before your lordships here in this R20.
My lord,
So
that is
in
not.
fact, in
that
our
is not-
submissions and the
once
judgments, my
prior
lord, we
to
have
that,
produced
Lord,
that.
there is a
All right.
final seniority list in the year
So
2022,
we have
not
produced
now.
judgments and in the synopsis we have mentioned that how and on basis of the judgment that they'll have to be placed below the degree holders. So that was one of our prayers. Second was with regard to the cadre and recruitment rules to the extent of.
The simple answer to this. Nobody need be placed anywhere. 12 is yours, 4 is theirs.
So now,
One, purti hella. 12 is yours, 4 is theirs. So all of you are getting into the cadre of executive engineer. On the now, how a seniority list should be drawn here is on the basis of the feeder cadre.
Yes.
Feeder cadre is AAA. AAA ostensibly they have become in 2007 and you come in 2010. Notwithstanding that you are a degree holder. It is like
ಅಲ್ಲ the thing into service ಅಂತ ಅಲ್ಲ ತಾವು ಅದು ನೋಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಿ ಯಾಕಂದ್ರೆ what I want to know from you my lord whether your lordships are going to decide that issue also
what
here.
I'll decide, why should I tell you?
Beg your pardon?
What I'll decide, why should I tell you?
No. Whether allow or dismiss that your lordship need not
ಮತ್ತೆ
say.
reason ಏನ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ
ಅದನ್ನ ಕೇಳಲೇ ಇಲ್ಲ
ಮತ್ತೆ
ತಾವೇನ್ ಹೇಳಿದ್ರಿ ಇದ್ರ ಬಗ್ಗೆ ನಾ ಡಿಸೈಡ್ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಿ ಅದ್ ಕೇಳ್ತಾ
ಯಾವ್ದ್ರ
ಇದ್ದೀನಿ.
ಬಗ್ಗೆ
With regard to the promotion, the seniority list that your lordship said that in Bangalore
seniority list ಬೆಂಗಳೂರಲ್ಲಿ ಇಲ್ಲ ಸರ್ ಕ್ವಶನ್ ಮಾಡಿಲ್ಲ it is only promotion of R20.
So that we have what your lordship
You
said
want me
was-
to defer this, is it?
I'm not, my lord. My lord, what I am saying is, your lordship said that with regard to R20, that your lordships would not touch on that issue, and your lordships are going to go on the cadre and recruitment, where the diploma holders, the 4 posts, what are given, right or wrong, your lordships would obviously, and lordships have kind of expressed. I'm not getting into that.
No kind of express. It's only a dialogue.
Yes. So, my lord, now with regard to the promotion, my lord, for that, my lord, we have the judgment. So now, whether if suppose now here, if the final seniority list, my lord, if your lordships would, that's the reason I asked whether your lordships would make it clear with regard to that. Your lordships had said.
I'll make it clear in my judgment, sir.
Now, whether R20, then if she's entitled under those 4 posts, we have no objection. But if she comes under 12 posts, then she'll be above us. Then one of us will lose out on the promotion.
We'll see. That promotion itself is questioned there.
So, my lord, then by that time, then here,
Promotion
in
is
view of this,
questioned,
lord,
not
my
seniority
only, my only thing, my lord, if your lordships could protect, I mean, interest of both, I'm not saying anything, with regard to R20.
ಬೇರೆಯವ್ರದೆಲ್ಲ ಏನಿಲ್ವಾ ನಿಮ್ಮಂಗ ತೊಂದ್ರೆ ಓನ್ಲಿ R20 ಮಾತ್ರನಾ?
ಹೌದು,
ಬೇರೆಯವ್ರದ್ದು ಏನು ತೊಂದರೆ ಇಲ್ಲ.
ಬೇರೆಯವ್ರದ್ದು ಯಾರ್ದು ಇಲ್ಲ, ಅದು ಬೇರೆಯವ್ರದ್ದು ಅಂದ್ರೆ ಡಿಪ್ಲೊಮಾ ಹೋಲ್ಡರ್ಸ್. ಇವರು ಯಾಕಂದ್ರೆ she is qualified, she is qualified to become executive.
No problem. Yes, heard reserved.
So that your lordships.
How much do you want? 30 minutes side.
My lords,
30
one
or 40
submission.
minutes side.
My lords, one submission.
Too much for a service matter. Yes.
One submission, my lords. Some of the diploma holders already appointed as executive engineer by virtue of Annexure B
Rule 32, not Rule 30. Rule 30. So they are occupying the chair of executive engineer. They are not arrayed as a parties to the
Rule
present
32 again
litigation. Please,
independent charge.
please,
DPC ಆಯ್ತಾ?
Yes.
please, ma'am.
DPC ಆದ್ಮೇಲೆ ಕೊಟ್ಟಿರೋದಲ್ಲ?
Please.
Yes. Heard reserved.
Great. Great.
Interim order of any kind subsisting would continue to the next date of hearing.
Public.
Number 19.
Blood, reserve it, blood.
Out, sir.
For petitioner, my lords, seeking for quashing of article of charges which were issued 4 years after the incident, my lords.
The regulations, madam, for instance.
I have placed a synopsis, my lords, your lordship may kindly.
But a section, but employees service regulations, madam, section, regulation 171, madam. But may I read, madam? And the board further reserved to itself a right to withdrawing the pension or any part of it, whether permanently or for the specified period, and a right of ordering the recovery from the pension of the whole or a part of any pecuniary loss caused to the board. If the departmental or judicial proceedings, the pensioner is found guilty of a grave misconduct or negligence during the period of his service, including his service rendered or re-employment after retirement, provided that such a departmental proceedings, if instituted where the employee was in service, whether before his retirement or during his re-employment, shall be after the final retirement, during his re-employment shall be after the final retirement of the service, be deemed to be proceedings under the regulation and shall be continued and conducted in the authority by which it was commenced in the same manner as if the employee was continued in service. B is important plot. Such departmental proceedings, if not instituted while the employee was in service, whether before his retirement or during his employment, Roman 1, shall not be instituted save with the sanction of the board. Not here, the sanction of the board is there. Shall not in respect of any event which took place more than 4 years before such institution, shall be conducted by such authority and if such a place as the board may direct and in accordance with the procedure applicable to the departmental proceedings, in which the order of dismissal from the service could be made. Not here.
I'm all ears.
Not already we have not initiated, not the articles of charges have been not issued before the date of his retirement. He submitted his reply. But as he was retired, we have obtained prior approval from the board for initiating proceedings. Now, retired district judge and other 2 officers have been appointed as inquiry officers. Joint inquiry is commenced, and now the total loss cost, financial loss is 114 crores 63 lakh 65,977. All, not only petitioner, there are several persons are the charges have been, articles of charges have been initiated against them. Now the grounds urged by the petitioner is that.
1 minute, charge sheet date in 9/8/2024.
First charge sheet is dated 29/5/23. Second one is.
What?
My lords,
29?
29/5/23, which was served after my retirement, my lords.
That's all right. 29/5/2023.
Yes, my lords.
Where do I get that?
Second,
Page?
Page 42, my lords, first charge sheet.
Retire ಆದ್ಮೇಲೆ charge sheet serve ಮಾಡಬಾರದು ಅಂತಿಲ್ಲ.
That is the only charge sheet which was served after my retirement, my lords. All other charge sheets were served charge sheets
Prior to
dated
retirement.
after retirement, my lords. This is dated before retirement.
First charge sheet ಯಾವ್ದು sir? 20th November 2023. When did you retire?
I retired on 31/5/23, my lords.
Not annexure B, my lord.
1 minute, sir.
Please.
Next, ಅದರಲ್ಲಿ allegations ಏನು sir? You were working as ಲೆಕ್ಕಾಧಿಕಾರಿ between 1/4/2016 to 4/4/2022. Okay. ಆಮೇಲೆ
Allegation is that, my lords, in some bills.
Allegation ಬಿಡಿ.
Yes,
We are not an allegation.
And
So-
second charge sheet is at page 68, my lords.
68.
68.
ಅದರಲ್ಲಿ ಪೀರಿಯಡ್ ಏನು?
Period 2019 to 21, my lords. I have made a short synopsis about
ಅಲ್ಲ
all
ಅದರಲ್ಲಿ
this.
ಇದ್ರಲ್ಲಿ ಬನ್ನಿ, ಕಮ್ ಟು ದ ಚಾರ್ಜ್ ಶೀಟ್.
Yes, my lords. 2019 to 21, my lords.
19 to
21.
ಅಗೇನ್ ಇಲ್ಲ, ಪೇಜ್ 72 ಬನ್ನಿ. 16 to 22 again. ಆಮೇಲೆ
Third charge sheet is at page 93.
why 3 charge sheets have issued?
Please, my lord.
Why more charge sheet?
Lord, he is working in a different places, my lord. Therefore, a different, my lord, he has committed
Misappropriation.
not paid excess amount to the contractor. Lord,
ಎಷ್ಟು?
Lord, total, not only him, Lord, others persons, so total,
ಅಲ್ಲ,
Lord,
ಎಷ್ಟು ಟೋಟಲ್?
total 114 crores 63 lakhs 65,977.
ಎಕ್ಸೆಸ್ ಕೊಟ್ಟಿರೋದ?
Excess ಅಲ್ಲ ಇದು excess payment, my lord. Excess payment and financial loss cost to the, not only petitioners, but other, my lord, several persons.
ಮುಂಚೆ ಇಶ್ಯೂ ಮಾಡಕ್ಕೆ ಏನಾಗಿತ್ತು ಚಾರ್ಜ್ ಶೀಟ್?
Lord, we have issued, my lord, before the date of, my lord, retirement. Now, the
Merely because you take sanction, that will not take away the rigor of 4 years period. Sanction ಕೊಟ್ಟ ತಕ್ಷಣ ಅದೇನು everything it doesn't whitewash the law.
4 years ಬರೋದಿಲ್ಲ ಇದರಲ್ಲಿ. It is well within the, my lord, the time, my lord.
Not whitewash the law. Yes.
It is not within, my lord, it is not after lapse of 4 years, my lord. It is within time. my lord.
What are you? ಈಗ one ನಿಮಿಷ. What is your ground, sir?
My lords, my first ground is that, my lords, charge sheet number 2 to 9 are issued after retirement. That is the issue pertaining to 4 years prior to the event happened, my lords. Second ground is that, my lords, entire amount has been recovered. I have produced that document,
From
my lords.
whom?
From the companies, my lords. Third ground is that, my lords, they are initiated the inquiry against their own circular, my lords, which is produced at annexure
What
B.
circular, sir?
ಒಂದು ವರ್ಷದಲ್ಲಿ ಮಾಡ್ಬೇಕಂತ ಇರ್ತೈತೆ.
Their circular says the disciplinary authority has to conduct and complete the inquiry within 9 months from the date of knowledge to the disciplinary authority, my lords.
Knowledge?
Yes, my lord.
ಎಲ್ಲಿದೆ ತೋರಿಸ್ಬಿಡಿ ಅದು?
My lords, may kindly.
Date of knowledge ಅಂತ ತೋರಿಸ್ಬಿಡಿ, 9 months ಅಂತ
Yes, my
circular.
lords. May I read, my lords?
ಓದಿ.
ಸರ್ಕಾರಿ ನೌಕರರ ಅಕ್ರಮಗಳು, ದುರ್ನಡತೆಗಳು ಶಿಸ್ತಿನ ಪ್ರಾಧಿಕಾರದ ಗಮನಕ್ಕೆ ಬಂದ ದಿನಾಂಕದಿಂದ ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿಯನ್ನು ತಯಾರಿಸುವ ಸಲುವಾಗಿ ದಾಖಲೆಗಳನ್ನು ಪಡೆಯಲು ಅಥವಾ ಪ್ರಾರಂಭ
ಗಮನಕ್ಕೆ ಬಂದ ದಿನಾಂಕದಿಂದ ಅಂದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಇಶ್ಯೂ ಮಾಡಿದ ದಿವಸದಿಂದ.
Even if we consider that also, my lord, they have not completed the inquiry within 9 months, my lord.
That is not, that's directory, sir. It's only a circular. We will direct the inquiry to be completed within a time frame now.
My lords, the issue on hand is covered by judgment of this honorable court, my lords.
What,
I have
sir?
placed
4 years.
4 years. It says from the date of event, my lords, division bench of this honorable court.
Event ranges from 16 to 22.
Yes, my lords.
Yes, sir.
22. Charge sheet is issued in the year 23 and 24, my lords.
What, sir?
4 years.
16 to 22, it stretches, sir. It is not a solitary incident in 2016 for 4 years.
My lords, from
Pradna Koti
2018.
ಕೊಟ್ಬಿಟ್ಟು you want to escape.
My lords, from 2018, period completes in the year 2022, my lords. They issued the charge sheet in the year
2018 la, sir. The events are between 2016 to 2022. You retired on 31/5/23. Charge sheet is issued, first charge sheet is September 23.
That is only first one charge sheet, my lords.
All right, ಆಮೇಲೆ
Not on the
ತೊಂದ್ರೆ ಇಲ್ಲ, same period, 4 years ಅಂತೂ ಇಲ್ಲ ಬಿಡಿ.
This is not regarding the term which I have performed my work, my lords. This is regarding the work which took place, my lords. Your lordship may kindly peruse
No,
the
no,
judgment for a moment, my lords.
That I am aware, sir. 214 2B2 ಅದು KCSR.
171B. Yes, my lord.
171B is 214 2B2. Yes.
Yes, my lords. And entire amount has been already recovered, my lords. There is no loss to the corporation, my lords. I have produced that document as well, my lords.
We'll see. Difficult. Interim order ಇದೆಯಾ?
Interim order is there, my lords.
Let the inquiry go on. We'll direct it to be concluded within 6 months.
Your lordship may kindly pass over for a moment, my lords. I will.
ಆಯ್ತು, pass over. Next.
Number 20, Girish Weaver.
Minimum wage ಇಸ್ತಾ?
This is regarding regularization.
Library supervisor.
Library supervisors. My lord, this
Consider.
petitioner. My lord, ಅಲ್ಲ consider ಬೇಡ my lord, positive.
Considered ಬೇಡವಾ? ನೀವು ಕೇಳಿರೋದು ಬೇಡವಾ?
Positive direction.
ಅಲ್ಲ ಕೇಳಿರೋದು ಬೇಡವಾ?
ಅಲ್ಲ. Sought for a direction to appoint
Direction,
them.
your lordship, as per the 22 guidelines, your lordship, notification.
What guidelines, madam?
Qualification for the supervisor post, your lordship. They must pass PUC, ದ್ವಿತೀಯ ಪದವಿ ಪೂರ್ವ ಮತ್ತು along with library science Kanishta ಮೂರು ತಿಂಗಳ
Qualification ಏನು
computer
ಇವ್ರದ್ದು ಈಗ?
computer course also, Your Lordship.
Now, what they are stating is the qualification is applied in the year 2022. I have been appointed in 1994. Then it was SSLC.
Jaggu.
And
Same,
Dharmendra Singh also.
same ground is rejected. ಏನು ಮಾಡ್ತೀವಿ?
ಮತ್ತೆ
Lunch.
ಅಲ್ಲ only 1 year left ಮೇಲೆ ಅದಕ್ಕೆ ಸರ್ವಿಸ್.
Only 1 hour left, sir, ಮಧ್ಯಾಹ್ನಕ್ಕೆ.
Please.
Yes. Yes. Next.
21, KL Patil, Niledri Reddy Gunde.
ಇದಕ್ಕೆ ನೆನ್ನೆದಲ್ವಾ? ಹೌದು, ಮಧ್ಯಾಹ್ನ ಬಂದ ತಕ್ಷಣ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀವಿ.
22, Venkatagiri.
Appearing for the petitioner, my lord.
Yes, government.
Section 11 says, as here the Milords, the person who has suffered the order, Milords, one person residing at Milords, Bangalore. As per section 11, provision of section 11 of
Senior Citizens Act.
Senior Citizens Act, for enforcement of Milords, the maintenance order, they have filed a writ petition before this honorable court.
Okay, why have you not enforced it?
Milords, it can be enforced against Milords, the second petition, second daughter.
Whoever is there.
Idರಲ್ಲಿ section 11 of the,
10 ವರ್ಷ,
section 11 of the Milords Act.
ಏನು jurisdiction?
Jurisdiction.
Whatever it is, ಇಲ್ಲೇನ್ ಇಲ್ಲ ಅಲ್ಲಾಗಿರೋದು ಆರ್ಡರ್ ಸಿರ್ಸಿ.
ಇಲ್ಲೇ ಬರುತ್ತೆ.
Yes.
May I take
Learned AGA to secure instructions as to why the order of the Assistant Commissioner is yet to be enforced, notwithstanding the clear mandate in law. List the matter on 26th or 28th. Yes, next.
Till number 23, K. Rajendra Rao, PV Gunda.
One submission. 81 years ಆಗಿದೆ.
26, ಈಗ ಮಾಡ್ತಾರೆ ತಗೊಳ್ಳಿ, they will enforce it. This will take it on Monday, on Tuesday. Yes, list on Tuesday. Next.
Till number 24, Rakesh Satyakati.
Please, my lord, sir, regarding the GST, appeal has been dismissed on the
Ground of delay.
My colleague is held up in another court.
ನಾನೇ ಮಾಡಿದ್ದೀನಿ ಕೊಡಿಯೋದು. ಇವ್ರದ್ದು ಗಿರೀಶ್ ಹುಳ್ಮನೆಯಲ್ಲಿ. Let him come. He has passed orders and pass over.
Please.
We'll dispose it. 2:30 ಗೆ ಕರೆದು ಬಿಡಿ pass over. Yes, next.
25, BV Somapur, Shukmar S. Badwargi.
Pay for the respondent.
I request for the next week onwards to seek further developments in the matter. Seek information regarding further developments in the matter.
Oh, this one. Yes.
Please.
List after 2 weeks. Yes. Next.
26, Ramchandra Mali.
Seeking mandamus to change in the name, my lords, in the SLC marks code as for this circular.
Learned AGA.
Notice as already.
ಆಗಿದೆಯಾ?
Already
10 days
happened.
time to secure instructions and make his submissions. List on 1st December.
Applies.
No further adjournment would be granted in the matter. Next.
So one submission is that, my lords, now the student is in the final sem, my lords. And so,
Let's see. First,
please,
yes.
please.
7, Srinand Pachapuri.
KPID matters, my lords, where an endorsement is issued.
Will Viresh Budiyal.
Yes, my lords. There is one order being passed by the coordinate bench, my lords, wherein, my lords, Mr. Viresh Budiyal appeared there. But what is the?
I appear on behalf of Mr. Viresh Budiyal, my lord.
This is second round, in fact, my lords. Earlier, we had made a representation. On that, my lords, the claim was.
ಇದು ಕ್ವಾಶ್ ಆಗಿದೆಯಾ ಇಲ್ಲಿ?
ಅಲ್ಲಿ ಎಂಡೋಸ್ಮೆಂಟ್ ಕ್ವಾಶ್ ಆಗಿದೆ. The matter is remitted. Time limit ಹಾಕಿಲ್ಲ. The SOP for the KPID matters, what it says is, my lords, within 15 days, but that has to be issued. We have given.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ? Viresh.
Yes, lords, Viresh ಅವ್ರಿಗೆ ನಾವು.
Yes, madam. Look into this.
The claim applications.
Pass over.
We'll reconsider, my lord.
ಮಾಡ್ತೀರಾ?
Please.
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that the issue in the list is akin to what is decided by the coordinate bench on 4th November 2025. The coordinate bench has held as follows. The learned counsel appearing for the petitioner submits that only the outer limit is 6 months anta illi.
ಅಲ್ಲ 15 days ಇದೆ. What has happened is all are age not all are 80 above.
15 days ಹೆಂಗಾಗ 6 months ಕೊಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲಿ. The learned counsel for the petitioner would now contend that the standard operating procedure for the competent authority to consider the applications of the kind that is now projected before the court is 15 days. The 15 days. 15 days. In that light, the action shall be taken by the second respondent to complete the entire exercise with an outer limit of 6 weeks from the date of receipt of the copy of the order, if not earlier ordered accordingly. All contentions remain open. Next.
It's 27.2 millards. There, millards, we have challenged the constitutional validity of section 7.2 millards.
You want to pursue that separately?
Yes, milord, that your lordship.
Dealing 27.2. Make it there to close.
Please.
Number 28, Suraj Ballodi. Tail party.
Provident fund matter, milords. I am filing statement of objection. Non-payment of milords.
Statement of objections.
Kodi. Aithu. 230. Please, you will dictate it 230.
Obliged.
Yes. Madam, sir. Well, madam.
One prayer. 73, my lord, if your lordships could accommodate you. Lordships have recorded in the order sheet that it will be taken up today. 40-50 crores due.
Let's see. Yes.
Milords, 38 milords. 38 milords. I need to secure instructions, milords. 2 weeks.
38.
Please, milords. I'll inform to the other side, milords. 2 weeks.
Serial number 182, my lords. Listed,
182.
listed in
Adjournment
preliminary.
beka.
No, my lords, to be for the early hearing, my lords.
Early hearing?
At least at 4:30 PM. my
At
lords.
least at 4:30.
We are seeking for the vacating of the stay, my lords. Some of the
Which vacating
respondents.
stay, madam? Party in person.
Yes, my lords.
Yen stay ಇದೆ? Party in person is here? Is the party in person here?
3 times it was listed, my lords. She is not presenting, my lords.
In bar council ಎಲ್ಲ ಇದೆ? What's the matter?
Yes, my lords. Regarding the bar council.
Let us
It's
see.
for 4:30.
Let's see.
Serial
List
number,
ಅಲ್ಲಿ reach ಆಗ್ಲಿಲ್ಲ ಅಂತ
serial
ಆಮೇಲೆ
number 192, my lord. Land acquisition matter covered by judgment of Indoor Development Authority, my lord, 2017.
ಆಯ್ತು ನೋಡೋಣ.
Serial number
Yes.
83, my lord. Serial number 83, my lords. I have informed other side.
Other cases you want adjournment?
Please.
Serial number 170 covered matter is there. milords.
ಎಲ್ಲ covered.
Benefits have been.
ಯಾವ್ದ್ರದ್ದು?
170 minutes.
Covered by what?
Pensionary benefits have been withheld, my lords.
How does it get covered?
Similarly placed employee also, my lords, in the same investigation. His pensionary benefits have been released, my lords. Mine have been withheld.
You mentioned before the end of the day.
Please.
Yes.
permission, may I mention item 194, my lord? It's fixed at 2:30 PM. It's a Supreme Court expedited matter relating to Anjanadri Betta, my lord. Yes, its direction is there for 6 months disposal. Yes, my lord. I'm not, your lordship had fixed today's date.
So when is that 6 month ending?
January, my lord. But senior is joined online, my lord.
All right, we'll see. We'll take it. Before the end of the day, we'll do it.
Mr. PB Suresh is joined online.
No problem. Before the end of the day.
My lord, serial number 76, my lord.
It's a 2:30, I know, but I'm a little slow today. We'll see. Yes.
My lord, serial number 76 is covered, my lord. Serial number.
Number 10 and.
Allah, 76 covered, we'll do it. ನಾನು ಸ್ಲೋ ಆಗಿದ್ದೀನಿ ಫಾರ್ ಎ ರೀಸನ್.
Because
ಆರ್ಡರ್ ಬಂದಿಲ್ಲ ಅಂತ ನೀವು ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ನಾನು ಆರ್ಡರ್ ಬರೆಯೋದು ನಿಲ್ಸ್ಬಿಡ್ತೀನಿ. Why do you all do that? You know the amount of cases I am taking and trying to dispose everything. ಒಂದೆರಡು ದಿನ ಡಿಲೇ ಆಗುತ್ತೆ, ಇಲ್ಲ ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ. You go to the ARG, you
It is not from our bar, it seems. Some other persons have done it. It's highly impossible. Thank you.
Sorry for it.
Therefore. Yeah, no, more than 80-100 worth.
We are the sufferers.
Ultimately, we will be the sufferers first.
Sorry for it.
Not no deal. We'll just verify who has done this, your lordship. Just will make definitely. Nam bar na rang ಮಾಡ್ಲಿಕ್ಕೆ.
ಬೇರೆ ಔಟ್ಸೈಡರ್ಸ್ ಯಾರು ಬಂದಿಲ್ಲ.
ಅಲ್ಲ ನಿಮಗೆ ಗೊತ್ತಾಗ್ಲಿಕ್ಕೆ ನಾವು ವಿಲ್ ಜಸ್ಟ್ will inquire your lordship.
We are the ones who
Otherwise,
suffer
very
then.
Ultimately, we will be the sufferers. Entire bar will be sufferers.
Your lordships are very fast, man.
No,
it's not. We'll cooperate your lordships and we'll just ಅಷ್ಟೇ. ಇನ್ನು ಈಸಿ ಆಗುತ್ತೆ. Yes. ಇಲ್ಲ ಮತ್ತೆ being spoken to duff. Yes.
Maybe a superhuman being, but still a human.
No, it's a fact. It's a fact also, your lordship. It's very difficult.
We understand. ಅಲ್ಲ ಇಷ್ಟು ಸಿನಾಪ್ಸಿಸ್ ಬೇರೆ ಕೊಡ್ತೀವಿ, ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಬೇರೆ ಕೊಡ್ತೀವಿ.
Yes. Sorry, your lordship. May I make one submission, your lordship? ನಲ್ಲಿ ನಾನು ಅದನ್ನ ಕೇಳ್ತೀವಿ ಇಲ್ಲಿ ಹೋಗ್ತೀವಿ. ಇದೊಂದು ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್ ಇದೆ. ಮೇ ಐ ಮೇಕ್ ಒನ್ ಸಬ್ಮಿಷನ್? That's already, your lordship, that voting rights were given. Now the elections were completed, your lordship. What I declare the result 64 and 140.
ಪ್ರಸಾದ್ ಅವರ
ಹೌದು
ಅಂತದ್ದು ಯಾವ್ದಾರು ಇದ್ರೆ ಹೇಳ್ಬಿಡಿ.
64 and 140.
140 senior counsel is appearing, my lord.
140 ಇಲ್ಲ?
Yes, ma'am.
ಯಾಕೆ ಆ ಆರ್ಡರ್ ಬರೆಯಕ್ಕ?
No, in that 13 days complied, my lord. So everything beyond to impleading application is filed, my lord.
ಅಲ್ಲ ಅಲ್ಲಿ ಎಲ್ಲ contest everything there.
My lord, here there is a compliance itself. In addition to that, there is no transfer. Maybe taken.
140 ಬೇಕಾರೆ ಆಮೇಲೆ
ಇದು ಯಾವ್ದು ಜಗದೀಶ್ ಪಾಟೀಲ್ ಸರ್?
64 ಅದನ್ನೇ ಹೇಳ್ತಾರೆ. 140 ಬೇಕಾರೆ ಆಮೇಲೆ ಅದರಲ್ಲಿ ಹೇಳ್ತಾರಂತೆ. ಆಯ್ತಾ? Same. ಆಯ್ತು.
I'll take it. ಅರ್ಜೆಂಟ್ ಇದೆಯಾ? ಅಲ್ಲ ಫ್ಲೈಟ್ ಇದೆಯಾ?
ಸ್ವಲ್ಪ ಹೋಗ್ಬೇಕು ಅದಕ್ಕೆ. I'll not trouble your lordships, my lord, much.
No, I'll take it. It's not a problem. Then I'll take any.
I understand, my lord. Your lordship sit till very late, my lord. That's why, my lord, very reluctantly, my lord, we make.
ತಗೊಳಕ್ ನನಗೆ ಯಾವ ಮ್ಯಾಟರ್ ತಗೊಳಕ್ ಒಂದ್ 2 ದಿನ ಲೇಟ್ ಆದ್ರೆ ರಿಲೀಸ್ ಆಗೋದು. ಶುಡ್ ವೇಟ್ ಅಷ್ಟೇ. That's all.
ಇಲ್ಲ ಅದರಲ್ಲಿ that is some urgency. Otherwise, my lord, we would not. Other matters I'm not mentioning, only this.
No, in fact, if I have granted interim orders, I have not kept any matter. Sayankala, I'll finish everything and go and see to that it is uploaded. Final orders sometimes will,
It will obviously, it will.
for some fine tuning, I would have kept it. ಅದಕ್ಕೆ ಮೆಮೊ ಇಲ್ಲಿ ಮೆಮೊ ಮಾಡೋದು ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದು.
No, it is not proper on our part.
Along with 140, 64 also along with 140.
64, you want to argue?
First week ನಲ್ಲಿ ಹಾಕಿ.
ಆಯ್ತು ಸರಿ. 60 ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಯಾವ್ದು ಕೊಡ್ತೀನಿ ಬಿಡಿ. Wait, give me 5-10 minutes, I'll run through and get, yes.
45 ಅಲ್ಲಿ 20 ಮ್ಯಾಟರ್ ಇದೆ, ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್ಸ್.
ಎಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡೋದು ಅದು?
ಅದ್ ಮಾಡೋದು ರೀಚ್ ಆದಾಗ ಮುಗಿಸ್ಬೋದು.
5 ನಿಮಿಷ ರೀಚ್, ಎಸ್.
My lord, serial number 76. Your lordship morning you.
76 disposed. ಅದು ಗ್ಲಾಡ್ ಖಾನ್ ಸರ್ ಹೇಳಿದ್ರು ಸೇಮ್. 10 ನಲ್ಲಿ ಏನ್ ಬರ್ತಿದೆ ಆರ್ಡರ್ ಸೇಮ್ 76.
Even the notice date is same.
ಎಲ್ಲ ಸೇಮ್.
Only survey.
RS number
Only survey number is different. RS.
Please.
ಏನದು? ಅವರೆಲ್ಲಿದ್ದಾರೆ? ತಗೊಂಡು ಬಿಡಿ ಆಮೇಲೆ 5 o'clock ತಗೊಂಡು. ಎಸ್. PF.
Given list of dates, my lords, yesterday.
ಈಗ ರಿಲೀಸ್ ಮಾಡ್ತಿರಲ್ಲ?
ಇಲ್ಲ sir, what has happened is Provident Fund entire amount is released.
What do you want then? Interest?
He wants interest for the.
Interest from what date to what date?
My lords, from the dates, my lords, the amount was lying with the respondent, my lords.
Your contribution or their contribution?
Both, my lords.
Both you can't. ನಿಮಗೆ interest only your contribution to provide. ಯಾವತ್ತು ಕೊಟ್ರಿ? ಎರಡು ಕೊಟ್ರಾ?
ಎರಡು ಸೇರಿ amount ಕೊಟ್ಟಿದೆ. That has been adjusted.
Provident Fund amount is released, but the interest that was accrued, my lords, over the amount for the period, my lords, that the amount was lying with the respondent. I am entitled, my lords, for interest.
And let's see, tomorrow we'll dictate.
Please.
Synopsis ನೋಡ್ಕೊಂಬರ್ತೀನಿ. Yes, tomorrow in fresh matters. Next.
Oblige.
Serial number 21 on the. Please. 21 also your lordships have taken.
ಆಮೇಲೆ ಮಾಡ್ತೀನಿ.
Yes.
For the petitioner, my lord, mandamus, my lord, compassionate ground. Respond number 2, my lord.
Consider your lordship, but there are two more siblings of the petitioner, your lordship.
In accordance with law.
With their consent, they have.
Yes, the petitioner is before this court seeking the following prayer. The petitioner is the wife of who is the employee?
Mother.
Mother died.
Mother died.
The mother of the petitioner is said to have was an employee of the respondent corporation, Karnataka State Road Transport Corporation. The mother dies in harness on 1/9/2021. The petitioner, claiming to be the dependent daughter, submits an application seeking appointment on compassionate grounds. The reject ಮಾಡಿದಾರಾ?
Please, on the ground that married daughter.
The said claim comes to be rejected on the score that she's a married daughter and would not come within the definition of daughter as obtaining under the extant rules. The issue whether a married daughter would be entitled to compassionate appointment or not is considered by this court, madam. Judgment ಇದೆ. ಎಲ್ಲಿ judgment ಕೊಡಿ? Judgment.
In repetition number. In repetition number 101-711 of 24.
ಒಂದು ಮೊನ್ನೆ ಮಾಡಿದ್ದೀನಲ್ಲ ಮೇಡಮ್.
101-711 of 24, your lordship.
2024.
Even corporation filed writ appeal, your lordship.
ಅದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು?
No, your lordship.
ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? ಆಯ್ತು ಸರಿ. 101-711 ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದೀನಿ ಅದು ಮಾಡ್ಬಿಡಿ. ಮಾಡ್ಬಿಟ್ಟು the application of the petitioner seeking appointment on compassionate grounds can be should merit consideration in accordance with law with the affidavit of the petitioner that she is the dependent and she would take care of inyaridaru siblings.
Siblings, your lordship, at page number 15.
Younger
elder
siblings?
brother and elder sister are there.
They are
elder brother, elder sister. take care of us, that she was dependent upon the mother at the time of submission of the application. The application shall be considered within an outer limit of 12 weeks from the date of receipt of the copy of the order, if not earlier. Yes, next.
Please.
This part, Chief Financial Officer, Chief Financial Officer, promotion posted to
Ex-cadre and
Oh, yes, Vikram Holigoda appeared.
Senior Counsel Sri Ranga appeared last time.
Pass over. Let's see. Next.
But after lapse of 27 years,
That one, yes, sir.
file of society came to the chair.
One submission, my lord. Yesterday I filed wakalat in first matter, my lord, for respondent number 4, my lord. My name is not shown, my lord.
Interim order idea.
Howದು, interim order.
interim order.
The learned counsel Vishwanath Hegde submits that his entered appearance for which respondent?
Respondent number 4, my lord.
Respondent number 4 in 32. Registry to print the name of so and so as appearing for the fourth respondent. List the matter on 27th. Interim order subsisting will continue to the next date of hearing.
My difficulty is, now counting is stayed. In the meanwhile, but administrator is also appointed.
Administrator is assumed charge?
Oh,
Not yet.
no, he has not taken the charge. But in the interim order, it is stated that if charge is not taken, but within 1 hour, but the order is passed, the administrator has taken the charge by calling the resolution book, original resolution book, without visiting the office of the.
Now what do you want, sir?
It is to be heard.
Yes, 27th. What the time kept Vishwanath?
But 33 and 34, my lord. Another, my lord, the writ petition is pending, my lord. Same society, my lord. 107.
Same society and same petitioners are there, your lordships. There are 3 petitioners who are also petitioners in the connected matter.
Same order.
That's next day matter. But here, 13D, my lord, we have complied. Society has complied. And the election result, the counting is stayed, my lord. After election, the counts, my lord, other 2% are, my lord, equal votes are there. Therefore, question of not announcing result does not arise. One. Another is, not I have issued not a registered port certified copy, not the notice to the petitioners. Not they have received and they have failed to attend not the AGM meeting.
Then it will have to be heard.
Yes.
List the matter on 27th.
Along with not
lordships.
Tag the petition along with so and so. Could you?
Lordships, third, your lordships, on 27th.
Yeah. Any problem with
Your lordships, I am out of station, your lordships.
Please. Yes. Third, fine. Please. List on third. Interim order, yeah?
Yes, your lordship.
ಅದು
Interim order is
voting
to
ಅಷ್ಟೇ
voting and contesting also is being.
Yes, next.
One week time for this. Direction to Lord fourth respondent to Lord delete the Lord name of the bank from column 11. There is already order passed by the Tahsildar, Annexure H, Lord. Page
Leave the name of the bank where?
In Lord encumbrance and Lord column 11 of RTC.
Why?
This is KPID Lord auction. I am the auction purchaser. I'm not the
auction purchaser.
Yes.
ಯಾವಾಗ ಮಾಡ್ತೀರಾ ಸರ್?
1 week time.
You will comply with it?
Take instructions.
No instruction. Yes. The learned AGA to secure instructions.
Last time also the Lord they sought 2 days time to seek instruction.
ಏನು ಅರ್ಜೆನ್ಸಿ ಮಾಡಬೇಡಿ, ಸುಮ್ಮನೆ ಬರ್ಲಿ. ಫಸ್ಟ್ ನಾನು ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಕ್ಲಿಯರ್ ಮಾಡ್ತೀನಿ ಆಮೇಲೆ.
Now they are in verge of Lord releasing the amount. Lord
ಸ್ಟೇ ಮಾಡಿದ್ದೀನಲ್ಲ ಸರ್.
ಅಲ್ಲ ಸ್ಟೇ ಇದೆ.
ಡಿಸ್ಪೋಸಲ್ ತಾನೆ, ಹಳೇದು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. ಎಸ್. The learned AGA to secure instructions as to why the indication of a charge upon charge in
RTC
in
column
RTC
11
and column number 11
and encumbrance.
Encumbrance and column number 11 of the RTC still shows the name of the bank notwithstanding the fact that the petitioner is the auction purchaser. In the event by the next date, remedial action is not taken, it would be construed that the remedial action is not taken, appropriate orders would be passed for dereliction. Yes.
Interim order.
Interim orders of, the interim order granted earlier stands extended till the next date of hearing. The interim order so granted will not come in the way of the aforesaid remedial action that is directed to be taken.
Any date?
27th.
Please.
Nenne matter, three delegation. Now the only distinction here is the
ಯಾಕೆ ನೆನ್ನೆ ಆಯ್ತಲ್ಲ ಒಂದೇನೆ
ಒಂದಾಯ್ತು ಇದರಲ್ಲಿ what they would contend is since he was sent millets to vote in the elections for Saharda Bank, it is not governed by section 21(3). If you also take section, kindly see section 98H of the millets, Karnataka Cooperative Societies Act.
That will hear it on Monday.
Yes, because this will require something, because my lord, this is with regard to one is
Sauharda, yes.
Sauharda, and the other one is society. So my lord, there is a difference in our the entire thing of the apex body. Everything is.
When do you want it? Monday, Tuesday.
My lord, 1 minute. That may be posted on second, my lord, because.
Second. Yes.
And another thing is, my lord, on the same issue, 37 and
37 is
45.10, both having same issue. 45.
Those batch matters where your lordship's millets have got it listed for disposal, since the entire results are withheld. And the first matter is millet, the lead matter where appointment of administrator is millet.
45 which we want your lordship, there is some urgency there.
45 early.
Yes. This one, my lord, the lordship.
2nd December.
Please.
My lord, both may be connected. 45.
2nd December. Ad barli amal noಡ್.
Okay.
Don't confiscate the issue. Yes.
Okay.
Next.
Please. My lord, challenging the premature transfer of the.
Transfer.
Please. Yes. My lord, they are the employees, they are the deputed for the, under the board, Tungabhadra board, my lord. My lord, the guidelines are mentioned at the statement of objection of.
No, this is transfer within that 6 months adhe alva alli.
Houdu.
But the total tenure of an employee on deputation from Andhra Pradesh, my lord, is 5 years.
5 years.
Correct.
Which has been divided, my lord, in
Three slots.
2 stage, my lord.
ಹೇಳ್ಬಿಡಿ ಏನಾದ್ರು.
My lord, kindly peruse the statement of objection, my lord. The guidelines are very clear. In respond number 1 and 2 guidelines. The guidelines furnished by.
Page.
My lord, page number 6, my lord, furnished by respond number 1. Statement of objection is there. That is more legible. Please, page number 7 and 8 only guidelines under 3 slots, they have been divided, my lord, for the service, office service and field service.
Page number 6.
8 only, the guidelines. Statement of objection of respond number 1 and 2, the guidelines is visible.
Respond number 1 here. R1. Page number 10.
For petition alladre page number 14 allade sir.
ಯಾವ notification na?
Transfer guidelines, sir. That is the transfer guidelines.
ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ ಸರ್?
In page 14 of read petition.
14. Please.
Otherly, they already have police.
Please, my lord. 3 slots are there, my lord. Total is 5 years, divided into 3 slots. 1 year in any post in the office. Page number 14, my lord.
MM Patil ಹಾಕಿರೋದ್ರಲ್ಲ.
ಅದರಲ್ಲಿ ಪೇಜ್
ಅದರಲ್ಲಿ ಇದೆ petition.
ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 6 ಸರ್ MM Patil.
ತುಂಗಭದ್ರಾ ಬೋರ್ಡ್ ಬನ್ನಿ.
Please, my lord. ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 8 ಅಲ್ಲಿ the slot is been clear, my lord. ಅದರಲ್ಲಿ 1 year in any post in the office, 2 year in any post in the head works, 2 year in any post in the RB LLC. So there are 3 slots mentioned, my lord.
Page 8 ಅಲ್ಲಿ ಇದೆಯಾ?
Page 8 ಅಲ್ಲಿ.
ಆಯ್ತು.
They are the guidelines. My lord, kindly turn back to page number 2 of the same objection, my lord. This is my position. Page number 2 of the same. So HLC ಅಲ್ಲಿ 26 ತಿಂಗಳು, 26 months. LLC ಅಲ್ಲಿ 21 months, my lord. I should have been posted for 24 months, but they extended for their own reasons. Then second slot, my lord, 21 months. Office service, my lord, hardly 5 months. Now they want to shift me back.
ಎಲ್ಲಿಗೆ ಮಾಡಿದ್ದಾರೆ ಈಗ?
ಅದು ಮತ್ತೆ ವಾಪಸ್ ಫೀಲ್ಡ್ ಸರ್ವಿಸ್ಗೆ ಈಗ ಆಫೀಸಿಗೆ ತಗೊಳ್ತಾ ಇದ್ದಾರೆ ಸರ್. ದಿ ಗೈಡ್ಲೈನ್ಸ್ ಸ್ಪೆಸಿಫಿಕಲಿ ಕೈಂಡ್ಲಿ ಟರ್ನ್ ಬ್ಯಾಕ್.
Internal transfers and postings.
Please, madam.
All right, subdivisional officers posted at one place for a full period of tenure develop vested interests in water regulation, therefore seriously affecting him. To avoid such situation, working tenure spells below.
A stipulation ಇದೆ.
Officers in the board shall comprise
24 months and 12 months is the slots. 3 slots should be there, my lord.
ಆಯ್ತು 48 months ಇದ್ರೆ
ಆಗಿದೆ. Total 48 hours minute has been completed.
48 months field service ಮುಗಿಸಿದಿರಲ್ಲ?
ಆಗಿದೆ. ಅಲ್ಲಲ್ಲ, ಇಲ್ಲಿ ಏನಾಗಿದೆ ಸರ್? 26, 24, please.
48 months field service ಆಗಿದೆ.
Please. My lord, kindly come to page number 8 back.
ಈಗ ವಾಪಸ್ ಆಂಧ್ರ ಪ್ರದೇಶ ಕಳಿಸಬೇಕಾ?
ಇಲ್ಲ, ಇನ್ನೂ ಇದೆ ಸರ್ ನನಗೆ. ಏಪ್ರಿಲ್ ವರೆಗೂ ಇದೆ.
You want me to send?
ಅಲ್ಲಲ್ಲ, ಏಪ್ರಿಲ್ ವರೆಗೂ ಇದೆ ಸರ್ವಿಸ್.
You want me to send now?
No, my lord.
We'll send you.
ಅಲ್ಲಲ್ಲ, ಇನ್ನೂ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ ಸರ್.
ಯಾವ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ?
ಅದೊಂದು 5th month
ಇರೋದು ಡೆಪ್ಯುಟೇಷನ್ ಮೇಲೆ. ಇದು 48 months ಆಗೋಗಿದೆ ಆಗ್ಲೇ.
ಅಲ್ಲ ಸರ್, 5 years ಆಗ್ಬೇಕು.
48 months ಒಂದೆರಡು ಸ್ಪೆಲ್ ಆಗಿದೆ ಈಗ.
Please.
ಈಗ ನೀವು ಅಲ್ಲಿ ಹೋಗ್ತೀರಾ ಅಂದ್ರೆ ಪರವಾಗಿಲ್ಲ.
ಅಲ್ಲ
ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತಾರೆ.
ಕೈಂಡ್ಲಿ ಪೇಜ್ ನಂಬರ್ 8 my lord. Kindly page number 8. Please, page number 8 my lord. ಅಲ್ಲಲ್ಲ, ಏಪ್ರಿಲ್ ಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಬೇಕಂತ the guideline specifically speaks that I should be transferred in the month of 18. ಅಲ್ಲಿ 1 ವರ್ಷ ಇರೋದು.
I am not bound by your guidelines. By judicial order I can ask you to be repatriated.
ಅಲ್ಲಿ 24 months ಇದೆ my lord. For their own reasons they extended me.
You should have told them, no, don't extend it. 24 ಮಾತ್ರ ಇರೋದು ನನಗೆ ಬೇರೆ.
ಅಲ್ಲ, even office service ಅಲ್ಲಿ it should have been 12 months my lord as per their own guidelines. Abruptly my lord, like musical chair ಅಲ್ಲಿ 5 ತಿಂಗಳಿಗೆ ನನಗೆ ಇಲ್ಲಿ ಕಳಿಸ್ತಾರೆ.
ಎಲ್ಲಿ ಹೋಗ್ತಾ ಇದೀರಾ ಸರ್ ಮ್ಯೂಸಿಕಲ್ ಚೇರ್?
ಅಲ್ಲಲ್ಲ, 5 ತಿಂಗಳಿಗೆನೇ they are shifting.
ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ ಸರ್?
ಅಲ್ಲ, from field service to the office service.
Yeah. Field service to you are supposed to be like that only. ಯಾವ ಮ್ಯೂಸಿಕಲ್ ಚೇರ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ?
ಇಲ್ಲ ಸರ್, ಅದು ಏನು 12 months for the officer.
ಮಾಡಿದ್ಯಾ?
ಹೌದು. ಅಲ್ಲಲ್ಲ, 24 months for the field service and 12 months for the office service ಅಂತ ಗೈಡ್ಲೈನ್ಸ್ ಇದೆ ಸರ್. In between that expire of that ಆ period ಗೆ ಮೊದಲೇ ಕಳಿಸ್ತಾ ಇದ್ದಾರೆ ಮೇಲೋಡ್. Neither I am completing that period nor this period.
ಈಗ ಆಫೀಸ್ ಸರ್ವಿಸ್ ಎಷ್ಟಾಗಿ ವಾಪಸ್ ಫೀಲ್ಡ್ ಸರ್ವಿಸ್ ಯಾಕೆ ಆಗ್ತಾ ಇದ್ದೀರಾ?
No, my lord. He has not already worked office service my lord on earlier occasion 5 months 24 days. Now he is required to work my lord for another 6 months 6 days. So now he has been posted to office work.
ಈಗ ಆಫೀಸ್ ಹಾಕಿದೆ.
Office they don't want to continue in office. He want
ಫೀಲ್ಡ್ ಚೆನ್ನಾಗಿದೆ.
48 ಏನಿದೆ 4 ವರ್ಷ ಆಯ್ತು ಸರ್. That's right. But ಇಲ್ಲಿ ಏನಾಗಿದೆ ಈಗ 5 months ಆಗಿದೆ. They want me to compensate that debt.
ಈಗ ಆಫೀಸ್ ಸರ್ವಿಸ್ 5 months and 24 days ಆಗಿದೆಯಲ್ಲ?
ಹೌದು.
ಇನ್ನು ಮಿಕ್ಕಿದ 6 months ಆಗ್ಬೇಕದು.
ಅಷ್ಟೇ ಸರ್.
ಮುಗಿಸ್ಬಿಡಿ ಅದು.
ಅಲ್ಲ, ಏಪ್ರಿಲ್ಗೆ at least.
ಅಲ್ಲ, ಅವಾಗ ಆಫೀಸ್ ಸರ್ವಿಸ್ ಮುಗಿಸ್ದಂಗೆ ಆಗಲ್ಲ, ನೀವು ಫೀಲ್ಡ್ ಅಲ್ಲೇ ಇದ್ದಂಗೆ ಆಗುತ್ತೆ.
Their guidelines says that ಏಪ್ರಿಲ್ ಟೈಮ್ ಅಲ್ಲಿ ಮಾಡಬೇಕು.
ಏಪ್ರಿಲ್ ರಿಪ್ಯಾಟ್ರಿಯೇಷನ್ ಗೆ
I will be sent back to the.
You will be sent back.
ಅಲ್ಲ, at least for their reason my lord they have extended the period, not for my reason or not my request.
Petition is claiming all this. Anything else?
No.
Yes. ಆಫೀಸ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡಿ ಬರೀ ಫೀಲ್ಡ್ ಅಲ್ಲೇ ಇದ್ರೆ ಹೆಂಗೆ? The petitioner is before this court calling in question an order dated 23/10/2025 by which the posting of the petitioner is varied within the board Tungabhadra board. The petitioner heard so and so. Facts and brief germane are as follows. The Tungabhadra board, hereinafter referred to as the board for short, in terms of its resolution, framed rules and transfer guidelines. In terms of the said guidelines, a person from the state of Andhra Pradesh is entitled to come on deputation to Karnataka Tungabhadra Dam for a period of 5 years. In terms of the said guidelines, the petitioner is deputed to the post of subdivisional officer on 26/5/2021. On 26/7/2023, the posting is varied within the board in terms of the guidelines. Later, on 23/10/2025, the petitioner by the impugned order is transferred back to the office from the field. This is what is called in question in the subject petition. This court, owing to the submission of the counsel appearing for the petitioner, had granted an interim order of stay of the impugned order, which is in subsistence even today. The learned counsel for the petitioner submits that the impugned action is contrary to the guidelines and therefore it is contrary to law. According to the learned counsel, he has to complete another 6 months, he has to complete the tenure in field service for till the month of April 2025, and therefore the transfer would be violative of the guidelines. Per contra, the learned counsel Rajshekhar Burje and M.M. Patil would, appearing for the respondents, would in unison contend that the petitioner has completed 48 months in the field service and is now posted back to the office where he has to complete his tenure in terms of the guidelines. He would therefore submit guidelines. He would therefore submit that the petitioner does not derive any indefeasible right to continue in the same post as his internal transfer is strictly in consonance with the guidelines. The aforenarrated facts are not in dispute. The guidelines, ನೀವು ಹಾಕಿದ್ದೀರಾ?
Page 14 ಅಲ್ಲಿ ಇದೆ.
14 ಇದೆಯಾ?
Writ petition in page 14.
The guidelines, insofar as it regulates the entry and exit of officers from Andhra Pradesh, is as follows. Page 12 to 14. Internal transfers and posting is also a part of the aforesaid guideline. In terms of the said guideline, for 1 year would be in the office, 2 years in any post in the field, and 2 years in any post in the RB LLC division. In terms of the said guideline, the tenure of the petitioner is divided in this manner. Page 2 of the SO. The petitioner, after posting, was in the HLC division for 26 months and 14 days. In the LLC division, 21 months and 16 days. Therefore, has completed 48 months, 4 years in the field, as is obtaining under the guidelines. The petitioner is now posted back to the office from the field for completion of 1 year in terms of the very same guideline, as the petitioner has completed only 5 years and 24 days in the office. The petitioner cannot now contend that he must be continued in the field up to the month of April, so that he completes his tenure and gets repatriated on completion of the period of deputation. The said submission is unacceptable. The petitioner has completed 48 months in the field work, in the field posting. How he has completed is not the concern of this court, as it does not cause any prejudice to the petitioner. And 1 year the petitioner had to complete in terms of the very guidelines he places reliance upon. In that light, the impugned order of internal posting does not brood any arbitrariness for this court to intervene and obliterate the same. In the light of the in that light, petition lacking in merit stands rejected. Yes.
In this case, filing objections today.
Objections, sir. Is the license renewal?
Yes, my lords. They have at annexure M, my lords, they have issued a notice pertaining to the cancellation of the renewal of the license of the rifle, my lords.
Crime. That my lordship please to dispose of that application, that petition notes, and allowed that. And the endorsement issued by the authority saying that there is no life threat. That is one of the
life threat.
Our petitioner.
License ತಾನೇ ಅದು.
ಹೌದು.
ಕೊಡ್ಬೇಕಾರೆ
ಅದು it is my lords given my lords way back in the year 19.
Way back in the year ಅಂದ್ರೆ license renewal ಕೇಳ್ತಿರೋದು. The petitioner is before this court seeking the following prayer. Heard so. The petitioner in the year 1998 is said to have granted an arms license pursuant to an inspection or training conducted in accordance with law. The license comes about on 28/1/1998. for the purpose of protection of the petitioner and the family. On ಯಾವಾಗ expire ಆಯ್ತು madam?
2024, my lords.
The license was renewed from time to time for every 5 years period, and the last of the renewal had happened between 1998 to 2017, and again last of the bada renewal had happened 1998 to 2017, and again
17.
on 25/12/2000 again on
36
Last was
2020.
17, my lords, but the
Like
annexure H1 is the
last renewal ಯಾವುದು madam?
2024, again, the application was issued for the purpose of renewal, my lords.
Sir,
2017 was the last renewal.
After the said renewal, the petitioner submits an application after the said date, i.e. After the said year 2017, the petitioner submits another application seeking renewal of the license, which comes to be rejected. Reject ಮಾಡಿದಾರಾ?
Reject ಮಾಡಿದ್ರು. Annexure M.
Comes to be rejected on certain premise. The premise is that the son of the petitioner, son of the petitioner had got himself embroiled in a crime, in crime number 134 of 2019.
ಇನ್ನೊಂದು recall application ಇರ್ತಾರೆ. ಅದಕ್ಕೆ objection ಇದೆ.
2019, and therefore and there is no life threat to the petitioner for renewing the license. The arms license, renewing the license. The learned counsel appearing for the petitioner submits that the license cannot but be renewed as it was renewed from time to time. The only time when the license was not renewed is when the surrender of arms had happened on account of the registration of the crime in crime number 19 of
134 of 2019.
in crime number 134 of 2019. The learned counsel would submit that the investigation in crime number so and so is quashed by this court in crime number 134 of 2019 is quashed by this court.
Page number 14.
Of its order dated 26 March 2024. After the quashment of the crime, the petitioner has submitted another application seeking renewal of the license. That the rejection the learned counsel submits is on the face of it contrary to law. The learned AGA would only place the judgment and the reason for rejection being that there is no life threat to the petitioner, and a communication dated 22/11/2019 or 23/11/2019 by which the son of the petitioner getting embroiled in a crime had led to surrender of the arm. That having been surrender of the arm, I have given my source. Therefore, narrated facts are not in dispute. The only issue is whether the petitioner's arms license should be permitted to be renewed or should be directed to be renewed or otherwise. As observed here and above, the objection that is projected in the statement of objections by the state is that the son of the petitioner getting embroiled in a crime where the weapon was directed to be surrendered. The crime has been obliterated in criminal petition 101-496 of 2021. There is no direction in the said while disposing the said petition that the arms license of the petitioner should not be renewed. In the light of the only circumstance, even in terms of the objection so filed that the license cannot be renewed for the purpose that the crime is registered, that no longer in subsistence, the arms license cannot but be renewed in terms of section 17 of the Arms Act. Arms Act ಇದೆಯಾ?
1959, my lords.
1950 Arms Act 1959 section 17 ತಾನೆ?
Section 17 speaks about
17 of the
suspension of
Arms Act, so and so. In the light of the aforesaid reasons, the petition deserves to succeed. The petition allowed, quashed. The respondent shall now reconsider the application of the petitioner seeking renewal of license and pass necessary orders in accordance with law, bearing in mind the observations made in the course of the order within an outer limit of 12 weeks from the date of
The rifle is under the custody of the respondent, my lords. Respondent.
so and so. ಅದ್ಯಾಕೆ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಇನ್ನು? Please. ಅದು crime ಆದ್ಮೇಲೆ release ಮಾಡಿಲ್ವಾ?
Another case, that case against remaining accused case is pending.
ಅದಕ್ಕೆ ಇವ್ರದಾಕೆ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಸರ್? The learned counsel for the petitioner now submits that the weapon that was seized at the time of registration of the crime in crime number 134 of 2019 has not yet been released in favor of notwithstanding the order becoming final. The learned AGA would submit that the crime is pending against other accused. If it is pending against other accused, it cannot be a circumstance that the license standing in the name of the present petitioner, father of the accused, should be detained without any rhyme or reason. ಮಿಕ್ಕಿದೆಲ್ಲ ಹಂಗೆ ಇರಲಿ. ಪ್ಯಾರಾ ಆ್ಯಡ್ ಮಾಡಿ.
Grateful.
But I'm sorry to intervene, my lords. May I make one request? Serial number 68, my lord, yesterday's matter of externment.
ಅದು ಕೊಡಿ. ನಂದಾಗಾರ್ ಇದ್ದಾರಾ?
Please.
Yes.
Please. Lord, my first submission is that this order is not based on the order dated 15/10/2025 passed by the Bijapur. It is an independent order, my lord. The independent, before that matter, I request this honorable court kindly, what is the order passed by the Supreme Court, my lord. In the paragraph 2 itself, my lord, it says, after that period, in that period also, the deputy commissioner has a power to extend the period also. That has been made it very clear. That is my first submission, my lord. This submission, this order passed by the deputy commissioner Dharwad is an independent order. This order is not based upon.
It does not relate to the earlier order.
Please. Before that, my lord, I request this honorable court, this order, only 2 paragraphs, my lord, the statement which are made by the
page.
Please, my lord. In the page, running page 18, my lord.
What potential threat do you see?
Running page 18, one paragraph ತಾವು ನೋಡ್ಬಿಟ್ಟು paragraph 6.
ಅದಕ್ಕೆ ಏನು ಆರ್ಡರ್ ಕೊಡಕ್ಕೆ ಮುಂಚೆ ನಿಮಗೆ ಕೇಳಬೇಕು ಅಂತ ಹೇಳಿದೆ ಅಷ್ಟೇ.
Greatly.
Yes.
Paragraph 18 ಅಲ್ಲಿ ಸ್ವಾಮಿ. Only statement.
Page 18.
Page 18, running page 18, internal page 8 of learned single judge order.
ಅದೇ, that's what, before this delves into the matter. ಅದಾ?
ಅಲ್ಲ, running page 8 ಮೇಲೆ paragraph 6 of the learned single judge order.
6 ಅಲ್ಲೇ ಇದೀನಿ ಅದೇ.
Paragraph in ಕನ್ನಡ.
ಉಲ್ಲೇಖ 1.
Please.
ಹೇಳಿ.
ಪೊಲೀಸ್ ಅಧೀಕ್ಷಕರು ವಿಜಯಪುರ ಇವರು ಇತ್ತೀಚೆಗೆ ಮಹಾರಾಷ್ಟ್ರದ ಜತ್ತಿ ತಾಲೂಕಿನ ಬೀಳೂರು ಗ್ರಾಮದ ಸಮಾರಂಭದಲ್ಲಿ ಕನಕೇರಿ ಮಠದ ಅದೃಷ್ಟ ಕಾಡದೇಶ ಸ್ವಾಮೀಜಿಯವರು ಗುಡ್ಡಕ್ಕ ಹೋಗ್ಬೇಡ್ರಿ ಅಂತ ಪ್ರಚಾರ ನಡೀತೈತಿ. ತಿಂಗಳು ದೀಡ ಮಾಡ್ತಪ್ಪ. ಮುಖ್ಯಮಂತ್ರಿಗಳ ಕೃಪಾ ಕಟಾಕ್ಷದಿಂದ ಲಿಂಗಾಯತ ಮಠಾಧಿಪತಿಗಳು ಒಕ್ಕೂಟ ಕಲಾವಿದರನ್ನು ಕೂಡಿಸಿಕೊಂಡು ಬಸವ ಸಂಸ್ಕೃತಿ ಅಭಿಯಾನ ಎನ್ನುವ ನಾಟಕವನ್ನು ತೆಗೆದುಕೊಂಡು ಇಡೀ ಕರ್ನಾಟಕ ರಾಜ್ಯ ತುಂಬಾ ತಿರುಗಾಡಿ ದೇವರ ಗುಡಿಯಾಗಿಲ್ಲ, ಗುಡಿಯಾಗ ಹೋಗ್ಬೇಡ್ರಿ, ಮನಸ್ನಾಗ ದೇವರುಗಳು ತೆಗೆದುಕೊಂಡು ಒಳಗಾಕ್ರಿ, ಹೋಟೆಲ್ಗೆ ಹೋದ್ರೆ ದಾರು ಕುಡಿರಿ, ಆರಾಮಿಗಿರ್ರಿ, ಮಾಂಸ ತಿನ್ರಿ, ಅವರ ಮುಂದೆ ಕುಸ್ಕೊಂಡು ಡ್ಯಾಶ್ ಬುದ್ಧಿ ನಾನೇ ಹೇಳಬೇಕು, ಹಿಡಿದು ಮೆಟ್ಟಿಲು ಹೊಡೆಯಕ್ಕೆ.
ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಗದಗ ವಿಜಯಪುರ.
So this is a statement, my lord. This was condemned by Honorable Supreme Court and warned the petitioner. Subsequently also he made a lot of statement on the basis of this. This is an basis for this created he made a open allegations against the Lingayatism. He made an allegations against the Basava Tattva. He made an allegation against these are the words used against the Swamijis of the Karnataka. But this is still in the minds of the Lingayat community. This is an order, is recently, my lord, this is a statement he has made in the month of October. On 7/10/2025, he made a statement. So because of this statement, my lord, it is in the, now he has been invited to the other functions. So therefore the representation is given.
This statement ಮಾಡಕ್ಕೆ ಬೇರೆ ಫಂಕ್ಷನ್
ಅಲ್ಲ ಬೇರೆ ಫಂಕ್ಷನ್ ಮಾಡಿ ಅವರು ಇನ್ವೈಟ್ ಮಾಡಿದ್ದಾರೆ. On the basis of this statement, my lord, see, it is a recent statement he has made. Even that is why, my lord, considering this, Honorable Supreme Court has warned the petitioner, don't indulge in this type of, because he is a Swamiji, my lord. So now it is still in the minds of the people, my lord, and more against the creating the disharmony in the society, my lord. So therefore, my lord, my most respectful submission is that this is an order passed by independently by the exercise of the power by the deputy commissioner. At no point of time, deputy commissioner influenced the order passed by the other district commissioner. And the independent order, my lord, there is no bar either under the Supreme Court Act, Supreme Court judgment or any other the provisions to pass an independent order, my lord. It is a well-considered order, and this order has been passed on the basis of the information received from the superintendent of police.
No, another thing I'm asking is, this statement led to an order being passed within the region of Gulbarga there. That was challenged.
That was challenged.
Challenge is applied Supreme Court.
Yes,
force.
yes, yes.
Now, on the same reason, can you pass another order for another state?
Disharmony is causing because of this statement. This is the first thing. Second thing is that even after Supreme Court has warned, he has indulged in the same type of the statements.
Where is
that is on the basis of the, that is why, my lord, that is why.
The order of the Supreme Court which warned him.
Lord, in page 28 is the order.
My lord, that is, the order is silent about that, my lord. The word, but that was been reported in the, even this thing, my lord. It was, there was the statement orally, the Honorable Supreme Court has warned. That was not recorded. This type of statement, my lord, creating the disharmony in the society, my lord. And especially, my lord, after Supreme Court said also, he made a similar statement. Swamiji has made a similar statement. That is in the, that is, so in various places he has made, he has protested, all those things has been happened. And on the basis, my lord, this is an order has not passed by the deputy commissioner, the report has been obtained from the superintendent of police. My lord, in the place where the function is organizing, 70% of the population belong to the Lingayat there.
ಇದು ರಿಪೋರ್ಟ್ ಕೊಡಬಾರ್ದು ಅಂತ ಅಲ್ಲೇ ಬರ್ದಿರೋದಲ್ವಾ, ಕೊಡೋದು ಬೇಕಾಗಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ಈ ಕೇಸಲ್ಲಿ ಬರೆದಿಲ್ಲ ಸರ್, ಅದು ಎಕ್ಸ್ಟರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕೇಸ್.
ಎಕ್ಸ್ಟರ್ಮೆಂಟ್ ಅಲ್ಲ, ಅದು ಪ್ರೊಹಿಬಿಟರಿ ಆರ್ಡರ್.
ಅಲ್ಲ, ಇಲ್ಲಿ ಪ್ರೊಹಿಬಿಟ್ ಇಲ್ಲ, ಅದು ಎಕ್ಸ್ಟರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕೇಸಲ್ಲಿ, ಇದು ಪ್ರೊಹಿಬಿಟರಿ ಆರ್ಡರ್.
ಯಾವುದು ಎಕ್ಸ್ಟರ್ಮೆಂಟ್ ಆರ್ಡರ್?
ಅಲ್ಲ, ಅದು ಒಂದು ರಿಪೋರ್ಟ್ ಕೊಡಬೇಕು ಅಂತ ತಾವು ಬರ್ದಿರೋದು.
ಅದು ಬೇರೆ.
ಇದರಲ್ಲಿ ಬರ್ದಿಲ್ಲ.
ಪ್ರೊಹಿಬಿಟರಿ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ when Justice Magdum has written, you need not even furnish the report ಅಂತ ಬರ್ದಿದೆ.
ಅದು ಫೈಂಡಿಂಗ್ಸ್ ಇದೆ. ಇದು ಇದೆ.
So on what basis did you have a report now?
Yes, ma'am.
Based on the report you have.
Please, ma'am. Please, ma'am. My report says, ma'am. Report the basis for is that the place where the function is organized, 80% of the population belong to the Lingayat.
Yes, sir.
So therefore, my
function was over on 7/11/2025.
Why don't you encourage restraint?
Definitely, my lord. Definitely,
if you are a pontiff, you should pontificate and not politicize.
My lord, can I just make one?
You should not play politics.
My lord, definitely, my lord. Can I make one statement? My lord, to give a preface to this entire episode, my lord, there was a Basava Samiti function was organized with the government. My lord, pontiffs were there. My lord, they wanted to propagate that Hinduism and Basava Tattva was two different sects, religions. And they called the goddess Lakshmi as Julie Lakshmi and all those things. Then for reply, he has done it. Definitely, he will not use any abusive words. But the very basis of the order is that 7/11, there was a function. We have spent that 7/11 already. If you also were to see the impugned order, 7/11 was the last date. There is no reason as to why I should be restrained for 2 months. Lord, please see the representation which has given. It refers to the order of the Bijapur District Commissioner, order of the learned single judge in the coordinate bench, order of the apex court. Last time, my lords, my colleague gave a representation to lordships, given by one community. My lord, this is the basis. My lord, the apex court in division bench of this court in Seniority's case has said that proportionately you can impose, but I am not denying the power. But question is, my lord, there is no satisfaction at all. If you lordships were to see the impugned order, my lord, page 32 for a moment. My lord, there are no reasons. The request itself is for between 5 to 11, 5 to 7. So, my lord, prohibiting me up to January 2026 makes no sense for them. Now my learned friend is trying to say subsequently I have made some statement and all, my lord, extraneous considerations. He cannot try to, my lord, infuse a prejudicial aspect to the case. Please see page 34, in page 34. What is the request of the organization is?
ಅಲ್ಲ, ನಿಮ್ಮ ಹೆಸರು ಅದೃಶ್ಯನಾ?
My lord, it is a Adrushya Kadeshwara Matha, my lords, actually. My lord, he is a philanthropist. He educates 600 children belonging to poor community. He has set up agricultural units.
The court is only telling that.
Yes, my lord, I would advise, I would definitely advise not to use the foul language. I follow that. But my lord, this is creating an emergency like situation for him.
Well, yes.
I follow, my lord.
No, that is, the defense is precise.
Yes, I follow, my lord. What falls from your lordships, definitely, my lord, I'll pass it on. I am not a person who is going to be, my lord. But this kind of order should not.
Anything else?
Because this incident is a recent incident, my lord. It is in the minds of the people, my lord. So that is why it is the emotion, my lord. He is playing with the emotions of the people.
Don't try to say something which is not part of the.
That is the reason
I
why.
understand the sensitivity. My client also.
That is the reason why I read out the statement made by the Swamiji. So very purpose I read out it, not it's definitely hurt the feelings of the.
If you are a philanthropist, you continue, not a problem. That's why I said a pontiff should pontificate and not.
Yes, I follow that.
Please.
So Lordship may kindly consider. There is one judgment, my lords, which my colleague would pass it on. Division bench judgment has considered all the previous aspects. My lord, it is a case of Soumya R. Reddy versus State of Karnataka, a petition.
Justice Oak and Justice Hemant.
Yes, my lord. Just for the record, my lords, I'm sure your lordships would have been aware of this.
2020, sir.
Yes, my lord.
Will third result.
Great.
ಯಾರ್ದು ಮೇಡಮ್ ಅದು ಪೆರೋಲ್ದಾ?
Yes, minutes.
Cancel.
10 years.
Yes, no parole today. Mobile use ಮಾಡ್ಕೊಂಡು ಕೂತ್ಕೋಬಿಡಿ ಅಂತ ಹೇಳಿಲ್ವಾ?
Your Lordship, I am not using mobile, Your Lordship. I am appearing through mobile itself, Your Lordship.
Yes.
302 is the offense. 302 minutes, 5 years.
ಅದಲ್ಲ 230 ಮೋಡ್ ಮ್ಯಾಟರ್ ತಗೊಳ್ತಾಳೆ. ಯಾರು ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಅನ್ನಲ್ಲ. ಜ್ಞಾನೇಶ್ ಸ್ವಾಮಿ.
I appear for the petitioner in 712. Am I audible?
Hearing sir.
230 more, please.
I appear for.
Good matter. I'll take it later. Hearing sir alva. I'll take it a little later. You tell him. Yes. Sir. Not yours. I'll take it a little later. 4:30.
Order of attachment, Lordship, the trial court passed the order. Page number.
Land bearing survey number ಏನಾಗಿದೆ ಈಗ? ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಮಾಡಿದಾರಾ?
ಮಾಡಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ತಹಶೀಲ್ದಾರ್ ನೋಟಿಸ್ನು ಮಾಡಿದ್ದಾರೆ.
ಎಷ್ಟಿದೆ ಅರಿಯರ್ಸ್?
3,90,000 ಇದೆ ಸ್ವಾಮಿ. 1,90,000 ನಾವು ಕಟ್ಟಿದೀವಿ.
ಯಾವಾಗ?
ಅಲ್ಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅವಾಗ ಕೊಟ್ರೆ.
ಇವಾಗ ಎಷ್ಟು?
ಈಗ 2 lakhs my lord.
ಕಟ್ತೀರಾ?
ಅಲ್ಲಿ ಕೊಡ್ತೀರಿ ಸ್ವಾಮಿ. ಅದಕ್ಕೆ ಈಗ ಡೇ ಬಿಫೋರ್ ಎಷ್ಟೇ my lord 25,000 ಕೊಟ್ಟಿದೀವಿ. ಮತ್ತೆ ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಇದೆ.
There shall be an interim order of stay of the impugned order and all further proceedings taken thereto, subject to the condition that the petitioner would deposit 1 lakh on or before the 10th of December.
75. ಈಗ 25 ತುಂಬಿದ್ವಿ ಆರ್ಡರ್ ಶೀಟ್.
75,000 on or before the 10th of December. List the matter on 10th December. In the event no amount is deposited, ಎಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಿ?
ಅಲ್ಲೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
In the event the amount is not deposited before the trial court, not only the interim order would get vacated, the petitioner would run the risk of the petition itself getting dismissed. Emergent notice to the respondent. Next.
Seal number 2, Mrityunjay Smatpati.
AM India Private Limited.
Yes. This is that matter of what happened, Lord, was there is an execution proceeding initiated by them. In the execution proceedings, we have made payment of over 90% of the money. 10% is left. The reason why the 10% is not paid is because we made an application for correction of the decree.
Correction of?
The decree, because there's a mistake in the calculation. At that point in time, the request is made saying issue warrant of arrest against the
The learned senior counsel Dhyan Chinnappa appearing for the petitioner. The petitioner shall serve the decree holders, respondents by way of hand summons, list the matter on 3rd December in the fresh matters list till such time further proceedings, till such time the order dated 23/9/2025 and all further proceedings before the executing court and execution case 147 of 2024 shall remain stayed.
Brief, both matters.
ಎರಡು ಅದೇನಾ?
Milord 712.
No, he's also appearing.
712.
This is identical. Mr. Rao also is appearing in the second matter, the next matter.
Third matter. Heard the learned senior. Yes, sir. Yes, sir. Heard the learned senior counsel DLN Rao appearing for the petitioner ಅಂತ. ಅದ್ರಲ್ಲಿ ಅವ್ರು ತಾನೆ?
ಹೌದು.
Appearing for the petitioner ಅಂತ ಮಾಡಿ same order. Yes, sir.
Grateful.
Number 4, Vijay Srinivas.
In terms of memo. Now continue the list.
Number 41.
What's offense? Comment. First time, huh?
Salma.
First time.
Offense 302, my lords. My lords, 4 years, 8 months he is in custody.
First time ಬರ್ತಾರದ?
ಹೌದು.
Learned AG is directed to accept notice for the respondent list on Monday. Fresh matters list. Yes.
Jurisdictional police ಒಂದು ಪಾರ್ಟಿ ಮಾಡ್ಲಿಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿ.
ಈಗ ರಿಪೋರ್ಟ್ ತರಿಸ್ಕೊಂಡಿದ್ದೀರಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋ.
The learned counsel for the petitioner is directed to implement the jurisdictional police. Which jurisdiction?
Where their
jurisdiction, the jurisdictional police, jurisdiction of the residence of the petitioner. Yes. As a party respondent. Next.
42.
Same.
Next.
For the first time, same order.
First time.
43.
For petitioners. This is with regards to setting up of mobile tower in the private property. The municipal corporation has refused by way of annexure B has refused the permission but as per the new telecommunication right of way rules 2024 under rule 15
ಎಲ್ಲ ಪಕ್ಕದಲ್ಲಿ ರೇಡಿಯೇಷನ್ ಬಂದು ಎಲ್ಲರೂ ಹೋಗ್ಬಿಡ್ಬೇಕು, ನೀವು ಮಾತ್ರ ದುಡ್ಡು ಮಾಡ್ಬೇಕು ಅಂತನಾ?
Indeed not. The entire report has been submitted to the municipal corporation.
How reports are generated, I know, sir. Yes, we'll see.
Please.
Learned AGA is directed to accept notice for the respondent 1. Please. All the respondents.
That's for municipal corporation.
ಎಲ್ಲಿದೆ? ಓ, ಹುಬ್ಳಿ ಧಾರವಾಡ. ಸುನಿಲ್ ನೀವಿದ್ದೀರಾ? TMC ಯಾರಿದ್ದಾರೆ?
Josna.
Bhushan Kulkarni. Bhushan Kulkarni is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid council list on 4th December.
Please. Great.
44.
In 44, I pray 1 week time, my lords, to file.
This is covered matter. Only on the basis of the change of name of the hospital, my lord, my medical reimbursement has been
reimbursement
rejected.
of medical bills.
Squarely covered by 4 lakhs and
lakhs and odd. Next
Tomorrow,
week.
wait, next week?
Monday, my lords.
Allah, what is the reason? Kudil?
Page number 47, my lord. On the basis of the change of name of the hospital from
Yes,
KLE.
Surat Sahib order full covered.
Yes.
Completely covered. We'll pass
Page
the
number
same
53.
order. Why, what is it? Impugned order kudi.
Page number 53, my lord. Impugned order is page number 47, annexure C.
ಅದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರ ಇಲ್ಲಿ ಚಿಕಿತ್ಸೆ ಪಡೆದಿರೋ ಈ ಆಸ್ಪತ್ರೆ ಸರ್ಕಾರದಿಂದ ಮಾನ್ಯತೆ ಪಡೆದಿಲ್ಲದಿರುವಾಗ ಆದ ಕಾರಣ.
Earlier
Name
it was
of the
known
hospital.
as, yes, name of the
Earlier,
it
hospital. Earlier, was it enlisted?
Yes, my lord.
It was an enlisted hospital.
Yes, my lord.
Where is the list?
Please, page number 12. Serial number 20. KLE's Hospital and Medical Research Center, Nehru Nagar, Belgaum. Now it is renamed as KLE's Dr. Prabhakar Kore Hospital. ಅದಿಷ್ಟಕ್ಕೆ ನಮ್ದು ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ.
Time back. The petitioner is before this court seeking the following prayer. Heard so and so facts in brief germane are as follows. The petitioner, the issue lies in a narrow compass. The petitioner gets herself treated in a particular hospital KLE's medical hospital and medical research center Belgaum the petitioner being a civil government servant submits an application to the state seeking reimbursement of medical expenses. The said implement order ಇದೆ
Page number 47, my lord. Annexure C.
The said claim of the petitioner seeking medical reimbursement comes to be rejected by the following order. The learned counsel for the petitioner submits that the hospital is the same. The nomenclature is changed. Earlier, it was
Kaylee's Hospital and Medical Research Center.
Kaylee's Hospital and Medical Research Center, and now the name is changed to Kaylee's Prabhakar Kore Hospital and Medical Research Center. It is nobody's case that it is a different hospital and not enlisted. Once enlisted, mere change in the nomenclature cannot be used to deny medical reimbursement of a government servant if the government servant is otherwise entitled to. In identical circumstances, a coordinate bench of this court has held as follows. Page 53 order. In the light of the aforesaid facts and the identical issue being decided by the coordinate bench in favor of the petitioner therein, the petition deserves to succeed. Same order. Yes.
Please.
Allowed.
Grateful.
Next.
Number 45, Gayatri sir.
May I request to pass over, my lords, yesterday's matter.
Your Lordship,
He is
my lord,
arguing
what
in
had happened
parted
was-
matter.
May I just, your Lordship, my lord, had passed an order that.
ಇದೇನು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದು ಅಂತ ಮಾಡಿದ್ರಲ್ಲ ಸಾಧ್ಯ
45.2.
ಅಲ್ಲ 45 ಏನಿದೆ your
ನಿಮಿಷ
lordship.
ಅದು ಯಾವ್ಯಾವ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದು ಅವ್ರು ಹೇಳಿದ್ದಾರೆ. ನೀವೇ ಹೇಳಿ ಮೇಡಮ್, ಯಾವ್ಯಾವ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದು, ಯಾವ್ದು ಉಳಿಬೇಕು ಇದ್ರಲ್ಲಿ.
45.2 ಮತ್ತು
ಒಬ್ಬರಾಗಿ ಹೇಳಿ. 45 ಏನು?
Lords, it is appointment of administrator that is called in
45
question.
will retain.
Yes.
ಆಮೇಲೆ 45.1.
Yes, it can be, Justice Shyam Prasad Saib's judgment.
ಸರಿ. 45.1 Justice Shyam Prasad Saib order.
ಆಮೇಲೆ 45.5
ಒಂದು ನಿಮಿಷ, ಒಂದೊಂದೇ. 45.2
myself.
yourself.
45.2 ದಲ್ಲಿ ನಾ ಇದ್ದೀನಿ. So they
45.2 ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದಾ?
ಅಲ್ಲ, he has filed objection recalling.
45.2 ನು ಮತ್ತೆ 45.11.
11 and
ಅದು
13.
there is.
45.2 ಆಗಲ್ವಾ?
11 and 13 my lords.
45.2 ಇಲ್ಲ. 45.3.
Yes, my lords, it can be disposed.
Same Justice Shyam Prasad order. 45.4. Sadanand.
Yes, my lords, it's
45.4. 45.5.
Yes, same judge.
Same. ಆಮೇಲೆ 45.6 Vijay Kumar Ganpati Bhatt. Same. Yes. 45.7 Sadanand.
Yes.
Yes. ಆಮೇಲೆ 45.8 Srinath.
Yes,
Yes. 45.9
Vinay Kumar.
Ganpati Bhatt. 45.9. Same. Yes. ಆಮೇಲೆ 45.10.
That is 37, my lord, your Lordship.
ಆಯ್ತು, ಈಗಿಲ್ಲ ಡಿಸ್ಪೋಸ್ ಇಲ್ಲ ತಾನೆ?
ಇಲ್ಲ.
ಆಯ್ತು, ಅಷ್ಟೇ ಇದೆಯಾ ಇಲ್ವಾ ಅಷ್ಟೇ. 45.11
ಅದು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದು, ಅವ್ರು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ.
11 my lords. 11 and 13.
ಅವ್ರು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ.
Retain it.
11 and 13 ಇಲ್ಲ. 12 ವಿಜಯ್ ಮಲ್ಯ.
Yes, my lord, it can be.
12. ಆಮೇಲೆ 14.
30
ಇಲ್ಲ, 14 ಇಲ್ಲ.
13 ಅದನ್ನ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ತಿದ್ದಾರೆ.
13 ಅದು ಮ್ಯಾಂಡಮಸ್ ಇದೆ, ಅದು ಅಲೋ ಮಾಡಿ ರಿಟ್, ನಂದೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಹಂಗಾರೆ ವೇಟ್ ಮಾಡಿ, ಅದು ಮುಗಿಸೋಣ. ಎಸ್.
ಅಲ್ಲ, ವೋಟಿಂಗ್ ಆಗಿದೆ ಅದಕ್ಕೆ ಹೇಳಿ.
ಅದಕ್ಕೆ ರಿಟ್ ಅಲೋ ಮಾಡಿಬಿಡಿ, ಅದಕ್ಕೆ
ಅದಕ್ಕೂ
ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ತಾರ. ಅವ್ರು ರಿಟ್ ಅಲೋ ಮಾಡ್ರಿ ಅಂದ್ರೆ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ.
ವಾಟ್ ವೆಂಕಟೇಶ್, ಮ್ಯಾಂಡಮಸ್ ಕೊಡ್ತೀನಿ ಅಂದ್ರು ಬೇಡ, ಕೊಡಬೇಡಿ.
ಬಿಕಾಸ್ ಮಲೋಡ 1 month ಆಯ್ತು ಇಲೆಕ್ಷನ್, ಅಲ್ಲಿ ಎರಡಪ್ಪ ಆಗಿ ಮಲೋಡ
ಡಿಸ್ಪೋಸ್ ಇಟ್. ವೇಟ್, ಇದು ಯಾವ್ಯಾವ್ದು ಕವರ್ಡ್ ಅಂತ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ. 45.14
ಇಲ್ಲ, ರಿಟೇನ್.
ರಿಟೇನ್
ಹೌದು.
45.15
Please, dispose of as per annexure D.
Yes. 45.16 Venkatesh Karvi.
Retain. ಅದರಲ್ಲಿ ಕ್ವಶನ್ ಇದೆ.
ರಿಟೈನ್
ಇಟ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ. ದಟ್ ಇಸ್ ರಿಟೇನ್ ಇಟ್ my lords.
ಈಗ ಸರ್ಕಲ್ ಮಾಡ್ರಿ, ಇದೆಲ್ಲ ಸರ್ಕಲ್ ಮಾಡಿರೋದೆಲ್ಲ ಬರ್ಕೊಂಡು ಉಳಿದಿದ್ದು ಮಾಡಿ.
My lord, may I submit one thing? My lord, for bank, my lord, I am appearing, my lord.
In which matters? All the bank.
In all the cases, my lord, rule 13D is complied, my lord.
ಅದೊಂದು ಸೆಂಟೆನ್ಸ್ ಹಾಕ್ಬೇಕಾ? The learned counsel for the Vishwanath Hegde appearing for the respondent bank, ಯಾವ್ಯಾವ ಕೇಸಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ವಿ. would submit that in all these cases, Rule 13D has been complied. The submission is placed on record. However, it is always open to urge all these grounds before the authority.
Please. Your Lordship, may I make my submission? I could not make submissions because the online list and the physical list are varying. Writ petition 107803. In the online list, it is 45.3. Joshi Shri Prasad Jaitirth, I appear in that matter. So that is covered by your Lordship's judgment regarding 3 votes by a single delegate.
Which is that?
107803.
1078?
03, your Lordship.
No.
14. That is,
No, no, my
that
lord,
I have not disposed.
No. 14 has to be retained, my lord.
It is retained.
It is retained, yes.
Lord 15, my lord, it is your Lordship's judgment.
15, yes. 15, ನನ್ನ ನೋಡ್ರಾ ಯಾವುದು?
ಅದೇ 3 continuously 3 votes, my lord. 3 meetings, my lord.
ಅದು my lord, that facts again has to be retained, my lord.
ನೀವಿದ್ದೀರಾ ಅದರಲ್ಲಿ?
ಅಲ್ಲ ಇಲ್ಲ, but ಅದನ್ನ ನೋಡಿ.
ನೀವಿದ್ದೀರಾ ಅದರಲ್ಲಿ?
No, my lord.
ಮೇಲಿಂದ್ರಲ್ಲಿ.
ಮೇಲಿಂದ ರಿಟೇನ್ ಆಗಿದೆ. ಕೆಳಗಿಂದ ಯಾಕೆ?
ಕೆಳಗಿಂದ್ರಲ್ಲಿ.
ನೀವಿದ್ರೆ ಹೇಳಿ.
Annexure D, my lord, I have made.
ಅದರಲ್ಲಿ ನನಗೆ ನೋಟಿಸ್.
ಪರಮಗೌಡ ವಿಶ್ವನಾಥ್ ಹೆಗಡೆ.
My lord, yes, I am only there. Notice was issued to me only, my lord.
ವಿಶ್ವನಾಥ್
He was undertaken, my lord.
I had undertaken, my lord.
GV ಪರಮಗೌಡರು.
GV ಪರಮಗೌಡರು represents.
ನೀವು ಯಾರಿಗೆ?
ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ R6.
ಅದು ರಿಟೈನ್ಡ್.
ರಿಟೈನ್ಡ್.
ಅದು ರಿಟೈನ್ಡ್. ಗುರುದಾಸ್ ಕಣ್ಣೂರ್ ಅವರು ಇಲ್ಲಿ ರಿಟೈನ್ಡ್. You can't go now.
Lordships have retained me for 2 days. And I've been detained also.
In the lighter way, sir. In the lighter way, don't mind.
Obviously. Lord, 45.
Now, ಈಗ ಉಳಿದಿರೋದು ಹೇಳಿ.
My lord, what your Lordships had said, that if an administrator is not appointed, administrator not to be appointed. My lord, we have no.
Yes.
My lord, that order, we have no quarrel with that order so long as. Now, what happens is, your Lordship passes that order on 14th, though the matter was listed on 17th. On 14th, my lord, they hold a Turtu Sabha emergency meeting where purchase committee expenses and they send one delegate also. And in that, my lord, what has happened is the old quorum is taking a decision where, my lord,
administrator is taking a decision or the
the old one. My lord, what happened was the old board came before your Lordships and said, administrator should not be appointed and we should continue. Now what?
Term ಮುಗಿದೋಗಿತ್ತಾ?
Term the elections are held. Elections are held, my lord. So it is
what ground is the interim order sought?
Beg your pardon?
On what ground is the interim order sought?
Interim order, my lord, we are not against.
ನೀವಲ್ಲ ಸರ್.
ಅವರು.
ದೇ ಆಗಿರೋದು ಯಾಕೆ?
ಅವ್ರು ಎದಕ್ಕೆ ಕೇಳ್ತಿದ್ದಾರೆ ಅಂದ್ರೆ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಬಾರ್ದು ಅಂತ. On that, my lord, an administrator, that the particular rule what they're saying, they don't read the second part of the.
One ನಿಮಿಷ ಗಾಯತ್ರಿ ಮೇಡಮ್, why are you asking?
The interim order was sought on the ground that Mullat's expiry would on 11/11 Mullat's. On that day, yes.
See, the term was yet to expire.
Yes.
Justice Nataraj Rangaswamy is held. Unless the term expires, the state has no jurisdiction to appoint an administrator for conduct of elections.
My lord,
correct.
Yes.
That is the reason why I granted.
No, my lord, that's why what your Lordships have granted, my lord, no quarrel with that. Now my lord, what happens is this. After your Lordship passes the order, now my lord, total 16 candidates are there. In the petitioners, 2 of the petitioners, my lord, their results are not declared. And the old quorum, my lord, 2 have already lost the elections. In respect of others, it's not been declared. But they have, my lord, called an emergency meeting. They are taking all policy decisions. In fact, a coordinate bench of this.
I will direct them not to take any.
Yes, that's not to give effect to that, my lord, and let the results be declared also, my lord. We have no, or your Lordship have it on any other.
11 ಆಗೋಯ್ತು. 11 ಆಗೋಗಿದೆ ಈಗ.
That's
What
one
date is
small.
today? 11th ಆಯ್ತಲ್ಲ?
This is of course with regard to municipality.
Before that,
only the
Mullat,
last line is relevant, my lord. Make clear that petitioner shall not participate in any decision involving policy and finance.
So that is correct. That I will.
That's all, my lord. Caretaker,
That's
we have
short
no
pass, sorry,
objection. We are not saying
Lordship may pass
administrator to be appointed.
Malikarjun ಬರ್ಬೇಕಾ?
Yes.
Let him
He's
come.
on his
That is
legs
the
and
order I
quotal
will
number
pass.
8. Yes.
You tell him that is the order I will pass. ಆಮೇಲೆ ಎಲ್ಲ ಖಾಲಿ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬಿಡ್ತಾರೆ.
Allah, they
Lordship may
have sent
pass
a
an
delegate
orders.
already, and then purchase committee expenses ಎಲ್ಲ ಶುರು ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. And that too, previous board, some of them have indisputably lost. They are sitting in the board.
Let's short password, my lords. Yes.
ನೀವು ಹೊರಡ್ಬೋದು. ಅವರಿದಾರಲ್ಲ.
Yes.
And that is the order I'm going to pass.
Yes.
You shall
I'll
not
just-
take any policy decision involving any finances of the society.
And any decision taken, my lord, should also not be implemented, my lord, because we have
Now,
produced.
ಈ decision ಇಲ್ಲಿ
Yes, after the order. Yes.
ಟರ್ಮ್ ಆಗೋದ್ಮೇಲೆ
I'll just seek instruction with regard to that.
Yes, fine. Pass over.
Yes, great.
Your Lordship, a matter at 45.5, even that may be, that is a simple voting.
45.5
107670.
Oh, ಅದು disposed.
My lord has disposed.
That is disposed.
Dispose ಆಗಿದೆ ಅಷ್ಟೇ.
ಎಲ್ಲ separate copy paste. ಇಲ್ಲ ಇಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಆಗಿದೆ, ಟ್ಯಾಗ್ ಆಗಿದೆ, ಮತ್ತೆ ಯಾಕೆ ಒಂದೇ ಮಾಡಿ. Yes, next.
46. Ready, Nada?
What is this?
Mobile seizure case, my lords.
Sir, mobile. Kindly see the order sheet set.
Lords, Justice Suraj Govindara sir has framed some guidelines with respect to seizure and etc. But there is no time framework, my lords. So I am just WP number 11759. It is 115 pages, my lords.
ಹೌದಾ?
ಹೌದು
ಇಲ್ಲಿದ?
ಬೆಂಗಳೂರು ಇದೆ ಸರ್. ಬಟ್ ಅದರಲ್ಲಿ ಟೈಮ್ ಫ್ರೇಮ್ ಸ್ಟಿಪ್ಯುಲೇಟ್
ಆಗಿದೆ.
2020 ಇದೆ ಸರ್. 21 ದಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ. ವೀರೇಂದ್ರ ಖನ್ನಾ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್.
ಅಯ್ಯೋ, ವೀರೇಂದ್ರ ಖನ್ನಾದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರಿವರ್ಸ್ ಮಾಡಿದೆ.
ಪೆಂಡಿಂಗ್ ಇದೆ ಸರ್ ಕನ್ಸಿಡರೇಷನ್ ಅಲ್ಲಿ
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಹೌದು ಸರ್.
ವೀರೇಂದ್ರ ಖನ್ನಾ is
page number 12 of the petition. Please.
However, sir, time frame is not stipulated.
It's in the Supreme Court, sir. Yes. I guess it is the reverse also. Just check.
ಇದು ಪೆಂಡಿಂಗ್ ಇದೆ ಸರ್. ಆಕ್ಚುಲಿ ಅದು ಕನ್ಸಿಡರ್ ಆಗಿಲ್ಲ. My grievance is at page 12.
The matter, sir.
This is for, he has filed application for release of the mobile phone. That the mobile was sent for RFSL. The order passed by the learned trial court shows that
It is only after it is returned back from RFSL.
Yes, ma'am.
Yes.
If it comes, we will give back.
FSL ಹೋಗ್ಲಿ ಬಿಡಿ, ಯಾಕೆ?
FSL ಹೋಗಿದೆ.
ಆಗಿದೆ, ಕ್ರೈಮ್ ಆಗಿದೆ ಸರ್. But my concern is, sir, that is the only mobile phone which I have for my personal use. And since June.
One more, sir.
No, sir, I cannot afford to, sir.
Cannot
Since
afford,
June, sir, that is another aspect, sir.
What is the allegation against you?
My lords may remember illegal custody of a person for 13 hours. Instagram influencer. Yes, it is his case only, sir.
What happened to that case?
That is pending for 21st.
Number ಕೊಡಿ. ಅದಿರ್ಲಿ, anyway.
ಅದರ ಜೊತೆ ಇನ್ನೊಂದು ಕೇಸ್ ಕನೆಕ್ಟ್ ಆಗಿದೆ ಸರ್. This is two different aspects. So,
but
grievances, my lords.
Crime ಆದ್ಮೇಲೆ crime register ಆಗಿದೆ.
Crime ಆಗಿದೆ.
Crime register
I'm not
ಆಗಿದೆ.
saying that it is not so.
Mobile was sent
But
for
my concern is,
RFSL.
ಮೇಲೆ ಕೊಡೋದು.
If they
How can I
take
direct
it,
FSL ಮಾಡ್ದೇನೆ ಕೊಡಕ್ಕೆ?
My lords, 4 months, 5 months, if they are taking in such a manner.
We'll direct the FSL to examine it early and finish it.
It is not.
We can't direct the phone to be returned to you.
No, I'm not seeking. Even my prayer is to send the mobile phone to the concerned court so that I can release from there. Apart from this, my lords, my humble submission is, if this RFSL is taking mobile phones or any article for the purpose of investigation for months and months and months, and that's the only article if I am about to use, then I cannot use those articles for long pendency. And that is what, there comes my grievance, my lords. I'm seeking a time frame. If we made so, then it will help.
ಏನು ಅಲಿಗೇಷನ್ ಮೇಲೆ?
ಅದು ಒಂದು ವಿಡಿಯೋ ಮಾಡಿದ್ದೆ ಮೈ ಲಾರ್ಡ್ಸ್ ನಾನು. ಅದು ಅದರಲ್ಲಿ ಇಲ್ಲಿಗಲ್ ಕಸ್ಟಡಿ ಕೇಸಲ್ಲಿ ಇದೆ ಮೈ ಲಾರ್ಡ್ಸ್.
ಏನ್ ವಿಡಿಯೋ?
That I have referred to. When the Chhawa movie was released.
Which movie?
Chhawa.
Oh.
Other related ಇದೆ my lords. So I have made one video with respect to maintaining the harmony in this society.
Maintaining the harmony.
And Police Commissioner of Belagavi has also given statement. Referring to that, yes, to maintain the harmony. And referring to that statement, I have made a video. And to that video, they lodged a complaint against me. It took me for 13 hours illegal custody.
ಈ ವಿಡಿಯೋ
ಅದೇ ಕೇಸ್
page 15 ಅಲ್ಲಿ ಕಾಲಮ್ 10 ಅಲ್ಲಿ ಇರೋದು is the allegation.
Yes, sir.
ಸುಮ್ಮನೆ ಇರಕ್ಕಾಗಲ್ವಾ?
Sir, ಇದೇ ವಿಡಿಯೋ ಬಗ್ಗೆ ಇದೆ.
Can't keep quiet, is it?
Sorry, sir.
We can't keep quiet. Why do you generate disharmony every time?
Sir, there is nothing in the video. If Lordship peruses it, there is nothing in the video. which, I'm involved into creating the disharmony.
Creativity ಇದೆಯಾ ಅದರಲ್ಲಿ? Creativity ಇದೆಯಾ?
Just I have sent a message to maintain the decorum, my lords, in the society, Belgaum. Because some other elements have issued some other video.
We should all encourage restraint. Why all this? One person creating disharmony and everything flaring up. Why? Necessary.
Lords, he has made a video.
Why is it
to
necessary?
maintain the decorum, my lords. Some other persons have made the video which has discouraged and created the disharmony.
All right. Iga, let's not get into this religious
Yes,
overtones here. This,
My lords, the article was sent for RFSL.
when was it sent?
My lords, immediately after my lords, the seizure, it was sent.
This report is at last page, my lords, at
And,
page 20.
When is that?
Page 19, 22 March 2025.
ಓ ಏನ್ 6 ತಿಂಗಳಿಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Release immediately
ಏನ್ ಬೇಕಾದ್ ತಗೊಳ್ಳಿ, ಅಲ್ಲಿರೋದನ್ನ ನೋಡ್ಕೊಂಡು ಕೂತ್ಕೋಬೇಕಾಗಿಲ್ಲ.
As expeditiously we will
The
do.
petitioner is before this court seeking the following prayer. Pursuant to registration of the petitioner gets embroiled in a crime for offence punishable under section 153A alva? 153A.
Yes, sir.
For offence punishable under section 192 of the BNS 2023, which is 153A of the earlier regime, the IPC. The issue in the list is not with regard to the merit of the matter. Pursuant to the registration of the crime, it transpires that the instrument, the mobile phone that was used by the petitioner, is seized and is sent for sent for examination to the FSL. The petitioner claims that the petitioner approaches the concerned court and files an application for return of the mobile phone, which is declined on the score that it would be returned only after it is returned from the RFSL. The counsel is therefore before this court. The learned counsel submits 6 months ago his mobile was taken and he has no means to buy another phone for his usage and is now without a mobile phone. Adella sullu bidi. Mobile phone illa yaru irtare nodi. Without a mobile phone. Therefore, he seeks a direction in the hands of this court for release of the mobile phone from the hands of the respondent. The learned AGA submits at the moment it is released, they returned from the FSL laboratory, it would be handed over to the petitioner in accordance with law. In the light of the said submission, it is necessary to observe that the mobile phones that are seized cannot be kept with the FSL for a long time. 6 months have lapsed by. Therefore, the state shall see to that the FSL finishes its examination of the mobile phone and is placed before the concerned court within 6 weeks from the date of receipt of the copy of this order, if not earlier. Yes. It is open to the petitioner to file necessary application before the concerned court for release of the mobile phone once it is released.
Application is already on
application.
It is already on.
If not already filed. Ordered accordingly.
Please, preparing for the learned counsel.
Cholamandalam.
Please.
Senior
my lord, please.
For petitioner.
Petitioner. Please, my lord. The only relief is, my lord,
mostly 1 crore 2 crore ಇರುತ್ತೆ ಇದರಲ್ಲಿ.
2 crore.
ಮತ್ತೆ ಸೀನಿಯರ್ ಬಂದಿದ್ದಾರೆ ಅಂದ್ಮೇಲೆ ಅಷ್ಟಾರು. Yes, sir.
My lord, only prayer is, my lord, is ready to pay. He was operating a bar and bar license, my lord, a liquor shop. There was huge license. 7 ಇದು. ಆಗ ಅವರೊಳಗೆ ಲಾಸ್ ಆಯ್ತು ಅಂತ ಕಟ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದಾರೆ, ಟೈಮ್ ಬೇಕು ಅಂತ ಅಷ್ಟೇ. That's all, my lord.
You are the first person who is telling CL7 ಅಲ್ಲಿ ಲಾಸ್ ಆಗಿದೆ ಅಂತ.
ಆಗ ಅದು ಲಾಸ್ ಆಗಿದೆ. Actually, at that time, my lord, he obtained the loan and that loan was for the business improvement, my lord.
Sir, CL7 ಅಲ್ಲಿ ಲಾಸ್ ಆಗಿದೆಯಾ?
ಹೌದು. Because, my lord, he wanted to improve it, extend it, my lord, invested for extension. That much of business did not come immediately. That's all. Now they have locked it. Now he has obtained ready to
CL7 loss.
My lord, the only thing is for a restaurant connected with that, my lord, he obtained a loan and invested for the restaurant. That much of business did not come for restaurant section, my lords. For the other section, regular business was there. There he could not repay it immediately, my lords. My prayer is, my lord, is ready to repay it. Kindly give us some time, my lords. Your lords may kindly put us to terms. Now what they have done is they have seized it, my lords. This is the problem. As far as the liquor is concerned, I am required to, my lord, sell as per their stipulations, my lords. I undertake to repay complete amount, my lords. Only thing is, my lords,
A reasonable time is required, my lord. That's all the humble prayer before my lord.
ಅಲ್ಲ ಈಗ ರೀಸನಬಲ್ ಟೈಮ್ ನಿಮ್ಗೆ ಓಪನ್ ಮಾಡಕ್ ಬಿಟ್ರೆ ಅದು ಮರ್ತೋಗ್ಬಿಡುತ್ತೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ ನಾವು one portion
ಲಿಕರ್ ಸ್ಟೋರ್ ಓಪನ್ ಮಾಡಕ್ ಬಿಟ್ಮೇಲೆ ಲೋನ್ ಕೊಡ್ಬೇಕು ಅಂತ ಮರ್ತೋಗ್ಬಿಡುತ್ತೆ.
No, my lord. So now we undertake it within time limits fixed by
Both of them don't go hand in hand, liquor and loan.
This case, because of my lords, the undertaking given by the honorable court, my lord, it's a reminder, my lords. Always you will be conscious of the undertaking, my lords.
So ಏನ್ liquor ಇದ್ರೂ ಕಾನ್ಶಿಯಸ್ನೆಸ್ ಇರುತ್ತೆ.
Please, my lords, because the undertaking under the court, my lords.
Yes, sir. Respondent ಯಾರು ಇಲ್ವಲ್ಲ, ಎಷ್ಟು ಏನಿದು?
No, my lord, the total loan liability, my lord, as per page.
Total ಅಲ್ಲ, what is the outstanding, sir?
ಈಗ 2 ಕೋಟಿ 2 crores, my lords, 82 crores 56 lakhs.
ಆಯ್ತು, ಈಗ ಎಷ್ಟು ಕೋಟಿ ಕಟ್ತೀರಾ?
No, my lord, we will deposit, my lords, within a month 25%, my lord. Then your lords may kindly give us the reasonable time.
No percentage, sir. 2 weeks 50 lakhs, 2 weeks 50 lakhs.
Would your lords be kind enough to extend the time little more, my lords? We will deposit, my lords, because he is arranging for the funds, my lords.
2 weeks 50 lakhs, 2 weeks 50 lakhs. The petitioner is before this court calling in question a possession notice issued by the respondent bank. In the normal circumstance, this court would not entertain a petition and drive the petitioner to relegate the petitioner to the DRT as is held by the apex court in plethora of cases. The petition is entertained on the score that the Learned Senior Council undertakes that in the next 4 weeks, 1 crore would be deposited to the bank. Deposit to the bank to give one opportunity to the petitioner to show bona fides. I deem it appropriate to stall all further proceedings pursuant to the possession notice till the next date of hearing, subject to the condition that the petitioner would pay deposit 50 lakhs on or before the 30th of November 2025 and 50 lakhs on or before the 15th of December 2025. In the event the first installment is not deposited, the petition interim order would stand automatic. Not only the interim order would stand vacated, but the petition would run the risk of getting it dismissed.
Please, may I humbly pray, my lords, as far as the position of the liquor shop is a running establishment, my lords. Some
stay ಮಾಡಿದಿನಲ್ಲ ಈಗ.
My lords, they have taken position notes ಕೊಟ್ಟು ಇದು ಮಾಡಿದ್ದಾರೆ, position ತಗೊಂಡವ್ರೆ ಅವರು, ಲಾಕ್ ಮಾಡಿ ಹೋಗಿದ್ದಾರೆ.
The moment the petitioner deposits 50 lakhs with the bank, the possession shall be restored in favor of the petitioner, which however shall remain subject to the result of the payment of other 50 lakhs.
Please.
ನೀವು ನಾಳೆ 50 ಕೊಟ್ರೆ ನಾಳೆ ಪೊಸೆಷನ್.
ಅಷ್ಟು ಬೇಗ ಈಗ ಲಿಕ್ಕರ್ನವರಿಗೆ ಮಾಡೋದು
ಈಗ ಲಿಕ್ಕರ್ ಓಪನ್ ಮಾಡ್ಬೇಕಲ್ಲ, ನಾಳೆ ಬೆಳಗ್ಗೆನೆ ಕೊಡ್ತೀರಾ?
ಓಪನ್ ಮಾಡಿದ್ಮೇಲೆ ಹಣ ಬಂದ್ಬಿಡ್ತು ಸ್ವಾಮಿ. Please, I am greatly obliged.
Petitioner to serve on the council or serve on any panel council representing the respondent bank or take out hand summons. Yes, next.
Please.
No.48.
Please, ma'am. Lord, petitioners have challenged the constitutional validity of Karnataka Act number 73.
Would be needed. Yes.
Learned AG will appear also.
The amendment to the Cooperative Status Act, my lord.
Learned AGA is directed to accept notice for the respondents. Since the constitutional validity of certain provisions of the Cooperative Societies Amendment Act 2025 is called in question, objections of the state is imperative. Objections, if any, by the next date, list the matter on 13th December.
Little earlier, my lord. Because
constitutional validity.
Amendment to section 2, they are expanding the definition of assisted society so that now.
Correct, we'll see.
Even if a member receives any subsidy from the government, society becomes assisted society.
13th December.
Please.
Objections, if any, by then. 12th December. One dina munde. 12th December. Yes.
Bill number 50, Edinada.
Well, item 49, my lord.
49? ಯಾರು ತಗೊಂಡ್ರು? ಯಾವಾಗ ಕೊಟ್ರಿ? ಯಾವತ್ತು ಕೊಟ್ರಿ? 24? ಮಂಡೇ. CB ಅಂಗಡಿನ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ ಮಂಡೇಗೆ.
Monday I'll be full.
24. Yes.
I'm great.
Next.
Seal number 50.
Janam se pyar. Yes, sir.
Yesterday I submitted all the records, my lord. With respect to only missing complaint that I have submitted, my lord.
ಮದ್ವೆ ಯಾವತ್ತು?
In that case, they are investigating.
21 ನವೆಂಬರ್.
ಎಲ್ಲಿದೆ ಇನ್ವಿಟೇಷನ್?
ಆರ್ಡರ್ಗೆ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೆ.
ಇನ್ವಿಟೇಷನ್ಗೂ ನಾನೇ ಆರ್ಡರ್ ಕೊಡ್ಬೇಕಾ?
ಅದು ನಾನು ತಂದ್ಬಿಡ್ತೀನಿ ಸರ್.
ಹಾ?
ಆರ್ಡರ್ ಕನ್ಫರ್ಮೇಶನ್ ಆದ್ರೆ ಅಂದ್ರೆ ಮುಹೂರ್ತ ಫಿಕ್ಸ್ ಆಗಿಬಿಟ್ರೆ ತಗೊಂಡ್ಬರ್ಬೇಕು ಅಂತ.
ಆಯ್ತು. ಒಂದ್ ಸೆಕ್. I'll pass an order.
Please, sir.
Pass.
51. Sadiq in Gudwala, Jay Shetty.
Lord, some.
Number 181.
Intermodal ಇದೆಯಲ್ಲ?
ಇದೆ.
Yes. ನೋಡಿ 181 reach ಅದಲ್ಲ. That's yes.
Can you have it on Monday, my lord?
Monday ತಗೋಬೋದಲ್ಲ? Monday or Tuesday.
Along with serial number 181.
Tag the petition along with 181, list the matter on Tuesday. Interim order subsisting will continue to the next week. Next.
52 is SM Mamdapur.
I beg to appear for petitioner. I'm seeking fresh investigation in crime 46. It's coming up for first time.
We take notice for the state.
What's the prayer?
Fresh investigation in crime 46. De novo investigation. What happened?
Why?
The petitioner's son, that is the deceased Kumar Gowda Patil Millets, admittedly is a PWD engineer working in Ramdurg Millets. On 13/5/2024, while going on an inspection to the one particular site Millets in Oblapur main road, he was found dead Millets. My lords may kindly see page 70 Millets, that is the photos of the.
ಆಯ್ತು, ಈಗೇನ್ ಕ್ರೈಮ್ ಕ್ಲೋಸ್ ಮಾಡಿದ್ದೀರಾ? ನನ್ನ UDR ಮಾಡಿದ್ದೀರಾ?
They have under 279 and 304 AMLs.
302 ಬೇಕಾಗಿತ್ತಾ?
No, there is no the single bike only Malats on the road. None of the witnesses were present, and the page number
279 304 ಹೆಂಗೆ?
Skid Millers, kindly see complaint at Millers.
Skid ಆಗಿದೆಯಾ?
The blood samples were sent for the FSL after 26 days delay.
Complaint heading page 27.
This was got to the notice of the IO also, Millers, that the blood samples had to be sent immediately.
He is directed to accept notice for the respondent to go through the papers and make his submissions. All the respondents go through the papers and make his submissions on the next date. List on 2nd December. Next.
Obliged, Millers.
53.
53, I appear for the petitioner, Lord. This is yesterday's matter. Lord, in the morning, Lord, we had made a mention to have the matter tomorrow, my Lord. We'll appear physically before my Lords, my Lord. We have some objections to the impleading application as well as some documents to file.
No, impleading application, what objections can you have? He has been a party throughout in all the litigations.
That is not connected to this. I mean, they want to make it seem that there is some connection, but this is not connected to the earlier litigations. I'll point out not how.
At my base, the entire litigation started from 2020.
Oh, if they are implementing 4/1/2025, 4/1/2025 was generated because of his petition.
Lord, they are not seeking to implement 4/1/25 at all. In the guise of implementing 4/1/25, Lord, they want to stop operations which are not covered under 4/1/25. That is the only submission. We will appear tomorrow, Lord, and physically make submission. Lordship, I kindly have it tomorrow.
Well, what is going to happen in one day, my lords? We are just requesting for one day so that we physically come there.
Will grant.
I request for 27th, my lords.
But my undertaking,
He has given undertaking.
My lords may only demonstrate with two points, my lord.
What undertaking, my lords? Let them not be permitted to make submissions, my lord. We have objections to their making submissions in the first place. Kindly take a look at their impleading application, my lord. Look at how generically it is worded. How are they? It is between me and the state. Let the state argue their case.
State will answer.
My lord, all these points have been made before the honorable division bench. Now the order has been reserved.
No. Before the division bench, both of you are parties?
Yes, my lords. We are the parties. My lords,
On their locus, we have made submissions on their locus. My lords, these people are coming here and saying.
Before the division bench, locus is raised?
Yes. We have raised the issue of locus specifically. My lords, these people before your good self are trying to implement the Kane Commissioner's order. I mean, that's what the submissions are. There, they submitted for months saying that the Kane Commissioner does not have jurisdiction. We will point out all those documents, just one day, my lords.
No problem, tomorrow, yes.
Grateful, grateful.
Let's tomorrow.
The undertaking may continue.
My lord, let them not precipitate. My lords had given us the protection. Let them not precipitate, just.
Yes.
Undertaker.
Yes.
Grateful.
ಏನ್ ನಾಳೆ ಕ್ಲೋಸ್ ಮಾಡಬೇಡಿ ಅಂತ ಅಷ್ಟೇ, ಬೇರೆ ಏನಿಲ್ಲ. ನೀವು ಕ್ಲೋಸ್ ಮಾಡಿಸ್ತಾ ಇದ್ದೀರಾ ಇದನ್ನ?
Close ಮಾಡಿಸ್ತಾ ಇದ್ದಾರೆ. That is what we have challenged before, my lords.
Today, the closure order happened on 21/10/2023. My lords, from 21/10/2023.
My lords, let them wait till their impleading application, till my lords take a decision on that. Grateful, grateful.
Objections to the IAU file today itself.
We will try, my lords.
The objection ready ಇದೆಯಾ?
ಇಲ್ಲ, ಮೆಮೊ ಇದೆ consisting of all the
AGA, sorry, learned additional advocate general, sorry. Additional advocate general files his memo along with documents. Copy. Along with documents, the same is taken on record. Please. Adano go through those things also and make submission.
My lords, if they can send a soft copy to us, my lords, it will be grateful.
that also.
The learned additional advocate general undertakes that the soft copy would be furnished to the petitioners.
Please.
Grateful, grateful.
Bill number 54, MB Hireman.
ಇಲ್ಲ, ಈಗ ತೊಗೊಳ್ಳಿ 230 ಯಾವ್ದೋ ಮ್ಯಾಟರ್ಗಳಿದ್ವಾ ಕರೀರಿ.
Short
230 ಮ್ಯಾಟರ್ಗಳಿದಾವೆ ತಗೊಂಡ್ಬಿಡಿ.
Yes.
Number 192, Martin.
Giving a phone number to this matter.
ಏನಿದೆ ವಿಜಯ್ ಕುಮಾರ್?
Earlier, he has withdrawn the writ petition. Subsequently, after 11 months, he has filed a fresh writ petition. Meantime, he has given the charge. He has taken a charge in a
Transfer
different
matter.
Transfer alla. Termination order he has challenged.
Termination. Last time it was heard, Your Lordship, and order was also
Please to
passed,
direct
but
the DC to
subsequently-
file affidavit.
Affidavit ಹಾಕಿದ್ದೀರಾ?
Please, Your Lordship, I have filed affidavit. On the same day, Your Lordship, two orders were passed, Your Lordship. One is relieving order and one more is another person is hand charge.
Earlier writ petition ಯಾವುದು?
Yes, yes.
WP Millards 103730.
Where is that order?
Millards annexure
H.
Millards.
Page 71, my lords. Lord, may I? I'm representing reform number 2 in this matter. Two orders are passed. 29th.
No, one is termination, one is relieving ಅನ್ಸುತ್ತೆ.
In charge already. Because that post has to be, Lord.
All right.
This matter required consideration. May I seek on Monday, Millards, here having some personal inconvenience.
ಈಗ ಸ್ಟೇ ಇದೆಯಾ ಇದ್ರಲ್ಲಿ?
Stay there. I mean, it's reinstate by virtue.
Lord, he discharging the executive post where we cannot continue in a.
By virtue of this honorable court's order, Millards have been reinstated into those. But Monday,
Without
Millards.
making me a party to the proceedings, he has obtained the interim order.
Who are you?
I have taken the
Person,
charge
Millards.
as per the order of the.
Impugned order, he
You are
person.
the person who is in charge.
Yes, Your
ಇವ್ರು
Lordship.
ಯಾರು?
Vote he has joined. The petitioner has joined at the Mysore.
ನಾಳೆ
Monday, Millards. Alone, on Monday, Millards. Personal
Taken a
inconvenience.
sufficient time. You are also last.
I'm not requesting Millards. I'm not requesting Millards.
To make submission. They come all the way from Bangalore, so this week. It's not right.
ಬೆಳಗ್ಗೆ ಯಾವುದಕ್ಕೂ ಬಂದ್ರಲ್ಲ?
Some material before you.
Copy, sir. Go through and make on submission.
All the way from Bangalore ನಡ್ಕೊಂಡ್ ಬಂದಂಗೆ ಹೇಳ್ಬೇಡಿ.
ಇಲ್ಲ. Personally, this matter, Lord, would have come, Lord. Kindly come to page 45. Lord. This is the
ನನ್ನ ಆರ್ಡರ್ ಚೇಂಜ್ ಇದೆ.
house.
ಹಾ.
Disproportionate of assets, Lord. Lord, the raid has taken place in the year 2023.
That is
But the
different issue,
investigation
Milord,
is
not
still going on. Lord, where therefore, Lord, he had.
ನಿರ್ಮಿತಿ ಕೇಂದ್ರ ಅದ?
Yes, please.
Howdu?
Not related to this particular issue,
Lord, he
Milord.
is
That's a
continuing
different issue,
in
Milord.
the same place.
In view of this
In view of
interim
the
order.
Interim orders coming after 11 months, Lord. After 11 months, he has got an interim order, and on the basis of interim order, Lord, he is continued in the post of project director.
What I am supposed
ಪ್ರಾಜೆಕ್ಟ್ ಡೈರೆಕ್ಟರ್ ನಿರ್ಮಿತಿ ಕೇಂದ್ರ.
Yes, please.
Howdu?
Milord.
It is a temporary
ಟರ್ಮಿನೇಷನ್
post, Lord.
ಆಗಿದ್ದು ಯಾವತ್ತು ಸರ್?
Milords, on two dates, Milord, 29/6/2024.
2024.
Please.
ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿರೋದು ಯಾವತ್ತು ಸರ್?
The first
July
it
2025.
first it is on 2/7/2024.
27?
2024, first writ petition.
What happened to that petition?
That one withdrawn, my lord, without liberty, my lord. That is what your lordship for please to direct the other side on the government.
Where
to
is
file.
that?
Lords,
71.
Page 72, my
Page?
lord. 72.
I'll clarify to that order.
One nimsham.
72, my lord, this honorable court, please to permit me to withdraw the order, my lord.
1 minute.
Please.
ನೀವೇ ಹಾಕಿದ್ದಾ?
ಹೌದು,
Please.
ಇಲ್ಲ ಬೇರೆಯವರು.
ಅಲ್ಲ ಪಾರ್ಟಿ ಇವ್ರೆ.
ಅಲ್ಲ ಪಾರ್ಟಿ ಸೇಮ್.
ಅಲ್ಲಿ ಇವ್ರು ಅದು.
ಕೌನ್ಸಿಲ್ ಬೇರೆ.
ಹಾ. Then second petition.
My lords, by before this honorable court, my lords, on 27/2025.
No, why second petition?
For the reason that, my lord, it was given an impression that, my lord, he will be, my lord, placed on the same place. Due to political pressure, my lord, there is some.
ನಿಮಗೆ ಯಾವ political pressure ಬೇಕು sir? You are under pressure already.
It is admitted that, my lord, there was a political pressure.
ಅದೇ ಇವರೇ ಅಂತ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಸರ್.
My request, my lord, on Monday, my lord,
ಯಾರು ಹೇಳ್ಬೇಕಲ್ಲ ಮತ್ತೆ.
I have taken the charge.
It was a glorified project director ಇವರು.
Yes.
Monday, my lord, sir.
He cannot
Monday.
in an executive post. That's what my submission is. And
How
not
are you
I have
continuing
placed the
in the
material
same
to show.
post? ಅದನ್ನು ಹಾಕ್ಸ್ಕೊಂಡಿದ್ದೀರಾ?
By virtue of this honorable court order, my lord, I have been.
ಯಾವತ್ತಾಗಿದ್ದ ಆರ್ಡರ್ ಸರ್?
My lords, on my lords, 14/7/25.
14/7/25.
Please.
ನೀವು ಟರ್ಮಿನೇಟ್ ಆಗಿದ್ದು ಯಾವಾಗ ಸರ್?
Initially, my lords, on 29/6/24. ಅದಾದ್ಮೇಲೆ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಅವಾಗ ರೀಇನ್ಸ್ಟೇಟ್ ಆದೆ. ತದನಂತರ
ಯಾವ ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಆಗಿದ್ದು?
ಅವಾಗ ಫಸ್ಟ್ ರೇಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ
ಮೈ ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಆಗಿದೆ.
ಇಲ್ಲ. On 3/7/2024 ಅಲ್ಲಿ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಆಗಿತ್ತು ಮತ್ತೆ ಫಸ್ಟ್ ರೇಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ. ಆ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಪ್ರಕಾರ I have joined again. Then I have withdrawn the same, my lord, by impression that, my lord, he will be protected, and then due to political pressure, my lord, this all things happen, my lord.
ಹೇಳಿದ್ನಲ್ಲ ಪ್ರೆಷರೇ ಬೇಕಾಗಿಲ್ಲ.
That's what, my lord, I am submitting, my lord, required consideration on Monday, your lordship, please to.
ಯಾವಾಗ
32 ಮೆಕ್ಯಾನಿಕ್.
ಈಗ ಯಾರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರೆ ಇನ್ಚಾರ್ಜ್ ಆಗಿ?
Impleading applicant.
Applicant who has come on application.
And without making me a party.
ಎಲ್ಲ ಪ್ರಾಜೆಕ್ಟ್ ನೀವೇ ತಗೊಂಡ್ಬಿಟ್ರೆ ಅವ್ರಿಗೆ ಬೇಡವಾ?
On Monday, my lord, I have thought.
He was not reinstated. Lord, kindly come to page 32, the memo which I have submitted, my lord. Lord, he has come and reported to the Karnik, second respondent here in Lord. And we have given him posting of deputy director. He comes and report to the post. Thereafter, Lord, he remained unauthorized absent.
ಆಮೇಲೆ ಬಂದು ಇಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ.
He files writ petition here. And the on the basis of interim order, my lord, he is forcefully has taken the charge of the post at Bagalkota, my lord, as project director, without, my lord, following the due process, my lord. Handing over and taking charge.
Should be dismissed with cause. And I am going to do it with cause.
My kind request to your lordship, my lord. My lord, tomorrow,
Monday. Yes, Patil illi.
So personal inconvenience father.
Ellidare?
Father garam Bangalore. Please. So, my lord, I am requesting again and again. Monday, my lord.
Permitted to appear through video conference.
You come, sir.
Please.
Monday.
ನೀವೇನು ಇರೋದು ಬೇಕಾಗಿಲ್ಲ ಇನ್ನು.
Please. Grateful.
He has a Herculean task now.
Tomorrow in fresh roads, fresh order.
Fresh ಆಗಿ ತಗೊಂಡ್ಬಿಡು.
ಅದಕ್ಕೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೇನೆ.
Monday, my lords.
List the matter on Monday in the fresh matters list.
Interim order subsisting.
That memo may be taken on record.
The Learned Counsel Vijay Kumar appearing for Bagalkot.
Respond number 2.
Respond number 2 files a memo along with documents. The same is taken on record. ನನಗೆ ಒಂದು ಆರ್ಡರ್ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ರೆ ಸಾಕಾಗ್ತಾ ಇತ್ತು. ಬಿಕಾಸ್ ನಿಮ್ ಗುಣಗಾನ ತುಂಬಾ ಮಾಡಿದೀವಿ ಇದರಲ್ಲಿ. Yes.
Grateful.
ಹಾಕಿದ್ದೀರಾ?
PCI filed affidavit.
Learned HGP submits the deputy commissioner has filed his ಇನ್ನೊಂದ್ರಲ್ಲಿ ಯಾವ್ದೋ ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ ಹೇಳಿದ್ನಲ್ಲ ಅದು ನಾಳೆ. He submits that the affidavit of the deputy commissioner is on record, is placed on record. The same is accepted. Interim order subsisting. Patil ಹೇಳಿ.
Please.
ರೆಡಿ ಆಗಿರಲಿ ಮಂಡೇಗೆ.
194.
Please, Lordship, in this case, on last date of hearing, our argument was completed, Lordship. They were directed to produce the.
Yes. But the original records are available.
So I am appearing for the petitioner. On the last occasion, we concluded our argument. The state was.
Yes, you concluded. State was too, sir. Yes.
Yeah, exactly.
But, the state of Karnataka registered this temple and declared as a endowment temple under section 23B. That was been questioned in these repetitions. The specific question was asked to the state is that on what basis you have declared this temple as an endowment temple, madam? The state in earlier affidavit,
A lucrative temple.
Yes. But to answer before this answering my lord's question about specific about the registration and all those things,
Why have you not taken over the temple?
So, one second. Therefore, my lord, I request this honorable court, kindly take my written submission. Within 5 minutes, I will answer that question, my lord. Why, when it has been registered, what are the documents which has been registered? Written submission, the 27/10/2025. Lord, before that, my lord,
But I did not find anything in the register last time when so it was specifically pointed out that there is no procedure in accordance with law.
Please, that judgment, I also distinguish the judgment, my lord, which we relayed by Lord Senior Counsel. Before that, my lord, this small note also, my lord, about the 4 details about the 4 cases, my lord.
Yeah, your mela.
No, total 4 writ petitions are pending. These are the 5 writ petitions are pending. The gist of this. All these cases, they have questioned the value. Basically, they have questioned the notification
So
itself.
is it not, all these are not listed today?
All are listed today.
All are listed.
Today. That is only just the synopsis. Before that, I request this honorable court the written submission. Only 5 minutes. I will go through that. Then I will make. About this location of this temple. This is a temple was constructed by the then king of Vijayanagara, that is Krishna Deva Raya. This is a temple believed to be constructed by the Krishna Deva Raya. How those? This is a temple, location of the temple, this is a temple is the temple is located in Gangavati Taluka, that is a place called Anjanadri, believed to be the birthplace of the Lord Anjaneya Swami. See, this document number 2, this is a temple located at the forest land. The records of rights indicate that it is in the government land, it is a forest, reserved forest land. This is my submission. Then the next is about the history of temple. This I already said, this is a temple of anciently believed that has been constructed by the king. Then the interesting point is that all these cases, the petitioners, all 5 petitions out of 4 petitions are filed by the petitioner. One Mr. Vidyadas Babaji. These 4 petitions are filed by. First case is filed by Vidyadas Babaji. Third and 4 and 5 also by the same petition. The second petition is the filed by the trust, who is the legal heirs of the kingdoms of Vijayanagara. They have filed this writ petitions. This is very important, this aspect.
One moment, please. This second serial number 2
please.
The charitable trust go Vidyadas Babaji
Sambandha. The Vidyadas Baba was appointed by charitable trust. There is a collateral proceeding. Straight I will go to the point.
We disputed it on the last occasion.
Let I will answer this.
No, it's my question. Yes.
But I request this honorable court, there is a collateral proceedings before the trial court. The suit have been filed. I request this honorable court kindly take page 40, the OS 173 of 2008, for the movement. This is a suit filed by Tulsildas. He is claimed to be the priest of the temple. Then against the legal heirs of the kingdom, that is Raja Narasimha, the second petitioner, and the petitioner name that's in the serial number 13, page 41. He is a defendant before the trial court.
Vidyadas Babaji.
Please, my lord, the suit came to be decreed. In this suit, my lord, they have taken a specific contention. Suit is barred by the provisions of the Hindu Religious Endowment Act. And also, my lord, please, I request this honorable court. There was a findings by the trial court saying that this is an ancient temple. So this was constructed by the then king, my lord. This has been findings have been given. And I request this honorable court, page 84, my lord, is running 84, my lord. There was the additional issue was answered.
No, plaintiff is the priest anta madidru.
There is a rivalry claim.
It does not bind the plaintiff anta madidru.
This is a rivalry claim.
Who is the plaintiff?
The rivalry, another priest, my lord, rivalry priest. So in this case, my lord, the Babaji is a petitioner herein.
So what happened in the first appellate court?
Yes, my lord. First appellate court reversed the findings.
What happened before this?
Before that, my lord, before that, I request this honorable court, page 103. Ali, they have filed a written statement, page 104, David. See, Anjanadri Parvati Charitable Religious Public Trust, registered same bearing so and so, dated so and so. The temple is under the trust of legally. The suit is barred by the provisions of Hindu Religious Endowments Act. This is the contention before the trial court. Then the same page, 104, on the bottom line, please, I request this page 104. It is a case that after the death of Narayan Das in 2008, one Vidya Das is appointed the trustee to the priest of the temple, perform the puja. He was appointed in the year 2008 by the trust. Now he is claiming the ownership over the temple.
Now, what does the trust say? Our own petition.
ಅವರು ಹಾಕಿದ್ದಾರೆ, they claim that it's belonging to the trust. Trust itself is registered in the year 2008. That is in the page 104 ಅಲ್ಲಿ ತಾವು ದಯವಿಟ್ಟು ನೋಡಿ. Page 104 ಅಲ್ಲಿ. Anjanadri Parvata Charitable Public Trust was registered in the year 2008. Page 104 ಅಲ್ಲಿ some.
Yes.
See, when the people started visiting this temple, see, automatically this register came to be, the registration has come, and this trust has appointed the petitioner here. And
that is in 2008.
2008. 2008. 2008.
Now the temple is managed by the trust.
Now the temple is managed by the government. After this.
Government, allivargu temple was managed by the trust.
Before that, nobody was managing. Only the earlier some priests are performing the puja, not by the Vidyadas. It was all public servant.
Vidyadas Babji is appointed by the trust to perform puja.
Puja in the year 2008 by the second, by the.
What is the date of the impugned action?
This is an impugned action in the 24/9/2018. We registered, we declared that as the endowment temple. But it was the endowment temple, my lord, but under the notification issued under the present act only on 24/9/2008, my lord. Before that, it was an endowment temple. I will demonstrate, my lord. My lord, in the RA, my lord, the findings have been reversed. Against that, the regular second appeal is pending before this honorable court. But this honorable court, when this impugned order has been questioned, protected the interest of the petitioner to perform the puja, my lord. That he has been carried out to the till Supreme Court. Supreme Court said in terms of the interim order, permit him to perform the puja. But till today, all the actions, all the government fund development activities are to be carried out by the government of Karnataka only. I request this honorable court, madam. There are many the sanctioned plans. The amount has been released for the purpose of the trust, madam, for the development of the theft.
I am only asking. Don't go to contempt. Go to the document of declaration and law.
Before that, only 2 minutes I will complete this. I request page number, document number 15, page 218. Only I will. This is, even though it's not directly answering the question of my lord, only for my, these are these things, my lord, about the petitioners, my lord. Kindly take note of the judicial fact, my lord. These are the things.
ಅನೈತಿಕ ಚಟುವಟಿಕೆ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅರ್ಚಕರು.
Please take page 220, my lord.
ಯಾರು ಅನೈತಿಕ ಚಟುವಟಿಕೆ?
The petitioner here. Page 220, my lord.
I am on 220.
220, 221, 222. These are the incidents happened in the year 2021, 2022.
Involved in these things.
Please, madam.
Involved in these things.
Yes, madam. And FIR has been registered against the Swamiji. And madam, this is another one complaint, madam, which has been the foreigners. There are a lot of foreigners are visiting, madam. Page 215. There is the sexual harassment cases filed by the foreigners. Page 215.
Foreigners.
Foreigners ಕೊಟ್ಟಿದ್ದಾರೆ. And moreover, madam, before that, I request this honorable court kindly see. He was appointed. He was removed by the trust also. I request this honorable court kindly take page 141, my lord, document number 9. Page 141, my lord.
ಇದು ಮೆಮೊ ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಾ ಅವರು?
ಇದು ಕೊಟ್ಟಿದ್ವಿ ಅಲ್ಲಿ ಅಫಿಡವಿಟ್ ಹಾಕಿ earlier first round of litigation
ಇದೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ. This is part of the record, my lord. Earlier affidavit has been filed. This is a compilation, convenient compilation volume. I request this honorable court page 141, my lord, document number 9. The trust was removed him already. Page number 9, my lord, 141.
What has happened to all the communications? All the crimes registered?
Now the trial is going on, my lord.
ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದ್ರೆ ಎಲ್ಲದರಲ್ಲೂ?
ಎಲ್ಲದೂ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ. ಹೌದು ಆಗಿದೆ. That is an affidavit.
How many crimes are registered?
2. I request this honorable court. Yes, ma'am.
Page?
One second. Page, the affidavit, my lord, page 201. This is an earlier affidavit we have filed by the state.
All are state loads by.
All are state.
All.
ಮತ್ತೆ ಟ್ರಯಲ್ ಆಗ್ತಾ ಇದೆ ಅಂತೀರಾ?
ಅಲ್ಲ ನನಗೆ
ಸಾಹೇಬ್ರಷ್ಟೇ ಮಾಡಿ.
ಓಕೆ. Let factually I will correct. ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ. Page 201. These are the affidavit filed in the year 2022 itself, my lord.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಬರೀ ಹೋದಂಗಿದೆ.
ಅಲ್ಲ ಇದು against interim orders, they are not permitting to puja. That is why they went repeatedly. Contempts have been filed. State is objecting to perform the puja. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಒಂದು page number 141, document number 9. ದಯವಿಟ್ಟು 141, document number 9. The trust is already removed him. Page 141.
You shall not work in the capacity of
Please.
priest.
Then, my lord, document number 10 is another crucial document. Now the ancestors of the legal heirs of the kingdom, my lord, has wrote a letter to the government.
Kingdom.
Vijayanagara kingdom. Yeah. Page 142, document number 10 ali. Now they are saying, let the government manage the temple. Page 10 ali, page 142. Now the temple is under the paragraph 2. Now the temple is under the endowment government of Karnataka. Case is pending in the Honorable High Court. I express my gratitude to the Department of Endowments, Government of Karnataka, who is sparing the effort to smooth functioning of the temple. Further, I came to know that new trust is being formed by take all the control of the temple. He has formed a new trust subsequently, the Swamiji. So that is why I filed a third petition after framing the petitions. After framing the trust. So therefore, he is requested, let the government run the trust. Temple. So he admit that all the collateral proceeding.
You can run the temple only if you have declared it
I will demonstrate.
The manner known to law,
Yes,
if you have
yes,
declared, will permit.
Yes. Then this is about the other aspect. Now I will come to the important aspect of the case.
You are referring to contemporaneous documents or events.
Please.
But where is the direct document
Please,
so that you
please,
have?
please.
Adu nodide last time.
ಅದಲ್ಲ ಇದಲ್ಲ ಅದು ಬಿಟ್ಟು ಇದು ಬೇರೆ ಡಾಕ್ಯುಮೆಂಟ್.
ಬೇರೆ book.
ಇದು ಅದು ತಾಲೂಕಾ ರಿಜಿಸ್ಟ್ರಿ ಮೇಂಟೈನ್ ಮಾಡಿದ್ದು, ಇದು ರಾಯಚೂರು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಆಫೀಸ್ ಮೇಂಟೈನ್ ಮಾಡಿರ್ತಕ್ಕಂಥ ಬುಕ್ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಎಂಡೋಮೆಂಟ್ ರೆಗ್ಯುಲೇಷನ್.
ನಾವು 1942 ಇದು
1968 ಅಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಆಗ್ತದೆ.
Revenue records.
I am filing this placing through affidavit, my lord. This is the original 110, my lord.
ಯಾವುದು
Anjanadri.
ಅಲ್ಲ ಇಲ್ಲಿ serial number
110.
These papers are so fragile.
What does it say?
Anjanadri temple.
Please.
Big canal, ancient, puja, public.
Does it say that?
Next, they have also argued
ancient puja public.
This another document. It should be in terms of the regulations anta they have argued. So there is another document which indicating this units. These are the after registration they have taken action to publish in the official gazette also. This is a document. ಅದು ಮುಕ್ಬಲಿ ಆಫ್ ಎಂಡೋಮೆಂಟ್ಸ್ ಅಂತ ಇದಲ್ಲ. This register is in terms of the endowment regulation. I will demonstrate now. There is a schedule. This is in accordance to the schedule only. But next paragraph, next page ಮೇಲೆ
ಇದು ಅವಾಗಿಂದನೇ it has been an endowment property ಅಂತ ಅಂದಮೇಲೆ why had you left it
please
loose?
please yes my lord, this is a crucial question my lord. Because of the oversight my lord, it has been not done.
Oversight
ಹೌದು, ಆಗಿಲ್ಲ ಅದು ಅಷ್ಟೇ, ಅದು ಆಗಿಲ್ಲ ಅದು ಅಲ್ಲ. ದಯವಿಟ್ಟು ಪೇಸ್ಟ್ ಅದೇ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಒಂದು ನಿಮಿಷ ತಡ್ರಿ ಪ್ಲೀಸ್.
Wait sir, I'll get back to you. Senior is there, wait.
Take the document, same document. ಅದು ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಪೇಜ್ ತಾವು ನೋಡಿದ್ರಲ್ಲ, ಅದ್ರ ಬ್ಯಾಕ್ ಸೈಡ್ ಇರ್ತಕ್ಕಂಥ ಸ್ವಲ್ಪ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೋಡ್ಬಿಟ್ಟು ಆ ಫಸ್ಟ್ ಪೇಜ್ ತಗೊಂಡಿರೋ ಅದ್ರ ಹಿಂದೆ ಇರ್ತಕ್ಕಂಥ. ಸೊ ದಟ್ ವಾಸ್ ಬಿನ್ ಸಿ ದಿ ಕಾಪೀಸ್ ಆಫ್ ದೇ ಆರ್ ಫಾರ್ವರ್ಡೆಡ್ ಟು ದಿ ಫಾಲೋಯಿಂಗ್ ಅಥಾರಿಟೀಸ್. Even the endowment temple trustee compliance and all these things they have mentioned. My lord, in the first, when the affidavit was filed, the state has produced the document given by the taluk office. Now the efforts have been made, my lord. This has been after constant effort, my lord. These documents are found out at the Raichur office. My lord, these are the documents maintained by the public authorities, my lord. There is a presumption under the Indian Evidence Act, my lord.
And other than this, no direct.
My lord, this is in register maintained in terms of the endowment regulations, my lord. And I will the judgment which is relied by the learned senior counsel, kindly take the judgment.
Since when the government has taken over?
This was taken for first time. The order was came to be passed on 18/7/2018 without notifying it. Subsequently, the government realized that it is an endowment temple. So it was registered. No, it was registered before because my lord, this new act, my lord,
ಯಾವಾಗಿಂದ ನಡೆಸ್ತಾ ಇದ್ದಾರೆ
ಇದು ನಾವು ಈಗ 18/7/2018 ಇಂದನೇ ನಾವು ಆರ್ಡರ್ಸ್ ಪಾಸ್ ಆಗಿರೋದು.
Orders pass ಆಗಿರೋದು. Since when are you running the temple or still
it is temple is run by the my lord. It was On fact,
on facts, I'm asking you. Today, the government is running the temple, or this
today it is government is running
this
it.
whoever is
My lord,
performing
today,
puja is
today,
running the
today's
temple.
government is running a temple.
How?
After the notification, my lord, before that also, my lord, it was under, my lord, before that also, it was the government temple only, my lord. He was conducting puja only. After registration.
You have not appointed him, sir. Trust has appointed.
Yes, my lord. After registration, my lord, it was under the government control only, my lord. After it is declared as endowment temple under the Hyderabad regulations, the government temple only. But the corresponding government order was made under the new act in the year 2018. Before that, it was registered under the Hyderabad Endowments Act only. It is presumed to be government temple, my lord. My lord, the learned senior counsel has argued the case, relied upon the Supreme Court judgment, my lord. He pointed out that is in respect of private land. Private land,
this is forest land.
It is a forest land. The judgment which is relied by senior counsel, madam, kindly take up judgment, madam. That is 2018.
That is forest land. Let it be with. Yes.
Madam, 2018 judgment, madam.
Madam, original paper. Krishna Devaraya.
This 2018 judgment nalli, the land is blank. The temple is situated in the private land. So there was an bequeath by the father of the appellant. So therefore they disputed, without following the procedure, you are considered this as an endowment temple. So there, my lord, the land was in the name of appellant. My lord, in the present case, my lord, what is the locus standi of the petitioner, my lord? He was appointed. Can he claim the only provision under which came if he is hereditary? He has not produced any document to show that it is hereditary temple. This was a temple built in the year 16th century, my lord. So therefore, my lord, my most respectful submission, the judgment which is relied by the senior counsel is in respect of the private land where the procedure has not been followed. So therefore, Honorable Supreme Court has remanded the matter. And now, see, this is a historical temple, my lord. I also produced the document through affidavit.
Historical temple with distorted history that you have told.
Alala.
Yes.
Please, my lord. Considering this, my lord, see, the petitioner have no locus standi to question the validity of the government notification. Moreover, it is the government temple, government land.
All right.
It is the ancient public. Please.
Yes. Senior.
Yeah, may I please, your lord. My lords, the point is very simple, my lords. The question is whether it has been duly notified or not under section 23B. If it is duly notified, certain consequences would follow. If it is not duly notified, certain other consequences would follow. What we have sought before your lordship is that the notification under 23B should be struck down for two reasons. Number one, that there was no gazette notification, my lords, which should have preceded the issuance of notification under the Hyderabad Regulation Act. Now, as far as I had taken your lordship to the Hyderabad Regulation Act, Regulation 5, 6 and 7, under which, my lords, this temple ought to have been notified. The 23, the impugned order taking over the temple under 23B is on the premise that it was already a notified temple under the Hyderabad regulation. So the simple question, my lords, that has been repeatedly put to the state councillors, learned state my lords, is that whether it is a temple which has been notified and registered under the endowment, Hyderabad endowment. Now the question is, my lords, they have not even today produced the procedure to be followed, namely whether it has been duly notified. Number two things they are supposed to do. One, whether it has been duly notified under the regulation, Hyderabad regulation, namely 5, 6 and 7, which I had taken your lordship on the last occasion. Number two, my lords, whether if it is duly notified. Number two, whether it has been published in the official gazette. These are the two twin conditions, my lords, which is a sine qua non for them to issue the notification under 23B in 2018. According to me, my lord, these twin conditions have not been satisfied. They are not able to produce, my lords, first of all, the procedure adopted to be notified, namely the notification. Number two, the gazette. And number three, whether under the Hyderabad notification, my lords, it has been notified or not. Once those three, the twin tests fail, then the 23B, my lords, order also fails. Now, my lords, my submission is, your lordship may kindly see, I am depending, my lords, on one document filed by them itself that will clearly quench the issue, the total issue. Lordship may kindly look at page 72, my lords, of my writ petition.
72.
72.
Yes, sir.
This has not been denied. This is an admitted document. This is the office of the district collector, my lords, dated 2/4/2008. My lord,
Yes.
this will absolutely lay bare what the issue is and whether they have got a case or not. Now, your lordship may kindly see, this is dated 2/4/2008 from the office of the district collector to the religious endowment commissioner. My lords, I'll just read in connection with this letter would be important. In connection with the above subject matter, this is to hereby apprise that in accordance with the above reference number 1, I'm sorry, my lords. My
Yes,
lords,
yes, you can. Yes.
72 of the writ petition. In connection with the lordship got it, my lords?
Yes, yes, sir.
In connection with the above subject matter, this is hereby apprised that in accordance with the above reference number 1, it was requested to conduct an enquiry in connection with the above temple under section 42-43 of the Hindu Religious and Charitable Trust Act 97 and to send a report in this regard. The Tahsildar Gangavati was requested. In accordance with that concern, Tahsildar Gangavati conducted the spot inspection of the above and submitted a report via reference number 3 by mentioning that the said temple does not get covered under the ambit of the endowments department. This is in 2008. In 2008 itself, they are very, very clear. It is not covered under the endowments department. It is not run by them. And very importantly, the next line, as it is being a private temple, my lords, your lordship, kindly mark this. This is their own admission. As it is being a private temple, the authority to appoint any priest temple does not fall under his official duties and responsibilities. In this temple, since last 8 years, Sri Tulsi Baba, son of so-and-so, is conducting the religious rites related to the worship of the deity of the temple. But in connection with alleged irregularities being going on in the same temple, complaints have been received. This I am answering this question. Not only from tourists, but also from institutions, associations, and president so-and-so, so-and-so. And according to the complaint association, the villagers of so-and-so have requested to use the said Tulsi Baba. My lords, who is the plaintiff in that suit? He has to be ousted from his present priesthood. My lords, your lordship, kindly the complaints were against him.
Yes, yes.
It has been reported that the villagers have removed the said Tulsi Baba from the priestly duties and appointed another person as priest, due to which it has been apprehended by the Tahsildar in this report that it has aforesaid Tulsi Baba is reappointed. There may be law and order problems. Therefore, my lords, the interseed dispute is that the earlier priest was having problems. This is the government's own version, and therefore having him is a problem. But the fact remains, my lords, today, admittedly, I have been in charge of the temple as the priest. My lords, in your lordship, it's now very well settled. I'll circulate those judgments, which says, my lords, it is the temple priest or anybody, my lords, in case of a Shabbat, anybody who is interested in the temple or a devotee can maintain a petition. Today,
locus, you need not elaborate. Yes.
Very well, my lords. Very well. I am deeply obliged. Therefore, my lords, now if in 2008, as per the government's own admission, if it is a private temple, how come, my lords, in 1979, your lordship may kindly look at that, 11/6/1979, that is at page 101. How is that in 79 it could have been notified? My lords, it would continue to be a government temple right from the day
But
itself.
what are these allegations against you?
My lord, these are allegations, my lords. Certain allegations
Allegations
are
of
being made.
sexual harassment, why?
My lords, absolutely, my lords, I deny these allegations. Let them produce, my lords.
No,
I
I
am not.
myself stayed it. Nane stay kottidina.
How, sir? This is after this filing
My
of
lord-
writ petition, lordship, they have lodged a FIR, lordship.
Yes, after it.
My lords, after
Close ಆಯ್ತಾ?
No, after filing of this writ petition, they have filed one other FIR, lordship, against.
ಇನ್ನೊಂದು FIR ಹಾಕಿದ್ದಾರೆ. ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ಮೇಲೆ.
How's in 2018, 19, 20.
And my lords, your lordship may kindly consider this. Today, my lords, this temple is what it is because of this man, my lords. When there was hardly anything, this man used to climb up the steps.
So he has
The temple is what it is
strived
today.
for the development of the temple.
It's time for the development of the temple, my
No,
lords.
he has strived, I say. Yes.
And very, very importantly, my lord, they can't see interseed disputes and then the government cannot run its case on the shoulders of somebody else. Today, my lords, I am the priest, my lords, admittedly. and it is a private temple admittedly by virtue of the collector's letter since 2008. If it is a private temple admittedly in 2008 and thereafter, my lords, I am continuing to be the priest which I was even earlier, then under these circumstances, my lord, it will not be open for them to say that in 1979 it happened to be an endowment temple. If it was an endowment temple in 1979, which they say at page 101, whereas it can't be an endowment temple under 23B subsequently. That is my point. Your lordship may kindly for a moment look at page 101. Whereas this is the counter of the Tahsildar at page 100, annexure A18.
But gazette notification ಆಗಿಲ್ಲ.
ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ಆಗಿದೆ, ಅದು ಅದರಲ್ಲಿ ತೋರಿಸಿಲ್ಲ, ಅದು ಸಿಕ್ಕಿಲ್ಲ, ನಮಗೆ ಸಿಕ್ಕಿಲ್ಲ. ಅದು ದಟ್ ಇಸ್ ವೈ my lord I specifically refer that endowment register last portion which is there, it is sent. My lord, this also, my lord, after my lordship has
submission.
This we have taken 15 days time. It was also taken lot of.
And one more thing, my lord, if the gazette notification was not at all available at the time when 23B was issued, this is a point I make.
Now it is not available.
Even now, it is not, on what basis that notification could have been issued that it was a gazetted temple? On what basis? There was absolutely no basis, my lords, under 23B.
The register itself,
even in 2008, if it's a private temple, how could you claim it to be a public temple?
Why
in
did you pass
79?
that order in 2008 saying that we don't want to involve in the affairs of the temple, it's a purely private temple?
ಅದು ತಹಸೀಲ್ದಾರ್ ಏನು ಗೊತ್ತಿಲ್ಲದಂಗೆ ಬರ್ಕೊಟ್ಟಿದ್ದಾನೆ. There is a statement of against the record, my lord. The statement of the Tahsildar cannot be overruled against the record, my lord. The record speaks, my lord.
Why did Tahsildar say it's a private temple, you manage your business, don't bring us into it?
endorsement ಅಲ್ಲಿ ಬರ್ಕೊಟ್ಟಿದ್ದಾನೆ, but against record can it be holds, my lord?
That will see.
Please,
but it's your,
my lord,
Tahsildar,
my lord, sometimes they will write, my lord. That is extraneous consideration.
I have not seen any.
Page 124, one second, submission. Both are admitted as a public temple. There is a findings by the trial courts.
Trial court in that.
Oh, the ಎರಡು ಕೇಸಲ್ಲಿ public temple ಅಂತ findings ಇದೆ. About history has been referred. Please, grateful.
Deeply obliged, my lords, for the time given, my lords.
Reserved entry order ಇದೆಯಲ್ಲ?
Interim to conduct the puja. That we are not objecting.
Well, there is already an order.
He is conducting puja. He is conducting puja. We are not obstructing. We are not obstructing.
Don't obstruct.
No. 3 affidavits have been filed before this court.
Contempt Supreme Court have granted the.
Yes. Puja you can't stop.
No. We are not. 3 affidavits we have filed. We are saying that he has continued to be permitted and room is also been on
the Lord Hanuman temple.
Lord Hanuman temple. After construction of Ram Mandir, this temple has got more historical importance. Please.
I heard reserved.
Grateful.
Deeply obliged for that.
Heard the learned senior counsel P.B. Suresh appearing for the petitioner, the learned additional advocate general.
That was not in record, my statement, my compilation.
I will take it on record. Please. The learned additional advocate general has filed a memo along with documents on record. My memo documents, the same is taken on record. The learned additional advocate general has also produced 2 registers of the year 1962 to buttress his submission with regard to the entry of this temple being an endowment temple. The same is also taken on record and kept in safe custody. ಯಾವುದು ಕಾಪಿ ಅದು?
ಇದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ
ಒರಿಜಿನಲ್ ಇರಲಿ, kept in safe custody.
It is indicating that these are the original records in the affidavit act.
And the learned additional advocate further files an affidavit yardu
of the Tahsildar of the concerned
taluk, of the Tahsildar who has placed in
original records,
who deposes, who has averred in support of the documents to contending that it is genuine.
Please, brief.
My friends are assisting me. I have given the list of my colleagues who are assisting.
List of, sir?
I have given a list of my councils.
Oh, all of them. Whoever is there,
I am deeply.
Give the list. Heard, so learned senior counsel P.B. Suresh along with all these. Yes. Along with all this, and learned additional advocate general Gangadhar. What's your name, madam? So along with you, right?
Please.
Along with Sunita and Ramesh Chigri.
Please.
ಮೇಡಮ್
195.
Still,
Kannur appears.
where is he?
Request, madam.
Passover.
ಇಲ್ಲ, there in this EC minutes some other matter.
ಆಯ್ತು, ಯಾವತ್ತು?
27th minutes at
27.
2:30 minutes. Please.
196. Anushayal.
ಸೀನಿಯರ್ ಇದ್ದಾರೆ ಇವತ್ತು?
ಸಾರಿ ಮಲಡ್
ಪರವಾಗಿಲ್ಲ ಸರ್, ಸುಮ್ನೆ ಕೇಳ್ತಾ.
ಇಲ್ಲ, ನೆನ್ನೆ 4 ಕೋರ್ಟಲ್ಲಿ 2.5 ಅಂತ.
ಆಯ್ತಾಯ್ತು, ಸುಮ್ನೆ ಜಸ್ಟ್ ಲೈಕ್ ದಟ್ ಟೆಲಿಂಗ್ ಅಷ್ಟೇ.
ಇನ್ಫ್ಯಾಕ್ಟ್ ಐ ವಾಂಟೆಡ್ ಟು ಆರ್ಗ್ಯೂ ದಿಸ್ ಮ್ಯಾಟರ್.
ಇಲ್ಲೇ ಬರ್ತೀರಾ?
ಇಲ್ಲ ಇವಾಗಲೇ ಮಾಡ್ತೀವಿ.
ಎಸ್
ಮಲಡ್, ದಿಸ್ ಇಸ್ ಎ ವೆರಿ ಹಾರ್ಡ್ ಕೇಸ್ ಟು ಬಿ ಕ್ರಶ್ಡ್.
ಶ್ರೀಧರ್ ಪ್ರಭು ಸರ್, ಯಾವ್ದಕ್ಕೆ ಕಾಯ್ತಾ ಇದ್ದೀರಾ ನೀವು? ಅಲ್ಲ, ಇವರು ಸೀನಿಯರ್ ಈಗ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಇರಿ ಫ್ಲೈಟ್ ಎಷ್ಟೊತ್ತಿಗೆ? 10 ಗಂಟೆ ಒಳಗೆ ಬಿಟ್ಬಿಡ್ತೀವಿ. ಎಸ್ ಹಾ.
But this is a case where the private aided institution was taken over by the government on 4/12/2010. May I take, may I request your lordships to take the writ petition number 103399 filed by the staff,
I am there. I am holding it. Yes.
Annexure D, page 68, is the committee which has been constituted by the state government. Page 85, they deal with all liabilities, and liability was 2,93 lakhs rupees. Still, it has not been cleared by the government. But page 80, page 80.
Serial number 2 along with this matter.
Malad, page 85, Malad, there is a specific recommendation. So far as the unaided courses, there are totally, Malad, 7 courses, 4 aided, 3 unaided. Then 3 unaided courses are concerned. The finding of the committee, Malad, would be, it's only 3 sentences. ಸಂಸ್ಥೆಯ ಸಿಬ್ಬಂದಿ ವರ್ಗಕ್ಕೆ ಸರ್ಕಾರ ಈಗಾಗಲೇ ಅನುದಾನ ನೀಡುತ್ತಿರುವುದರಿಂದ ಉಳಿದಂತಹ ಅನುದಾನದಡಿಯಲ್ಲಿರದ ಕೋರ್ಸ್ಗಳ ಬೋಧಕ ಮತ್ತು ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿಗೆ ವೇತನ ನೀಡಲು ಪರಿಗಣಿಸಿದ್ದಲ್ಲಿ ಅಂತ ಹೆಚ್ಚಿನ ಆರ್ಥಿಕ ಹೊರೆಯಲಾಗದು. Now, my lord, the committee recommendation is both aided and unaided should be taken over is the position. Then, my lord, in the government order dated 4/12/2010, the last condition would say, ಈ ಸಂಸ್ಥೆಯಲ್ಲಿ ಅನುದಾನ ರಹಿತವಾಗಿ ನಡೆಸಲ್ಪಟ್ಟಿರುವ ಕೋರ್ಸುಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಬೋಧಕ ಮತ್ತು ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿಗಳ ಕುರಿತು ಸರ್ಕಾರವು ತೆಗೆದುಕೊಳ್ಳುವ ಅಂತಿಮ ನಿರ್ಧಾರಕ್ಕೆ ಒಳಪಟ್ಟಿರುತ್ತದೆ. That is a condition. So though the order was passed on 4/12/2010, courses are being continued. There was some interim order in the Supreme Court pertaining to the property. They did not take over. It is only in a contempt jurisdiction was filed. They took over, only on 19/7/2019. 19/7/2019. Sorry, 9/7/2019. Now, this is the actual position. Actual taking over took place only in 2019. Now, from 2010 to 19, both aided and unaided classes were continued. Now, so far as the teachers are concerned, there were 4 writ petitions are filed. There is a mandamus issued by this honorable court. that their salary will have to be payable. My lord, E, F, G, in this petition, my lord, there are 4 orders. Then contempt proceedings were initiated, and may I take your lordship, page 194 is the same. Page 194, ultimately in 2020, page 194, the Director of Technical Education has recommended that the salary shall be payable to them. Ultimate remainder and contempt jurisdiction, the government has rejected by means of an endorsement of July 2021 that has been challenged in other petitions. In other petitions. Well, this is the position so far as the staff is concerned. They were continued to work from 2010 up to 2022 when the state government has decided to discontinue these 3 unaided courses. They have not been paid salary for the last 15 years. It is only at page 233, annexure Y.
Lordship, those are not at all aided, Your Lordship, and they were not at all taken with the.
I do concede it was not aided. 3 courses were unaided. The committee, my lord, which recommended, felt and recommended that by taking over this institution, there is no question of financial burden. Now, page 233, my lords, annexure Y of the same writ petition, on 28/3/2024, all the original testimonials have been returned to the principal of the college.
So the issue is the government could not have taken 3 subjects to aid and left 3 courses to aid and leaving behind the other courses. That is all the issue.
Your lordships are right, man. There is one more thing, my lords. If the state government has taken over the entire institution, my lord, the judgment of
You are sailing with the senior.
With that management.
Management.
4 courses were aided. 3 courses were not aided.
Now the 4 courses aided, there is no problem.
There is no problem.
So the 3 courses which were unaided, there the employees teachers have a problem. Salary is not paid. So the contention is that the piecemeal aid is not correct. Yes. The entire thing should have been taken on aid. How is that you are making subject matter course aid because of the
Fellowship in the year 2000,
it is an aided institution from 2001 itself. In the synopsis I have taken. In the synopsis we have given the indicate the dates that it was admitted to the granting aid in 2001 itself. My lord, I just wanted to remind your lordship, I have extracted, my lord, the judgment of the apex court 77-2 SCC 508, where the apex court has said state of Orissa versus NN Swami, my lord, in the other writ petition, my lord, where there is a recognition. My lord, in that case, my lord, may I take your lordship, my lord, I'll just read one paragraph. Page 82. Page 82. When a fairly well-recognized institution, as in this case, run for more than a century, is completely taken over by the government for management, it is not merely taking over the land and buildings, tables and chairs. It has to tackle at the same time a human problem. That is to say, the fate of the teachers and the staff serving that institution.
Yes, madam. Human problem. State should tackle with this human problem.
12 acres of land was taken. 16 acres of land.
Table chair ನೋಡ್ಕೊಳ್ಳೋದಲ್ಲ. Human problem ನೋಡ್ಬೇಕು.
I'll just only in 3 sentences I'll complete. In 2022, state government did not move an application to the AICT for recognition. Then when we came up before this honorable court, this honorable court said, my lord Justice Suraj Goindra J my lord, has passed an order. Once it is taken over, the question of aided, unaided would not arise at all. That is a clear finding, my lord. That is one submission. The second, my lord, would be that when we filed a writ petition for recognition, writ petition has been allowed. AICT has granted the recognition for the year 2024 and 25. And again, 25 and 26, we filed a contempt. The recognition, my lord, has been approved for all the three courses. Then the director of the technical education, who agreed, my lord, in the contempt jurisdiction.
Yes, sir.
The director of technical education, a contemptor, who agreed in the contempt court, stating that the recognition would be complied. He writes a letter to the government. But in the additional document I have produced the decision of the government where if there is a necessity, courses can be continued. Malad, this is a position. In the meanwhile, Malads, we filed a writ petition stating that whether it is aided, unaided, the seat matrix has to be included because in all polytechnic flood, even if it is aided or unaided, the 50% will have to be paid by through the government quota. That is how, my lord, when we filed a petition, the AICT said we have granted the recognition. It is for the state government. My lord, these are all the facts of the case. Now, in a contempt jurisdiction, when the recognition is granted, we have not been allowed to take the admission. These people are working for the last.
That is the connected matter. That is the
Yes,
connected matter.
yes, connected matter. 20 years. Totally, Millard, as on today, it will become 20 years. Now, there are other angle, Millard. If it is taken over, they cannot decide it is aided, unaided. That is one thing, Millard. In fact, even if it is unaided, we wanted to proceed by based on the recognition, and we wanted to run the institution. The director of technical education is coming in the way. But now, in the additional document, we have placed on record, Millard, the order of the government, where government said the government sought for a report if there is a necessity or if there is essential, this for the institution can run. Malad, as on today, that these are the facts. Now coming to the Malad, the similar facts involved in the the Nagpur Malad's bench has taken the view in Barun Kumar's case, where it is a private in polytechnic and engineering colleges. They wanted to close down. Then, my lord, based on the AICT, the rules book, that is approval procedure, where when a litigation was pending, the AICT should grant the permission. Now the government has not obtained any permission from the AICT, nor the management. The division bench held, my lord, as per the AICT rules, the full salary, that is 6-pay commission, has to be payable. Now, the matter went to the apex court, my lord, when the institution closed down. In fact, my colleague is holding a Supreme Court order. Supreme Court said, you pay 70 crores rupees. The question of closing down the institution would not arise at all. My lord, this is a very human problem. People who are working, my lord, for the last 20 years without a salary, the government wanted to discontinue in
ಸ್ಯಾಲರಿನೇ ಕೊಡ್ತಾ
2000.
ಇಲ್ವಾ? ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಕೊಡ್ತಾ ಇಲ್ವಾ?
₹1 ಕೊಟ್ಟಿಲ್ಲ ನಮಗೆ.
Institution
₹1.
Government has taken over.
Courses are not taken over. The aid is only to particular courses.
4 courses.
ಇದು ಯಾವ ಕೋರ್ಸ್ ವೈಸ್ ತಗೊಳ್ಳೋದು?
Earlier, Your Lordship, in
Law
the
permits.
2001, we have taken over the management, the courses of 4 courses, Your Lordship: civil engineering and computer science, instrumental technology for
ಈಗ
4 courses.
ಈ ಟೀಚರ್ಸ್ ಎಲ್ಲ ಯಾವ ಕೋರ್ಸಸ್?
These belongs to another 3 courses, Your Lordship,
unaided
which they
3
have
courses.
started in the year 2002.
Oh, after the taking
After
over.
taking over, Your Lordship.
No permission is
No
granted?
permission, Your Lordship, and it is the duty of the management to give the salary and whatever
But there is, I'm
uh,
sorry, there is one mistake by madam. My lord, these courses are open.
So now who
Not
should
after
pay
taking
salary to
over.
these people? Management or the state?
2010
ನೀವು ಎಲ್ಲಿಂದ 20 ವರ್ಷದಿಂದ ಸ್ಯಾಲರಿ ಕೊಡ್ಬೇಕಾ? So they are working without salary for 20 years.
they are the management, Your Lordship. They are not outsiders. We have visited
Teachers also.
teachers and management one and the same.
2010 ಇಂದ
They are
ಇವತ್ತಿನವರೆಗೂ
not separate.
ಗವರ್ಮೆಂಟ್
Very
ಪೊಸಿಷನ್
ಇಲ್ಲ ಇದು ಸ್ಯಾಲರಿ ಇಲ್ದೆ ಬದುಕೋದ್ ಹ್ಯಾಬಿಟ್ ಆಗ್ಬಿಟ್ಟಿರುತ್ತೆ ಬಿಡಿ, ಪರವಾಗಿಲ್ಲ. 20 ವರ್ಷ ತಗೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಬೇಕಾಗಿಲ್ಲ.
Earlier, students were also filed a writ petition before this honorable court, Your Lordship. At that time, this honorable court has directed.
ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ನವರೇ ಟೀಚರ್ಸ್ ಅಲ್ಲಿ ಇನ್ಸ್ಪೆಕ್ಷನ್ ರಿಪೋರ್ಟ್
ಆಗಿದೆ, and we have filed affidavit also, Your Lordship. Affidavit on.
ಈಗ ಎಷ್ಟು ಕೋಟಿ ಬರ್ಬೇಕು ನಿಮ್ಗೆ ಸ್ಯಾಲರಿ ಗ್ರಾಂಟ್ಗೆ? Memo of calculation.
6/10/25, we have filed a memo, affidavit along with all the documents wherein.
50 crores ಆಗುತ್ತಾ? 50 ಕೋಟಿ.
My lord, the management wanted that the entire taking over should be annulled, my lord. In fact, today there is an instructions to me that we want the entire taking over should be annulled if the stand of the government.
ಏನು ಬೇಡ ನಿಮ್ಗೆ? ಇರ್ಲಿ, ಏನು ಬೇಡ.
12 ಎಕರೆ ಇಲ್ಲಲ್ಲ, 12 ಎಕರೆ ನಾವು ಬರ್ಕೊಟ್ಟಿದೀವಿ.
ಅದು ವಾಪಸ್ ಕೊಟ್ಬಿಡ್ಲಿ.
ಅದು ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅದು ವಾಪಸ್ ಕೊಡ್ಲಿ, ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ವಾಪಸ್ ಕೊಡ್ಲಿ. ನಾವು ಈ 3 ಕೋರ್ಸ್ AICT ನಾವು ಗ್ರಾಂಟೆಡ್ ರೆಕಾಗ್ನಿಷನ್. We wanted to run the institution. What is the right of the state government blood to close down? They should seek the permission from the AICT, and this is how the Bombay division bench has said.
Yes, that is fine. State has no business to close down without permission. Overnight you can't lock some institution.
Correct. 2010 to 2024 till our marks cards are returned, my lord, we were under the purview of the government. There was no private management.
ನಾಳೆ ಮಾಡಿ, ನಾಳೆ same time evening.
Please, Your Lordship.
Let's heard the learned senior counsel Shri V. Lakshmi Narayan appearing for the petitioner. Let's the matter tomorrow at 2:30 p.m. ನಾಳೆ ಮುಗಿಸ್ಬಿಡಿ ಮೇಡಮ್.
This issue, human problem, only your lordships can resolve. ನಾನು ಒಂದು 10 ಜನ ಹತ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಫೇಲ್ ಆಗ್ಬಿಟ್ಟಿದ್ದೆ.
ಅಲ್ಲ, ಫೇಲ್ ಆಗ್ತೀರಾ ಸಕ್ಸೀಡ್ ಆಗ್ತೀರಾ ಗೊತ್ತಿಲ್ಲ, ತೀರ್ಮಾನ ಅಂತೂ ಮಾಡ್ತೀರಾ.
ಅಲ್ಲ, ಯಾರಿಗೂನು ಗ್ರಿಪ್ ಸಿಗ್ಲಿಲ್ಲ.
Yes. Two still number 2. This continue the list. ಏನು ಇದೆಯಾ? 330 Shivsai Patil.
The affidavit also filed, Your Lordship, along with this.
What are those matters?
Affidavit, my lord, along with documents. First matter, my lord. Can you have it on 26th and 27th, my lord?
Officers list was.
The lordship had directed me to produce the officers' details and action taken. In first matter, I filed affidavit along with document.
What are these 25 matters? 26 matters.
It is regarding allotment of plots. Small, they wanted industrial plots, so they applied. They
off matters.
They deposited 20% of the amount, and the names were selected, but they are not pronounced. 2021 notification was made. 24 they cancel it and they say you take your money and go back. The online has not taken place. That single window agency has not cleared the names.
ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದು ನೀವು?
21. As per 21 notification.
ಆಮೇಲೆ ರಿಪ್ಲೈ ಮಾಡಿದ್ದು ಯಾವತ್ತು?
24.
Meantime, some of the land owners have filed a writ petition, my lord. Some of the petitioners filed writ petition, my lord, for allotting the same land to them, my lord. The case is till disposed on 2022, my lord. Subsequently, that proceedings has been continued, and subsequently what happened, government has issued notification saying that, my lord, the online application has to be compulsory in respect of allotment, my lord.
ಈಗ ಆನ್ಲೈನ್ ಅಪ್ಲಿಕೇಶನ್ ಕಂಪಲ್ಸರಿ ಒಂದು ಈಗ ಫಿಸಿಕಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವರು
Or earlier physical it, my lord. They have filed physically.
Not so. They themselves have.
They have filed physically.
ಆನ್ಲೈನ್ ಫಿಸಿಕಲ್ ಅಪ್ಲಿಕೇಶನ್ ಇದೆಯಾ?
Application is there, my lord.
They have produced.
ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಕನ್ಸಿಡರ್ಡ್ ಎಟ್ ಆಲ್.
We have considered interval agide. But what happened, my lord, the single window agency, the headed by the DC, has not approved, my lord. That's only.
Communicated anything to them? Whatever has happened, you communicate to them. You can't keep their fate in limbo.
Yes, we will. That's why the endorsement I have given to them, that has been challenged, my lord.
Endorsement ಕೊಟ್ಟಿದ್ದಾರಾ?
Yes, my lord.
Can
Annexure
they say
N.
that we'll return the amount?
Amount ತಗೊಂಡು ಹೋಗಿ ಆನ್ಲೈನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ we have given annexure N endorsement. That has been challenged.
ಯಾವ್ದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಎಲ್ಲದರಲ್ಲೂ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಎಲ್ಲದರಲ್ಲೂ ಕೊಟ್ಟಿದ್ದೀವಿ. All the 48 members, my lord.
ಕೊಡಿ. That is 31.
Annexure N is the endorsement given by the respondent number 8, my lord.
21 ನಲ್ಲಿ notification was made, and 24 they say that we'll return your amount back.
Oh, reconsider them. If it's not allotted to anyone else now.
Not allotted to anyone.
Then reconsider their case. ಹೆಂಗು ದುಡ್ಡು ಕೊಟ್ಟಿದ್ರು ನೀವೇನ್ ಕೇಳಿದ್ರೆ ಫಿಸಿಕಲ್ ಆಪ್ ಕೊಟ್ಟಿದ್ರೇನೋ ಆನ್ಲೈನ್ ಕೊಟ್ಟಿದ್ರೇನೋ ಅಪ್ಲಿಕೇಶನ್.
But the respondent number 6 has given direction to the authority, KDB authority, to cancel the.
Why?
Because, my lord, annexure G, my lord.
Why?
Because government has taken a decision that all the pending matters has to be taken online, and there is no transparency.
The issue is only online, offline.
There is no transparency, my lord, in the selection list.
ಅದೇ ನಾನು ಕೇಳಿದೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಆಫೀಸರ್
That I filed affidavit, my lord.
ಏನ್ ಮಾಡಿದ್ರಿ? What is the
affidavit? There is no, as per documents are produced, my lord, there is no leniency, but the officer then tappilla, my lord, because
transparency ilde irodu eralla.
No, this is the committee is headed by the joint commissioner, joint director of the industrial department, my lord. That's why I filed affidavit along with the various documents, my lord.
Online application or otherwise, you consider their grievances and then pass appropriate orders, not the online ಹಾಕಿದ್ದಾರೆ transparency. ಅವ್ರದೇನ್ ತಪ್ಪದ್ರಲ್ಲಿ? ಅವ್ರದೇನ್ ತಪ್ಪದ್ರಲ್ಲಿ? Will direct you to reconsider the whole.
Reconsider,
yes, in accordance with law.
Yes.
Lord, what happens now?
We'll make all observations and then direct. Positive direction I can't give. Yes. Let us see. Nature of activity. All shops idu.
No, my lord. Industrial land, Auto Nagar, in the Dandeli.
Small, not big industrialists. Small.
Small plots, my lord. These are small plots.
ಜೀವನ ನಡೆಸ್ಕೊಂತಾರೆ ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಮಾಡ್ತಿರಲ್ಲ. We'll pass a detailed order later. The petitions are allowed in part. The matter, impugned endorsements stand quashed. The matter is remitted back to the hands of the board.
Respondent number 6.
Respondent number 6
and 8, my lord.
6 and 8 to reconsider the application stroke cases of these petitioners in accordance with law, bearing in mind the observations made in the course of the order. All other contentions that are urged in the subject petition shall remain open to be urged in the event of need by these petitioners at a later point in time before this court. Leaving open the said remedy.
197 for 19, I will take notice. That is no notice not has been ordered, my lord. Respondent number 3 and 8.
19. Yaru Shashank
Hegde. I will
counsel Shashank Hegde accepts
for respondent number 3 and 8.
3 and 8.
And 197, 7, 10, 12, 13 and 20, my lord. The other advocate has take notice. I have directed me to, I will file.
Shashank Hegde ಹಾಕಿದ್ದೀರಾ?
Point 7, 10 and separate order.
ಯಾವುದಕ್ಕೆ ಬತ್ ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ separate order.
Separate order me first.
Separate order ಮಾಡಿದ್ರೆ ನಿಮಗೆ ಲಾಭ. Separate order ಮಾಡಿ.
Amounts are different. In each petition amounts are.
our subsequent now paper publication ಹಾಕಿದ್ವಲ್ಲ ಅದನ್ನ they have challenged.
The applications, ಅಲ್ಲೊಂದು ಬರ್ಕೊಂಬಿಡಿ. In the light of the disposal of these petitions, the pending applications also stand disposed.
197.19 ಅಲ್ಲಿ.
170.
AGA ಎಲ್ಲೆಲ್ಲಿದ್ದಾರೆ AGA ಅದು ಹಾಕಿ. Yes. Yes.
Correct submission. Serial number 2, my lord.
2.
Bangalore list, my lord.
Bangalore list, wait, sir. We'll take. Yes.
198.
Lordship, item number 31, it's being passed over, Lordship.
198 Purnima Bankar.
Matter pertains to service, my lord. This matter, my lord, the KP Tisla Authority passed resolution, my lord.
Which serial number?
198.
Yeah, 3:30 PM ನಾನು ಹಾಕಿದ್ದೆ. Come to sir.
Please. This is appointment by transfer. It requires little bit time. It will require time.
List on 27th.
May I request 28th?
Same timing.
20?
28th or
All right. Yes.
Same time.
28. Intermodal ಇದೆಯಾ?
ಇಲ್ಲ. It's appointment by transfer.
Appointment,
Yet to be
ABT,
appointed.
consideration.
Please.
ತಗೊಂಬಿಡಿ. ಏನಿದೆ ಅಲ್ಲಿ? ಕರ್ಬಿಡಿ ಬೆಂಗಳೂರು ಅಷ್ಟೇ.
Matter pertains to principal bench. Serial number 1, Nanjuna Gowda.
Lord, I appear for respondent. Lord, I appear for respondent number. Yes. Lord, I appear for respondent number 2, my lord.
ನೀವು ಹೇಳಿ ಅದಿದ್ದೇ ಇರುತ್ತೆ ಡಿಸ್ಟರ್ಬೆನ್ಸ್.
Yes, my lord, they had filed IA for vacating stay on 5th of October.
You are for the petitioner.
I'm for the respondent, my lord.
You have
Second
filed vacating
respondent.
stay application.
Yes, my lord. My lord, this application has been filed. The stay was granted, my lord, and they have provided misleading facts and documents, suppression of facts, and absolutely false information. The misleading documents are the release deed dated 13th of.
No, it's not your problem. It's problem there. Yes.
The release deed dated 13th of September 2022. GPA sale agreement all dated 13th of September 2022. My lord, in this release deed, they have it is forged, and in the said release deed, they have misrepresented the schedule and location of the property bearing survey number 74/6. Survey number 74/6 is 3 guntas of land, which was acquired by BDA for the formation of outer ring road in further extension of HBR third stage. And compensation was also given to the landowners.
You have instituted a civil suit as well?
Yes, my lord. They've instituted a civil suit against us, saying that we have encroached their land. In actuality, when they have encroached my land, a portion of my land, claiming that this 74/6 is in my land, that is 73/4.
Should it not be decided in a civil proceeding?
Yes, my lord, a civil suit is already being proceeded.
Then
Here,
why criminal also being set into motion?
my lord, here the problem is they are intending to grab a portion of my land by saying that this 74/6 is in my land. And while this is
That is what is pending adjudication in the civil court.
Yes, my lord.
Then why criminal case?
My lord, it's clearly shown here that based on this GPA, he executed a sale agreement to one Mr. Sia.
Who executed the GPA?
His daughter, the petitioner's daughter, petitioner number 3. She has executed this sale agreement in favor of one Mr. Sia Ullah, and she also received sale consideration of rupees 25 lakhs.
Who are you?
I am for the respondent number 2.
That's true.
Yes,
Who is the respondent number 2?
He is the owner of the neighboring, the adjacent
What is
land.
the relation between petition number 3 and respondent number 2?
They are neighbors, my lord.
Only that.
Yeah, he is claiming that in this release deed, he's saying that a survey number 74/6, which he sold, is located between survey number 73 and 74. When actually there is no land there.
What will the police decide? Where is 73? Where is 74?
No, my lord. Police have filed charge sheet claiming that these said accused, petitioners number 1 to 8, they have all forged these documents, claiming that it is theirs. Then they are not holding any portion of land in survey number 74, and they have also received consideration stating that this 74/6 is located in my land, and they are also encroaching into my land on that basis. They're dumping stones into my land, my lord.
Dumping stones.
Yes, my lord. There is a stone carving center there, but they're dumping stones and slowly extending their boundaries. Hence, I have filed a complaint before the police.
So you also dump stones.
No, my lord, I have approached this honorable court. They have approached, to quash this said complaint. My lord, if this said complaint is quashed, my lord, I will.
Not quashing, it's only stayed.
Yes, my lord, it has to proceed, my lord, as I am not able to do anything in my land, my lord. They are constantly making third-party rights again over this said BDA acquired land.
You should have sought injunctory orders in the civil court.
My lord, I have sought injunction. They have also suppressed facts of court proceedings.
What happened? Injunction is not granted?
My lord, I find counterclaim. And I was also granted injunction against which they filed an MFA. They filed an MFA, and right now the case is pending. Yes, my lord. They have suppressed those facts in
That's
this
all right.
petition.
MFA pending idea.
My lord.
MFA is pending.
Yes, my lord. Two MFA. MFA 2081.
All right. When is the next date?
My lord.
When is the next date in the MFA?
My lord, right now, currently it's posted for for admissions. But if I may be allowed to produce this document of the status of this MFA. My lord, and another MFA which we had filed against an order that they got in their favor at the civil suit, OS 5941, they acquired a favorable order by producing false documents. No, my lord, at the Honorable High Court of Karnataka, in MFA, they provided false documents of electricity bills, stating that they had taken electricity connection in a shed situated in my land. That said bill itself is manipulated. In the said bill, it shows survey number 18, not 74/6, and it says Amanikera village. My lord, if I may be allowed to produce that through a mem.
What's your name?
Nimdalla,
sir. One nimsha. What's your name?
My name, sir? My lord, my name is Belinda.
You're from which place?
From Bengaluru, my lord.
Oh, High Court of Karnataka jurisdiction layer.
Yeah. My lord, this is a successive petition. The petitioners had earlier filed another petition.
Withdrawn it because
Yes,
charge
ma'am.
sheet is filed.
With liberty to challenge the charge sheet. My lord, they have suppressed facts and they have produced misleading documents, and even now they continue to make third-party rights over my property. My lord, I pray that the stay may be vacated. My lord. This matter requires full
hearing,
full trial. And
full trial.
Yes, my lord. I have, my lord, I have Supreme Court precedents in support of my arguments.
Give it, madam. Give it, yes.
My lord, and a High Court judgment, my lord, passed by Justice Suraj Govindraj, where the same state, my lord, a civil suit was instituted against the complainant.
Good year.
Yes, my lord. Well, if I may further rely on the precedents to. Yes, my lord. My lord, in the first judgment passed by Justice D.Y. Chandrachud, page 4, if I may rely on para 10 of the judgment, that though the accused did not have title of the property, she had dealt with the property, and it was on that basis that the complainant was induced to part with valuable consideration. My lord, section 463 of CRPC of IPC states that forgery is it's said to commit that forgery if the person who forges a document and it
This said document as genuine.
My lord.
And uses the document as genuine.
Yes, my lord.
Said to be committing forgery.
Yes, my lord. Through this document, I am made to part with a portion of my land. And it's not only affecting me, it's affecting also the public. Because this is a BDA acquired portion which they claim to be theirs. And which is clearly stated that they've even received compensation from BDA through LAC 85/1990 to 1990. Yes, ma'am.
Yes. Good preparation. Yes. Yes, sir.
My lord, the charge sheet allegation is, my lord, the entire 25
File discharge.
My lord, all the ingredients are fully satisfied, my lord. Yes.
File discharge.
For the
Yes.
state,
Huh?
I am for the state, my lord.
State, ಎಲ್ಲಿದ್ದಾರೆ petitioner?
Petitioner ಇಲ್ಲ.
ನೀವು ಹೇಳ್ಬೇಕು ತಾನೆ ಸ್ಟೇಟ್ಗೆ ಅಂತ.
State here. That's why I am got to.
There is no representation on behalf of the petitioner. The learned counsel appearing for the complainant, Berlinda Boban.
For respondent number 2, my lord.
Complainant?
Yes.
Oh, correct. Complainant has taken this court through the documents appended to the petition, the judgments, and has made elaborate submissions to buttress and has raised several contentions to buttress her submission that the petitioners have played fraud, have forged the documents and claimed the land that is the petitioners to be belonging to them. Notwithstanding the filing of the civil suit and its pendency, the learned counsel submits that the criminal law can be set into motion in the light of plethora of judgments rendered by the apex court and this court, that the two can go hand in hand. In the light of the, however, as a last chance, awaiting the appearance of the counsel appearing for the petitioner, list the matter on Tuesday. In the event the petitioner would not appear, the interim order would stand automatically vacated. Next.
Grateful, my lord. Much.
Yes.
Bill number 2, Sharat J.M.
My lord, my lord, in this case, we filed an application for further extension of parole period, my lord, for 90 days, my lord.
ಯಾರಿದ್ದಾರೆ ಅಲ್ಲಿ? State.
Earlier it has been granted on second.
So like, actually 29/10/2025 ಗೆ he has to surrender before the ಕಾರಾಗೃಹ ಇಲ್ಲಿ ಮುಚ್ಚ ಇದು ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಬಿಡುಗಡೆ ಷರತ್ತು ಒಪ್ಪಿ ಸಹಿ ಮಾಡಿರುವ ಕರಾರು ಪತ್ರ ಹಾಗೂ 6,000ಗಳನ್ನು ಮುಚ್ಚಳಿಕೆಯನ್ನು ಈ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿ ಒಪ್ಪಿಸಿದೆ. ದಿನಾಂಕ 29/10/2025 ಸಂಜೆ ಒಳಗೆ ಬಂದಿಯ ಕಾರ್ಯಕ್ಕೆ ಸ್ವಯಂ ಶರಣಾಗಬೇಕಾಗಿರುತ್ತದೆ. ಬಂದಿಯ ಶರಣಾದ ನಂತರ ವರದಿಯನ್ನು ಒಪ್ಪಿಸಲಾಗುವುದು ಎಂದು ಮಾಹಿತಿಯಲ್ಲಿ ಮಾನ್ಯರಲ್ಲಿ ಸಲ್ಲಿಸಿದೆ. The report has clearly given by the ಮಾನ್ಯ ಮಹಾನಿರ್ದೇಶಕ ಗೃಹ ಕಾರ್ಯ ಸುಧಾರಣೆ ಸೇವೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ. ಬಟ್ ಇವರು 29/10 ಹೋಗಿ ಶರಣಾಗಿದೆ, ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳ್ತಾರೆ ಸರ್. ಅಂಡ್ ಮೋರ್ ಓವರ್ ಇನ್ ದ ಕಂಡೀಷನ್ ಅವರು ಓವರ್ ಆರ್ಡರ್ ಅಲ್ಲಿ
ಒಂದ್ ನಿಮಿಷ you have not returned to the goal.
ಪೇಜ್ ನಂಬರ್ if any violation
ಸರೆಂಡರ್ ಆಗಿದ್ದೀರಾ ಇಲ್ವಾ?
Surrender ಆಗಿದ್ದೀವಿ ಸ್ವಾಮಿ.
ಯಾವಾಗ?
Earlier, as per the order of this honorable court, we surrender and then we are seeking, my lord.
The learned HCGP submits that the petitioners are seeking extension without returning to the goal. Therefore, the learned HCGP to secure appropriate instructions as the learned counsel of the petitioner submits that the petitioner has returned to the goal and then seeking extension. List the matter on Monday in the fresh matters list. Yes. ಯಾವ್ದು ಮೇಡಮ್? ಅದ ಇರಲಿ, ಅದು 5 ಗಂಟೆ ಆಯ್ತು, 6 ಗಂಟೆ. Now get back to the list. Get back. Wait, I'll continue the list.
54.
Unless all of you are in a hurry to go.
Lord, serial number 4, my lord.
ಆಮೇಲೆ wait.
54.
Seal number 54, MB Hiremat.
Lord appears. Let's they filed application. Lord, no, we are all sailing together, my lord. Madam Sunitha Kalsuri is opposing.
Against you then.
Madam Sunitha Kalsur is against us.
Sunitha Kalsur.
Sunitha Kalsur appears against us. Both.
ಅವರು 4:45 ಮೇಲೆ ಇರಲ್ಲ.
Lordships, elections were, my lord, already.
So far as the second petition is concerned, which is filed by Sunil, the elections are over in that matter.
54.
How?
ಆಯ್ತು ಬಿಡಿ, ಎಲ್ಲ ಆರ್ಡರ್ಸ್ ಅಲ್ವಾ?
Orders. One matter would survive, which is filed by me, because the membership is under challenge in that.
54.1 Infructuous.
That is rendered infructuous.
We have already voted, my lord, the counts. But my lord may say that writ appeal is a remanded matter of the writ appeal.
ಹಾಗಾದ್ರೆ ಇರ್ಲಿ ಬಿಡಿ.
So that
55, 54 list on 27th.
Please.
Yes. Entry model ಇದೆಯಾ?
No, it's
ಸರಿ, ಆಯ್ತು, next.
Yeah, you have
55.
97th.
ಆಯ್ತು, 56.
Mrinalini Patil.
2 weeks time to do the needful. Next.
57, Government Advocate.
RP.
Rashikar Bihalli.
Review petition filed by the state.
Yeah,
What's
sir.
against the order of?
Review petition was allowed. Last orders, my lords, kindly see. And the writ petition is restored, my lord.
It is restored. Why has it come in review? This court,
Regarding, my lord,
by an order dated 27/10/2025, had allowed the review petition and restored the
no, my
petition
lord,
to file.
before that, my lord, before they were made a false submission.
Please. So and so. In the light of the allowing of the review petition, the registry to list the matter in the fresh matters list and not show it, not list it as a review petition. List on Monday, fresh matters.
Please.
59,
Sadiq,
Monday gets it.
Monday.
59, Sanket Shankarappa.
Office objection counsel.
Last time I was directed to take notice.
ಅಲ್ಲ ಇದನ್ನ ಕೊಟ್ಟಿಲ್ಲ ದುಡ್ಡು
ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ನಾನು ಕಾಪಿ ರಿಟ್ ಪೆಟಿಷನ್ ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ and they have
ರಿಟ್
said
ಪೆಟಿಷನ್ ಕಾಪಿನ ಕೊಟ್ಟಿಲ್ಲ ದುಡ್ಡಲ್ಲಿ ಕೊಡ್ತಾರೆ This court, the coordinate bench of this court on 36/20/25 had passed the following order. The learned counsel appearing for the respondent bank submits that not a rupee has been paid pursuant to the order dated 16/9/2025 and 29/10/2025. There is no representation on behalf of the petitioner. It's beyond 4:45. ಅದಕ್ಕೆ dismiss ಮಾಡೋದು ಬೇಡ. ನಾಳೆ day after tomorrow fresh matters. Yes. Next.
Seal number 60, Shivraj Valluli.
Office objection is that perhaps one of the signatories to Annexure A is not a
Overruled
party.
Monday.
Please.
Next.
But in the meanwhile, second respondent, perhaps I may be permitted to.
Yes.
Please.
61,
Overruled Monday.
62,
There is an interim order in 61.
ಇದೆಯಾ?
Please.
Overruled. Interim order subsisting will continue to the next date of hearing Monday ಬೇಡ. Next.
May I request for a date?
Interim order ಇದೆಯಲ್ಲ. Next.
Obliged.
65, Praveen Tarikar.
65, I am for the respondent number 1, my lord.
ಏನಿದೆ interim order ಇದೆಯಾ?
interim order.
ಏನದು?
Not to allow to work until the order of the
What's the matter?
Kindly, may I make a submission, ma'am?
List the matter on Tuesday in the fresh matters list, 25th.
Kindly on 27th or 28th, madam.
28th.
Interim order, Mr.
Interim order
Much
subsisting will continue to the next date of hearing.
Please, oblige.
Please.
Post immediately after service of notice upon
My
response.
lords, my friend is already appearing, my lords, for the other respondents.
Which other respondents?
My lords, respondents,
I'm not appearing for directors. I have made submission.
Anyway, yes, post immediately after service of notice upon response.
one submission, lords. In the earlier round of litigation, they were directed to file their objections before 30th September. And my lords, thereafter the dispute to be resolved, my lords, within a period of 90 days. Till date, they have not filed the objections.
No, my lord, that has come in the order sheet itself. I have filed it on 26th itself. That has come in the order sheet.
List on 28th, yes.
26th, my lords, that is, he's filed the objections to the IA. To the main petition, objections are not yet filed.
See, it has to be, my lord, considered as one and the same. I have prayed for that.
He can file, he could have filed made a submission before.
We'll adopt that only, sir. Why are you worried?
Allah, but for that, my lords, it is being dragged.
Kindly see.
I'm not dragging for that.
Before the authority, my lords.
Authority will say list on 26th, yes.
Please.
67, Jagdish Patil.
In this case, my lord, the tenure of the board of management has.
Lord, interim order. Administrator Lord took charge of the board before Lord term could expire.
The judgment of coordinate.
Covered by decision, my lord. The in WP, can you pass in WP, my lord, when pass or some missing, my lord.
Covered against them.
Against. No. Once the tenure of the board of management is expired, they don't have a legal right to continue against the constitution. ಮುಗಿದಿದೆ.
ಅಲ್ಲ ಅದು
ಮುಗಿದ್ಮೇಲೆ
for 4 days of the one thing.
ಆಯ್ತು ಇವತ್ತು as on today tenure ಮುಗಿದಿದೆಯಾ ಇದೆಯಾ?
ಅಲ್ಲ as on today it is ಮುಗಿದಿದೆ. ಬಟ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ election ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿ interim order is granted in the Lord connected writ petition.
ಯಾವ್ದದು ಕೊಡಿ.
ಇದೆ. That is part of Lord the Lord order Lord writ petition. There is a interim order operation.
Petition pending ಇದೆಯಾ?
ಇದೆ.
Tag this petition. ಬಂದಿದ್ಯಾ ಅದು?
ಇಲ್ಲ.
Tag this petition along with so and so.
104677 of 2025.
This on Tuesday in fresh matters list.
Please. Lord, your lordship may clarify that interim order, my lord.
No, already administrator has taken charge. The interim order itself says, my lord, it is only if they not taken charge, there is the interim order.
It's my order.
Please, please. Your
Correct.
lordship's order. Please.
Not taken charge, stay.
Yes,
Taken
been
charge.
taken
subject to
charge.
this.
No, in
Our
fact, my
statement-
lord, that was, as my lord, we, my lord, filed the, my lord, application seeking, my lord, correction of that, my lord, order.
Why?
Since, my lord, your lordship specifically, my lord, expressed that, my lord, the, your lordships have stayed the order of, my lord, the.
Administrator.
How do?
Because the coordinate bench judgment.
Yes.
Even then, only not taken charge ಅಂದ್ರೆ ಮಾತ್ರ every case ಅದೇನೆ. Direct ಆಗಿ ಯಾವುದು ಕೊಟ್ಟಿಲ್ಲ ನಾನು.
ಅಲ್ಲ, but interim order ಇರೋದ್ರಿಂದ the bank could not have, my lord, proceeded with the, my lord, to hold the elections. Even otherwise also, my lord, what happened is.
Interim order ಏನಕ್ಕಿದೆ?
Not to conduct the elections ಅಂತಿದೆ.
ಅಂತ ನೀವು ಕೊಟ್ಟಿದ್ದೀನ.
ಹೌದಾ?
ಹಂಗ್ ಕೊಟ್ಟಿದ್ದೀನ.
ಹಂಗ್ ಕೊಟ್ಟಿದಾರಲ್ಲ, ಹಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಹಿಂದ್ಗಡೆ ಬೆಂಚ್ ಅಲ್ಲಿ.
My lord, that is on the ground that the elections was not held to one.
There has to be a lapses on the board.
Tuesday, fresh matters.
Please.
Number 69. Vinayak SC.
Because in this matter, despite having issued form GST move 5, that is release order, the goods are detained and confiscated now. I have come against.
Confiscation challenge ಮಾಡಿದ್ರಾ?
ಮಾಡಿದ್ದೇನೆ here. This is the confiscation challenge here.
Another matter is connected.
ಇನ್ನೊಂದು ಯಾವುದು confiscation challenge ಮಾಡಿದ್ರು?
108319.
That is for the detention, Your Honor.
Lollet, which is that?
108319 of 25.
Tag this petition along with so and so. List this matter on Tuesday.
Interim order, please.
Tuesday ಏನಾಗಲ್ಲ.
They are proceeding to auction the goods.
Let them, the goods confiscated shall not be auctioned without the leave of the court.
Please, Your Honor.
Yes, Tuesday.
Previous matter. Today that connected matter where the interim order is in operation, not to conduct the election.
Serial number.
ಇದೆ 110.
Wait for 10 minutes.
Please.
Urgent ಮನೆಗೆ
ಇಲ್ಲ, I am for the petitioner in that matter, my lord.
ಸರಿ ಆಯ್ತು. ಇವತ್ತು ನೀವು ಎಷ್ಟೊತ್ತವರೆಗೆ ಇರ್ತೀರ ನೋಡೋಣ ಎಲ್ಲರೂ.
Ah. 70, Anand P. Saudi.
All these preliminary matters will post it. ಕರಿತಾ ಹೋಗಿ ಲಿಸ್ಟ್ ಆನ್ ಇದು ಕೊಡಿ ಮೇಡಮ್, ಲಿಸ್ಟ್ ಕೊಡಿ. Twenty-seventh.
71 Nagaraj Hegde.
27th.
73 Peter Prabhu.
27th, my lord. Obliged.
Could it be, Lord, it's just 5 minutes, my lord, if I, the cross subsidy surcharge is the issue, my lord. Cross subsidy surcharge nalli, my submission is, my lord, that.
You have bought him out of the VC?
Yeah, yes. No, the issue is this, my lord.
But them out of the VC rather.
No, we tried to come last time also. In fact, we moved the matter, Your Lordship, because
There is
the order is
urgency, my lord,
operating.
there 100 crores is at stake. In fact, my contention is fourfold. My
About
lord.
40 crores, Your Lordship. Due to the interim order, they have not paid us about 40 crores over a period
I'm
of
saying
2
100 crores, he's saying 40 crores.
No, why you have not paid any amount?
No,
Because of
the
the-
cross subsidy surcharge, my lord, is stayed. I'll, my lord, make submission. The first submission is, my lord, that there is no license is the first contention, and based on which, my lord, the interim order was granted. The license, my lord, licensing provisions, my lord, under section 14 requires consideration, my lord. Therefore, I'm rushing through the. Day after tomorrow, if your lordships could have at 2:30, I'll only take 20 minutes, my lord. I'll not take much.
20 minutes you can take. We'll take it at 6:15.
Yes, I'll wait for you.
But you have flight?
I have flight at 8:15, Your Lordship.
Oh, then you'll have to rush.
Day after tomorrow,
you
Lord.
can go fast.
Yes, I'll.
So you appear on VC. Why did you come?
I wanted to attend this matter in person. It's been pending for quite some time. You've been trying to move this matter.
Not on Friday. On Tuesday, we'll post it in fresh matters and
Yes,
close it.
yes.
Tuesday, I'm not there.
Tuesday or Wednesday, whichever
Tuesday,
day you want.
Tuesday.
Tuesday in fresh matters, we'll decide.
We will come down again and we'll argue.
That's up to you.
Yes, sir.
Number the other 80, that matter may be adjourned, my lord. That matter is reserved. Lordships, my lord, 83.
Division bench ಅಲ್ಲಿ ಏನಾಯ್ತು ಅದು?
ಅದು ರಿಸರ್ವ್ ಆಗಿದೆ 86.
May I file a list of documents and
ಅದು ಕೊಡಿ, ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂಡ್ ಜಡ್ಮೆಂಟ್ಸ್ ಏನಾದ್ರು ಇದ್ರೆ ಕೊಡಿ. Sridhar
We
Prabhu
also
sir,
have, yes,
avat-
I'm producing.
we'll finish it on that day.
Yes.
Interim order is absolute not to pay anything.
26th.
Ma'am.
We'll take it on 26th.
Yes. 26th.
Wednesday.
Allah, Tuesday, my lord, if you're not sure. 26th is someday. Either this way or that way. 27th or 25th.
27th ಆಗ್ಬೋದು 25th ಆಗ್ಬೋದು ಇರ್ಲಿ 25th ಇರ್ಲಿ
ಆಯ್ತು 25th.
But in the fresh matters list.
Yes, great.
Close it.
Grateful.
Number
Yes.
75, Anusha L.
And also, I'm so sorry, my lord, and 185 and 144 also may be had on same day.
Along this,
Allah, better, very matter.
185 and?
I'll cross on 144 and 185, my lord. Different matters, the interim order subsists there.
But Sridhar Prabhu's matters. So
I'll
we'll
argue
have
them
it
physically.
on that day.
There, before your lordships.
All.
Great. Great.
Interim order ಇದೆಯಾ ಇದರಲ್ಲಿ?
There are
interim order ಇದ್ರೆ continue ಮಾಡಿ.
in all the issues. Great.
Yes.
Number 75, Anusha L.
Yes. 86 also interim order is there, my lord, it may be.
ಅದು ರೀಚ್ ಆದಾಗ ಹೇಳಿ. 27th.
77, Sunil S. Desai, Dinesh M. Kulkarni.
Day before yesterday matter, regularization, 27 years of a service. He retired on 2019.
Tuesday, fresh matters. 26th, fresh matters.
Please.
ನನ್ನ ಜಡ್ಮೆಂಟ್ ಎಲ್ಲ ಇಟ್ಕೊಂಡ್ಬಿಡಿ.
ಎಲ್ಲ ಕೊಡು.
ಇಟ್ಕೊಂಡಿದ್ರೆ ಎಲ್ಲ ಕವರ್ ಆಗುತ್ತೆ.
ಇಲ್ಲ.
Including Dharam Singh have
Yes,
written one.
yes.
Yes.
29, Anand P. Saudi.
28th.
Number 80, KL Patil.
This is pension matter, my lords, where provisional pension was sanctioned owing to pendency of criminal proceedings. Now that has been quashed. At last time your lordships had passed an order to bring them the pension sanction order, etc.
ಬಂದಿದ್ಯಾ ಮೇಡಮ್? ಯಾರು ಕೊಡ್ಬೇಕು?
Corporation.
My lords, I
ಎಸ್ ಸರ್ ಕೊಡಿ ಸ್ವಲ್ಪ ಇಲ್ಲಿ. Costs of litigation, interest ಎಲ್ಲ ಬರುತ್ತೆ. Switch off your mobile, sir. Yes.
My lordship,
Sound process, my lord.
tomorrow, my lordship.
Let's tomorrow, day after tomorrow in the fresh matters. ಮೇಡಮ್ ಪೆನ್ಷನ್ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ 1 ಲಕ್ಷ ಕಾಸ್ಟ್ ಡೆಫಿನೆಟ್ಲಿ ಹೇಳಿ ಆಲ್ರೆಡಿ ಬರ್ದಿದ್ದೀನಿ ನಾನು. ಎಸ್ ನಿಮ್ಗಲ್ಲ ಅವ್ರಿಗೆ ಹೇಳಿ ಗುರುದೇವ್ ಹೇಳಿ, ನೀವು ಗಾಬರಿ ಆಗ್ಬೇಕು.
82 lordship, not the denial of not the retrospect, not the absorption and promotion to the petitioner lordships. Denial of not the absorption to the not the
445 ಆದ್ಮೇಲೆ ಕ್ಲಿಯರ್ ಆಗಿರ್ಬೇಕು, ಇದ್ರಲ್ಲಿ ಗೊತ್ತಾಗಲ್ಲ.
denial of retrospective, not the absorption and promotion to the petitioner lordships. And the ground that not the departmental inquiry was pending, your lordships. Not the similarly placed persons who are not the juniors to the petitioner, not the promotion has given to the not retrospective effect. Retrospective effect, your lordship.
ಗೊತ್ತಾಯ್ತು ಯಾಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ಲಿಸ್ಟ್ ಆನ್ 27 ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
28 your lordship.
28
fresh matters. Please.
I request this on 28th, your
28 yes.
in fresh matters.
Sadiq,
Fresh matters if possible, your lordship.
PDS patent. Yes. 28
Fresh matters.
ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್. yes.
Obliged.
85, CR Hiremat.
This is covered by your lordship.
Additionally, my lords, he has filed an application for additional documents. Producing
documents are
14
left.
documents. I have to my lord, go through it and
Only
file objections also.
one submission, only one submission.
December.
So one submission.
ಹೇಳಿ ನೀವು.
That's covered by your lordship judgment. I have produced the additional document, that is the judgments of the some judgments of lordship and also of the court. And all the documents are not relevancy, my lords. It is only a medical document just to show that, my lord, petition number 2 is carrying the petition number 1. It's a compensatory appointment. It is upper age, my lords.
Next week, any date, my lords.
ಅದೇ ರಿಟೇಬಲ್ ಸ್ಟೇ
Covered.
ಮಾಡಿಲ್ವಾ?
ಇದ್ರೊಳಗೆ objections ಹಾಕೋಣ ಅಂತ ಹೇಳಿ.
It is covered by judgment, your lordship.
ಲಿಸ್ಟ್ ಆನ್ 1st December, 2nd December.
Please. Great.
ಆಯ್ತಾ
Fresh.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
Yes.
ಇವೆಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡೋ ಫ್ರೆಶ್.
Yes.
And any relies on.
86, my lord, the honorable division bench has reserved the judgment, lords.
Lord, I appear for
I
respondent.
succeeded in the
succeeded in
ಅದೇ
division bench
ಆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ನಲ್ಲಿ ಇವರು ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿದ್ರು, ದಟ್ ಇಸ್ ರಿಸರ್ವ್ಡ್.
Lord,
Third
in
and
this,
reserved.
Lord,
by the present bench or what?
Honorable Justice Anu Shivraman in Bangalore.
Lord, that matter, my Lord, where the government order was challenged and partially Sridhar Prabhu succeeded. There is an appeal filed by us and that is now heard and reserved. So far as this identical prayer as he has made in this patch is concerned, my Lord, it is covered by another judgment which I have passed on.
No, I
That's
don't
the
think
reason
so.
this
That is
matter was
reserved.
listed.
Now that judgment, connected judgment says link it with the division bench matter, that is reserved. Now, my lord, in the reserved matter, can I go and get this matter linked? Your lordships, my lord, passed a detailed order in the section 11, those connected matters, saying that, my lord, it's still
ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ?
ಅದು
My
ಚಾಲೆಂಜ್
order is
ಮಾಡಿಲ್ಲ
not challenged.
ಇಲ್ಲ
That
ಅದನ್ನ
writ
ಚಾಲೆಂಜ್
petition
ಮಾಡಿಲ್ಲ
is
ಅಂದ್ರೆ
disposed of.
that matter they filed a vacating stay in the matter where both of us were heard, and honorable single judge said, my lord, go and appear before the division bench, you make an
My
application
Lord had
before the
granted
division
an interim order.
sorry, yes,
I have written all that, I guess.
yes, is all that is written. Now that is
There was-
reserved, my lord.
there
Why
was-
again
There is
what
an
do we
interim
deny?
order which was subsequently writ petition is disposed of.
Yes.
List on 5th December.
Right.
Interim order
Great.
subsisting will continue to the
Yes.
next week. Next.
राजेश ये अभी आप कोई सेल्स कॉल है ना, अभी मेरे को नहीं करनी है.
Bill number 88, Manjunath Thurgad.
Lords filed a rejoinder along with a citation, my lords. Wherein it indicates the petitioner is eligible to appoint as a librarian under state pay scale.
That librarian matter, my lords,
State
wherein
pay
you-
scale ಇದು ಅಂತ.
State pay, state scale.
He is agreeing for state scale.
State pay scale.
ಅದೇ state scale and state pay scale. Second December, yes. Next.
89, Prashant Iskardeva, MB Kanvi.
Lords, my on fresh matters.
Third, the service fresh metal act.
Please.
88. 2. 212. 89, 312.
Bill number 90,
My lords, this is a matter, my lords. Group A officer, my lords, sanction of the chief minister is required. My lords, they kindly see the order dated 30th of July. my lords.
KPC or what?
I'm sorry, ma'am.
KPC.
Sorry.
ಯಾವ್ದ್ರದ್ದು ಇದು?
Service.
Government?
Government.
All right.
My lords, KS officer, my lords, on 14th of February, my lords passed an order saying, get the records to see whether chief minister's sanction has been obtained under transactional business rules. On 30th of July, they made a submission saying that chief minister's sanction under transactional business rules is not required because the KCS rules ಅಲ್ಲಿ amendment ಆಗಿದೆ, ಅದರ ಪ್ರಕಾರ ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. My lords, matters covered by my lords, Shiv Shankar judgment and my lords, Dr. Chandrasekhar judgment of my lords, transaction of business rules is completely independent from KCS. Transaction of business rules clearly it stated. I filed
That
a
is my judgment, I guess.
Yes, both are my lord's judgment. My lords, can I pass the judgment? My lords, I had given a small note.
Statement.
I'm so sorry. I'm so sorry. My lords, I had passed a small note on the last occasion, my lord, that extracts
So
the.
Chandrasekhar is mine, is it?
Both are my lords, my lords. My lords, in Chandrasekhar, my lords looks at the Peshway judgment, my lords. The reason I have given the.
Peshway, correct.
Yes. My lords, Peshway squarely covers it. My lords have explained why exactly by relying on MRF, my lords. If my lords were to just see the order of 30th of July, my lords, that.
Nodi.
Please,
Who appears? Nivena.
please.
We'll take it on second or third. Interim order ಇದೆಯಾ?
Interim order, my lords, the only difficulty is that.
Difficulty is interim order.
ಇಲ್ಲ interim order ಇದೆ. ಇದೆ. My lords only granted the interim.
Sir. List on 3rd December. Interim order subsisting will continue to the
But
next
is
date
it
of hearing.
possible to take it up in
Preliminary hearing. Yes. Interim order ಇದೆಯಲ್ಲ?
Swami, the difficulty is
appointment
ಇಲ್ಲ. The problem is that June he is retiring, he is eligible for promotion and that promotion has been withheld because of this proceeding. That's why.
List in the fresh matters list.
91, Sajid Ahmed Budwala, Girish Azwa.
Please.
Vacating stay list on 3rd.
Only one submission, last time also. What is questioned is, my lord, only an order appointing an inquiry officer under section 25 of the.
Correct.
Yes.
Yes, sir.
That order, my lord, is writ petition is premature. That's what.
My lord, the petitioner is an educational institution. The respondent number 4 to 9 are the ex-board of directors.
Maybe.
Earlier, my lords, the.
What's the prayer?
To quash that order appointing inquiry officer. At the next E, my lords.
That is 6/2/2025.
Yes. Page 22.
Page 22.
What's wrong with that?
My lords, there are several allegations against them, my lords.
Against whom?
My lords, earlier, I have
Inquiry
approached.
officer ಮೇಲೆ allegations ಇದೆಯಾ?
ಇಲ್ಲ, ಅವ್ರು ಸುಮ್ ನಮ್ಮ ಮೇಲೆ ಕೇಸಸ್ ಎಲ್ಲ ಹಾಕಿದ.
ಸುಮ್ನೆ ಅಂದ್ರೆ ಎನ್ಕ್ವೈರಿ ತೀರ್ಮಾನ ಆಗ್ಬೇಕಲ್ಲ.
ಇಲ್ಲ, there are.
It can't be that way. List on 26th in fresh matters.
Please.
Yes. Your time ಇಲ್ಲ.
Please.
26 ಮುಗಿಸು.
Yes.
Sriharshi Nilopan?
Right.
Short accommodation, my lord. December first week, any date maybe.
Third, ಒಂದು ನಿಮಿಷ. 3rd December.
In fresh matters.
ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? ಇಲ್ಲ. Emergent notice to the respondents. Yes, next.
95?
95.
Please, my lords.
95?
My lords, here the qualification of respondent 2 to hold the post of president of Anjuman Islam is challenged. My lords, senior is briefed in this matter. May I please have a date on Tuesday, my lords, if possible?
26th.
20 Tuesday, my lords.
25th.
Please, in fresh matters, my lords.
25th.
Please.
Yes.
26, Pontiffs Hiremat, Viresh Putihar?
Lordship,
3rd
I
December.
appeal for.
3rd December. Yes, next.
27?
Same.
My lordship, I produce medical certificate and prescription bills and my lordship.
Prescription na?
Medical my lordship.
Surface Act.
Surface Act my
ಅದು
lordship.
ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು ಹೋಗಿ ವಿಸಿಟ್ ಮಾಡಂದ್ರಿ ಬ್ಯಾಂಕಿಗೆ. He has come at 8 o'clock night and says that to legal section, not recovery section.
ಆಯ್ತು, ಈಗ ಯಾವಾಗ ಹೋಗ್ತೀರಾ? ಹೋಗಿಲ್ವಾ ಈಗ?
ಹೋಗಿ ಬಂದಿದ್ದೆ.
ಏನಾಯ್ತು? ನೋ ಸೆಟಲ್ಮೆಂಟ್?
ರಾತ್ರಿ 8 ಗಂಟೆಗೆ ಬಂದಿದ್ದಾರೆ. Nobody is
ಬೆಳಗ್ಗೆ 8 ಗಂಟೆಗೆ ಕಳಿಸ್ಲಾ?
working hours any time 5 o'clock ಒಳಗಡೆ.
Not your working hours, bank working hours. Yes, list day after tomorrow, fresh
Recovery.
matters list.
Tomorrow my lordship.
Day after tomorrow.
Please.
My lordship, interim order.
Oh, sorry.
Extra.
Interim order stands.
98, Abhinandan Hiremat?
What is this 98?
Let's weeks accommodation.
List next week. Yes.
Here in petitioner is working as a waterman in restaurant number 4, Gram Panchayat. His name is not considered for the approval. Instead of restaurant number 5, who is working as a DTO, his name is considered for approval. Against this challenge annexorial. His salary bill and other things is in the name.
99. I am for the contesting respondent. I am
3rd
seeking
December.
accommodation.
3rd December. Yes. Next.
Much of it.
100, Pontiffs Hiremat?
Yes. Up to 119. Ella 3rd December. Interim order.
118, my lord. Serial number 118. Only to consider the representation, my lord, for regularization.
118.
Yes, my lord.
That's 3rd December. Yes. 118. Consider representation. Fresh
Consider
matters.
the representation. That's all.
Fresh matters. Yes. In other consider representation idea. In any of these cases, only consider representation. There should be no certiorari. Only consider representation. Yavada list kodi. Ivattinna list alli. Point 1 idre beda. Connect agidre beda.
Lord,
Wait,
168.
I'm asking
Serial number
consider
168 also, my
representation.
lord, to consider the representation, my lord.
1
Serial number 168, my lord.
168.
Yes, my lord.
168. Again.
Consider
Monday.
the
Fresh
representation.
matters. 25th. Sorry, 20. Another Monday. 24th. Yes.
124, my lord.
Consider representation.
No, it's a dispose of matter. Seeking time limit was not fixed for compliance.
124.
124. For refund of tax amount collected, my lord, as per the interest, so apex court judgment, my lord.
List on Friday, fresh matters.
Please.
Covered by Allah. Third, fourth. Yes.
172 minutes,
Third or fourth.
172 minutes, only
Allah.
mandamus relief has been sought.
1 minute. 20 up from come to ಇದೆಲ್ಲ fresh matter dispose ಮಾಡೋಲ್ಲ. 172 to 190. List them all on Tuesday, fresh matters. Please. ಎಲ್ಲ ನೋಟಿಸ್ ಆಗಿಲ್ಲ, ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕು.
ಎಂಟ್ರಿ ಮಾಡಲ್
ಯಾವುದು 190? 191 ಹೇಳಲೇ ಇಲ್ಲ.
171
ವರೆಗೆ ಮಾತ್ರ.
171 entry model.
Entry models will continue wherever. 106 representation. 106 post it on Monday. Fresh matters.
My lord, 107, my lord.
Consider representation. 180.
Good evening.
What is the challenge? Who? Bar Council ga. Chetan Kulkarni.
कौन सी डेट को कौन सी तारीख को
वो सामने वाला
172 fresh matters ಅಂದ್ರಲ್ಲ.
Which is this criminal petition? We'll hear along with that. Tag this petition along with ಯಾವ criminal petition ಅದು ಯಾವುದು ಸ್ಟೇ ಆಗಿದೆ ಅಂತಾರೆ?
Bangalore petition.
Bangalore ಅದಾಗಲ್ಲ ಬಿಡಿ.
There are criminal petitions pending here as well, my lords, against the petitioner.
Now what is under challenge here?
The challenge is for the enrollment, my lords, enrollment of the this is my statement of objections and
File in the registry. List the matter on Tuesday in fresh matters list.
My lords, the registry may consider without the signature of the
Which signature?
no the
serving
I will take,
serving the
you
public.
get it, we'll take it on board next time. Yes. Allah, because it's party in person, list on in the fresh matters list on the matter. Yes. Mikidalla, it will come on third.
My lord, serious.
My lord, may I make a mention?
PC, please, 1 minute. Yes.
Please.
20?
25.
What auction? Auction ಯಾವತ್ತು? Monday. 24th Monday. List on Friday ಹಾಕಿ. 135 ಮಾತ್ರ list on Friday. Fresh matters. ಒಂದು ನಿಮಿಷ ಅದು ಮಾಡಿಫೈ ಮಾಡ್ಬೇಕು ನೀವು. Wait. You shall not take any decision.
I'll make my submission.
No, then ilva illa.
I'm not that. So what has happened is elections.
Wait.
Yes.
Serial number 91. Interim order may kindly be extended.
ಏನ್
Already heard matter.
ಇಂಟರ್ ಮಾಡಿ ಎಕ್ಷನ್ ಮಾಡಿಲ್ವಾ ಯಾವತ್ತಾದ್ರೂ?
91.
ನಾನು ಏನೋ ಸೀರಿಯಸ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಇಂಟರ್ ಮಾಡಿ?
Lord, serial number 127. It's on a very short issue. May I request on to be listed in 127, my lords, to be listed in preliminary hearing, my lords.
No, short issue ಎಲ್ಲ ಲಾಂಗ್ ಇಶ್ಯೂ ಎಲ್ಲ ಅವತ್ತೇ ಬರುತ್ತೆ. ಬೇರೆ ಡೋಂಟ್ ಪೀಸ್ ಮೀಲ್ ಬೇಡ. ಥರ್ಡ್ or fourth ಹಾಕಿದ್ದೀನಿ ಎಲ್ಲ. ಇಂಟರ್ ಮಾಡಿಸ್ ಎಲ್ಲಿದೆ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Which one? 115. ಯಾಕೆ?
Since 2000 notes, bills are not clear. Even notes DCS given notes and endorsement will take that much. But bill to the tune of 2 crore 42 lakhs is pending. Not I issued a direction of procedure inspection as to what till date the bills are. COVID-19 daily notes the work order was placed. The items are not surgical items are supplied.
List on 25th in fresh matters list.
My lord, serial number 110.
21
ಪಾಸ್ಡ್ ಓವರ್ ಕರಿತೀನಿ. 6 ಗಂಟೆ ಇರಿ.
My lord,
All other matters, third,
My
fourth. Yes, Rohan, when do you want? 30? Which date you? Third, all right. 120, 129, third. 159, third.
Serial number 170 is a covered matter.
Third.
my lord,
Serial number 107 is consumer member is deputed to Bagalkot. And after reappointment at Dharwad, they are not relieving. Last time you were
ಗೊತ್ತಿಲ್ಲ ಅದು ಯಾವತ್ತು ಬರುತ್ತೆ ಬರ್ಲಿ.
my lord, Monday, my lord. May I request on Monday?
number 110, my lord.
May I request on Monday, my lord?
No, it will come third. Yes.
Serial number 184.
ಬೇರೆ ಎಲ್ಲ ಥರ್ಡ್ ಅವ್ರದ್ದು
Serial-
ಜನಂ ಸೆ ಪ್ಯಾರ್ ನಾಳೆ ಮಾಡ್ತೀನಿ.
My lordship.
My lord,
Serial number 184, my lordship. Serial number 184.
What do you want?
I'm for respondent, my lordship.
What do you want, madam?
After 10 days.
Sorry.
My lord, serial number
Third
110,
is after 10 days only. Yes.
serial number 110, my lord. It may be taken on Friday, my lord.
No, sir. Why?
In fresh, my lord, Saturday the election notification will be
On
given
the
on
Friday, fresh matters. Serial number
110, my lord.
110. Yes.
Oblige.
ತಂದ್ರ ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ. ಮಂಡೇ ಕೊಡಿ ಅದು ಮಂಡೇ ಕೊಡಿ.
Serial number 1.
I'll call, wait. Yes.
My lords, serial number 50, my lords, tomorrow at 2:30.
ಯಾವುದು?
ಅದೇ ಜನಂ ಜನಂ.
ಜನಂ.
For
Yesterday also it was ordered for 2:30. my lords.
ಅದಕ್ಕೆ ಮೇಡಮ್ ನಾಳೆ ಜನಂ ಸರ್ ಪ್ಯಾರ್ 2:30 ಗೆ ಆಗ್ತಾ ಇದೆ. Yes.
Grateful, sir.
My lord.
132. Damage claim. Damage award.
Damage.
Or demurrage.
my lord, serial number 169, my lord.
It will come third or fourth. Yes.
Serial number 169, my lords. It's for mandamus. It may be taken.
Mandamus 169 Monday hacking. Fresh
It
matter.
appears my friend mentioned serial number 110 for Friday. What's that election matter which Srinivas Nayak earlier mentioned in 67. Both matters may be taken on Tuesday, my lords.
ಆಯ್ತು ಮತ್ತೆ ಯಾಕೆ ಫ್ರೈಡೆ ಅಂತ ಹೇಳಿ?
ಇವರು ಹೇಳಿದ್ರು ನನಗೆ he does not appear in that matter, but please.
ಯಾವತ್ತು ಬೇಕು ನಿಮಗೆ? ಮೇಡಮ್ ಅದು ನಾಳೆ ಬರುತ್ತೆ, ಇವತ್ತೇನೋ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. Where is your band?
Serial number 192, my lord. Acquisition is in the year 2008.
ಕೇಳಿಸ್ತಾನೆ ಇಲ್ಲ ಏನು? ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
Serial number 192, my lord.
ಕಾಣಿಸ್ತಾನೂ ಇಲ್ಲ. Band
Serial number 192.
Where is your band?
Till today they have not paid any
ಕೇಳಿಸೋದು
compensation.
ಇಲ್ಲ ಕಾಣಿಸೋದು ಇಲ್ಲ ನನಗೆ. Yes. How can you appear without a band? What is all?
Band.
Just because you are in the office, you can appear however you want. What, madam?
174.
ಯಾವತ್ತು?
Sorry, my lord.
ನಾಳೆ?
ಫೆಬ್ರವರಿಯಿಂದ ಬರತ್ತಿದ್ದೆ ಸರ್ ನಾನು.
ಫೆಬ್ರವರಿ ಬರತ್ತೀರಿ? ಎಲ್ಲಿಂದ ಬರತ್ತೀರಿ?
80,000 ಅಷ್ಟೇ ಇದೆ ಸರ್.
ಅಲ್ಲಿ ಎಲ್ಲಿಂದ ಬರತ್ತೀರಿ? ಅವೇ ಸರಿ, ನಾಳೆ ಬೇಕು. ನಾಳೆ ಆಗಲ್ಲ, ಲಿಸ್ಟ್ ಆಗ್ಬಿಟ್ರೆ ಸೋಮವಾರ ಬನ್ನಿ.
Serial number 181, my lords. There is an
ಬೇರೆ
interim.
ಆಯ್ತಲ್ಲ, ಇನ್ನೇನು ಮತ್ತೆ?
Alla, my lords, today, my lords, the serial number 51 is tagged along with serial number 51 is tagged along with 151, my lords. It may be listed in a fresh matters because, my lords, the order passed in serial number 51 is in contradiction to the order passed in serial number 181, my lords. I request, my lord, there are 6 to 7 writ petitions.
No problem. It will get listed. You mention on that day. Yes.
Yes, it is on 25th.
Interim order.
Before yesterday lot, for the PA token adopted one matter, more lot to issue lot. Tomorrow date was fixed lot. Lot rejected the matter for tomorrow lot. It is coming from renewal lot. Tomorrow lot.
ಆಯ್ತು ಹಾಕೋಣ. ಆಯ್ತು. ನಂಬರ್ ಕೊಡಿ.
Serial number 114.
We'll see. Yes. The fresh matter ಎಲ್ಲರದು ತಗೊಂಡು ಮುಂದೆ ಹೋಗಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ಡಿಸ್ಪೋಸಲ್ ಆಗ್ತಾ.
My lords, serial number 125, lordship. I am for the respond number 1, my lords. This is the rivalry between trust and society, my lords.
ಏನ್ ಬೇಕು ಹೇಳಿ ಸರ್?
Kindly, my lord, any short date, lords.
3rd December. Yes. ಏನ್ ಸದಿ?
ಸೀರಿಯಲ್ ನಂಬರ್ 45 ಡಿಸ್ಪೋಸ್ ಮಾಡಿಬಿಟ್ರೆ ಇವತ್ತು.
ಅದೇನೋ ಗಲಾಟೆ ಮಾಡ್ತಾರೆ.
ಅವ್ರದ್ದಾಯ್ತು, ನನ್ನಲ್ಲಿ
ನಿಮ್ದ್ರಲ್ಲೆಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಯ್ತು.
ಆಗಿಲ್ಲ. ಇವ್ರು ಕರ್ವಿಯವರು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದಾರೆ.
ತಮಗೆ ಯಾವ್ದು ಬೇಕು?
ಒಂದ್ ರಿಟ್ ಅಲೋ ಮಾಡಕ್ ನಂದೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಮ್ಯಾಂಡಮಸ್ ಇಟ್ ಮೇ ಬಿ ಅಲೌಡ್.
ಅದು ಅವ್ರಿಗೆ ಬೇಡ ಅಂತಲ್ಲ.
ಅವ್ರಿಗೆ ಬೇಡ ಅಂದ್ರೆ ಅದಕ್ಕೋಸ್ಕರ ನಂದು ಇದು ವೋಟ್ಸ್ ಕೌಂಟ್ ಆಗ್ತಾ ಇಲ್ಲ.
ಅಂದ್ರೆ ರೀಸನ್ ಇಸ್ ದಿಸ್, ಯಾರ್ಯಾರು ಸೋಲ್ತಾ ಇದಾರ ಅವ್ರು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕಂಟಿನ್ಯೂ ಆಗಲಿ ಅಂತ. ಈಗ ಅದು ನನ್ನ ಮ್ಯಾಟರ್ ಏನು ವಾಟ್ ಐ ರಿಕ್ವೆಸ್ಟೆಡ್ ವಾಸ್ ಎಲ್ಲ ರಿಸಲ್ಟ್ ಡಿಕ್ಲೇರ್ ಮಾಡ್ಲಿ. The board which comes millets will take decision.
ಎಲ್ಲ ರಿಸಲ್ಟ್ ಡಿಕ್ಲೇರ್ ಆಗ್ಲಿ.
ಅಷ್ಟೇ
in my matter where the interim order is
ಒಂದ್ ನಿಮಿಷ ಎಲೆಕ್ಷನ್ಸ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ. 25/10 ಆಗಿದೆ.
Yes, millets.
ಆಗಿದೆ.
ವಿಲ್ ಡಿಸ್ಪೋಸ್ ಎವ್ರಿಥಿಂಗ್
ಅಷ್ಟೇ.
ಅಲ್ಲೇ ಅರ್ಜಿ ಮಾಡ್ಕೊಳ್ಳಿ. ಯಾರ್ದಾರು ಆಗ್ಲಿ, ವೆಂಕಟೇಶ್ ಕಾರ್ವಿದಾರ ಆಗ್ಲಿ,
ಅಷ್ಟೇ ಮಾಡಿದ್ರೆ ಸಾಕು. ಎಲ್ಲ ಮ್ಯಾಟರ್ಸ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ.
ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ಯು ಟೇಕ್ ಇಟ್.
Kindly listen.
ಯಾನ್ ಬೇಕಾದ್ರೂ ರಿಟ್ ಅಪೀಲ್ ಹಾಕೋತಾರ ಬೇಕಾದ್ರೆ.
ಯಾವ್ದ್ರಲ್ಲಿ 482 ನಾನೆಲ್ಲಿ ಕೇಳಿದೆ?
ಅದು ತಮ್ಮದೇ SSC petition ಕಬೀಲ್ ಅಹಮದ್ ನಂದು. Yes, your lordship are pleased to hear the matter. The charge sheet consists.
How come 6 o'clock ನೀವು ಹೋಗಿಲ್ಲ?
ಇಲ್ಲ, ಈಗ ಬಂದಿದ್ದಾರೆ ಅವ್ರ ಮನೆಯಿಂದ. From morning he is not seen.
ಕೊಡಕ್ ಬಂದ್ರಾ? ಗಿರೀಶ್ ಕೊಡ್ತಾ
Reference to the pages in the charge sheet. 568 pages ಇದೆ ಅದಕ್ಕೆ.
ಅಲ್ಲ, ಇದನ್ನ ಕೊಡಕ್ ನೀವು ಅಲ್ಲಿಂದ ಬಂದ್ರಾ?
ಅವರು ಈಗ 6 ಗಂಟೆವರೆಗೂ ಇರ್ಸುತ್ತೆ. Still the court is going on.
ಅನಂತ್ ಸಾಹೇಬ್
serial number 45
it is not the case. It was retained 4-5 matters in that hearing.
That is the intention.
No, all right. Why not dispose everything to her?
Yesterday.
ಆದ್ರೆ ಏನಂತ?
Yes, millets.
Kindly listen.
ಗೊತ್ತಿರೋರ್ದು ಮಾತ್ರ ಇಟ್ಕೋಬೇಕು, ಗೆದ್ದಿರೋರ್ದು
ಹಂಗಲ್ಲ my lord.
That is his intention, millets.
Yesterday, my lord has passed an order under 21(3). Even I have the case of the same kind.
21(3).
Yes, that's what I made submission.
No. 21(3) I will retain.
Yes.
Others where elections are over.
Yes.
Yes.
21(3) ಇವರೇ ಮಾಡಿದ್ದಾರೆ.
21(3) ಇದೆ. ಇನ್ನು 4
ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ. I'm not saying about 21. Other matters.
And 21(3) we will dispose everything to
yes.
be.
Other than 21(3), yes.
Only one matter is there in that 21(3).
And 45, my lord, that order has to be modified.
No,
Why?
I will.
Senior,
Order has to modify.
that senior has made a submission, my lord, after taking the order from the hands of this honorable court, interim order, as to
ಅದನ್ನ modify ಮಾಡಿ.
yes, that has to be done. If that is
I'm
done,
not
my lord,
opposing.
yes.
I'm not opposing his prayer. No, one.
No.
I'm not. Yes.
No, you administrator is not assume charge ಅಂತ order ಮಾಡಿ.
Yes.
Now your term is over.
Yes.
Correct?
Yes.
Even as on today, your term is over.
Yes.
So you shall, as Justice Anant has passed an order, you shall not take any policy or financial decision.
Yes. One submission.
You can't. And
No, I
whatever
can't.
financial decisions you have
No,
taken.
but I'll
you will-
certainly, financial decision, absolutely, we can't take it.
No.
So far, one submission. Now, millets, the person who are elected, now this is the election to the apex body.
Whatever it is,
Yes.
sir, your term is over.
Yes, millets, we are.
When your
No, the
term
one
is
who is
over,
elected.
when your term is over, everything is over.
No, the persons who have been declared as elected. Now, we are required to send it, 22nd is the last date for sending the delegation.
That's all right. That doesn't mean your term
No,
will
except that.
continue.
Except that.
Now,
Because of policy
elections are over.
Yes.
Then your term is over, elections are over, few of you are defeated, few of you are retained, whatever it is, that's a different
Yes.
thing. Now, I have only directed that if administrator is not assumed charge, he shall not assume, he has assumed charge.
No, in this
He
case, he has
has not assumed charge.
All right.
Yes.
Now, since your term is over, till everything else is over, don't take any financial decisions.
No, yes.
Don't drain the society.
Yes,
Any
no.
policy decision
Millets, I
you
will
should
give,
not take.
I will only make submission, no financial decision will be taken.
Policy and financial
Yes.
decisions you shall not
Wait,
take
one second, sir.
as Justice Anant has held in the
Yes.
other case.
No, except sending the delegation. The reason is this, millets. We will lose one vote in the apex bank. Now, because of these
Your term is over, elinda bantu losing.
the elected person is sent. In a newly elected.
Newly elected body has come into existence.
No, because of the interim order. That's the reason why I requested.
No.
No,
The earlier body cannot send any delegation. Straight away, I will pass a detailed order if you want. Earlier body.
That's the reason why I
Earlier body whose term is over will not send any delegation for elections. New body coming in, definitely they will do it, no problem.
Yes,
And
yes.
You want the interim order to continue, it shall be on the term that no policy and financial decisions.
Please. No, millet, my request is this, millet. Let the direction be issued to the returning officer to declare the election. If there is a quorum,
Simple.
body will be constituted.
Simple.
ಅದಕ್ಕೆ ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಅಂತ ನಾನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರು. ಯಾಕಂದ್ರೆ ಅವರು ದೇ ನೋ ದೇರ್ ನಂಬರ್ಸ್.
ನಿಮಿಷ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ. I will dispose it and say that till the new body comes in, the present body will not, will be defunct.
Yes, my lord. Let there be a direction to declare the result within a period of 3 or 4 days, whatever bloods.
Still remaining, that 21-3 issue, that is still remaining. Another 4 petitions are there before my lord.
21-3 issue is independent of this.
Exactly.
Let the results be declared.
Yes.
Let the, whatever, they will not take any financial decision till the new body comes into it.
Exactly. By retaining that 21-3 issue 4 matters, the results, other
ಅಲ್ಲ
results
ಇವರು
may be
ಲೋಕಲ್
declared.
ಸೆಂಟಿನಲ್ ಅಂಡ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ I'll take your lordship. Since your lordship said I should not take financial decision, I'll agree to that.
ಅದರಲ್ಲಿ ಒಂದು ಕೆಲಸ ಮಾಡಿ. List on Monday in the fresh matters list. The interim order stands extended subject to the condition that the present body who is functioning on the strength of the interim order shall not take any policy or financial decisions till the next date. Monday will decide.
Please.
45.
All the matters will listed on Monday, my lord. 21-3 no your lordships can decide.
Serial number ಯಾವುದು?
45.16, my
My lord, 37, my lord, that senior had appeared, it is posted on 2nd, my lord. He is coming physically on 2nd on that. That 2 matters.
ಅಲ್ಲ ಅವ್ರಿಗೆ
Yes.
ಈಗ they can't have both, my lord.
Monday ಬರಲಿ. Let it come on Monday, we'll decide.
Yes.
My lord,
What can appear on this?
Yes.
45.2 and 45.11.
ವೆಂಕಟೇಶ್ ಕಾರ್ವೆ ಹತ್ರ ಹೇಳಿ.
ಅದೇ ಅವ್ರದೇ ಮೆನ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಕೊಡಿಸ್ರಿ ಕರ್ಕೊಂಡು ಹೋಗಿ.
My lord, regarding 45/1111, concern only, my lords, there were no resolution by the bank.
ನೀವು ಯಾಕೆ ಫೋನ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ? ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ serial number ಯಾವುದು correct ನೋಡ್ತಾ
Serial
ಇದ್ದೀನಿ. So there is no resolution. Resolution in respect of AGM, to attend the AGM ಅಷ್ಟೇ. That is only mine.
Disputed question of fact.
No disputed fact.
ಅಲ್ಲೇ
ಅಲ್ಲಿ ಅಲ್ಲ while
ನೋ
granting
AGM ನಾನು ಇಲ್ಲಿ ತೀರ್ಮಾನ ಮಾಡಲ್ಲ. What ವೆಂಕಟೇಶ್?
ಅಲ್ಲ my lord, while getting the interim, they have produced the AGM copy. AGM resolution of the copy ಹಾಜರ್ ಮಾಡಿದ್ದಾನೆ ಅಷ್ಟೇ.
ಅಲ್ಲೇ ಮಾಡ್ಬೇಕದು, ಇಲ್ಲಿ ಬರಲ್ಲ.
And second, my lord, 16.
ಅದಕ್ಕೆ ಡಿಸ್ಪೋಸ್
ಅದರಲ್ಲಿ
ಅದು ಮಾಡಿದ್ದು ರಿಕಾಲಿಂಗ್ ಮಾಡಿಸಿದ್ರು.
My lords, 16 is concerned. 4516. That term of the
ನೀವು ಫಸ್ಟ್ ಟೈಮ್ ಗೊತ್ತು ಒಪ್ಕೊಂಡಿದ್ದು ಕರೆಕ್ಟ್ ಆಗಿತ್ತು, ಕವರ್ ಅಲ್ಲಿ ಕಳಿಸ್ಬಿಡಿ ಅಂತ.
ಹೌದು.
ರಾತ್ರಿ ಯೋಚನೆ ಮಾಡ್ಬಿಟ್ಟು ಬೆಳಗ್ಗೆ
ಮತ್ತೆ ಬಂದು ಮಾಡಿ ಮತ್ತೆ ಎಲ್ಲ ಆರ್ಡರ್ ರಿಕಾಲ್ ಮಾಡಿಸ್ಕೊಂಡ್ರು.
ಎರಡನೇ 4516 ಅಲ್ಲಿ my lord, so far as writ petition 4516 is concerned, ಅದರಲ್ಲಿ the CEO has no already his term is expired ಅಂದ್ರೆ 60 ಏಜ್ ಆಗಿದೆ. ಅಲ್ಲ ಎಕ್ಸ್ಪೈರ್ಡ್ ಅಲ್ಲ, ಟರ್ಮ್
ಮ್ಯಾಂಡಮಸ್ ಅಲೋ ಮಾಡಿ ನಂದು ರಿಟ್ ಅಲೋ ಮಾಡಿಬಿಡಿ, ನಂದೇನ್ ತೊಂದರೆ ಇಲ್ಲ. ರಿಟ್ ಪಿಟಿಷನ್ ಅಲೋ ಆಗಕ್ ತೊಂದರೆನೇ ಇಲ್ಲ ನಂದು.
ಟರ್ಮ್ ಈಸ್ ಎಕ್ಸ್ಪೈರ್ಡ್ even though he has made a resolution.
CEO ಎಕ್ಸ್ಪೈರ್ ಆದ್ಮೇಲೆ ಹೆಂಗ್ ಮಾಡಿದ್ರೆ
that is your 1516 ಅಲ್ಲಿ ಬರಲ್ಲ.
Now my lord, he has in 45.2 and 45.11 we both have voted. Your lordship may direct to count the election and declare the results. But 45.13 is the mandamus to consider his representation. Let his writ petition may be allowed direct to consider his representation.
ಅಲ್ರಿ 16 ಅಲ್ಲಿ ನಾನು ಕೇಳಿನಿ, ಸೆಟ್ ಸೈಡ್ ಕೇಳಿ, ಯಾಕಂದ್ರೆ he has no
ಫ್ರೈಡೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ನಾಳೆ ಲಿಸ್ಟ್ ಆಗೋಗಿದೆ.
ಪ್ಲೀಸ್
ಫ್ರೈಡೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲ ಮುಗಿಸ್ಬಿಡೋಣ.
ಅದು 25ರಿಂದ ಅದು ಎಲೆಕ್ಷನ್ ಇದಾಗಿ
ಏನ್ ಮಾಡ್ಲಿ ಈಗ? ಅವ್ರು ಖುಷಿಯಾಗಿದ್ದಾರೆ 8 ಜನ.
My lord, one submission.
45.14 can be disposed of. ಅದು voting ಇದೆ.
List day after tomorrow. ಅವ್ರದ್ದು ಯಾವುದು?
45.2, 45.11 and 13
ಬರ್ಕೊಂಡ್ರೆ 45.2, 45.11 and 45.13.
45.
Friday fresh matters.
0.14 can also be.
My lord,
0.14.
No.
14 also.
My lord,
20 ಆಗುತ್ತೆ ಏನೀಗ?
My lord, 21.3, 21.3 is involved in this.
ಒಂದೇ vote ಇರೋದು.
Because my lord, yesterday my lord has passed an order similar, same kind of order. He has voted thrice. He has taken delegation thrice.
What I am saying is, let his vote be considered. If the difference is more than 1, then my result should not be declared.
Yesterday my lord, he only, I mean, the same council had argued.
ಅದನ್ನೇ ಅವರು ಹೇಳ್ತಾ ಇರೋದು ಈಗ.
Let his petition be allowed.
If it is even, it should not be counted.
Yeah, if it is more than 2, let his results be not declared. If it is more than 1 ಅಂದ್ರೆ ಅವ್ರು ಒಂದೇ vote ಸಲುವಾಗಿ.
Friday ಅದು serial number ಏನು?
Monday.
45.14.
ಅದು Friday, fresh
My
matters.
lord, Monday, other matters are coming, like,
But
ನಿಮ್ಗೆ allow ಮಾಡಕ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಸರ್.
ಅಲ್ಲ, correct.
Friday, fresh matters.
45 my lord, 15.
ನೀವಿರಲ್ವಾ? ಸಿರ್ಸಿಗೆ ಹೋಗ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ, KDCC ಬ್ಯಾಂಕ್
Lords,
ವತಿಯಿಂದ
45.15 my lord, 15. Lord, it is covered, my lord, your lordship's order. Lord, 21.3 my lord. He has, my lord, already voted twice, my
ಆ ಥರ
lord.
ಆಗಲ್ಲ. We'll have to pass a detailed order. Wait.
ಅಲ್ಲ, it is
ಅದು
covered.
Friday ಹಾಕೋಣ.
Your lordship's order is there.
Friday will pass. If the other side says it is covered, we'll close it. Who is the other side?
He's, my lord, he was under.
ಅವರಲ್ಲಿ ಹೋಗ್ತಾರೆ.
Initially,
ಅಲ್ಲ,
ಅಲ್ಲ, initially only he was under.
ಅವ್ರು ಒಪ್ಪೋದೇ ಇಲ್ಲ.
My name has to be shown. in
ಅಲ್ಲ,
that
he himself,
matter.
his order is there. He was appeared. He was appeared and argued in that matter.
Yes,
My
yes.
name may be shown, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ? 45.
15.
45.15 registry to print the name of Saurabh
Saurabh Hegde.
Hegde appearing for
R number 6.
respond number 6. ನಿಮ್ದೇನು ಸರ್?
My lord, I am passing the two judgments passed by the honorable coordinate bench of this honorable court, my lord. For this reason only, my lord, he is not cooperating the disposal of the cases, my lord. My lord, the result of the election conducted.
Friday ಅಷ್ಟೇ. No further non cooperation. Friday.
Please.
ಎಲ್ಲ ಫ್ರೈಡೆಗೆ ಹಾಕಿದ್ದು. ಈ ಕೊಟ್ಟಿದ್ದೆಲ್ಲ ಫ್ರೈಡೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Please.
ಅಷ್ಟೇ.
Lordship, it's pass over matter. Lordship. Item number 31 of first list.
ಏನಕ್ಕೆ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ? ನೀವು ಇದ್ದೀರಾ? Why was it passed over?
Senior counsel was not there, Lordship, and it's not been enabled to appear since some technical issue, Lordship.
In the meanwhile, my lord, I'll file statement of objections also for
ಈಗ
R5.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ?
No,
Entry
Lordship.
model.
Randomness ಕೇಳ್ತಾರೆ.
Entry model and final reply for the
ಡೈರೆಕ್ಟರ್
same.
Chief Financial Officer.
ಚೀಫ್ ಫೈನಾನ್ಷಿಯಲ್ ಆಫೀಸರ್.
Yes, sir.
Entry model and final relief for the same, lord.
ಆಯ್ತು, we'll take it on Tuesday then.
Not,
No, Lordship.
could it be on
Wednesday, Lordship.
third,
ಶ್ರೀರಂಗ
lord?
ಸರ್, ನಿಮ್ ಮುಗಿಸಿದೀರಾ? Tuesday, yes.
Sir, I'm Lordship.
Lord,
I'm opposed.
I'll
It may be
file
having
SO
on Wednesday,
meanwhile,
Lordship. Why? Wednesday, Lordship, instead of
ಆಯ್ತು,
Tuesday, Lordship.
Wednesday, fine, yes.
Please, Lordship.
26th, fresh matters.
Please, Lordship.
Serial number 20, my lord, that also passed over.
Regularization, list after 2 weeks. Yes.
Told by my lordship's judgment.
ಅದಕ್ಕೆ list after 2 weeks. ಇರಿ ಸರ್ ಮಾಡ್ತೀನಿ. List on 2nd or 3rd ಹಾಕಿ. Passed over matter 3rd, 20 ಹಾಕಿ. Yes.
21 passed over covered ಇದೆ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಮ್ಯಾಟರ್.
ಅದು that's we'll take it on Tuesday. ನಾನೇ ಡಿಕ್ಟೇಟ್ ಮಾಡ್ಬೇಕಾಯ್ತು. Tuesday.
With apologies, morning I made a mention regarding one matter. Memo is given tomorrow. It appears there is some road. It has come to the board branch. There is a caveat also. Again, Marod, by moving tomorrow, I don't want to take him by surprise. So tomorrow it may be directed to be listed. Fresh matter.
ಈಗ ಈ ಲಿಸ್ಟ್ ಆಗೋಗಿದೆ. ನಾಳೆ
Board ಗೆ ಬಂದಿದೆ.
ನಾಳೆ ಮಾಡಿ 2:30 ಗೆ ಹಾಕ್ತೀನಿ.
ಅಲ್ಲ, ಅದೇ 2:30 ಅಂದ್ರೆ caveat Marod. Sunday there are elections. So I don't want to.
ಕೇವೇಟ್ ಯಾರು?
Kalwad ಅವರು ಇದ್ದಾರೆ.
ಕಾಲ್ವಾಡ ಕೊಡಿ.
ಕಾಪಿ ಕೊಟ್ಟಾಗಿದೆ ಆಲ್ರೆಡಿ.
ಕೊಟ್ಟಾಗಿದ್ಯಾ?
It is listed tomorrow, then Marod I can.
Now it can't be listed. List is already out.
I'm told it still can be ಹಾಕ್ಬೋದು.
ಅಲ್ಲ, ಲಿಸ್ಟ್ ಆಗುತ್ತಾ ಮೇಡಮ್? ನಾಳೆ ಲಿಸ್ಟ್ ಆಗುತ್ತಾ? ಆಲ್ರೆಡಿ ಆಗೋಗಿದೆ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿ ನೋಡಿ. ಎಲೆಕ್ಷನ್ಸ್ ಇದೆ ಯಾವ್ದು? ಕಾಲ್ವಾಡ
This is challenging the disqualification order. So the entire Marod TAPCMS will be deprived of Marod voting in the. Please.
ಅವರಲ್ಲಿ ಸರ್ ಬನ್ನಿ. ಗಂಗಾಧರ್, ನಿಮ್ದು ಯಾವ್ದಾರು ಇದೆಯಾ? ಯಾವ್ದಿಲ್ಲ.
ಮಿಲಾಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಬ್ಯಾಂಗ್ಳೂರ್ ವಿಸಿ
ಅವರೇ ನಿಂತಿದ್ದಾರೆ ಸರ್ ಮಾಡಕ್ಕೆ. ನೀವು ಕೇಳಿಸ್ಕೊಳ್ಳಿ.
ಆಯ್ತು. ಮ್ಯಾಟರ್ ವಾಸ್ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ಜಡ್ಜ್ಮೆಂಟ್.
It was not posted for judgment. It was reserved for judgment.
Yes. Reserved.
In trial court, posted for judgment annake.
Reserved.
Yes.
Sir, the transaction amount is rupees 68 lakhs. ಅದರಲ್ಲಿ amount by
Mic use ಮಾಡಿ ಸರ್.
Claimed amount by way of check is 1 crore 36 lakhs 50,000. The difference between the claimed and check amount is 68 lakhs 50,000. And claiming interest at 2% per annum, amounting to 24% annum, and he has claimed rupees 26 lakhs 70,000 as previous balance amount, but he has not filed memo. Having received the final amount, withdrawn the cases. Accused was an MLA for 3 terms and is now defeated MLA of reserved constituency, which is Mudigere.
ಡಿಫೀಟ್ ಆಗೋದಕ್ಕೂ ಚೆಕ್ ಕೊಡೋದಕ್ಕೂ ಏನು?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದನ್ನ ನಾನು ಚೂರು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಬಿಕಾಸ್ ದ ರಿಲೇಶನ್ಶಿಪ್ ಗೋಸ್ಕರ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಆಯ್ತಾಯ್ತು.
Complaint is a native of Mudigere constituency, had a close acquaintance of about 15 years. Accused has a lot of fight on complainant. He has entrusted public work relating to the constituency and personal work, including the financial matter, to the complainant. Complaint has deposed before the trial court in the cross-examination. The page number 1, para 1 and 2, with respect to difference in writing of check, if marked as exhibit P1 to exhibit P12. Complaint has admitted that there are difference in check writing in cross-examination. PW1 is in page number 8. PW1 page number 11. Complaint is an accused number 1 in CC number 2616 of 2019, pending before the senior civil judge and CJM at Chikmagalur under IPC section 468, 471, 420, read with section 34. It is still pending. During the cross-examination, the complainant has stated that he has possessed a BPL ration card, for which families who has less than income of 1 lakh and 25,000 only per annum are eligible. Possession of the said card was not accidental, but it is intentional, for the reason he has not surrendered the same despite newspaper publication to that effect by the government. Complainant claimed through his advocate at the time of hearing on before this hearing. Maswami, my lord, 31/10/25, the wife has obtained the BPL ration card without the knowledge of the complainant, he states. It is not visible. Per contra, the state of Karnataka, as per present norms, woman who is the head of the family, ಹೌದು ಹೆಡ್ ಇದಕ್ಕೆ BPL ಕಾರ್ಡ್ಗೆ
BPL ಕಾರ್ಡ್
ಯಾತಕ್ಕೆ ಕೊಡ್ತಾರೆ ಅಂದ್ರೆ, ಇವ್ರು ಬಾಕಿಯವರೆಲ್ಲ ಡ್ರಿಂಕ್ಸ್ ಮಾಡ್ಕೊಂಡು ಮಿಸ್ಯೂಸ್ ಮಾಡ್ತಾರೆ ಅನ್ನೋ ಉದ್ದೇಶಕ್ಕೆ ವುಮನ್ ಅವರ ಹೆಸರಲ್ಲಿ ಹೆಡ್ ಆಫ್ ದಿ ಫ್ಯಾಮಿಲಿಗೆ BPL ಕಾರ್ಡ್ ಕೊಡ್ತಾರೆ.
ಮೆನ್ನೆಲ್ಲ ಕುಡಿದು
ಅನ್ನೋ ಒಂದು ಸದುದ್ದೇಶದಿಂದ ಅದನ್ನ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. Income, the family and other members, including their children, and BPL card is used as a family as a whole and not issued to a single person or ಹೇಳಿದಂಗೆ. Individually, every member is liable to disclose his income and surrender the BPL ration card if he is not eligible, if annual income of the family, including all the members, should not exceed rupees 1,25,000 per annum. The advocate of the complainant has claimed that the complainant's family has already surrendered the BPL card, but has not produced the documents pertaining to this before this honor board. Hence, it is to be concluded that still complainant is possessing the BPL ration card. And as per section 138 NI Act, the complainant can secure only transaction amount and not entitled to claim any interest. In these cases, the complaint has paid rupees 68 lakhs as principal and has claimed 68 lakhs rupees 50,000 as interest. 68 ಲಕ್ಷ ಕ್ಲೈಮ್ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ 8 ಚೆಕ್ಗಳಲ್ಲಿ. ಅದು ಪ್ರೀವಿಯಸ್ ಚೆಕ್ ಇನ್ ಬಗ್ಗೆ ಅವ್ರು ಹೇಳ್ತಾರೆ, ಅದಕ್ಕೆ ಮುಂದೆ ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ.
ಮುಂದೆ ಹೇಳಿ.
Further, the complainant is claiming 2% interest per month, which amounts to 24% per annum, which is barred by law. Further, the complainant is not registered money lender. And he is not entitled to make final transaction, even if they agreed by this accused according to the General Clauses Act. In respect of exhibit P16, complainant claims that the accused had admitted the transaction of rupees 68 lakh in 8 cases which are pending before the honorable court. ಸ್ವಾಮಿ ಇದರಲ್ಲಿ
ನೀವು MLA ಅಲ್ವಾ?
ಅವ್ರ MLA
ಅವರ
ಈಗ ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವಾಗ
ಅವಾಗ MLA ಅಲ್ವಾ?
ಈಗ
ಇವ್ರ ಹತ್ರ ಯಾಕೆ ಇಸ್ಕೊಂಡ್ರಿ ನೀವು? ಇವ್ರ ಹತ್ರ ಯಾಕೆ ಇಸ್ಕೊಂಡ್ರಿ
ಸ್ವಾಮಿ? ಇದರಲ್ಲಿ ಪ್ರೀವಿಯಸ್ ಅಲ್ಲಿ ಅವರು ಅದನ್ನ 1 crore 65 lakhs ಅಂತ ಇಸ್ಕೊಂಡಿದ್ರು 3 ಕೇಸಸ್ ಅಲ್ಲಿ.
ಅಲ್ಲ, BPL ಕಾರ್ಡ್ ಹೋಲ್ಡರ್ ಹತ್ರ ಹೋಗಿ ದುಡ್ಡು ಯಾಕೆ ಇಸ್ಕೊಂಡ್ರಿ ಅಂತ?
ಅವ್ರು BPL ಕಾರ್ಡ್ ಹೋಲ್ಡರ್ ಅಂತ ಸುಳ್ಳು ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅಂದ್ರೆ ಈಗ BPL ಕಾರ್ಡ್ ಹೋಲ್ಡರ್ ಇವರು ಸರ್ಕಾರಕ್ಕೆ ಸುಳ್ಳು ಹೇಳಿ BPL ಕಾರ್ಡ್ ಪ್ರೊಕ್ಯೂರ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಹಿ ಇಸ್ ವೆಲ್ ಟು ಡೂ. ಯಾಕೆಂದ್ರೆ ಇನ್ ದಿ ಇದರಲ್ಲಿ
ಏನೋ ಹೇಳಿದ್ರಲ್ಲ, ಏನ್ ಹೇಳಿದ್ರಿ? ಈಸ್ ವೆಲ್ ಟು ಡೂ ಅಂದ್ರಿ ಅಲ್ವಾ? BPL ಕಾರ್ಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೋಯ್ತಾ?
ಅಲ್ಲ, ಹಂಗಲ್ಲ. ನಾನು ಹೇಳ್ತಾ ಇರೋದು BPL ಕಾರ್ಡ್ ಅನ್ನ ಒಬ್ಟೈನ್ ಮಾಡಿದ್ದಾರೆ, ಪ್ರೊಕ್ಯೂರ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ವೆನ್ ಇಸ್ ಅಡ್ಮಿಟೆಡ್. ಇದರಲ್ಲಿ ಸಪರೇಷನ್ ಆಫ್ ಮೆಟೀರಿಯಲ್ ಫ್ಯಾಕ್ಟ್ಸ್
ಅಲ್ಲ, ಬಟ್ ವೆಲ್ ಟು ಡೂ ಇದಾರೆ ಅಂದ್ರಲ್ಲ. ಈಸ್ ವೆಲ್ ಟು ಡೂ
ಅಲ್ಲ, ಅದನ್ನ ಅವರು ಈವನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಅವ್ರು ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ. ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ದಟ್
ಅಂದ್ರೆ ಚೆಕ್ ಅಮೌಂಟ್ ಕೊಡಕ್ಕೆ
ಅಲ್ಲ, ಹಂಗಲ್ಲ. ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ದಟ್ ಈಸ್ ಸ್ಟೇಟಿಂಗ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ದಟ್ ಐ ಆಮ್ ಎ BPL ಕಾರ್ಡ್ ಹೋಲ್ಡರ್ ಅಂತ ಅದನ್ನ ಹೇಳಿಲ್ಲ.
ಅಂದ್ರೆ ವೈಫ್ ಇಸ್ BPL ಕಾರ್ಡ್ ಹೋಲ್ಡರ್.
ವೈಫ್ ಅಲ್ಲ ಟೋಟಲಿಗೆ
ಗಂಡಸರು ಕೊಡಲ್ಲ ಅಂದ್ರೆ ನೀವೇ.
ಒಂದ್ ನಿಮಿಷ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ
ನೀವೇ ಈಗಲೇ ಗಂಡಸರು ಕೊಟ್ರೆ ಕುಡಿದ್ ಬಿಡ್ತಾರೆ ಎಲ್ಲ ಅನ್ಬಿಟ್ಟು ಕೊಡಲ್ಲ ಅಂದ್ರೆ
ಇಲ್ಲಿ BPL ಕಾರ್ಡ್ ಎಕ್ಸಿಬಿಟ್ ಮಾರ್ಕ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ 5 ಜನದ್ದು ಫೋಟೋ ಇದೆ ಸ್ವಾಮಿ.
ಫೋಟೋ
ಅಂದ್ರೆ ದೇ ಆಲ್ ಆರ್ ದಿ ಮೆಂಬರ್ಸ್ ಆಫ್ ದಿಸ್ ಫ್ಯಾಮಿಲಿ. ಅಂದ್ರೆ ಗೌರ್ಮೆಂಟ್ ಪ್ರೊಕ್ಯೂರ್ ಮಾಡಿರೋ BPL ಕಾರ್ಡ್ ಅಂದ್ರೆ ಹೂ ಇಸ್ ನಾಟ್ ಈವನ್ ಏಬಲ್ ಟು ಈಟ್ ಹಿಸ್ ಓನ್, ಇದರಿಂದ ಅರ್ನ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ.
Not able to eat his own food.
He deposed before the court. ಆಮೇಲೆ ಅದ್ರ ಜೊತೆಗೆ there are 2 ಏನಂದ್ರೆ BPL ಕಾರ್ಡು ಇದೆ ಅಂತ ಒಪ್ಕೋತಾರೆ, ನಾನ್ ಟ್ಯಾಕ್ಸ್ ಕಟ್ಟಿದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. When he has claimed 1 crore 40 lakhs, he has not ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಆಗ್ಲಿ ಏನೂ ಕಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ. ಆಯ್ತಾ? ಅದರಲ್ಲಿ
ಬಟ್ ಕನ್ವಿಕ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದ್ದೀರಲ್ಲ ನೀವು.
ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಆದ್ರೆ ಅದನ್ನ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆಗ್ಲಿ, ನೆಕ್ಸ್ಟ್ ಕೋರ್ಟ್, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮತ್ತೆ ಅಪಲೆಂಟ್ ಕೋರ್ಟ್, ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಕನ್ಸಿಡರ್ಡ್ ಮೈ BPL ಕಾರ್ಡ್ ವಿಚಾರನ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ. ಜೊತೆಗೆ
ಎವ್ರಿಥಿಂಗ್ ರಿವಾಲ್ವ್ಸ್ ಅರೌಂಡ್ BPL.
Everything revolves around BPL card because the previous transaction, whatever it has done.
No, everything revolves around BPL. Neighbors envy, owners pride.
ಅದರಲ್ಲಿ ದೃಢೀಕರಣನು ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ 26/3/2018 BPL ಕಾರ್ಡ್ ಚೀಟಿಯನ್ನು ಪಡೆದಿರ್ತಾರೆ. 5 ಜನ ಕುಟುಂಬ ಸದಸ್ಯರು 2018ನೇ ಸಾಲಿನಿಂದ ಜೂನ್ 22, 2022 ಮಾರೆಗೂ ಕೂಡ ಪಡಿತರವನ್ನು ಪಡೆದಿರುತ್ತಾರೆ. He has even obtained the government ಏನಂದ್ರೆ ಈಗ ಅಕ್ಕಿ ಬಿಡಿ ಫ್ರೀ ಅಕ್ಕಿ ಕೊಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಈಗೇನ್ BPL ಕಾರ್ಡ್ ಬೇಕಾಗಿಲ್ಲ, ಫ್ರೀ ಎಲ್ಲ ಬರ್ತಾ ಇದೆ.
ಅಲ್ಲ, BPL ಕಾರ್ಡ್ ಇದ್ರೆ ಮಾತ್ರ ಫ್ರೀ ಬರೋದು ಸ್ವಾಮಿ.
ಇದ್ರೆ ಮಾತ್ರ
BPL ಕಾರ್ಡ್ ಇದ್ರೆ ಮಾತ್ರ ಫ್ರೀ ಬರೋದು. ಅದು ಸರ್ಕಾರ ಪರ್ಚೇಸ್ ಮಾಡಿ ಇವ್ರಿಗೆ ಫ್ರೀ ಆಗಿ ಕೊಡುತ್ತೆ ಸ್ವಾಮಿ. 30 ರೂಪಾಯಿ ಪರ್ಚೇಸ್ ಮಾಡಿ ಕೆಜಿಗೆ ಫ್ರೀ ಕೊಡುತ್ತೆ. ಅಕ್ಕಿ ಕೊಡದೇ ಇದ್ರೆ ಈಗ ದುಡ್ಡು ಕೊಡ್ತಾ ಇದಾರೆ ಸ್ವಾಮಿ.
ಈಗ ಅದೆಲ್ಲ ಯಾಕೆ ಚೆಕ್ ಕೊಡಕ್ ತಾಕತ್ತಿಲ್ಲ ಅಷ್ಟೇ ತಾನೆ.
ಅಲ್ಲ, ನನ್ನ ಕಂಟೆನ್ಷನ್ ಏನಕ್ಕೆ ಅಂದ್ರೆ ಪ್ರೀವಿಯಸ್ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ಕಂಟೆನ್ಷನ್ ಅಲ್ಲಿ ಪ್ರೀವಿಯಸ್ ಇದರಲ್ಲಿ ವಿ ಹ್ಯಾವ್ ಪೇಡ್. ಹಿ ಹ್ಯಾಸ್ ಕ್ಲೈಮ್ ದಿ ಅಮೌಂಟ್ ವಿಚ್ ಈಸ್ ಬಿಯಾಂಡ್ ಇದು 68 ಲಕ್ಷ ಕ್ಲೈಮ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಸ್ವಾಮಿ. ಆದ್ರೆ ಅದನ್ನು ಕೂಡ ಅವರು 8 ಚೆಕ್ಗಳನ್ನ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಮಾಡಿ ಅದನ್ನ ಮಿಸ್ಯೂಸ್ ಮಾಡಿ ಅವ್ರು ಚೆನ್ನಾಗಿರೋ ಉದ್ದೇಶದಿಂದ ಅದನ್ನ ಮಾಡಿದ್ದಾರೆ, ಮೋಸ ಮಾಡಿದ್ದಾರೆ. ಜೊತೆನಲ್ಲೇ ಓಡಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಇದು ಕ್ಲಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನಲ್ಲಿ ಎಲ್ಲ ರಿವೀಲ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಯಾರ ಜೊತೆಯಲ್ಲಿ ಇದ್ದಿದ್ದು?
The MLA along with the complainant who is ಜೊತೆನಲ್ಲೇ ಫೈನಾನ್ಷಿಯಲ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಮಾಡ್ಕೊಂಡು ಜೊತೆನಲ್ಲೇ ಇದ್ದಾರೆ ಸ್ವಾಮಿ ಇದ್ರು ಅವಾಗ, ಬಿಫೋರ್ ದಿಸ್ ಹ್ಯಾಪನ್ ಆಗೋಕ್ಕಿಂತ ಮುಂಚೆ. ಈಗ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಪಾರ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಚೂರು ಹೇಳ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ. ಆರೋಪಿತ ಮುಳುಗೆ ಮನೆ ನನ್ನ ಮನೆ ಸುಮಾರು 30ರಿಂದ 36 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿ ಇದೆ ಎಂದ್ರೆ ಸರಿ. ಆರೋಪಿತ ಮನೆ ಕೂಡ ಇತ್ತು ಎಂದ್ರೆ ಸರಿ. ಸದರಿ ಮನೆ ನಾನು ಚಿಕ್ಕಮಗಳೂರಿನ ಮನೆಯಿಂದ ಸುಮಾರು
ನೀವ್ ಹಿಂಗೆಲ್ಲ ಓದೋದು ಸರಿ ಅಲ್ಲ, ಅದನ್ನ ನೋಡ್ಕೊಂತೀನಿ ಕೊಡಿ, ಅದೆಲ್ಲ ಸರಿ ಇದೆ.
ಇಲ್ಲಿ ಮೇಲೆ ಹೇಳಿದ 1,66,70,000 ರೂಪಾಯಿಗಳನ್ನು 2015ರಿಂದ 2017 ಒಳಗೆ ಕೊಟ್ಟಿರ್ತೇನೆ. ಕೊಟ್ಟಿರೋ ಬಗ್ಗೆ ಅಂದಿನ
2015ರಿಂದ 2017ರವರೆಗೆ
17ರವರೆಗೆ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಇಷ್ಟು ಮೊತ್ತವನ್ನು ಕೊಟ್ಟಿರೋ ಬಗ್ಗೆ ಅಂದಿನ ರಿಟರ್ನ್ಸ್ ನಲ್ಲಿ ತೋರಿಸಿರುವುದಿಲ್ಲ. ನೋಡಿ, ಅವ್ರು ಈ ಕಡೆ ಈ ತರ ಹೇಳ್ತಾರೆ. ಇದನ್ನೇ ಮತ್ತೆ ಹಂತ ಹಂತವಾಗಿ ನಗದು ಹಣವನ್ನು ತಂದು ಆರೋಪಿ ಕೊಟ್ಟಿರುತ್ತೆ. ಹಿಂದೆ ನಾನು ಆರೋಪಿ ವಿರುದ್ಧ ಚೆಕ್ ಅಮಾನ್ಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ 3 ದೂರುಗಳನ್ನು ಸಲ್ಲಿಸಿದ್ದು, ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ
ಅದು IPC ಅಫೆನ್ಸ್ ಅಲ್ಲಿ ಸಿಗಾಕೊಳ್ಳಿಲ್ಲ. ನಮ್ ಗತಿ ಏನ
ದಿನಾಂಕ ಇದರಲ್ಲಿ
38ಗೆ ಇಷ್ಟೊಂದು.
ದಿನಾಂಕ 4/4/2002 ನಾನು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮೆಮೊ ಸಲ್ಲಿಸಿ ದೂರನ್ನು ಹಿಂದಕ್ಕೆ ಪಡೆದಿದ್ದೇನೆ ಸರಿ. ಇದೇ ರೀತಿ ನಾನು ಇನ್ನು 2 ದೂರಿನಲ್ಲಿ ಕೂಡ ದೂರಗಳ ಹಿಂದಕ್ಕೆ ಪಡೆದುಕೊಂಡ. ಸದರಿ ಮೆಮೊಗಳಲ್ಲಿ ನನಗೆ ಇನ್ನು 26 ಲಕ್ಷ ರೂಪಾಯಿ ಬರಬೇಕು ಎಂದು ಹೇಳಲಿಲ್ಲ ಅಂದರೆ ಸರಿ. ಆ ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ ಪ್ರೀವಿಯಸ್ ಕೇಸಸ್ ಅಲ್ಲಿ. ಅದು 1,40,00,000 ಅಮೌಂಟ್ ಅನ್ನ DD ಮುಖಾಂತರನೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರಿಗೆ. ಅದಾದ್ಮೇಲೆ ಇವ್ರ ಕಂಟೆನ್ಷನ್ ಏನಂದ್ರೆ ಎಕ್ಸಿಬಿಟ್ P16 ಸ್ವಾಮಿ.
ಎಕ್ಸಿಬಿಟ್
P16 ಅದರಲ್ಲಿ ಪ್ರೀವಿಯಸ್ ಕೇಸಸ್ ಸಂಬಂಧಪಟ್ಟ ಹಾಗೆ ದ MLA ಆಸ್ ಎ ರಿಟರ್ನ್ ಲೆಟರ್ ಅಡ್ಮಿಟಿಂಗ್ ದಟ್ ನೀವು ಚೆಕ್ ಇಲ್ಲಿ ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ. ನಿಮ್ಮ ವಕೀಲರಾದ ಶ್ರೀಯುತ ದಯಾಸ್ ಅವರ ಮುಖಾಂತರ ನಾನು ಕೊಟ್ಟಂತಹ 3 ಚೆಕ್ಗಳ ಅಮಾನ್ಯಗೊಂಡ ಬಾಬತು ಕೊಟ್ಟ 3 ನೋಟಿಸ್ ತಲುಪಿರುತ್ತೆ. ನಾನು ಕೊಟ್ಟಂತಹ 3 ಚೆಕ್ಗಳು ವಿಜಯ ಬ್ಯಾಂಕ್ ಚಿಕ್ಕಮಗಳೂರು ಶಾಖೆ 2 ಚೆಕ್ಗಳು 70-49-49 ಮತ್ತು ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಕೋಆಪರೇಟಿವ್ ಬ್ಯಾಂಕ್ ಚೆಕ್ ನಂಬರ್ 42-19-17 85 ಲಕ್ಷ 80 ಲಕ್ಷ ಮತ್ತು 1,70,000 ನನಗೆ ಕೂಡಲು ಕೊಡೋದು ಕಷ್ಟಸಾಧ್ಯನೇ. ಇಂದಿನ 15 ದಿನಗಳಲ್ಲಿ ಕೊಟ್ಟು ನಿಮ್ಮಿಂದ 3 ಚೆಕ್ಗಳನ್ನು ವಾಪಸ್ಸು ಪಡೆಯುತ್ತೇನೆ ಅಂತ. ಅವ್ರು ಅದೇ ತರ 1,40,00,000 ರೂಪಾಯಿನ ಇವ್ರಿಗೆ DD ಕಳಿಸಿದ್ದಾರೆ. ಕೋರ್ಟ್ಗೂ ಕೊಟ್ಟಿಲ್ಲ. ಕೋರ್ಟಲ್ಲಿ 3 ಕಂಪ್ಲೇಂಟ್ಸ್ ವಾಸ್ ಪೆಂಡಿಂಗ್. ಅವ್ರು ಕೊಟ್ಟು 1 ತಿಂಗಳ ಆದ್ಮೇಲೆ ದಿ ಕಂಪ್ಲೈನೆಂಟ್ ಹ್ಯಾಸ್ ವಿತ್ಡ್ರಾನ್ ದೋಸ್ 3 ಕೇಸಸ್ ಮೈ ಲಾರ್ಡ್. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಪ್ರೀವಿಯಸ್ ಆಗಿ ಇವರು ಆ 68 ಲಕ್ಷನ ಇವ್ರು ಕೇಳಿದ್ರು ಅಂತ ಇವ್ರಿಗೆ ಮತ್ತೆ ಕಳಿಸಿದ್ದಾರೆ. ಅದು ಆ ಅಮೌಂಟ್ ಏನ್ ಕಳಿಸಿದ್ದಾರೆ ದಟ್ ಈಸ್ 68 lakh. ಅದು ಅವ್ರವ್ರ ಕಡೆಯವ್ರಿಗೆ ಅದು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ. ದಿಸ್ 68 lakhs ಏನಿದೆ ದಟ್ ಈಸ್ ಈಗ ಕೇಸಸ್ ಇರೋದು. ಇವ್ರು ಆಗ್ಲೇ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂದ್ರಲ್ಲ, ಅದಲ್ಲ ಸ್ವಾಮಿ. ಜೊತೆಗೆ ಮೆಮೊ ಕೂಡ ಇದಿದೆ. In relation to the Honorable Supreme Court on the judgment ಕೊಟ್ಟಿದೆ ಸ್ವಾಮಿ.
ಹೌದಾ?
ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ 2025 INSC 399 ರೇಖಾ ಶರದ್ ಯುಶಿರ್ ಸಪ್ತರ್ಷಿ ಮಹಿಳಾ ನಾಗರಿಕ ಸಹಕಾರಿ ಪಠಾಂಶ ಅಂತ ಸ್ವಾಮಿ. ಇಲ್ಲಿ Criminal Procedure Code 1973 Section 200 examination of the complaint not an empty formality, duty to ascertain truth. The examination of the complainant on oath by magistrate under Section 200 CRPC is not a mere procedural step but a duty bound exercise to ascertain the truth and determine if sufficient ground exists to proceed against the accused. The magistrate must apply judicial mind to the complainant accompanying documents and the statement recorded. When the facts or documents are suppressed by the complainant, it is hindered magistrate ability to make proper assessment. Had the support letters demanding documents been disclosed, the magistrate could question the complainants regarding the supply of documents potentially dismissed the complaint under section 203 CRPC if unsatisfactory. See, Negotiable Instrument Act, status notice reply, duty to provide relief upon documents upon demand. When an accused receives a statutory notice under section 138 NI Act before the expiry of the 15-day reply period of
ನೀವು ಆತರ ಪೂರ್ತಿ ಜಡ್ಮೆಂಟ್ ಓದಿದ್ರೆ
ಇಲ್ಲ ಇದು ಒಂದೇ
ನಾಳೆ ಬೆಳಗ್ಗೆ ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟಾರ್ಟ್ ಆಗ್ಬಿಡುತ್ತೆ.
ಇಲ್ಲ ಬಟ್ ಇನ್ನು ಒಂದೇ ಒಂದು
ಆಯ್ತು.
ಐ ವಿಲ್ ನಾಟ್ ಟೇಕ್ ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದಟ್.
ನಿಮ್ ಫ್ಲೈಟ್ ಎಷ್ಟೊತ್ತಿಗೆ?
ನಾನು ಟ್ರೈನಲ್ಲಿ ಹೋಗ್ತೀನಿ ಸ್ವಾಮಿ.
11 ಗಂಟೆಗೆ?
9:30 ಟ್ರೈನ್.
9:30ನಾ?
9:30 ಟ್ರೈನಲ್ಲಿ ಹೋಗ್ತೀನಿ. The quashing of complaint and cognizance order where the initiation of criminal complaint under section 138 NAC is found to be vitiated complaint suppression of material facts and constitutes an abuse of process of law. High Court ought to interfere and quash the proceedings. Consequently, complaint and the order taking cognizance issuing process passed by the magistrate are liable to be or hereby quashed and set aside.
ಆಯ್ತು, ಕ್ವಾಶ್ ಮಾಡೋಣ ಬಿಡಿ.
ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ
ಹಾ ಕೊಡಿ ಕೊಡಿ ಕೊಡಿ.
ಇನ್ನ ಒಂದಷ್ಟು ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಬಟ್
ಹೇಳ್ಬೇಕಾಗಿದೆ ಏನು?
ಹೌದು ಸ್ವಾಮಿ, ಇನ್ನೊಂದು 4 ಪಾಯಿಂಟ್ಸ್ ಇದೆ.
ಹೇಳ್ಬಿಡಿ.
ಅದನ್ನ ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಟ್ರೆ ಹೇಳ್ತೀನಿ.
ನೋ ಡೇಟ್ ರಿಸರ್ವ್ ಆಗಿರೋದು ಇವತ್ತು ಹಾಕಿರೋದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ನಥಿಂಗ್. ನೋ ಡೇಟ್.
ಆಯ್ತು ಸ್ವಾಮಿ. ಹೆನ್ಸ್
ಇದರಲ್ಲಿ ಹೇಳಿಲ್ವಾ ಪಾಯಿಂಟ್ ಗಳೆಲ್ಲ? ಆ ಪಾಯಿಂಟ್ ಎಲ್ಲ ಹೇಳಿಲ್ವಾ?
ಕೆಲವು ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ, ಯಾಕೆಂದ್ರೆ ಈ ಟೈಮಲ್ಲಿ
ಇಷ್ಟೊತ್ತಲ್ಲಿ ಅಂತಲ್ಲ, ನೀವು ಮುಂಚೆನೆ ಅವಾಗ್ಲೂ ಹೇಳ್ಬೋದು.
ಅಲ್ಲ ಹಂಗಲ್ಲ, ಯಾಕೆಂದ್ರೆ ತಮ್ಮ ಟೈಮ್ ಅನ್ನ ಈಗ ಇದ್ ಮಾಡಲ್ಲ ನಾವು. ಬಟ್ ಒಂದ್ ದಿನ ಕೊಟ್ರೆ ಅಲ್ಲ,
ರಿಸರ್ವ್ ಆದ್ಮೇಲೆ ಮುಗೀತು.
ರಿಸರ್ವ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಆದ್ರೂ ಇನ್ಸ್ಪೈಟ್ ಆಫ್ ದಟ್
ಇವತ್ತು ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
ಮೈ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್, ನನಗೆ ಈ ಕೆಲವು ಪಾಯಿಂಟ್ಸ್ ಗಳನ್ನ ಮಧ್ಯದಲ್ಲಿ ಅದನ್ನ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಕ್ ಆಗಿಲ್ಲ, ಎಲಿಸಿಟ್ ಮಾಡಕ್ ಆಗಿಲ್ಲ. ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ BPL
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, BPL ಕಾರ್ಡ್ ವಿಚಾರದ ಬಗ್ಗೆ ಕೋರ್ಟ್ ಕೂಡ ಈಗ ನಾನೇನ್ ಹೇಳೋದೆ ಅಂದ್ರೆ, ಕಂಪ್ಲೈನೆಂಟ್ ಅಕ್ಯೂಸ್ಡ್ ಗೆ ಕನ್ವಿಕ್ಷನ್ ಆಗಿದ್ರೆ, ಇನ್ ಕೇಸ್ ದಿ ಕಂಪ್ಲೈನೆಂಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಪೇಡ್ ಎನಿ ಟ್ಯಾಕ್ಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್, ಆಮೇಲೆ ಅವರು ಈಸ್ BPL ಕಾರ್ಡ್ ಹೋಲ್ಡರ್ ವೈಲೇಟಿಂಗ್, ಒಂದು ನಿಮಿಷ ವೈಲೇಟಿಂಗ್ ಕೋರ್ಟಿನ ಡಿಪೋಸ್ ಮಾಡಿರ್ತಾರೆ, ಅದಕ್ಕೆ ಕೋರ್ಟ್ ಸುವಮೋಟೋ ಆಕ್ಷನ್ ತಗೋಬೇಕು ಸ್ವಾಮಿ.
ಇದು ಪಾಯಿಂಟ್.
ಸುವಮೋಟೋ ಆಕ್ಷನ್ ತಗೋಬೇಕು. ಹ್ಯಾಸ್ ಹಿ ಪೇಡ್ ದಿ ಟ್ಯಾಕ್ಸ್?
ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್ ಪಾಯಿಂಟ್ ಕೊನೆಗೆ ಬಂದಿದ್ದೀರಾ.
Hence I pray this honorable court to take cognizance of this complainant. He is a BPL card holder. He is also violated before this honorable court.
ನೀವು MLA ಆಗಿ ಏನು ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ ಅವ್ರಿಗೆ?
ಅಲ್ಲ, ಅದು ಅವ್ರ MLA ಅವ್ರಿಗೂ ಇದ್ದಂತ ಬಾಂಧವ್ಯ ತುಂಬಾ ಚೆನ್ನಾಗಿತ್ತು, ಅವ್ರನ್ನ ತುಂಬಾ ನಂಬಿದ್ರು. ಆಮೇಲೆ ಅವರು ಕೋರ್ಟ್ ನಲ್ಲಿ ಮಾತ್ರ ಈ ವಿಚಾರಗಳನ್ನ ಹೇಳಕ್ ಸಾಧ್ಯ ಆಗಿತ್ತು. ಅವ್ರು ಇನ್ನೊಂದೇನಂದ್ರೆ, ಡ್ಯೂ ಟು ಅದರ್ ರೀಸನ್ಸ್ ಈ ಕೆನಾಟ್ ಹೇಳಿದ್ರೆ ಪಬ್ಲಿಕ್ ಲೈಫ್ ಅಲ್ಲಿ ಅವ್ರ ಇಮೇಜ್ ಇದಾಗತ್ತೆ,
ಚಿರ ಬಾಂಧವ್ಯ ತೊಂದರೆ ಆಗ್ತದೆ. ಆಮೇಲೆ
ಅದಕ್ಕೋಸ್ಕರ hence I pray this honorable court to allow my petition in the.
Yes ಸರ್, ನೀವು ಸಾಕು ಸುಮ್ಮನೆ ರೀ.
ನಾನೇನು ಹೇಳಿಲ್ಲ. ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 22, 23 ಎಲ್ಲ ನೋಡ್ಬಿಟ್ರೆ ಆಲ್ ದೀಸ್ ಕಂಟೆನ್ಷನ್ಸ್ ಹ್ಯಾವ್ ಬೀನ್ ಡೆಲ್ಟ್ ವಿತ್ ಬೈ ದಿ ಕೋರ್ಟ್ಸ್, ಬೋತ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಂಡ್ ದಿ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್. ದೀಸ್ ಆರ್ ಆಲ್ ರಿಪಿಟೇಟಿವ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಆಫ್ ಮೈ ಲಾಟೆಡ್ ಫ್ರೆಂಡ್.
ಅಷ್ಟಲ್ಲ ಸರ್?
ಅದೇ ಸರ್,
ಈ ಬರ್ಕೊಂತೀನಿ ಬಿಡಿ. ರಿಸರ್ವ್ಡ್ ಇರ್ಲಿ ಬಿಡಿ ಸರ್, ಚೇಂಬರ್ಲಿ ಬಿಡಿ.
My lord, as undertaken.
ಈ ನಿಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆಯಾ ಸರ್ ಇದರಲ್ಲಿ?
ಇಲ್ಲ, ಈ ಕೇಸಲ್ಲಿ ಏನಿಲ್ಲ, ನಮ್ದು ನಿನ್ನೆನೆ ಮುಗಿದಿದೆ ಸ್ವಾಮಿ. ಆಸ್ ಅಂಡರ್ಟೇಕನ್ ಐ ಆಮ್ ಜಸ್ಟ್ ಫೈಲಿಂಗ್ ಮೈ ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ಸ್ ಇನ್ ದಟ್ ಟೆಂಡರ್ ಮ್ಯಾಟರ್.
MSME
ಹೌದು.
ಇದು ಚೇಂಬರ್ ಕೊಡಿ.
My lords, I'm extremely sorry, my lords. In serial number 137, my lords, I have moved an application for vacating stay, my lords.
Very good.
That's an appealable order, my lords. Earlier round, they were directed to go and approach the education tribunal.
When have I posted it?
My lords, kindly have it on Monday in fresh matters, my lords.
1st December, fresh matters.
My lords, Monday if possible. They are enjoying the interim order from
December
last.
is also Monday.
Fresh matters.
Fresh
My lords, may I?
Very great.
Submission. I'm so sorry. May I mention a matter,
the
my
batch
lords?
matter, lords. 197. Batch matter disposed of once. And the direction may be issued 5, 6 and 8 respondent.
My lord, citations.
Kudi sir, kudi.
5, 6 and 8.
My lord, Bangalore matters, item 3, my lords.
My lords, item
Steel
3.
hypermart.
Yes,
That's
my
it.
lords.
Steel ಕಾಣಲ್ಲ ಇಷ್ಟೊತ್ತಲ್ಲಿ. Yes.
Milords,
We'll take it. I'll post it on Friday or Monday, someday. Yes.
Milords, may I request on 27th?
All right, 27th. Yes.
Milords, we'll have the benefit of your lordship in Bangalore. We'll place seal
Hey,
cover
how do
report
you know
and
I'm in
argue
Bangalore on that day?
Lords, your lordship told I are having the mining matter.
Oh, all right. Yes.
Very well, my lords. Then 27th, my lord.
Yes, madam.
So that Milords, we can also file our documents and argue
All
the
right.
matter.
Ange, yes.
Grateful, Milords.
My lord, I seek apology, my lord.
ಯಾರದು? ಮೇಡಮ್. ಈಗ ಹೇಳಿ. ಈಗ ಕೇಳಿಸ್ತಾ ಇದೆ, ಕಾಣಿಸ್ತಾ ಇದೆ ಎರಡು.
I seek apology, my lord. Serial number 192, my lord. It is acquisition in the year 1992. Till today, they have not paid compensation. It attracts section 24 of the Act 2013.
182 list on Monday, fresh matters list.
192.
92 na 82 na ಬೇರೆ ಯಾರಿಗೂ ಹೆಲ್ಪ್ ಆಗ್ಬಿಡುತ್ತೆ, ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ.
192, my lord. Please, grateful.
Well, as far as item 3 is concerned, the Bangalore
ಈಗ ಡಿಸೈಡ್ ಮಾಡ್ಲಾ? ಮತ್ತೆ
Monday or Tuesday.
My lord,
serial number 164, my lord.
CBI matter, could I only request if your lordships could have it perhaps in the first half or the morning session if possible for any day?
27th perhaps sitting would be at Bangalore. We'll have it there at 2:30.
Very well. So I'm very grateful.
My lord, 164, my lord. Cover by judgment is there. Kindly have it on Monday, my lord. 164. Please, ma'am.
ನಾಳೆ ಬರಬೇಕು ಬೇಡ
Court officer.
Madam, ಹೇಳಿ.
192, madam.
24th fresh matters list, madam.
192. Okay, thank you.